Pending matter, fresh matter.
Pending matter.
Next week ಕೊಡಿ.
Next week 25th.
25th ಬೇಕಾ ನಿಮ್ಗೆ?
25th of next month.
ಅದೇ ಬೇಕು. April 25th ಕೊಡಿ. Yes.
How given this one. Madam,
ತಗೊಳ್ಳಿ.
recently my lord.
25th of next month ಅಂತ ಇದ್ದೀರಾ?
That's for improvement after.
ಆಯ್ತು ಕೊಡಿ ತೊಂದ್ರೆ.
Somebody subject.
ನೀವು ಕೊಡಿ.
I have already submitted.
All right. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ? ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ? ಹಾ ಸರಿ. Yes madam.
It's association eviction. Sought for 33% reservation. It starts tomorrow. The process. It's covered by the
Supreme Court. Kodi. Yes. 2:30. Yes.
Madam, thank you.
No second row. Wait, I'll come. Yes. Tomorrow. Fresh matter. Huh? Pending matter next week, madam. Yes. No. Not on Monday. From Tuesday to Thursday we'll do it. Friday. Yes.
My membership is suspended. They have called for inquiry on Saturday, please, my lord. For 2:30 to 11.
Right, 2:30, please.
I am for petitioner in this case, my lord. Previously, crime FIR
Pending fresh.
fresh, my lord.
Monday ಆಗ್ಬೋದಾ?
August.
ಕೊಡಿ. You have come from the second row. Wait. You have missed the bus then.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು 2:30ಗೆ 51 ಸ್ವಾಮಿಲ್ನವ್ರದ್ದು ಫೀಸ್ ಜಾಸ್ತಿ ಮಾಡಿದ್ದಾರೆ 500 to 5,000.
2:30.
ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಹಸ್ ಬಿನ್
Fresh matter.
And wherever 2:30 move ಮಾಡಿದ state copy,
sir.
state government is the respondent. Serve it on the council here, not in the AG's office.
Please, sir. I'll
From today, no interim order if you have not served on the council.
serve it
My lord.
tomorrow morning.
ಆಯ್ತು,
Please.
tomorrow ತಗೊಳ್ಳಿ. ದಿನೇಶ್ ರಾವ್ ಅವ್ರದ್ದು ನಾಳೆ ಹಾಕಿ.
My lord, fresh matter. It's a agreed home
ಮಂಡೆಗೆ
buyer.
ಆಗ್ಬೋದಾ?
Tomorrow, my lord.
ಮಂಡೇವರೆಗೂ ವೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
My lord, it's a pre-EMI matter. The bank has been asking to pay the EMIs again and again. Ozone.
Then it's Monday, no problem.
Monday.
No issues. Monday ಕೊಡಿ.
Monday.
After confirmation
Monday.
of sale, my lord, auction borrower filed the writ petition before this honorable court. This honorable court said file an affidavit. My lord, the matter is not listed.
Friday.
Right.
2:30 ತಗೊಳ್ಳಿ madam. ಅದು 2:30 ತಗೊಳ್ಳಿ.
My lord, I am appearing. There are connected petition. Have it on Monday, my lord. There's some
ಆಯ್ತು,
other-
Monday ಹಾಕಿ. Monday. Monday ಸುಮ್ಮನೆ.
My father's.
ಹಾ ಸರ್, Tuesday ಗ.
It is a fresh matter. Account deal, my lord. I'm not having money to buy the medicine.
Monday.
My lord.
ಯಾವಾಗ ಫ್ರೀಸ್ ಆಗಿದ್ದು ಸರ್?
My lord.
ಯಾವಾಗ freeze ಆಗಿದೆ?
Yesterday got to know there is yesterday only they.
Then 2:30, give it. 2:30. Yes, give it. Monday.
Lordship,
Monday,
Your Lordship,
pending ಆದ್ರೆ Tuesday. Yes.
Your Lordship,
1 minute. Second roll ಯಾರಿದ್ದೀರಿ? ಹಾ. Give it. Vacating stay ಎಲ್ಲ ಒಂದಿನ ಹಾಕ್ತಾ ಇದೀನಿ ಕೊಡಿ. Friday or Tuesday will post it. Yes. ನಿಮ್ದೇನು? ಹಾ? ಆಪ್ಷನ್ ಫ್ರೈಡೇ ಇದೆಯಾ? ನಾಳೆಗೆ ಆಗ್ಬೋದಲ್ಲ? ನಾಳೆ ಕೊಡಿ. ಎಸ್. ಸೇಲಾ ಪೊಸೆಷನ್ನ ಏನು? 2:30 ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದ? 2:30 ತಗೊಳ್ಳಿ. ಎಸ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ. ಡೇಟ್ ಕೊಡಲ್ಲ. ಆಯ್ತು. ಒಳ್ಳೇದು. ನಾಳೆ ಹಾಕಿ ಕೊಡಿ. ಕೊಡಿ ಕೊಡಿ ವಿಡ್ರಾಲ್. ಎಸ್. ಆ 2:30 ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? 2:30 ಕೊಡಿ. ಎಸ್. ಹಾ ಈಗ ಹೇಳಿ. ವೇಟ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಫ್ರೈಡೇ 26th ಬೇಕಾ? ಆಯ್ತು 26th. Tomorrow, give it. Yes. 2:30. 2:30. ಏನು? Food grains, huh? Yes, madam. Friday ಕೊಡಿ madam.
For renewal of passport, my lord.
Your Lordship, pending matter, Your Lordship.
My lord, this is
Who mentioned now pending matter anta?
I am sorry.
Can't you wait?
So I'm sorry.
Yes.
respect to renewal of passports.
Give it. Yes.
And I,
Fresh matter is it?
no, my lord. it's a-
Pending.
Pen-
Next week we'll post them.
like to mention, this is with respect to vacating stay.
Both on next Tuesday ಹಾಕಿ madam. Passport ಆಮೇಲೆ.
With your permission, Lordship.
ಹಿಂದೆ third row, no. Yes.
Permission, pending matter, Your Lordship. The petitioner has been acquitted 8 years back. His name is still available in the website.
Rowdy sheet.
Date may be 2023 matter, Your Lordship. Any day, any week next week, a date may be.
ಅದು next Friday ತಗೊಳ್ಳಿ.
Next Friday.
ಯಾವತ್ತಿದೆ?
Next Friday.
2:30. ಸಿ ಮಿಸ್ ಆಡ್ರ? ಏನ್ ಮಿಸ್ ಆಗಿದೆ? ಇಲ್ಯಾಕ್ ಬರುತ್ತದು? GMFC ನನ್ ಕೋರ್ಟಲ್ಲ. GMFC ನನ್ ಕೋರ್ಟಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಿ. ಮಗು ಕಸ್ಟಡಿ ಇದೆಲ್ಲ ಇದ್ರೆ ಅಲ್ಲೇ. ಎಸ್. ನೀವು ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಆಗಲ್ಲ, GMFC ಹೋಗ್ಬೇಕದು. ಎಸ್. ಸರ್ಫೇಸ್ ಆಕ್ಟ್ ಕೊಡಿ. ಸರ್ಫೇಸ್ ಆಕ್ಟ್ ಮಗುಗೂ ಏನು ಸಂಬಂಧ? ಹೌದಾ? ಸರಿ ಕೊಡಿ. ಯಾವಾಗ ಬೇಕು? FR ನಂಬರಾ? ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ ಬರೋದು. Am I not listening here? Third row, you wait. Yes. Yesterday. Monday, all right. Give it. Don't worry about Monday either. Please give it. Wait. ಯಾಕೆ? You have missed the bus. Wait. Yes.
Supposed to be listed.
I've told you make rows 1, 2, 3. Then don't jump into each other. Yes.
Directed to be listed today. Not listed, my lords. I've already confirmed the sale. I have to recover 45 crores. They filed an affidavit.
Stay ಇದೆಯಾ?
The order sheet is also.
Friday ಹಾಕಿ ಮಾಡಿ.
My
My
lord,
lord.
tomorrow, my lord, because the
ನಾಳೆ.
purchases are.
ನಾಳೆ today Friday will post.
Lord, it is a pending matter, allotment of KIDB, my lord, where I have been.
Next week, give it. Pending matters ಕೊಟ್ಬಿಡಿ ಮೆಮೋನ.
My lords,
He has started constructing a warehouse in the property.
Tuesday ತಗೊಳ್ಳಿ. ಯಾಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
Hey,
ಮತ್ತೆ ಸ್ಟೇ ಇದ್ರು ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
no, subject to result of
Ah,
the petition.
ಈಗಲೂ ಅಷ್ಟೇನೆ ಆಗದು. Yes. It
my
has
lords,
to be
DRT
happened.
matter, DRT matter, possession notice has been issued.
When?
2:30. my lord.
2:30.
Your Lordship, this matter was listed on March 12th, Your Lordship, but because there was no sitting of this honorable court, Your Lordship may be pleased to list this matter on Monday, Your Lordship.
ಆಯ್ತು, ಮಂಡೇ ಆಗಲ್ಲ, Tuesday ಕೊಡಿ. Yes.
Tuesday, okay, please.
Don't say okay. Yes.
Account has been frozen. Refreeze the
2:30.
account. ಇನ್ನೊಂದ್ರಲ್ಲಿ I am the
Pending
borrower.
a fresh.
Pending ಸ್ವಾಮಿ ಎರಡು.
Next Tuesday. Yes.
That appointment of committee of
Committee of?
management to the ಕೊಲ್ಲೂರು temple.
ಹಾ.
ಏನಾಗಿದೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಈಗ ಪೊಲೀಸ್ ಎನ್ಕ್ವೈರಿ ನೋಟಿಸಸ್ ಕೊಟ್ಟಿದೆ.
So what?
That is under charge.
So what?
Friday or
Pending ತಾನೆ. Next week ಕೊಡಿ, yes.
Tuesday at least.
No, give it, yes. Give vacating stay application. Monday. ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ, ಏನಾಗಲ್ಲ, yes. ಮಂಡೇ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಪ್ಲೀಸ್ ಗಿವ್, ಡೋಂಟ್ ಮೇಕ್ ಅ ಮೆನ್ಷನ್. ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೇಕಾಗತ್ತ ಅವಾಗ, ಎಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇ ಪೆಂಡಿಂಗ್ ಗಿವ್ ಇಟ್ ವಿಲ್ಸ್. ಮೇಡಮ್ ರಿನ್ಯೂವಲ್ ಆಫ್ ಪಾಸ್ಪೋರ್ಟ್ ಇನ್ನೊಂದು ಯಾವತ್ತು ಹಾಕಿದೋ ಅವತ್ತು ಹಾಕಿ. ನೋ ಸರ್, ಎಸ್. ವಿಲ್ ಸಿ, ಎಸ್. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಮಂಡೇಗೆ ಆಗ್ಬೋದಲ್ಲ ಕೊಡಿ. Monday.
3 days they don't have electricity.
ಯಾವತ್ತು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿರೋದು ಸರ್?
ಹಬ್ಬದ ದಿವಸ,
ಯಾವ ಹಬ್ಬದ ದಿವಸ?
ಗುರುವಾರ. ಇದ್ರದ್ದು,
ಹ?
ಹೋಳಿ ಹಬ್ಬ.
ಹೋಳಿ ಹಬ್ಬದ ದಿನನ? ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೆ ಇದ್ದೀರಾ ಒಂದು ವಾರ? ಬೇರೆ ಎಲ್ಲೋ ಇರ್ತೀರಾ ನೀವು? ಕೊಡಿ, ನಾಳೆ ಕೊಡಿ, ಎಸ್.
That is memo is my lord.
ನಾಳೆ
Transfer
ಕೊಡಿ.
of authorization, my lord. Transfer of authorization, my lord. It is a notification.
ಕೊಡಿ, ನೆಕ್ಸ್ಟ್
Court
ವೀಕ್
matter.
ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ.
Tender matter, my
Next
lord.
week, any date.
ಕೊಡಿ ವಿಲ್ಸ್.
Tender
ವಿಲ್
matter.
ಗೆಟ್ ಆಲ್ PDS master posted one day, yes.
Tender matter, fresh matter.
ನಾಳೆ.
Matter is district for orders tomorrow.
Why?
Because in the Nayadhikari, against me, the orders being passed tomorrow. So kindly have it tomorrow morning itself.
Why I'm asking you, what is the matter? If you have not read the memo or read the file, read and come.
Final orders, my lord. They're passing orders against.
In what?
In possession, my lord. They're telling that I am not the trustee of the temple.
Which custody?
Trustee of the temple. The temple, man.
Give it tomorrow, yes.
Tomorrow.
ಯಾವತ್ತು? ನಾಳೆ ಕೊಡಿ, yes. ನಾಳೆ, yes. Friday,
My lord, account freeze ಆಗಿದೆ, school fees
pending matter,
pending matter.
Friday.
Fresh matter, tender matter, my lords. Today it had to be listed, if you can take it.
Had to be, don't tell that. What is the urgency?
The financial bid is opened and the work orders will be released, my lord.
Give it, 2:30.
Passport authority,
ಯಾರು ಹೇಳಿದ್ದಲ್ಲಿ? ಒಂದ್ ನಿಮಿಷ, I'm coming, wait. Yes.
passport authority has issued a notice, my lords, to seeking clarification regarding the pending criminal case. Last would kindly have it on Friday, my lord.
Friday ಕೊಡಿ.
Two petitions, auction of the.
Pending or fresh?
Fresh, your lord.
Monday.
Your lordship's auction is on the 24th, Monday.
Oh, then
Have it on
give
Friday.
it for Friday. No, ಇನ್ನೂ ಇದ್ದಾರೆ, ಹೇಳಿ.
Order of suspension passed with joint director.
ಆಯ್ತು, ನಾಳೆ, ಈ ವಾರ ಕೇಳಲೇಬೇಡಿ, ವೆಡ್ನೆಸ್ಡೇ ಪೆಂಡಿಂಗ್ ಮಾಡಿ.
Pending matter. My prayer is in the nature of final prayer.
Wednesday.
Civil report is being.
ವೆಡ್ನೆಸ್ಡೇ ಸರ್.
Wednesday, yes, great.
ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಕೊಡಿ.
Wednesday.
For being spoken to, ಅದು ಆರ್ಡರ್
ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ನಾಳೆಗೆ ಹಾಕಿ ಮಾಡಿ. ಎಸ್, ಏನೀಗ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮೆಮೊ, ಐ ಕಾಂಟ್ ಗಿವ್ ಡೇಟ್ಸ್, ಗಿವ್ ಇಟ್, ಎಸ್. ವೆಡ್ನೆಸ್ಡೇ ಆರ್ ಥರ್ಸ್ಡೇ ವಿಲ್ ಪೋಸ್ಟ್ ದೆಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. Friday, take that on Friday.
To manual scavengers, they cannot.
Friday, yes. Fresh up pending,
Fresh. I'm seeking 230 endowments matter.
2:30, yes.
230.
Coffee estate? ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. Fresh matter, Monday.
In spite of interim order, bank is re-auctioning the property.
In spite of interim order, ಆಯ್ತು, Friday, yes.
Tomorrow is only auction.
Interim order ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು?
21.
ಕಂಪ್ಲೈ ಮಾಡಿರಲ್ಲ, ಅದಕ್ಕೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. As simple as that.
My lords.
As simple as that. Give it tomorrow, yes.
Masking of names, my lords, this writ petition.
Masking,
Yes,
give
my
it, yes. Monday. Next, call the case. Yes, madam, ಏನ್ ಮಾಡಿದ್ರಿ? ಸದಾನಂದ್, ನಿಮ್ನೆ ಕೇಳಿದ್ದು, ಏನ್ ಮಾಡಿದ್ರಿ?
Before the petition.
Where's the file?
It is disposed of in the year 2021, my lordship.
ಅದು ಗೊತ್ತು madam, you have to, all, order is passed, I said you have to do something about it.
My lord, I have placed a request, but I'll come back. There LRs have.
ಗೊತ್ತು,
I have,
Now we have to redeem the situation, otherwise we'll have to recall this order and pass it on.
exactly. I have called the officers.
Oh,
On Monday, madam.
Monday told, list on Monday.
Number 2.
Petition. Earlier round of litigation, my lord. The tender was,
Detail order ಇದೆಯಲ್ಲ.
tender was quashed, my lord, on the ground, that there is no date of opening of financial bid and there is no description. After the cancellation of the tender, same tender is repeated.
The tender has already been finished, my lordship. and
Which
the
is, what is
construction-
finished?
The tender has already been given and the construction has already been done, my.
Already done.
Yes. my
There was
ಯಾವಾಗ, where is work order ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ?
There was interim order from December 23, my lord.
Interim order ಎಲ್ಲಿದೆ ಹೇಳಿ?
11th of December 2023.
11?
11th of December 2023.
2023.
They had said, my lord, there is only one
Ah.
order work issued and so for that.
Same,
tender,
subject to the outcomes.
Only one. Earlier, there shall be an interim order of stay with respect to all.
ಎಲ್ಲಿದೆ ಹೇಳಿ?
Third
In
paragraph, my lord.
respect to annexures D, J.
They said
But
for
work order
SBI,
ಯಾವಾಗ, work order ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
Sir, my lordship.
ಮೈಕ್ ಹತ್ರ ತಗೊಳ್ಳಿ. ವರ್ಕ್ ಆರ್ಡರ್ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
My lordship, I have not got any instruction from my senior. Pass over my lordship.
ನಾಗರಾಜಪ್ಪ ಅವ್ರ ಕೊಲಿಗ? ಬೇಡ, ಲೆಟರ್ ನಾಟ್ ಫೇಸ್ ಪ್ರಾಬ್ಲಮ್. ನಾಗರಾಜಪ್ಪ ಬರಕ್ ಹೇಳಿ. ಪಾಸ್ ಓವರ್.
Excuse them. I'll also verify with them, please.
ಆಯ್ತು, ನೀವು ಮಾಡಿ. Yes, list the matter on Tuesday in the fresh matters list. You should come prepared.
Okay,
Yes.
Position motive.
Lokesh,
My lords, so the order was granted in
19/1/2020, what has happened?
30% was ordered, my lords.
Yes.
As on that day, the due was 91 lakh 43,500.
Ah.
28 lakhs ಕಟ್ಬೇಕಾಗಿತ್ತು.
Ah.
As on today, they are paid only 21.4 lakhs. Lords, the lordship by order dated had told that interim order will not come into force if the interim order has not been complied. Now just order dated 18th, my lords.
18? 18/3.
18/3, my lords. So thereafter, we have attempted for the
18/3 is today, sir.
lords. Just,
Yesterday, yes, one.
lords, it was on 5/12/2024.
5/12/24.
Made
Made
clear
clear,
in the-
even,
Interim order is not come, interim order granted on 19/1, the interim order stands vacated. Thereafter, we are.
no sympathy jurisdiction here, yes. ಕಟ್ಟಿಲ್ಲ ಅಂದ್ಮೇಲೆ interim order vacated.
First installment, your lordship,
15%
we are. Late
1 minute, 5/12/2024, ಇಲ್ಲಿವರೆಗೆ ಎಷ್ಟು ಕಟ್ಟಿದ್ದಾರೆ?
21 lakh 76,000.
21 lakhs.
ಎಷ್ಟು ಕಟ್ಟಬೇಕಾಗಿತ್ತು?
7 lakhs ಕಟ್ಬೇಕಾಗಿತ್ತು.
Your lordship.
ಒಂದ್ ನಿಮಿಷ, ಟೋಟಲ್ ಡ್ಯೂ ಎಷ್ಟಿತ್ತು ಅವತ್ತು?
Total as on that day, my lord, 91 lakh 43,500 rupees.
ಅವತ್ತಿಗೆ ಅಷ್ಟಿತ್ತಾ?
Yes, my lords. 19/1/2023.
19/1/2023.
Thereafter, my lords, no EMIs have been paid. This order was passed. After this order was passed, that it was not informed to bank in terms of the stay is concerned. All physical portion ತಗೊಳಕ್ ಹೋದಾಗ court commissioner has been assaulted. Now, frequently this court has told that the court commissioner is extended arm of an.
Anything else, sir? Go before the DRT, sir.
Your lordship, kindly, your lordship.
Yes.
On 12/3/2025, I have produced certain documents. What they are making the allegation, kindly, your
Sir,
lordship.
you forget about the documents. ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
Good thing, clear the entire.
That swan song everybody will sing. I'm not going to listen to it.
Clear the entire dues, your
No,
lordship,
sir.
because your lordship.
ನೀವು ಕ್ಲಿಯರ್ ಮಾಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
your
The
lordship,
petitioner is before this court seeking the following prayer.
For a moment, your lordship, kindly.
This
for a
court, showing indulgence, granted an interim order on 19/1/2023. The order reads as follows. As on the date of the grant of the interim order, the amount in due according to the bank was 90 lakhs,
91 lakh 43,500.
91,43,500.
Till the date, they have not given the statement.
1
your
minute, sir.
lordship.
91,43,500. The first chunk of the interim order was complied, but the remainder was not complied with. The indication therein was any deviation in paying the aforesaid amount within the timeline stipulated would, even for the first instance, would entail vacation of the interim order and the dismissal of the petition. No amount, the interim order is not complied with it in its entirety. On 14/12, on 5/12/2024, the coordinate bench passed the following order. The coordinate bench was clear that if the petitioner does not comply with the interim order in its entirety, the interim order would stand vacated. Even today, the amount that is to be paid in terms of the interim order dated 19/1/2023, despite passage of 24 months, is not complied with. The learned counsel for the respondent bank submits that as on the date on which the interim order was granted, they were not, the interim order was granted without hearing the bank. And when the court commissioner went to take possession of the property, he has been assaulted and has produced certain photographs to that effect.
That
I have produced, your lordship.
our
Sorry,
produce madam.
wrong, your lordship. Kindly, your
Sir,
lordship.
that ಬೇಡ ಬಿಡಿ, ಅದಕ್ಕೆ enter ಆಗ್ಬೇಡಿ. So and so. In the light of the petitioner not complying with the interim order, despite passage of 24 months, which had to be complied in 8 weeks, no indulgence further can be shown, reserving liberty to the petitioner to avail of such remedy as is available in law. The petition stands disposed.
Tomorrow they will take the position.
ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ
15
sir.
days, your lordship.
No,
We will
sir.
approach the DRT.
No, approach the DRT. Yes.
Kindly, for a moment, your lordship. Their notice.
8 weeks ಅಲ್ಲಿ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗಿರೋದು 24 months ತಗೊಂಡ್ರೆ ಹಿಂಗೆ ಆಗೋದು. Next installment.
Next installment, late occurred, 3 months later. And we have paid that amount.
No,
Within 3
sir.
months we have paid.
No, nothing doing. Yes.
We'll approach you.
ಒಂದು ವಾರ time, in the light of the interim order subsisting in the case at hand, I deem it appropriate to extend it by another 10 days to permit the petitioner to avail of the remedy of approaching the DRT if he so desires. In the event he would not approach the DRT within 10 days from today, without waiting for the certified copy of this order, the interim order would stand vacated automatically and the bank would be at liberty to take steps in accordance with law. Next.
Four criminal cases were not registered against the petitioner, who the jeweler.
Last
Eventually,
time,
all the
he was
gold is
not
sold
present then also. No representation on behalf of the petitioner list in the month of June 2025. Next. Registry is directed not to list the matter before the first week of June 2025. Next.
5.
ಎಷ್ಟು cases ಇದೆ ಇವ್ರ ಮೇಲೆ?
Your lordship, there's only one case against him.
Hmm.
And there are few check bounce cases.
ಎರಡು
apparently, and
check bounce case ಇದೆ.
LOC ಇದೆ. Who is the originator?
We are those,
Then,
would be police. No, your lordship, because there are other few check bounce cases.
check bounce case ಗೂ LOC ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. Yes. ಬೇರೆ ಏನ್ ಕೇಸ್ ಇದೆ?
There's only one, and
Well,
the
where is
amount
Tahir
is
is colleague?
74 lakhs.
Yes, sir. You have told so many people are cheated. Where are the objections? Passed over to Monday. Yes. List on Monday in the fresh matters. Next. Yes, sir. KDB ಅವರೇ. ಇದರಲ್ಲಿ ಬೇರೆಯವರಿಗೆ JSW ಅವರಿಗೆಲ್ಲ given installments, payment.
Milords, KDB has not given to JSW. It is the Commerce and Industries Department which is directly given.
All right.
One.
Yes.
And in as much as Chanakya University is given, Milords, there is no installment. We have charged him the entire amount.
All right.
And they have remitted it and the land is given.
Hmm.
And in as much as that JSW is concerned, Milords, it was originally the land has a checkered history. It was acquired by the government of India in 1970 for Vijayanagara Steel
No, no.
Switch. The project was
Which are those documents, madam?
Your lordship, page 88. And the last page, page 93. Page 88 onwards, your lordship. The government order.
You copy ನೋಡಿದ್ದೀರಾ?
I've seen, Milords. Page number
88. 88 is,
A total of rupees 50 crore to the Center of Education, so
Yes,
and so, so and so.
hmm,
Your lordship, and page 93, your lordship.
ah,
Where it shows the cost 50, EMD, slum improvement, 30% initial
93
deposit
is it?
payable.
93.
Please, page,
93,
All right.
allotment letter.
Ah,
the 30% initial deposit payable.
hmm.
And they've asked them to remit 15 out of the 50,
Milords,
That is initial deposit.
please.
All right.
And within 3 months, he has to deposit the rest of it.
Same thing will be granted, no problem.
Milords, but they are seeking a relief as against the government revenue department, Milords,
No, no,
not
no.
KDB.
That's true.
Please.
As an illustration,
Please,
madam
please.
quoted this,
Please.
that the government do same thing ಮಾಡಿ.
Will not hand over possession, my lord, till they pay the entire amount.
Please, your lordship.
Possession will not be handed over.
We'll wait.
All right?
Please. We will deposit 1 crore immediately this week.
What's
And
the amount, total amount?
Total is
7 crores.
7.
7
We'll
crores.
deposit
7 odd
1
crores.
immediately and the rest
Hmm.
within 2 weeks, and the rest we will pay it in.
Again, this is an installment. This is an
ನೀವು
installment.
ಪೊಸಿಷನ್ ಏನ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತಾ ಇಲ್ಲ ತಾನೆ? ಸರಿ, ಅವ್ರು ಕೊಟ್ಟ ಮೇಲೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ. But outer limit, you can't take years together to do it. Timeline.
Let it not be a concession on my part.
No,
Within
don't
1
worry
year.
about it.
Within 1. Within 1 year.
1 year.
Oh, no. In KDB, we do it in 3 months. They have to make full payment, 3 months.
ಈಗ ಅಲಾಟ್ಮೆಂಟ್ ಯಾರು ಮಾಡಿರೋದು?
Government.
Government, right? Now it's been allotted to you. There is no illustration saying that
This allotment is not.
EMI
The rules, Your Lordship. The rules grants them flexibility, Your Lordship.
page, madam.
27 powers of the state government. Might I pass on?
Lease cum sale agreement. 27 lane ಇದೆ?
Your Lordship, powers of the state government wherein they can relax the provisions.
He's seeing good. The rules.
Might I-
Grant rules. Grant
The
rules.
grant rules. They say that the reason
the
they've rejected
grant
is that
rules.
they do not have any powers and there's no provision. There is a provision, Your Lordship, under 27.
Then you consider in terms of that. Could you? It's granted under these provisions,
Please.
land grant rules.
Please.
Under the rules, the time is stipulated, is it? Immediate payment anta?
Yes.
So there is power to relax. Case to case basis. If you find it relaxable, relax it. I will just quote this illustration as well. The petitioner, Karnataka Swill Twisters and Weaving House Building Cooperative Society, hereinafter a society, referred to as society for short, is at the doors of this court, calling in question an endorsement dated 16/3/2024, which declines the claim, declines the request of the petitioner for a installment payment in terms of the allotment, and seeks a consequential mandamus directing the respondent to consider the representation dated 16/1/2024. ಮುಂಚೆನೆ ಮಾಡಿದ್ರಾ? Yes, so on. Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner, the counsel learned HCGP and counsel B.B. Patil, who was directed to assist the court with regard to a particular illustration. Facts in brief, germane, are as follows. The petitioner is said to be a cooperative society registered under the Cooperative Societies Act on 29/12/1992. The society applies for grant of land to the government, and the government acceding to the request of the petitioner grants how many acres?
25 acres.
Grants 25 acres of land. The issue is not with regard to the grant. The issue is payment that is directed to be made to the society by the government towards the grant so made. The grant is made for a sum of rupees 7 crores. The
Not 7 odd crores, that's some.
7 odd.
744 lakhs.
7 crore 44 lakhs, etc. Sorry, etc. 7 crore 44 lakhs. Iದ್ ಮಾಡಿ ಡಾಟ್ ಹಾಕಿರೋದು ಅಷ್ಟೇ. 7 crore 44 lakhs.
Lordship, it's 7 crores, 6 lakhs and
Sorry.
6,000.
7 crore 6 lakhs ಅಷ್ಟೇನಾ?
6 lakhs.
7
and
crore
6,000.
6 lakhs and 6,000. The petitioners submit a representation on 16/1/2024 seeking payment of the aforesaid amount on installments on the score that the petitioners were a society which is running a scheme for weavers and twisters and would not be in a position to pay the entire amount in one go. The representation comes to be rejected, and the rejection of which has driven the petitioners to this court in the subject petition. The learned senior counsel Srimati Lakshmi Iyengar, appearing for the petitioner, would seek to place reliance upon an illustration where the KIADB has granted concession of payment within 3 months, payment of the entire amount in 3 months to one company by name JSW, and further quotes an illustration of inyao illustration ಇದೆ madam?
The Secretary Center for Educational and Social Studies.
Quotes further quotes another illustration where the amount is permitted to be paid in installments. Seeking the same prior, the learned senior counsel submits the petitioners have to be shown some indulgence by the state, as the amount to be paid in one go is virtually impossible. The learned counsel, learned HCGP would refute the submissions in contending that in no case where land is granted, the state has shown indulgence by giving amount in installments and giving possession at the same time. The learned HCGP would submit that
These are
the
leases.
represent
These are leases.
lease.
Lease cum sale
A
agreement.
lease cum sale agreement. A learned HCGP would submit that in lease cum sale agreement cases, the amount has to be paid in its entirety as is directed, failing which possession would not be handed over to the grantee.
No, lease cum sale agreements, there are rents to be paid on a monthly basis. That's why there is installments there.
In monthly basis,
Yes, there are rents that need to be paid on a monthly
ADB we
basis.
charge rents, my lords.
Rents per month.
Till the execution of the sale
Paid
deed.
about 20 crores.
That is their way of installment, your lordship. That's all.
Not a way.
That's all. Yeah, so I have given my anxious consideration. Learned counsel, Sri B.B. Patil, also would submit that JSW grant of 30%, grant of certain installments in paying to JSW cannot, the learned senior counsel cannot draw parallel to the concession shown to JSW as it was an acquisition of the year 1982 and has a checkered history. Insofar as the other illustration, the learned counsel would submit that it is for the government to take a decision, as the grant is from the hands of the government. I have given my anxious consideration to the submissions made with so and so. The aforenarrated facts and the grant is not in dispute. The grant is made by the state government under the provisions of the Karnataka Land Grant Rules 1969. As submitted by the learned senior counsel, section 27 permits certain relaxation of the provisions of these provisions of the rules, any provision of the rules. The section 27 reads as follows. Therefore, the petitioner's representation dated 16/1/2024 should now merit consideration in terms of section 27 of the land grant rules supra. The learned, as submitted by the learned HCGP, the possession of the granted granted land would be given only after completion of the payment in its entirety. The learned senior counsel for the petitioner submits, in the event the representation is considered, all other reliefs that they are seeking can be made subject to the outcome of the representation. Outcome of the representation, but however would submit that within 2 weeks 1 crore would be paid to the government, and later on
8 months.
let the 1 crore would be paid in the next 2 weeks. The state, while considering the representation of the petition in terms of section 27 of the Act, shall bear in mind that 1 crore is already paid towards the installment. Appropriate orders be passed within 4 weeks. Within 4 weeks from the date of receipt of the copy of this order.
As a result, Annexure Q.
As a matter of form, in the light of the aforesaid reasons, as a matter of form, the endorsement that rejects the representation stands quashed. Section?
Section, your lordship would substitute it with rules.
Rule ಹೇಳಿದ್ ನಾನು. Land grant rules ಅಲ್ವಾ? Yes. Rule ತಾನೇ ಹೇಳಿರೋದು. Rule. Next.
My lords, I appear for respondent number 3 to 6. My lords, chronological events as have transpired.
This is a matter where after payment of premium of about 12.5 crores, lease deed was executed in my favor. Then notice was issued to me saying that I have not yet put up the construction. Within 20 days of that, I submitted my plans. Without considering or approving those plans, my lease is sought to be terminated and possession taken. And a penalty of 25 lakhs is imposed on me. I have given several representations even after my building plan saying that my building plan has to be approved and no electricity water connection is there. This, and there was the COVID period was also there in between, my lords. Now this, when the first notice was given to me on 4/9/2019, specifically, they intimated to me that within 90 days I have to comply. Within 20 days of that, I have submitted my plans for approval. After that, till 2022, I have given 2 reminders for approval of my building plan. Nothing happens. Then in 2022, further order is passed directing me to pay 25 lakhs as penalty. Even then, my building plan is not considered. Actually, even as on date, my lords, my building plan is not approved. Aggrieved by that, I further make a representation requesting for further time to complete the construction and subject to approval of the building plan. That I give in 2022, my lords. In 2023, there is a notice issued to me saying that they intend to resume the land. Again, I make a representation saying my building plan is not approved, electricity is not this thing, kindly extend time. Ignoring all these, my lords, there's an order passed in 2024 directing to resume the land. Aggrieved by that, I am before my lords. Now, my lords, my only, my real point is, my lords, that at the time when my proposal was approved and I was asked to pay the premium, there was no delay. I have paid the entire premium. 12.5 crores I have paid to the government. No delay on that. And I am a genuine applicant and I am interested in carrying on the development. My only grievance, my lord, is that when my notice was issued to me to comply, immediately within 20 days, I have submitted my request for approval.
All right.
Despite that, 25 lakhs penalty is imposed, because of which I am before this.
Why
court.
was the interim order vacated?
My lords, the interim order was vacated because the KIDB submitted that they have taken possession of the property, which actually, my lords, I had the benefit of the interim order from 16/12/24 till 5/7/24. Sorry, my lords, other way, 5/7/24 to 16/12/24. On that day, my lords, there was a submission made that possession is taken, which on the records, it could not be possible because I had the benefit of the interim order. Then allotment is made to the applicants who have been implemented. Therefore, my lords, even now, even if I were to suffer the order, 25 lakhs penalty, even now, my lords, without prejudice, I am ready to pay. It is not that.
Third party rights are already created.
My lords, that is subject to during pendency of the writ petition and in violation of the interim order, my lords.
Violation illa. Yavat kottid nimge
Lord,
allotment?
I'll make submission.
One
on
minute.
merits.
When was the allotment made to you?
Yes, my lord, they have.
Wait, sir.
Allotment was made after the vacating of the interim
Allotment letter
order,
was
but
Date.
3/1/2025. Allotment letter was issued.
3/1/2020. Interim order is vacated on 16/12.
No, my lords.
Eh?
They have produced the documents. I
Sir,
point out.
6, come to order date 16/12.
I'll produce the memo, my lord, the allotment letter, my lord.
Attoli madam.
lords, even on merits, I want to make one.
One minute,
Please,
I'll come back. Let me first
Please.
see
please.
in the teeth of the interim order kottidara ilva anta ashte.
Kindly see, my lord, document number 1, which is at page number 2. This is the allotment letter which is issued for 2 acres of land.
3/1/2025.
Thereafter, my lord, possession certificate is issued. I have paid the monies at document number 3, page number 5.
On
The tune of rupees 8
10/3/25.
crore rupees.
7/3/25.
Our affidavit ಅಲ್ಲಿ.
ಅವ್ರ affidavit ಬಿಡಿ sir. Allotment
their
ಈಗ ಒಂದ್ ನಿಮಿಷ.
application, they have said.
ಒಂದು ನಿಮಿಷ. 16/12/2024 interim order gets vacated, correct?
Yes, ma'am.
Allotment is made later. Now, our point.
27/2024, my lords.
Sorry?
23/7/2024.
Allotment
Is the, as per their affidavit, as per their affidavit.
allotment late. Copy ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ.
We have served it.
Yes.
At single window clearance, my
Yes.
lords, they are interpolating between a
Single window clearance
and
will not
allotment
result in
by
allotment at all.
My lords have held that it is not.
Single window clearance is nothing if allotment is not done. Because single window will clear everything. Land ಇದ್ರೆ ತಾನೆ ಕೊಡಕ್ಕೆ.
My lords, when my writ petition is pending and there's an interim
That's a
order in
different
my
thing.
favor.
Interim order, one ನಿಮಿಷ sir. Interim order is vacated. So you can't say that during the subsistence of the interim order allotment is made. It may be subject to the result of the petition. That's a different thing. But don't make that statement that KIDB has allotted it in the teeth of the interim order. That's one submission is over. Next.
My lords, my lords, in so far as my bona fides are concerned, that is
That
what I am
will,
placing.
we
before
will
the-
hear all that. So then what is the other submissions we'll consider. Yes, sir.
Even the.
I'll
lack
just-
of-
ಆಯ್ತಲ್ಲ ಇನ್ನೇನು?
My lords may permit me to give this chronological
ಕೊಡಿ.
events. Just for getting the dates in place, my lords. I have the original file. I have marked every single one of the document for my lord's perusal. My lords may note that SLSWCC clearance in his favor happens on 13/4/2017. At the bottom of the page, my lords may see lease deed is executed on 18/12/2017.
ಯಾವ bottom of the page?
My lords,
Yeah, which page are
main
you?
page.
Page ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Last
Lease
one,
deed
my lords.
execute, ಇದ್ರಲ್ಲೇ.
Lease deed executed.
All
I've
right,
given only the dates, my lords. The
All
entire
right.
file is available.
all right.
is executed on 18/12/2017. As per the lease deed, he has to start construction by 2018.
All right.
He hasn't,
All
which
right.
means he has violated.
All right.
Next, my lords, board sends him a letter of reminder after that saying that you have not given the lease building plans as such. He doesn't give. That is
Given, my lord.
I'll tell my
Wait,
lords.
Let
Tell.
him finish. Yes.
After that, my lords, a 34B1 notice is issued. What is 34B1 notice, my lords? If there is any violations, if you can rectify within 90 days, then you do it. Could he have constructed the entire building within 90 days, my lords? No. What he does is, after I issue a 34B1 notice, he submits his building plan on 25/9/2019. Now, my lords, if my lords were to read 34B1, what would say? It says, I have to, anyone whom I'm issuing a notice, I should give him 90 days to rectify any mistakes if possible. He could not rectify because he could not put up the entire building as required as per the lease sale agreement. That is why we issued him a 34B2 notice. Then B3 order was passed. My lords may note the date is B3 order is in 2022. In 22, we say, okay, fine, you have had some trouble. We'll give you extension of 9 months, pay 25 lakhs as
Penalty.
From 22, the 9 months expires in 23, my lords. He doesn't pay. He approaches this court, my lords, in 24. When we finally issue him another notice, from 34B2 we start. Because 31B1 is already finished, my lords. At that point in time, we give him a fresh notice. He appears. And then we say that you have not implemented, you have not even taken advantage of the extension we gave you, nor did you pay the amount. And we resumed the plot.
Right.
Now, my lords, the order impugned here, there are two orders impugned. One, my lords, the resumption order, and one, the 2022 order. After 2 years.
So what?
No, my lords, the fact still remains is if he wanted to take benefit of it, he should have taken the benefit. Within 9 months, he could have made the payment. We gave him an advantage. He did not take advantage of that. And my lords, one more thing, that what is time and again being reiterated is that he submitted the building plan. It is how 34B1 is interpreted. I leave it to my lords. 34B1 says, in case of any violations of the lease cum sale agreement, he should be given 90 days to rectify. Rectification doesn't mean I'll give you the sanction plans now. Rectification is to put it back to where it ought to have been. He couldn't have started the civil construction at that juncture.
We'll see. Yes. We'll look at it on Saturday.
My lords, Annexure D, page 39, is my submission of the plan for approval, my lords.
Wait, what's the date, sir?
25/9/2019, my lords. 20
correct.
days after I have received their intimation, giving me 90 days time. Within 20 days, I have submitted my plan for approval.
No, that's not intimation. That is 30
When that had to be submitted, sir?
My lords, there is no
Time bar.
There's
no time limit.
My lease deed is dated 2017 and I have given an intimation.
All right.
20 days of that I have submitted, my lords.
My lords, it is there. It is there in the lease deed. I've given the date. Lease deed is, my lords, I'll give the records, my lords.
Goody. Records.
Additional point, my lord.
All of them are flagged. All documents are flagged.
Yes, sir.
There are 2 citations I would like to place.
Please,
my lord,
sir.
for
Goody.
consideration.
ಇಷ್ಟೊಂದು ಪೇಪರ್ ಇದೆ ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀರಾ?
Flag hakidene. Green side, all green flags on the right hand side
Lords,
of the requisite documents.
The first one is dated 7th September 2023, WP 16982 of 2017. Somewhat similar circumstances, my lord. Para 8 onwards. Para 8 onwards, my lords. The substance of the decision of this honorable court is that when electricity and suitability of the plot was not made ready by the respondents, they could not penalize the allottee if he was ready to comply. And eventually, my lords, the interest of the state is protected by imposing an interest on the amount payable. Here, there is no amount payable, my lords, because I have already paid the entire amount in advance and lease deed is registered in my favor. The only, my lords, the only grievance there for me was that though they have given me 90 days time and I submitted, they did not even consider that. Without that, they imposed 25 lakhs penalty. The other citation, my lords, is 28th November 2024.
Yes, yes.
WP 36944 of 2018. There, my lords, again, para 3 onwards.
6 months time was granted.
Because both the things in this one, first one, my lords, there is a specific averment that the facilities in the industrial layout were not provided. That is why, in as much as this layout where it is concerned, my lords have written in just dial case that entire amenities are available and all implementation has happened in both.
The Amazon had constructed.
Please.
In the
please.
second
And
judgment,
second one,
I had
second
appealed
one.
for the petition.
I'll clarify, second one. There was an undulation in the land due to which he had made a specific request for reallotment. That was being considered, and this, the honorable court ordered a survey and noted that the land is at a lower level. All those are not part of the pleadings here, nor is pleaded, my lords. And this layout, entire facilities are provided, and it's one of the hottest selling thing in KIDB today, my lords.
My lords,
There's a
it's
massive
already-
demand for it.
My lords, the lease deed at page 61 specifically deals with the circumstances which they are referring to, clause 5, to build as per the agreement.
We'll see. Yes, then we'll reserve it.
Please.
Original records.
Please.
Heard reserved. Yes.
Please, deeply obliged.
Yes, next.
Then 7,
ಇನ್ನು ಹೇಳ್ಬೇಕಾ ಏನಾದ್ರು?
just one last
ಹೇಳಿ.
submission, my lord.
ಹೇಳಿ.
Clause 7 specifically provides that in case of 1 year delay, 2% penalty.
Lease deed ಅಲ್ಲಿ.
Lease deed only, that is at page 63, my lord. Then next again, the lease deed provides page 63, my lord.
Yes, sir.
Clause 7, my lords.
Extension of time. Yes.
A is 1 year subject to lessee paying penalty of 2% of allotment cost.
All right.
B is subsequent extension of another 1 year subject to lessee paying penalty of 5% of allotment cost.
All right.
My lord,
Now,
they
my
are,
lords, after
they-
this,
Wait, sir.
my lords, also, at least 5% if they were to consider and I were not to pay, then they could have terminated. Apart from this, my lords, even as per the lease deed, when they terminate, they are supposed to refund 50% of the money. That also they have not indicated. So, my lords, the entire idea of exercising this power was to somehow deprive me of my allotment, which there is a lease deed registered in my favor.
All right.
And without prejudice to any of the contentions, my lord, even today, my lords, I am ready to pay the 25 lakhs penalty, and if interest were to be imposed, I am ready to bear that also to establish my bona fides.
Will
I am-
consider. Yes.
my lords, only one point. Now that they have pointed out, clause number 6 itself provides what is the time limit. It says 15 months for mega projects and my lords, within 3 years for the date of lease in case of so and so. Civil construction has to start 9 months. My lords. That is page number 63. 9 months it may be calculated from the date it is given.
Will.
And 7 which he is relying on is subject to single window clearance, which is not there in his case.
Yes.
Obliged.
Heard reserved.
Deeply.
Next.
Break.
Policy.
Well, I'm filing this memo along with documents, my lord.
Policy ಇದೆಯಾ?
There is no specific policy
Hmm.
covers all such things. What they have done is, my lord, they have followed the order of the central government in respect of personal defense personnel killed in war and the like situations. My lord.
Hmm.
That is a page 2.
Hmm.
What they have done is, my lord, they borrowed this one and they followed that thing to prepare in this specific case. There, what happens, only thing they ex gratia, everything they have maintained, except that there are some travel concession, all those ministries that come under the union has given
Correct.
some other benefits. That would not apply. If your lordship would kindly see page 4, there, my lord, at serial number 4, my lord.
Hmm.
They say ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಅಧಿಕಾರಿಗಳಿಗೆ GCOಗಳಿಗೆ as per their ranking 60, 40, 30 ಉಚಿತ ನಿವೇಶನ ನೀಡಲಾಗುವುದು ಅಂತಿದೆ. So in this case also what they said, that's why what they adopted was that they would give them a site at their native place. Now, my lord, here it's a unique case where he is from Maharashtra. And now that the Martyrd's widow wants to reside in Bangalore. Now, my lord, some observation from this court, my lord, and in teeth of that 5 FLA, if it can be considered, that's the only thing.
Yes, sir.
And also, my lord,
There
that
was no policy.
after having borrowed, my lord, idralli,
But earlier.
one more,
One
more,
state government allotted to the.
ಅದೇ
ಅಲ್ಲ,
ಇನ್ಸ್ಟೆನ್ಸಸ್ ಆರ್ ದೇರ್ ಅಷ್ಟೇ ಬಿಡಿಎ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
Yes,
ಅದು ಬಿಟ್ಟು ಕಂಪಲ್ಷನ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಈಗ.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲ, page 6 of the document.
ಈಗ ನಿಮ್ ನೇಟಿವ್ ಪ್ಲೇಸ್ ಯಾವುದು?
ಇವರೆಲ್ಲ ಬಾಂಡ್ ಬಾಟ ಬ್ಯಾಂಗ್ಳೂರ್ ಹಸ್ಬೆಂಡ್ ಅಲ್ಲಿ ಇದ್ ಮಾಡಿದ್ರು ಕೆಲಸ ಜಾಯ್ನ್ ಆಗಿರೋದು KSRP ಬ್ಯಾಂಗ್ಳೂರ್
It is native.
ಹಸ್ಬೆಂಡ್ಸ್ ನೇಟಿವ್.
ನೇಟಿವ್ ಪ್ಲೇಸ್ ಮಹಾರಾಷ್ಟ್ರ ಹಸ್ಬೆಂಡ್
ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಏನ್ ಕೊಡಕ್ಕಾಗತ್ತೆ ಇವರು?
ಇಲ್ಲೇ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಇವ್ರು ಇರ್ತಕ್ಕಂಥದ್ದು ಮತ್ತೆ ಜಾಬ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಇಲ್ಲೇ ರಿಸೈಡ್ ಮಾಡಿ.
ಕರೆಕ್ಟ್. ಯು ಕಾಂಟ್ ಆಸ್ಕ್ ವೇರ್ ಎವರ್ ಯು ವಾಂಟ್. ವಿಲ್ ಸಿ. Native place ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ already.
ಅಲ್ಲ, native place ಅಲ್ಲಿ because it is Maharashtra, we cannot allot.
Yes, now ಅದಕ್ಕೆ 4.5 lakhs.
4.5 lakhs, that is ready, my lord, if it is.
That is 4.5 lakhs. In lieu of a site ಅಂದ್ರೆ 4.5 lakhs ಏನ್ ಬರುತ್ತೆ?
Maybe, my lord, but then if it is to be.
You should,
If my lord could observe.
ಈಗ increase ಮಾಡಿದ್ರೆ then it will open box to
Yeah,
everybody.
Exactly.
Let's see. Yes,
My lord, in
we'll
fact,
post, we'll post it on Saturday.
Page 10 ಅಲ್ಲಿ, if your lordship could see what documents I produced, ಮುಂದುವರಿದು ಮೇಲ್ಕಂಡ 3 ಅಂಶಗಳ ದಿವಂಗತ ಮಹಾದೇವ್ ಮಾನೆ ಅವರ ಪ್ರಕರಣದಲ್ಲಿ ಮಾತ್ರ ಪಡಿಸತಕ್ಕದ್ದು ಅಂತ ನಾವು ಮಾಡಿದೀವಿ ವೆರಿ ಕ್ಲಿಯರ್ಲಿ, because it should not set a precedent ಅಂತ.
No, that is why. I would also not write something that would
Yes,
create a
yes,
precedent.
yes.
We'll see in the peculiar facts.
Yes.
List on Monday ಮಾಡಿ madam. Monday at 4:30 PM. For further hearing, we'll dictate on that. Next. Yes, Vignesh.
They were directed to file an affidavit. Directed.
Affidavit as
Hmm.
the word.
Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy
ಕೊಡಿ, copy ಕೊಡಿ. ಅವ್ರಿಗೆ ಕೊಡಿ first.
ಅವ್ರಿಗೆ ಕೊಡ್ತೀನಿ.
ನೀವು first ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು. List on Monday in the fresh matters list. Yes.
Entry model, my lord, maybe extend till Monday.
ಅಂದ್ರೆ Friday in the fresh matters list. Till Friday extended. Next.
Right.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
ಆಗ್-
Next. Madam. On this Friday, 21st.
10.
IOC, the NOC. Yes. ಹೇಳಿ ಸರ್. ಇನ್ನೊಂದ್ ದಿನ ಹಾಕೋಣ? ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಹಂಗಾರೆ ಇವತ್ತೇ ಹೇಳಿ. Yes.
The petitioner, Lord, in the first petition, has questioned the Lord NOC issued in the respondent number. Issued by the respondent number 1 in favor of the respondent number 2, Lord. Petrol and diesel retail outlet, Lord.
What is the ground, sir?
That ground says, Lord, the distance is, Lord, within 50 meters from the residential area. And
Who has determined that?
And another.
Who has determined that distance?
Tahsildar, in fact, it is.
Page.
Blood, you last may kindly see page.
ಎಲ್ಲಿದೆ ತಹಶೀಲ್ದಾರ್?
Page number 108.
108?
108. Annexure L.
Yes.
What is the finding here?
The finding, see, in the second para, last but 3.
ಪ್ರಯುಕ್ತ ರಾಜಸ್ವ ನಿರ್ದೇಶಕ ಒಂದಿಗೆ ಸ್ಥಳ ತನಿಖೆ ಪರಿಶೀಲನೆ
50 ಮೀಟರ್ ಅಂತರ ಇರುತ್ತದೆ.
25 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ಪೆಟ್ರೋಲ್ ಮತ್ತು ಡೀಸೆಲ್ ಬ್ಯಾಂಕ್ ಸ್ಥಾಪಿಸಲು
ಮತ್ತು ಪಕ್ಕದಲ್ಲಿ ವಾಸ ಉದ್ದೇಶಕ್ಕೆ ಭೂ ಪರಿವರ್ತನೆಯಾಗಿದ್ದು ಖಾಲಿ ನಿವೇಶನಗಳು ಇರುತ್ತವೆ. ಉದ್ದೇಶಿತ ಸ್ಥಳದ ಹಿಂಭಾಗದಲ್ಲಿ 160 ಅಡಿ ಅಂತರದಲ್ಲಿ ವಾಸ ಮನೆಗಳು ಇರುತ್ತವೆ ಮತ್ತು ಖಾಸಗಿ ಶಾಲೆಯ ಸುಮಾರು 200 ಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಇರುತ್ತದೆ.
What are the rules now?
Blood rules, your last may kind see the Supreme Court, blood, the Honorable Supreme
Page.
Court has held
Judgment.
page, blood, the 101 may kindly be seen. 101 page. Citing criteria of retail outlets, H, under the heading H. In case of citing criteria for petrol pumps, new retail outlets shall not be located within a radial distance of 50 meters from fill point dispensing units went by whichever is nearest from schools, hospitals, 10 beds and above, and residential areas designated as per local laws. In case of constraints in providing 50 meters distance, the retail outlet shall implement additional safety measures as prescribed by PESO. In no case.
ಇದು ಯಾವ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್?
Yes, yes.
ಯಾವ್ದಿದು?
This is the Supreme Court order in the year 2023, March 14th.
All right, yes.
Similar in pursuance of this direction, you last me kindly similar, next annexure I am page 109. Was district. Blood,
Subject compliance of Honorable Supreme Court of India judgment. Yes. The Honorable Supreme Court of India regarding setting up of new retail outlets wide judgment in civil appeal number so and so has given the direction for compliance which there should not be any residence, place of worship, school, college, hospital of 10 or more than 10 bed, etc. within 30 by 50 meters of proposed retail outlet and with special direction.
Now NOC is given to the respondent
Now respondent
is-
number 2.
and residential area, it is 50 meters from
Yes,
the
yes,
residence. That is your ground.
Yes. And also see notice, public notice was given to file objections in 15 days. But even before expiry of 15 days, they have issued NOC.
Where is
Without
the,
any-
where is the notification?
See,
Calling
notification.
for objections, page.
Public notice. Page 34.
ಸಾರ್ವಜನಿಕ ಪ್ರಕಟಣೆ.
Page 34.
2011-2024.
2011, 2024.
15 ದಿನ ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
In which see 15 days time was given. Last line. of the
ಯಾವುದೇ
page.
ಆಕ್ಷೇಪಣೆ ಎಲೆಕ್ಷನ್ಸ್
So
ಎಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್?
last line.
15 ದಿನಗಳ ಒಳಗಾಗಿ.
ಈ ಕಚೇರಿಯ ಪ್ರಕಟಣೆಯ 15 ದಿನಗಳ ಒಳಗಾಗಿ.
ಸೊ ಪ್ರಕಟಣೆ 2011. NOC
Annexure A may kindly be seen. Annexure A may.
30-11,
It is
10
on
days.
30th.
10 days ಕೊಟ್ಟಿದಾರ?
This the panchayat has given.
Yes, sir. Who is the allotee now?
And I am the allotee.
Yes, sir. Now, who is the, who appears the IOC?
I am for the.
IOC.
Number 2.
Yes, sir.
MRPL.
ಯಾವ್ದು MRPL? Mangalore refineries. Yes, sir.
My lord, first of all, the petitioner has no local stand to maintain the writ petition.
Why? Who is he?
He is a rival operator. He is having a petrol pump just diagonally opposite to this petrol pump. He is already having the petrol pump and he has got a personal interest to
The public interest.
to monopolize his business.
That's all right. ಆಮೇಲೆ.
My lord, he has already submitted the objections earlier itself at page number.
No, he may be having a petrol bump. That's a different thing. If the Tassildar's report is that in 50 meters there is a residential area and it clearly, that is clearly barred, who brings it before the court? I am not bothered.
It is not 50 meters, my lord. Supreme Court itself has said 30 meters. My lord has not read the document fully, my lord.
Page 101.
Page 101.
101, correct.
Last ಅಲ್ಲಿ
Next
30
page,
meters,
next page.
minimum
In
30.
no, in no.
1 minute. In no case, the distance between new retail outlet from schools, hospitals
Less
and residential area designated as per local law shall be less than 30 meters. So here it is between 30 and 50?
It is less than.
ಎಷ್ಟಿದೆ ಇಲ್ಲಿ?
ಅಲ್ಲ ಇದರಲ್ಲಿ 50 meters ಇದೆ. ಅದರಲ್ಲಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. It is 50 meters different distance, my lord. Document number annexure L. The Telecast says it is 50 meter distance. And in fact, the next document, my lord, annexure M, that also, my lord, pursuant to Supreme Court order, they said, my lord, the last line, my lord, in the first
30,
para-
20, 50.
no, not that, my lord. In the last line of the first para, the proposed retail outlet and the special directions of PESO, the above should not be within 30 meters. Should not be within 30 meters. It is above 30 meters.
Additional measures.
Distance is 50 meters.
All right.
Now, PESO has also given no objection. I produced in my statement of objection, page 46.
ನೀವು objections ಹಾಕಿದ್ರಾ ಇದಕ್ಕೆ?
ಇಲ್ಲ ಯಾರು ನಾವ್ ಹಾಕಿದೀವಿ.
ಹಾಕಿದ್ದೀರಾ?
ನಾವ್ ಹಾಕಿದೀವಿ.
ಯಾವುದು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಪ್ರಕಟಣೆಗೆ?
ಪ್ರಕಟಣೆಗೆ ನಾವು ಒಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದೀವಿ.
ಎಲ್ಲಿದೆ ಅಬ್ಜೆಕ್ಷನ್?
Annexure.
ರಿಲೇಷನ್ ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರು ಹಾಕಿದಾರಾ?
ಇವ್ರು ಹಾಕಿಲ್ಲ, ಇವ್ರು ಹಾಕಿಲ್ಲ.
ಇವ್ರ ಹೆಸರೇನು?
ಇವ್ರು
ಪದ್ಮಾವತಮ್ಮ. ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿದೆ ಸರ್?
My annexure F.
Annexure?
Annexure F1.
Page
Page 39.
39.
Yes.
ಎಲ್ಲಿದೆ ಪದ್ಮಾವತಮ್ಮ ಅಂತ ಹೆಸರು?
ಅಲ್ಲ ತಿಪ್ಪೇರುದ್ರಪ್ಪ is my brother.
ಅದು ಪರವಾಗಿಲ್ಲ, ನಿಮ್ಮ ಹೆಸರು ಎಲ್ಲಿದೆ?
ಇಲ್ಲ.
ತಿಪ್ಪೇರುದ್ರಪ್ಪ
is my brother.
ತಿಪ್ಪೇರುದ್ರಪ್ಪ is not before the court.
ಇಲ್ಲ is lad, I am an aged lady. I have stated in the petition. So I requested my brother to file on my behalf. Lad, this was the objection. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚಿತ್ರದುರ್ಗ ಜಿಲ್ಲೆ ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ನಾಯಕನಹಟ್ಟಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 212/5ರಲ್ಲಿ 25 ಗುಂಟೆ ಜಮೀನಲ್ಲಿ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳವರ ಕಚೇರಿ ಪರಿವರ್ತನೆ ಆದೇಶ ನಂಬರ್ 28/11/2023 ಆದೇಶವಾಗಿರುತ್ತದೆ. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿನ ಪಕ್ಕ ನಾಯಕನಹಟ್ಟಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 212/4ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಚೇರಿ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ನಂಬರ್ ದಿನಾಂಕ 25/10/2016 ವಾಸೋಪಯೋಗದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಪರಿವರ್ತನೆಯಾಗಿರುವ ಲೇಔಟ್ ಸಹ ಇದ್ದು, ನಾಯಕನಹಟ್ಟಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 212/5ರಲ್ಲಿ 25 ಗುಂಟೆ ಪರಿವರ್ತನೆಯಾಗಿರುವ ಜಮೀನಿನಲ್ಲಿ ಪೆಟ್ರೋಲಿಯಂ ಬಂಕ್ ಅನ್ನು ಸ್ಥಾಪಿಸುವುದಕ್ಕೆ ಉದ್ದೇಶಿಸಿದ್ದು, ಸದರಿ ವಾಸೋಪಯೋಗದ ಮನೆಗಳಿಗೆ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಹಾನಿ ಉಂಟಾಗುವ ಸಂಭವವಿದ್ದು, ಸದರಿ ನಿಯಮದ ಪ್ರಕಾರ ಯಾವುದೇ ವಾಸೋಪಯೋಗದ ಬಡಾವಣೆಗೂ ಪೆಟ್ರೋಲಿಯಂ ಬಂಕ್ ಅನ್ನು ನಿರ್ಮಿಸಲು 300 ಅಡಿ ಜಾಗ ಅದರ ನಂತರ ಲೈಸೆನ್ಸ್ ಪಡೆದು ನಿರ್ಮಿಸಬೇಕೆಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆದೇಶವಿದ್ದು, ಮತ್ತು ಈಗಾಗಲೇ ಹಾಲಿ PPL ಯೂನಿಟಿ ಪೆಟ್ರೋಲಿಯಂ ಬಂಕ್ ಇದ್ದು, ಇದು
ಆಯ್ತಾಯ್ತು, ಈಗ ಅಬ್ಜೆಕ್ಷನ್ ಓದಿ ಅಂತ ಹೇಳಿಲ್ಲ, ಹಾಕಿದೀರಾ ಅಂತ ಹೇಳಿ.
And it is to be strictly implemented according to the annexure.
Correct, Supreme Court itself says.
Yes, that
In
itself
terms
says.
of Supreme Court order, we'll pass the order.
Yes. 30, if there is any constraint. And 30 and 50 mentioned, 50 is compulsory. And whenever a relaxation is required, if there are any constraints, next permission will have to be taken. That is what it says. If you last may kindly say in the middle, in case of constraints, in providing, I am at page 101. In case of constraints in providing 50 meters distance.
Now, safety measures by PESO. It is for the PESO to do it.
PESO has already given a
It
certificate.
is true, but see,
Judgment
rule
put-
is 50. And then one another next.
Tribal judgment put it.
So next similar, and then see, the procedural irregularities have been there, objections have not been allowed to be filed by the public also. And it is evident from annexure, the issue by the Tahsil.
What was the great hurry in 15 days ಯಾಕೆ ಕಾಯಲಿಲ್ಲ? 15 days ಯಾಕೆ wait ಮಾಡಲಿಲ್ಲ?
But earlier itself, they have received all the objections from from all the public.
10 days ಗೆ ಏನಕ್ಕೆ ಮಾಡಿದ್ರಿ? Why did you issue innocent?
They have received the objection. After receiving the objection only, they have passed.
15 days time ಕೊಟ್ಬಿಟ್ಟು 10 days ಅಲ್ಲಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
That in fact, the document itself is doubtful, my lord.
Which documents?
That publication, my lord.
ಯಾಕೆ ಪಬ್ಲಿಕೇಶನ್ ನೀವು ಮಾಡಿದಲ್ವಾ?
Objections, blood. If they are disputing that.
ಒಂದು ನಿಮಿಷ ಪಬ್ಲಿಕೇಶನ್ ನೀವು ಮಾಡಿದ್ದಲ್ವಾ?
Application issued by the Gram Panchayat.
That
Gram
was
Panchayat.
issued in pursuance of the directions issued by the deputy commissioner.
Panchayat is not a part of the court.
Panchayat is not before the court. If you are disputing the document, you file your objections, let them also answer it. Pattana Panchayat has done.
ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ.
In fact, my lord.
Yes.
Original document is at page 33, typed copy 34.
Same Monday. Monday further hearing at 4:30. Dictate on that day, no arguments on that day.
Yes.
Next.
Interim order.
Interim order will continue till Monday. Yes, next. Second petition ಏನು?
One more person has filed. Site owner. Residential. House site is there, which is private.
Lord, he is a resident of Bangalore and he wants a site in the subsequent and no construction anything. He has got 2 roads, my lord, for his site. And he files
I will see.
Earlier he filed a suit, my lord. He was not successful. In
Next.
Yeah.
11.
But some confusion appears to have been.
1 minute. ಈಗ ಪ್ರಿಡಿಕೇಟ್ ಅಫೆನ್ಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಅದಲ್ಲ ನಾವು
ಅದು ಮ್ಯಾಟರ್ ಅದೇ ಅಲ್ವಾ?
ಅದನ್ನೇ ಹೇಳ್ತೀನಿ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. It is my duty to ward off the confusion that
Yes, sir.
came to be created in the previous date of hearing.
Hmm.
And I would like to request your lordship to first go to the order which came to be passed by the coordinate bench of this honorable court.
Justice
by-
Uma Madam Nalva.
No, Justice Hemant Chandragaud.
Elide.
In this petition.
Page. Order.
Order. You know, at times what happens, my lord? The courts would accept the statement made from the bar to its face value as true at times. And we have a bounden duty, my lord, to make proper and accurate and correct submissions.
All right.
May I now request your lordship to kindly have a cursory look at the order of the coordinate bench of this court on 16th of December 2024. She so-and-so Lawrence Senior Counsel representing the petitioner's counsel submitted that the alleged predicate offense were committed between June 2017 and August 2020. And the subject properties were purchased in the year 2011 and 2013. Therefore, the provisions contained in section 3 of the PMLA Act is not applicable. He further submits that the offences under section so-and-so held by the Honorable Supreme Court in the case of Delhi Race Club, etc., and the offence under section 120B cannot be a standalone offence constituting the offence under section 3 of the PMLA Act. Therefore, the provision attachment order and its adjudication lacks authority. Because these properties that are attached under section 5, my lord, are the one which came to be acquired long prior to years prior to the passing of the order of attachment under section 5. Now I request you, lordship, to kindly have a cursory look at the order which came to be passed, my lord, on the previous date of hearing.
Previous date of hearing.
Yes, my lord.
My order.
On 11/3.
Yes, sir.
I don't know who made this submission.
Alla predicate offense.
Allah, that is not the issue. In fact,
No, is one clarification. Is the attachment pursuant to registration of an ECIR or not? Correct. ECIR is registered on the basis of predicate offense or not? It is. Now the predicate offense is, challenge to the predicate offense is now dismissed, correct? Then how does this survive?
No, my lord. No, I am only inviting.
That's all I'm asking.
Allah, that we have made a wrong submission and obtained the interim order.
Ellide?
Yes, my lord. Kindly go to the order. That is incorrect. That is why I said, let me ward off the confusion that has been created. And that is why your lordship would say, directing the registry to list the matter for final disposal because the wrong submission came to be made.
One minute.
This is absolutely incorrect. On the score that the predicate
Submit that the predicate offense comes
Yes, my
down
lord.
heavily and so on so. And
is unfortunate. That is all I would say.
in the light of predicate offense being dismissed, the offense of PMLA state on strength of the said stay predicate offense needs to be
That an
vacated.
interim order came to be obtained in this case, my lord, by making a wrong submission.
Where have I said that?
Yes, my lord, your lordship. The subject proceedings are connecting the offences under the Prevention of Money Laundering Act. On the score that the predicate offence has been stayed long ago,
Our
in
concern-
the subject case, an interim order of stay was granted. That is.
Alla, then wrong submission ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ?
Does it mean?
ಅಲ್ಲ,
On the score-
I have not commented on.
Not
any-
your lordship, my lord. What I submitted to your lordship is confusion is created.
That's all right.
On the score that the predicate offence has been stayed.
Maybe I have myself created confusion.
ತಂದಲ್ಲ ಅದು ತಂದಲ್ಲ ನಾನ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀನಿ ಏನಾಯ್ತು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಬೇಕಾದ್ರೆ ಮುಂದಕ್ಕೆ ಹೇಳ್ತೀನಿ ಮುಂದಕ್ಕೆ my lord kindly have a look at the very next sentence. So and so Lawrence Senior Counsel appearing for the impleading applicant. ಎಲ್ಲಿದೆ? He is still to come on record. Under what authority he would make the
Was present
submissions?
the other day.
Under what authority? It is an ECIR attachment to what is his?
He is the complainant in predicate offense.
But he can't have a say in ECIR.
That's all right. Yes. You forget this is an
ಇದು
interim order.
ಅಲ್ಲಿ confusion
Sir,
create ಆಗಿರೋದು.
ಇದೆಲ್ಲ ತೆಗೆದುಬಿಡಿ. ಈಗ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳ್ಬಿಡಿ. Yes.
ಹೇಳೋಣ. Well, because
ಅಲ್ಲ,
you-
whether this, since the predicate offense, if you see Justice Uma Madam's order, it is, ಎಲ್ಲಿದೆ order? ಎಲ್ಲಿದೆ? Same petitioner, is it?
ಹೌದೌದು. Well, it is covered by the judgment of Supreme Court in Pavana Divorce case.
Pavana Divorce.
ಹೌದು.
Correct. 120B ಇಲ್ಲ ಅಂದ್ರೆ ಅಂತ.
ಅದಲ್ಲ.
But the whole problem is Prashant.
No. Well, these are the acquisitions which came to be made long prior to.
True.
the
That is
commencement.
exactly what Supreme Court considers in Prashant versus so and so rendered day before yesterday.
Well, ಇಲ್ಲಿ continuing cause of action ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
No, continuing cause of action alla. Money laundering continues.
In fact,
That is one, that was, the facts of that case was even before the act came into force, the predicate offense had been registered, closed. But Supreme Court says, really there.
Could I point out, my lords, in that case, it was a case of Hawala transaction. There the court held the Hawala transaction had been continuing.
I am only telling about what is laid down there.
My lords, what is laid down there is, my lords, if it is going to be.
All right, idralli heli. Yes, sir.
Idralli probably Pavana Debur covers this issue, my lords.
Pavana Debur,
Okay, it covers this issue, paragraph 19.
Kodi.
Could we just point
Pavana
out, my
Debur.
lords? Pavana Debur, paragraph 19.
Consideration of your lordship stand.
I'll do it, sir.
Just paragraph 9.
ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
Copy ಯಾರು ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ?
Copy we have served, my lord.
Is the copy served or not?
We have served the copy. I will just cross check it, my lord. ಇಲ್ಲ. 5th February 2025. ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ ಅದೆಲ್ಲ.
Your lordship held a state hearing in disposal of this petition.
No, not for any other reason, only for the reason that predicate offense is dismissed. That's all. That's the only reason I posted it today. Predicate offense is dismissed and ECIR arose out of the predicate offense. That's all.
My lords has Pavana Debur.
I have.
Aditi, paragraph.
Sir, my judgment is reversed.
How the paragraph 19, my lords may notice in paragraph 19, line about 10 in paragraph 19, the
Correct.
first property.
Correct.
The first property, ex face, my lords gets that portion, cannot be said to have any connection with the proceeds of crime as the acts constituting the schedule offense took place after its acquisition. Now, in our case, the attachment which has been done under section 5 are properties of 2006, 2011, 2013, predicate offenses 2017 to 20. That is what is challenged, lack of power and jurisdiction. And that's the reason, my lords, the interim order was granted. But however, when it came before my lords was under the impression the contention was as though on predicate offense. No, this was straightforward on power and jurisdiction under 5, my lords. And that's the interim order that was granted.
Yes, sir.
My lord, if the property is attached without invoking the value equivalent concept, my lord, the Pavana Debur holds feet. In this particular provisional attachment order, we have specifically mentioned that, my lord, it is value equivalent. And on the invoking that particular concept, we have attached that particular property. Then, my lord, if they are aggrieved by that particular portion, the adjudicating authority proceeding is pending. Like, let them appear before the adjudicating authority and let them argue on that particular aspect, my lord, that can be considered. This particular concept, my lord, para 68, 69 of the Vijay Madan Lal Chaudhary, and then, my lord, Delhi High Court judgment, one is Prakash Industries and Axis Banks Limited, my lord. In those decisions, my lord, this value equivalent concept has been considered.
Shukrara tagonತೀನಿ sir.
My lord, Shukrara, I am not in station, my lord. Sorry,
Next
my
week,
lord. Sorry, my lord.
all right.
On Tuesday, next Tuesday.
Please, interim order.
Interim order continue.
Last time, interim order extension ಬಂದಾಗ, no, it will not be extended unless and until we keep.
Heard the learned senior counsel, P.V. Nagesh appearing for the petitioner. ನೀವು ಯಾರಿಗೆ?
Our second petitioner.
My lords, there are 2 petitioners, accused 1, accused 6. I am appearing.
And the Karnataka counsel Sandesh Chota appearing for the
Probably you are not to put
petition
suddenly
number 2.
say, Sandesh Chota may write a thesis on this or some good articles in law journals.
As following you, sir. Yes.
That's what you will actually say.
All right, Wednesday at 3:30 PM. Yes.
Interim order.
Interim order will continue. Interim order granted on 16/12/2024 shall continue till the next date of hearing. Yes, next.
Yeah, for the first respondent, my lord. Not we have filed our statement of objections to the amended writ petition. Just day before they filed the rejoined, my lord, again raising some technical aspects. But I've sought instructions from the tender inviting authority. I request for next week, my lord.
Interim order ಇದೆಯಲ್ಲ?
Yes.
There's an interim order, my lord, saying that they cannot claim any equities and it is subject to the outcome of the petition. And what's happened, my lord, is there's a letter of intent. Now they say there's a letter of award issued. But we do not know what the letter, they don't produce the letter of award before your lordships.
Oh, the interim order is subject to result.
Yes. Financial evaluation which they claim to have done is not produced. The tender condition not takes into consideration the total cost to BHEL. It is not simpliciter, my lord, a question of examining what is the price quoted by each tenderer. And my lord, I've just produced along with my rejoinder, if your lordship.
Can I scrutinize all this?
No, your lordship can, my lord, because on the face of it, it is ex facie wrong, that's all. I'm of course not requesting your lordship to do a tender evaluation.
Exactly.
That I won't try, my lord.
You're
I'm not-
virtually asking me to evaluate the.
No, I'm not asking your lordship to evaluate. I'm saying they've not done what they're required to do.
Hmm.
Because if they had done what they were required to do, the answer would have been different. Therefore, my lord, it is, my case is not asking your lordship not to evaluate it again.
BHEL,
Yes, my lord.
what do you want time?
Yes, my lord.
Why?
My lord, they've again in the rejoinder raised some new issues, my lord. And they've again produced documents. We are seeking instructions from the tender inviting.
You should know what Avilash will do.
No, lordship may only see one document. I'm so sorry.
Yes.
Annexure S, my lord, to the rejoinder. I won't show anything right now. Please see Annexure S to the rejoinder, my lord. This is the portal.
Annexure S to the rejoinder.
Rejoinder at page 33. When is it?
Page?
33, my lord. This is for this project. Annexure S. Please see the status, my lord, in it. Financial bid opening is there. There's no financial evaluation or award of contract.
When was this?
This is as of yesterday, 11th of March.
Even yesterday it was.
Even yesterday, it was the same thing. If your lordship turns over the page, my lord, another tender
Hmm.
where we were awarded the contract. Financial bid, evaluation, award of contract, everything is there. Here it is not there at all. Yet, my lord, they claim that they've awarded a contract to someone else.
Who is that someone else?
He's a,
I appear for the respondent number 2.
When did they award the contract to you?
When its LOI was issued on
LOA, yavattu?
7th of December.
Letter of intent or letter of acceptance?
December.
LOI or LOA?
LOI means letter of intent.
Hmm.
The very next day, letter of acceptance was issued, my lords.
No, date ಹೇಳಿ madam.
18/12, my lords. My lords, I'll file my detailed objections in the course of.
ಯಾವ್ದಕ್ಕೆ objection ಹಾಕಿಲ್ವಾ ನೀವು?
We have filed.
ಇವ್ರು ಹಾಕಿದ್ದಾರೆ.
Well, you have filed.
They are the one.
Why is it kept blank? Why are these columns kept blank?
That's what, my lord. I'm seeking instructions on this aspect.
No, if tender had been, where is the letter of acceptance 1812 ಮಾಡಿದ್ದೀರಾ?
Yes.
But your website still shows it to be blank. Financial evaluation ಏನ್ ಮಾಡಿದ್ದೀರಾ? Where get the records?
Please. My lord, we are seeking instructions on that.
You see, whatever instructions you may see, get the original records. The learned senior counsel, taking the, Dhyan Chinnappa appearing for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that the financial evaluation and the award of contract in terms of what is depicted on the portal is not awarded as it is left blank. He would in juxtaposition refer to another tender status on the very same website which shows financial evaluation and award of contract. The learned, therefore, there is a needle of suspicion about what is done by the respondent BHEL. Respondent BHEL shall place on record, shall place the original records relating to award of contract to the successful bidder along with all our contract, along with all the tender, the documents of the tender scrutiny committee. List on, ಎಷ್ಟು ದಿನ ಬೇಕು sir?
I may request for 2 weeks time, my lord.
Why sir?
My lord, we'll
ಈಗ
file.
ರೆಡಿ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ,
ಮತ್ತೆ?
ಇಲ್ಲ, we'll have to respond to the rejoinder, my lord.
You respond, no problem. Respond, produce the records, list the matter on,
27th.
all right. List the matter on 27th at 3:30 PM for the hearing.
Great.
Great.
Paper petitioner, my lords, when this matter was listed on Monday, my lords, a learned friend submitted that, my lords, the bid submitted by us, my lords, is without GST. Insofar as, my lords, the bid submitted by H1, my lords, what they claim is, my lords, on higher side. I have filed amendment application, my lords, yesterday. May I request to kindly see order dated 7/3/2025.
No, 17/3/25.
17/3, correct, my lord.
I have
7/3.
modified the order.
Yes, now may I request my lords to kindly see my amendment application for.
ಪರವಾಗಿಲ್ಲ, ಅದು ಹಾಕಿ.
Hakin in all.
I've not looked at the amendment.
Yes, look.
Filed, yes.
List the copy of the amendment application be served upon the state.
Served, my lord. Already.
All right, learned HCGP seeks a week's time to secure instructions to go through the papers and make a submission.
Till then, let them not finalize, my
No,
lords. They have not
I
yet
made it
finalized.
subject to the result already.
I'm not on that issue, my lords. Kindly look at.
No, I am on that only.
Lords, may I request, my lords, may I take 1 minute of my
There
lords?
was only for representation of.
My lords, they have considered, now I have sought for amendment also, my lords. Now
No
kindly look,
objection for the amendment?
Let me look at it.
All right.
my lords, let them place on record, my lords, how they have conducted this bid, my lords.
Well,
Not
see,
placing it on record,
Next Friday, yes,
my lords, 28th,
28th, all right. Yes,
Friday, 21st,
28th, next Friday and the 28th.
Friday,
I said next.
at least on 25th, my
No,
lords. In case
yes.
if they finalize the
Next
bid, my lords, then I'll be nowhere.
Subject to
my
the result and madagide.
Please.
Once I modified the interim order, I will not put it back again.
At least
Yes.
let there be direction for them to produce on
We'll see,
records, my
we'll
lords.
see on that day, yes.
Otherwise, my lords, I'll be nowhere, my lords.
You'll be here only.
Lord,
don't
I
worry.
will be here, my lords. The
Yes, yes.
petitioner, my lords, kindly look at.
Yes, yes,
my lords,
next Friday,
In
yes.
my petition, my lords, it is in my bid, my lords, it is very specific. My bid is 25.96.
We'll hear you whole hog the next Friday, yes, next.
My lords, in the same stage, my
Same stage, tenders all will finish it off, yes.
please.
Petition. This is under.
Comment.
You have filed a statement, the private respondents have.
The next month puja yavaga?
Next to first of
First of
April, that's
April.
Tuesday.
April. Before that.
ಈ ತಿಂಗಳದಾಯ್ತು we have
ಈ
done.
ತಿಂಗಳದಾಯ್ತಾ? ಸರಿ, ಏನ್ ಹೇಳಿ ಈಗ?
Before first.
27 ತಗೊಳ್ಳುವ.
Agu.
List the matter on 27th and
Let them serve a copy of
preliminary
the
hearing.
statement of objection on me.
ಕೊಟ್ಟಿಲ್ವಾ?
Namdu, we have sent it by mail. I'll serve a hard copy also.
Doesn't matter.
ಇಲ್ಲಿ ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲ
Yes,
ಮೇಡಮ್?
we have already filed.
I will.
Heard the learned counsel, Chandana Tadiga, and the learned additional advocate general, Srimati Pratima Honnapra. This court on 4/3/2025 had passed the following order. The next puja date is on the 1st of April 2024-5. Therefore, list this matter on 27th.
Please.
Rejoinder, if any, to the statement of objections by then. Yes, next.
I just now received, my lord, the statement of objection.
My lords, I'll file it in the counter. In the meantime, my lords, this land is in Bagalkot, my lords, and in Dharwad High Court, as regards a certain portion of this land only, there is a writ and a contempt, which is, writ petition is
already a part
disposed,
of
a
my
contempt is pending.
Property in Bagalkot.
Bagalkot, my lords. Now there will be an interpolation, their orders are being passed here, my lords. This entire land is in Bagalkot.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲಿ ಒಂದರಲ್ಲಿ ಇದರಲ್ಲಿ certain portion ಅನ್ನ learned single judge is directed to resume because of non-implementation
All right.
and allot. ಅದ್ರ ಮೇಲೆ ಒಂದು contempt ಹಾಕಿದ್ದಾರೆ, contempt ಇನ್ನು pending ಇದೆ ಇವಾಗ.
Everything is part of my
R7,
petition. my
petitioner
lord.
is R7 in that.
Everything is part of my petition, my lord. I have
No, no,
produced all the.
He's not
offices.
saying you suppressed.
I'm not saying suppress, I'm just bringing it to the notice of the court. I've filed, our counter is ready, I'll file it in the registry, I have no problems with
Copy
it.
ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇವಾಗ, just now they have served a copy.
Tuesday, yes. List on Tuesday. Interim order, if any subsisting, will continue till Tuesday.
Great.
Next.
My lord, in this case, I'm the absolute owner of the property since 2005. Now.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರಿದ್ರಲ್ಲಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, in this
ಇಲ್ಲ
case,
ಅಂದ್ರೆ ಸೂಟ್ ಹಾಕಿ. ರಿಟ್ ಪೆಟಿಷನ್ ಹೆಂಗ್ ಮೇಂಟೈನಬಲ್?
my lord, in
ಎಲ್ಲದಕ್ಕೂ ರಿಟ್ ಇಸ್ ರೆಮಿಡಿ ಇಸ್ ಇಟ್?
this case, what happened?
Who are they you are asking an injunctive relief from the hands of this court, interim injunction restraining unknown persons
Yes.
to enter your property.
I don't
We will
know.
impose exemplary costs on this petition and dismiss it now.
It's not the honorable court has given in a previous case.
Which, sir?
My lord, in the case of
Which case, sir? Kodi, sir.
John Doe, there is a provision. my lord.
Unknown persons.
Unknown.
File a suit, sir. ಇದು MFL ಕೊಟ್ಟರದು, sorry. This is a writ petition.
This case,
You want to insist on an order? I will pass an order. That will be with exemplary costs.
my lord, in this case.
Don't misuse writ jurisdiction like this to grant permanent injunction restraining unknown persons as well as their agent so and so. File a suit, sir, to grant permanent injunction against unknown persons, restraining unknown persons.
Withdraw that and I'll go ahead with.
Do you know anything in this or all unknown persons?
Unknown.
Then unknown, You will withdraw, you have to, otherwise costs. Learned counsel for the petitioner seeks leave of this court to withdraw the petition and avail of such remedy as is available in law. Petition is dismissed as withdrawn. Next.
20.
We have filed our objections today.
ಇವತ್ತು ಹಾಕಿದ್ದೀರಾ? Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Difficulty which is.
Rejoined, some factual
All right,
aspects
no
I need to
problem.
deal with.
One difficulty which is no cost. But these are all church bodies, not which
Correct.
election of which he has challenged here.
Yes.
Lordship has said not to take any precipitative action.
Hmm.
But that is being interpreted to say no functioning at all can happen, not of the diocese. Now, my lord, bankers are asking questions whether we can allow the bank accounts to be operated. But we are.
Right, will you
The Lordship is saying,
rejoined ಹಾಕ್ಬಿಡಿ, we will decide.
not, may I just, the Lordship not, if he is
No.
concerned with any.
Functioning of the
Diocese, but there are.
Day-to-day functioning, my lord, that's not the point at all.
day-to-day
Then
functioning
not,
will
your
not
Lordship
come
might
in
just
the way.
clarify.
Let
Any
them
major
make-
policy
let them make
decision
an
will not take.
application for modification, I'll address it. The idea is not to, the idea is not to disturb anybody, but I don't know where he's coming from unless I know. My lord, I give a short date.
But your Lordship has said not to take any precipitative action. Not that case taken as virtually that the committee cannot function. Therefore,
Day-to-day functions, yes, he is also not objecting to it.
May I just make a request?
Are you objecting to
No,
day-to-day
not at all,
functions?
no.
Yes.
Lordship may clarify that because otherwise this order is floating around everywhere.
Made a
He has
mention
issued
about
notice.
banking
No,
operation.
not banking. Day-to-day functioning, yes, we will permit.
That's all not, that all, not your Lordship, we are having institutions also, not which are running. Therefore, not your Lordship would only.
The day-to-day functioning of
I make one submission.
the
Your Lordship may
respondent-
clarify that no major policy decisions will be taken till the next date.
day-to-day functioning will not come in the way. I will clarify that the order will not come in the way of day-to-day
Because
functioning
what
of
has
the
happened now,
respondent.
Lord, I'll just point out the Lordship, Lord. Before the order was granted, Lord, there was a resolution already passed. Lord, there is a lot of these pastors in different churches.
That
Lord,
is
they-
a- that is-
That is what is challenged here.
That is
No,
what
that is
challenged
no.
here.
What is challenged, my lord, is the election to the council itself, to the Diocese council.
We'll
Now, in
see.
so far, this person, my lord, has already filed a suit. In the suit, my lord, he sought for an order.
So, ನೀವು ಹಾಕಿದಿರಲ್ಲ ಈಗ,
ಹಾಕಿದೆ.
ನೀವು objections ಹಾಕಿದಿರಾ?
ಹಾಕ್ಲಿ.
Let Manian sir file his rejoinder,
No problem.
whatever.
All I'm
I'll-
requesting is, your Lordship may clarify. It will not come in the way of day-to-day
That
function.
I will clarify.
Till the next date of hearing.
Not with regard to banking things.
Your Lordship may only say, my lord, day-to-day activities will not come
My
in the way.
friend
So
is
that,
hitting a raw nerve. I know where he's coming from. I'll address
That's
that.
all right. No, I will only clarify that this
but I
order
have
will not come.
I have objections to the maintainability of the petition, my lord, when he has
That
filed
we'll
this.
see, yes.
That's why I'm
ಈಗ
not
object-
pressing on
ಈಗ
your
objection-
Lordship deciding this matter now.
Objections ಹಾಕಿದ್ದೀರಾ? Let the rejoinder come, pleadings complete ಆಗ್ಲಿ. I'll take it on Thursday, we'll close it.
Great.
Yes. This court on 10/3/2025 had passed the following order. The learned senior counsel Srinivas Raghavan, representing the respondent, would contend that the order is coming in the way of even day-to-day functioning of the respondent. Therefore, I deem it appropriate to clarify that the order will not come in the way of day-to-day functioning of the respondent.
Very good.
The rejoinder, if any, to the statement of objections by the next date, list the matter on Thursday.
Interim
In the
order
fresh
takes-
matters list, is subject to the aforesaid modification, interim orders continues till the next date.
Very great.
May I request, my lord, some difficulty, my lord, on Thursday.
ಯಾವತ್ತು?
Your Lordship may not have it.
First or second of it. First.
First April.
First,
Yes,
very grateful.
first April.
18.
Point number 3, my lord, one more time to file objections, my lord. Objection is ready, my lord, it has to be verified.
Interim order ಇದೆಯಲ್ಲ? Yes.
ಇದೆ, interim order.
27 ವರ್ಷ ಆದ್ಮೇಲೆ. Yes.
ಇಲ್ಲ 27 ವರ್ಷ old
Learned
act ಅಲ್ಲಿ.
counsel for the third
But it's transferred
respondent.
to the honorable tribunal.
ಏ, ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ madam?
Yes, my lord.
Learned counsel for the
But
third respondent seeks 2 weeks' time to file statement of objections. Objections, if any, by the next date, list the matter on 9th April. Interim order subsisting will continue till the next date of hearing.
18.
Yes, Shanti Bhushan.
Please. Look, there are 2 criminal cases against the petition.
What stage?
They're in the charge sheet has been filed.
Charge sheet is filed.
Charge sheet is filed.
Then short validity passport.
That's what I prayed for.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner gets embroiled in a crime number 37 of 2021. And another crime in which charge sheet is filed and matter is pending at CZ 4025 of 2021. in the light of the pendency of the criminal case in which the charge sheet is already filed, the petitioner ostensibly would not be entitled to a regular validity passport, but they would undoubtedly be entitled to a short validity passport in the light of the law laid down by this court in Santosh, alla?
Santosh.
Santosh so and so, same in the court madi, same order madi. Yes. When Shanti Bhushan is there, you need not worry at all. He would have directed the respondent. You appear before them.
Yes, yes.
You appear before them, you will be given short validity passport. This order tomorrow morning will upload it. Yes.
20?
Second, speak for a short passover.
Short passover.
I'll set up passover, but if senior friend is busy, I would some other time.
Passover, passed over to Tuesday. Fresh matters. List the matter on Tuesday in the fresh matters list. Interim order. Adike passover. Yen interim order?
Committee of management is constituted.
Thereafter, my lords, without hearing me, my lords, I have been removed from the committee and.
Oh, without hearing. All right, yes. List on Tuesday in the fresh matters.
Please.
Madam, list kodi. Matters list estiде.
Prepare for petitioner in this case.
Date, madam.
Petitioners have been petitioner have been blacklisted without hearing them.
ಅಷ್ಟೇನಾ? GST.
GST ಕಟ್ಟಿಲ್ಲ ಮತ್ತೆ ಟೆಂಡರ್ ಅಗ್ರಿಮೆಂಟ್ ಸೈನ್
ಅದು ಆಮೇಲೆ ನೋಡಿ. ಇದು ವಿತೌಟ್ ಹಿಯರಿಂಗ್ ದೆಮ್ ಅಂದ್ರೆ ವಿಲ್ ಕ್ವಾಶ್ ಇಟ್.
GST let them pay the subject to the payment of
ಇಲ್ಲ ಇಲ್ಲ ಅದೆಲ್ಲ ಆಮೇಲೆ. Yes, you hear them, let them reply. If they are paying, pay or whatever what you want.
already notice was
But in
issued.
fact,
ನೋಟಿಸ್ ಎಲ್ಲಿದೆ ಕೊಟ್ರೆ ನಿಮ್ಗೆ?
ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
File the statement of objections.
ಬ್ಲಾಕ್ ಲಿಸ್ಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಅಲ್ಲಿ ನೋಟಿಸ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ತಗಲಾಕಿದ್ರು, ಅದ್ರ ಫೋಟೋ
ತಗ್ಲಾಕ್ಬಿಟ್ಟಿದಾರ
ಅಷ್ಟೇ. ಅದನ್ನ ಜಾರಿನೂ ಮಾಡ್ಲಿಲ್ಲ ನಮ್ಗೆ.
ಎಲ್ಲಿದೆ ಸರ್ ನೋಟಿಸ್?
Page 30.
ಪೇಜ್ 13.
30. Statement of objections.
1 minute.
28.
Notice.
2 times notice was issued.
On 28 and order ಯಾವತ್ತಾಗಿರೋದು?
Order is
Order of blacklisting ಯಾವತ್ತಾಗಿರೋದು? 28?
19-2, which is a connection.
3 months ಆದ್ಮೇಲೆ. ಇದು ನಿಮಗೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Blood, I have not received blood. This
Oh.
they have never served upon us.
Twice,
This was never served upon.
Twice they have given the reply also.
ರಿಪ್ಲೈ ಇದೆ ಇಲ್ಲಿ. ಪೇಜ್ 32, 21/11/2024. So natural justice ಇಲ್ಲ.
Blood, in this, Milord, Milord, they have not stated regarding blacklisting also. They've only called upon us to pay. Now, Milord, for rent, Milord, beyond 10 lakhs, GST is applicable.
That we will hear on merits then.
Milord, blacklisting, Milord, beyond.
Blacklisting ಅಲ್ಲ ಇಲ್ಲಿ ಬ್ಲಾಕ್ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದೆ.
ಇಲ್ಲೇನು ಹೇಳಿಲ್ಲ. ಇಲ್ಲೇನು ಹೇಳಿಲ್ಲ.
Just disqualified them.
ಈಗ ಡಿಸ್ಕ್ವಾಲಿಫೈ ಮಾಡೋದ ಬ್ಲಾಕ್ ಲಿಸ್ಟ್ ಮಾಡೋದ?
Only disqualified.
No blacklisting.
Blacklisting, Milord, both are the same, Milord. Your Lordship may.
But disqualify ಅಂತ ಹೇಳಿದ್ರಲ್ವಾ ಅದು?
Disqualification ಇಲ್ಲೇನು ಹೇಳಿಲ್ಲ. Notice does it state like that? May I just read, Milord? Page number 30, annexure R5.
18 ತೆರಿಗೆ ಕೇಂದ್ರ ಸರ್ಕಾರ ಕಾಯ್ದೆ so and so.
7
7 ದಿನಗಳಿಗೆ ಸೂಕ್ತ ಸಮಜಾಯಿಷಿ ನೀಡಬೇಕಾಗಿ ಈ ಮೂಲಕ ಸೂಚಿಸಿದೆ.
ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವುದು ಜಾರಿ ಆಗಿಲ್ಲ ನಮ್ಗೆ, ಬಟ್ ಇರ್ಲಿ. ಯಾವುದೇ ನೋಟಿಸ್ ನೀಡದೆ
7 ದಿನಗಳೊಳಗೆ ಆಯ್ತು. ಮತ್ತೆ ರಿಪ್ಲೈ ಯಾಕೆ ಕೊಟ್ರಿ? Page 32 is your reply.
GST also not paid for me.
ಬರೀ GST ಇದಿರಲ್ಲ ಅವತ್ತಿಂದ.
Tender agreement also not signed.
ಅದೇ ಹೇಳಿ.
Produce the copy of the agreement.
ಎಸ್ ಸರ್. ಯಾಕೆ ರಿಪ್ಲೈ ಕೊಟ್ರಿ? ಯಾವ್ದಕ್ಕೆ ರಿಪ್ಲೈ ಕೊಟ್ರಿ? ನೋಟಿಸ್ಗೆ ರಿಪ್ಲೈ ಕೊಟ್ಟಿರೋದು.
ನೋಟಿಸ್ಗೆ this
ಮತ್ತೆ?
notice has been replied. These notices have been replied.
So natural justice violation is wrong.
But this doesn't state for disqualification. This notice doesn't state
Sir.
for disqualification.
7 ದಿನಗಳಾಗಿ ಸಮಜಾಯಿಷಿ ಕೊಡಿ. ಇಲ್ಲಾಂದ್ರೆ
ಕೊಡ್ಬೇಕಾಗಿ ಕೊಡ್ತೀವಿ.
ಇಲ್ಲಾಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರಲ್ಲಿ.
ಏನು ಹೇಳಿಲ್ಲ ಅವರು. ಈ ತಲುಪಿದ ಸೂಕ್ತ ಮೂಲಕ ಈ
ಸೂಕ್ತ ಕ್ರಮ
ಅಷ್ಟೇ.
ಮಾಡಿ ಮುಟ್ಟುಗೋಲು ಹಾಕುವುದು ಈ ಮೂಲಕ ಯಾವುದೇ ನೋಟಿಸ್ ನೀಡದೆ ತಮ್ಮ ಟೆಂಡರ್ ಅನ್ನು ರದ್ದು ಮಾಡಿ ಮುಟ್ಟುಗೋಲು ಹಾಕಲು ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಿದೆ.
ಅಷ್ಟೇ ಹೇಳಿದ್ರೆ ಹೊರತು ಬ್ಲಾಕ್ ಲಿಸ್ಟ್ ಮಾಡ್ತೀನಿ, disqualify ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿಲ್ಲ.
Tender agreement to sign ಮಾಡಿಲ್ಲ. Tender is going to end, madam.
GST
ಕೂಡ payment ಮಾಡಿಲ್ಲ.
One I would like to bring to your lordship's kind notice. Day before yesterday, my lord, a matter.
You will not get this tender.
ಆಮೇಲೆ ಟೆಂಡರ್ ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಕ್ ನಮ್ದು ಪಾರ್ಟಿ ತಗೊಳ್ಳೇ ಇಲ್ಲ ಅವರು. ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನಮ್ಮನ್ನು ತಗೊಳ್ಳಿಲ್ಲ, ಟೆಂಡರ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಟ್ರು ನಿನ್ನೆ.
ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ?
In yet another matter, which filed by my learned friend, that there was an order status quo. Violating that, yesterday they have conducted the bid, and we wanted to participate.
Which is that matter? Which is that matter?
79. May just.
WP? 79?
I'm sorry, my lord, one.
ಇಬ್ರು ಬರ್ಕೊಂಬರೋದ್ ಬಿಟ್ಟು ಫೋನ್ ನೋಡ್ತಾ ಇದ್ದಾರೆ.
7791.
7791. Tag this petition along with 7791 of 2025. List them both on Friday in the fresh matters. Yes. Next.
Till then, let the interim order.
Interim order subsisting will continue. Yes. Yeah, affidavit ಹಾಕ್ಬೇಕಾಗಿತ್ತಾ?
I filed my objections, Your Worship.
They have filed their objections. They have taken 3 stands, my lords, which I personally feel requires a rejoinder. My lords, initially I had only said that so far as the residential property is concerned, let them lay their hands off till the end of this academic year. But they said it is not possible because the secured assets is only about 12 crores, 13 crores as against the recoverable amount of 68
What are the legal grounds?
Lords, the
legal
legal grounds is this, my lords. It's
Because
petition
procedural
is-
violation is the matra entertaining.
Only, my lords, there are 2 legal grounds raised. The first of the legal ground is this is an MSME. Lords, for the purpose of treating an MSME as an NPA, there is a framework of 2015, which the Supreme Court says, my lords, in Pronit's case, it's mandatory to be followed, without which it should not have been treated as an NPA. Lords, after saying that my account is entitled for regularization and restructuring in terms of that policy and having taken 17 crores, they did not regularize my account. This is the first legal infirmity which I can find from the records. Second, my lords, what they did was, my lords, we approached the Union Bank to take over this loan. My lords, as on the date when I approached the Union Bank to take over this loan, the rating, the credit rating was shown as 3, which is very good. My lords, now what they do is, they, after the Union Bank issues a letter, they show it as 8. My lords, it's a communication to the bank. They deliberately show it as 8. The moment it is shown as 8, Union Bank will not be in a position to take over the loan. We immediately send them a letter.
One minute. Essay is dismissed.
They say is dismissed.
Appeal ಹಾಕಿಲ್ವಾ ಅದ್ರ ಮೇಲೆ?
Not
Appeal ಹಾಕಿಲ್ಲ.
Lords, now the question is only this.
Dispute questions of fact, can I go into?
Lords, I'm saying these are the only 2 legal grounds. I'm not getting into the factual aspects at all.
Did you urge those grounds before the?
This is essentially the ground.
Before the?
Yes, and
in
even
the
in the
essay?
writ petition,
Yes, it has been answered.
even in the writ
It has been
petition, my
answered.
lords, this is the ground raised.
And now, may I take your Lordship the page number 15 of my objections? Only one page, sir.
I guess you have to file an appeal.
Lords, I'll file my rejoinder, then your lordships may consider.
Only one page,
Because,
your Lordship.
Lords, I'm assuring the court that I am not getting into the arena of any disputed questions of fact at all. Lords, every single fact which is placed before the court is an admitted fact, purely a legal contention as to whether they have followed the procedure.
MSME matra I will consider.
Lords, the second question is also very important.
No,
Lords.
because see.
Second question is an admitted fact on record.
One minute, Ravishankar sir. Now the DRT has already considered both these submissions and
Lords,
rejected.
so far as these 2 submissions are concerned,
One నిమిషం.
it has considered but not answered.
Considered and rejected, whatever it is. If it is considered or not answered, considered or rejected, is writ the remedy?
Lords, that's the reason
Is
why I
writ the
said,
remedy?
Lords,
Should
I'm
you
more
not
than
prefer an
certain-
appeal against to the DR80?
Yes.
Because it's already considered and rejected.
Lords, I'm submitting, my lords, that it is not answered at all. My lords, I'll be in a position to
Even
demonstrate.
that position
Lords,
before the
Lords,
DRA.
I certainly understand, my lord, that I have a statutory right of appeal under section 18 of the Surface Act, no difficulty about it. But the ground which I am raising, the Supreme Court also says, my lords, pre-NPA stage is not the stage which is amenable to jurisdiction under section 17 because it's only the measures which are required to be considered under
ಆಯ್ತು
section
ನೀವು
17.
rejoinder ಹಾಕೋದ್ರೆ ಹಾಕಿ.
ಆಯ್ತು.
But what is running in my mind is that
I understand,
because
my lord,
all
I-
these are already answered, where is the question of writ,
I
a writ
just form a
petition
very
against
short
the
note.
order of the tribunal?
Lords, if the statements which I have now made stands answered by the tribunal, my lords, then of course, what your lordship said. But I am in a position to show that they have not answered it. It's not even referred to or adverted to the manner in which my lords have presented it.
That is a different
That
thing.
is essentially what is required
See,
of a tribunal to do.
erroneous order will not give you a jurisdiction before this court. Erroneous order is only appeal, because if you
I-
see
I-
para 11, para
Yes.
11 is what you have contended is answered.
Yes.
Procedure under the MSME is not followed.
Yes.
Writ is not the remedy.
But the reason why I'm submitting the procedure under MSME to treat it as an NPA, I can
But that's
understand,
what
my lords.
para 11 adene ಹೇಳಿರೋದು.
Lords, para
It has
11
rejected.
That's true, my lords. 11, my lords, the procedure under 13.2 at the time of treating it as an NPA is a pre-surface procedure.
That is also answered.
It's a pre-surface procedure.
That is
my
also
lords.
answered.
No, that's not answered, my lords. If your lords
Your
is
Lordship,
going to just
earlier,
take-
13, they have challenged the 13.2 notice also, 13.4.
That is here. Come
Yes.
to page para 7.
my lords, I am at para
Para
7.
7, 13.2, 13.4,
Yes.
MSME
Everything has been-
contentions, everything is answered.
Lord, so far as MSME contention is concerned, if your lords were to see, my lords, at paragraph number 12,
No, sir.
para 12, my lords.
ನೀವು rejoinder ಹಾಕಿ, but
I-
it's rather difficult to
Lords,
entertain.
I will take my chance because the whole reason is this. Lords, the only reason why we approach this honorable court is that they should not take any precipitative steps so far as the residential property is concerned.
ಅದನ್ನ
even
ನೀವು ಅಲ್ಲೇ
that concession-
ಕೇಳ್ಬೋದು. ನೀವು ಅಲ್ಲೇ ಕೇಳ್ಬೋದಲ್ಲ ಎಲ್ಲ. ಅಪೀಲ್ ಅಲ್ಲೂ
Lords,
ಕೇಳ್ಬೋದಲ್ಲ.
the appeal, what happens is this.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು. That's the problem.
The deposit is to be made. If the deposit is to be made, my lords, I would instead permit all my properties to be sold because it's worth 12 crores instead of depositing 35 crores, which according to them, the book value is 50 lakh rupees. They say
But
50
what to
crores.
do? The question, the apex court, even latest judgment
I
says.
have seen that,
This is not, you can't convert this court into an appellate
Lords,
jurisdiction.
I'm not saying that your lordships is converting this into an appellate.
No, because if your questions are already answered and they are erroneously answered, it is definitely enough.
I understand,
Yes.
my lords.
Your Lordship, the,
Rejoinder ಹಾಕದ್ ಹಾಕಿ.
Your Lordship, there is
Thursday,
interim order, the interim order may kindly,
Thursday.
Thursday.
interim order.
ಇಷ್ಟ ದಿನ ಇದೆ, ಇನ್ನೊಂದು ವಾರಕ್ಕೆ ಏನಾಗಲ್ಲ. Thursday, yes.
Please,
And
please.
Thursday, no time.
Lords, I'll
Yes.
certainly no time, my lords, but certainly I'll make an effort to see, my lords, whether, because the.
Because
question of-
I have seen both your contentions are answered.
Lords, the second contention, my lords, so far as malice is concerned, is not a question which can be answered. My lords, it is there. It
Yes,
is writ
sir.
large.
Very
Lords, I'll be in a position to demonstrate it is writ large.
That also you can urge before the appellate tribunal.
Lords, I'll urge my contentions, then I'm in your lordships.
Yes,
Lordships.
yes. Yes, next
Thursday.
Thursday, next Thursday in the fresh matters. Yes, next.
23.
And for the respondent, my lord.
Quash ಆಗಿದೆಯಾ?
In fact, my lord, while granting the interim order, my lord, it was noted that the predicate offense was quashed and actually the predicate offense was pending. My lord, the order which is
ಯಾವ
relied
quash
upon,
ಆಗಿದೆಯಾ?
These proceedings are
ಇಲ್ಲ,
quashed.
predicate offense quash
Which
ಆಗಿಲ್ಲ.
proceeding is quashed?
These proceedings are quashed. PMLA proceedings are quashed on the ground that the offense was committed prior to the enactment itself.
Oh, that, not the predicate
See,
offense.
these
Not
petitions,
the
Oh, this is that Amanat Bank da.
please,
ಹೌದೌದು.
1985 offense.
please.
My lord, on the ground of parity, yes, my lord, they would also probably be entitled.
Yeah,
because
where
at
is
least
that
number
order?
2,
191, my lord.
at page 191, my lord.
Para 11 would be the appropriate finding at 200.
Because my lord, it was
No, this is
submitted,
that Black Money Act.
Please.
because it was submitted, my lord, that the predicate offense, my lord, was quashed and that. No, that is still
No,
pending.
that, all right, yes. This court will grant, Singmar. The petitioner is before this court seeking the following prayer. This court while granting an interim order on 10/3/2020.
There is no interim order.
This
only
court on 10/3/2025 had observed as follows. It is clarified that the predicate offense was not quashed, but the offenses way the co-accused was quashed in writ petition, so and so, page 191. In the light of the quashment of the subject proceedings quay the other accused, the petitioner also becomes entitled to the same relief. This court has held as follows, same order.
Name may be
Right.
deleted.
ನೀವಿಲ್ವಾ?
Navel.
Registry to delete first separate order sheet. P. Prasanna Kumar deleted, Unni Krishnan retained.
Yeah, for the petitioner's counsel, madam. Challenge to a blacklisting order in relation to drugs that have been supplied under a tender. As your lordships have in fact seen one matter of the same parties in
Lordship,
relation to the
any-
same tender. I have supplied goods from October 2023. The total amount of goods I have supplied is at about 12 crores. They have paid me 4
Where
crores.
are the replies and notices?
Plus the
Notices and the replies given by you.
one show cause notice your lordship would find for blacklisting, that is.
There's no reply.
Page 60.
That's why, where is the
The
reply?
reply I have produced is it's at page 617. They issue the notice on 6th, my lords,
1 minute. 6-1?
617, volume 3. My reply is on 12th of February,
1 minute, 1 minute. 617 is 12th February.
12th February. 6th of February, they issue the show cause notice.
Where is the show cause notice?
That your lordships would find at 613. In the show cause notice, I'm given 7 days to reply. I reply even before the 7 days are completed. On 14th, they issue the order.
Notice 5-2, na?
6-2, it is served on me. That email is at page
All right,
613.
6-2 it is served. 7 days would be 13-2.
The order.
You reply on 12-2.
Please.
What is the date of the
Order is
order?
at page 63.
14-2.
63.
14-2. On the 8th, on the 7th day after I have received it.
Page 63, volume.
Page 63. No consideration, they say I have not responded. It's a completely non-speaking order. Para 6, you have not submitted any reply, and that is the only reason for blacklisting.
Blacklisting a particular drug or the company?
This is for a particular drug, Manoj. 2
That
times
is-
they have already blacklisted. One, your lordships had stayed in
That's
April of last year.
dextrose.
That's still pending. This is dextrose, yes.
Which is that?
That
Page.
your lordships would find the 4th April order
Page.
is at page 224. In that, they issued the show cause notice on 22nd March, sorry, 23rd March, but blacklisting order was the previous day on 22nd March. As a result of which your lordships had stayed that.
It's still pending?
This is still pending. There's a second one, my lords, which was issued, the order is at page 645, where again, similar circumstances, blacklisting show cause notice is given. I have responded. Without considerations, page 645. Again, this honorable court has stayed that order.
645.
645.
Where is the order?
It's at page 645.
645. Allah. Which Justice Hemant Chandan Gowda's
Please.
order. Yes.
All of this is victimization because I have been demanding 8 crores payment is outstanding. In addition to this blacklisting notice, your lordship will also see Annexure B, which I have challenged, which is at page 67. Which they say 91 of my batches have been tested and have come back as non-standard quality.
Where is the test report?
Annexure B.
Annexure B. Annexure B notice.
ಅದ್ರಲ್ಲೇ ಇದು
All of
detail ಹಾಕಿದ್ದು.
there's a table of all of the
67.
test reports. I have for all of these requested that the samples be sent to the appellate authority, the CDL. Out of these very list, the first 4 and serial numbers 9 and 10, the CDL has already cleared. It has come back saying it is of standard quality. That has not
You want
been
to file your
considered.
objections?
I want to file the objection, Lordship.
They're
And-
threatening to invoke a
It's-
BG. Sorry.
Dates?
Lordship, here what has happened is we have not received the copy of the reply filed by the petitioner to the show cause notice, Lordship. And with respect to the,
ನೀವು email ಕಳಿಸಿದ್ದೀರಾ ಹೇಗೆ? Reply.
It's on email.
When did you send it by email?
On 12th February itself.
The document that you
That does not have the email itself. Do you have the email?
is it sent by email? Where is the trail?
I'll just show my notes.
Where is the mail trail?
Lordships were to see this previous page, 613, just below that, 613 is their notice.
All right.
Below
Yes.
that is my email
Yes.
of February.
You file your objections, madam. No problem. Yes.
Lordship, one more request, Lordship. Petitioner is not given the legible copy of the writ petition and
He'll give it, no problem. The petitioner heard the learned counsel. Your name is Chandan?
No, man, it's Pradeep Naik.
Pradeep Naik.
Heard the learned counsel so and so appearing for the petitioner. Counsel Srimati Sumana Baliga, the caveator, and the learned HCGP. The petitioner is before this court calling in question an order dated 14th February 2025 by which a particular drug of the petitioner Dextrose FFS is said to be, blacklisted on account of, on the allegation that it is of poor quality. A show cause notice prior to the said blacklisting is said to have been issued by the second respondent. Where is that?
613 minutes.
Second respondent on, what was the date? 6th February 2025 by electronic mail. This was electronic mail attaching a PDF. The
So sorry,
PDF,
Manoj, that would be respondent 3. My apologies.
respond number 3, attaching a PDF. The PDF is the notice that is given to the petitioners. The petitioners submit their reply on 12/2/2025, which is before the expiry of 7th day. The reply is also found in the mail trail of the date 12/2/2025. The order is now passed on 14/2/2025. Paragraph 6 of the said order reads as follows. Where is that order? Order really?
That is at page 63, my lords.
60?
63.
Reads as follows, page 65, para 6.
Your lordships would see there, the date of the order just below 6th is 13th of February, even before 7 days after
Yes.
serving me.
The aforequoted paragraph indicates that the petitioner has not submitted any response to the blacklist notice so issued to the petitioner, stipulating within the stipulated time. The order also indicates that it is signed on 13th February 2025. The expiry of 7 days would be from the date of receipt of the document to the petitioner, document hyphen the notice. The mail trail is indicative, as observed herein above, that the notice is served upon the petitioner on 6th February 2025. Even before the period of 7 days could expire, the respondents have passed an order on the score that there is no reply submitted to the blacklisting. Learned counsel for the respondents, the third respondent, Srimati Sumana Baliga, submits that the reply was never received from the hands of the petitioner to the respondent number 3 prior to passage of the order. The submission is totally belied on the very perusal of the electronic mail trail, as it is it clearly indicates that the mail is received by them on 12th February 2025. Since it is an electronic mail, there can be no, it cannot be said that they have not received, they have not received the mail or the notice. In that light, there shall be an interim order of stay as prayed for. Tag this petition along with
Submission, Lordship.
along with 10393 of 2024 and what's that one more petition?
Lordship.
The others are
1 minute.
already tagged, Manoj. 34966 of 2024.
Petition and 34966 of 2024. How much time you want?
Lordship,
Objection?
kindly pass over, Lordship. I'll.
Pass over.
ಹೌದು ಸ್ವಾಮಿ, ನನ್ನ ಕ್ಲೈಂಟ್ ಹತ್ರ ಕೇಳ್ಬಿಟ್ಟು
ಅವೆಲ್ಲ ಇಲ್ಲ. ನೀವು ಕೇಳ್ಕೊಂಡು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ, ತೊಂದರೆ ಇಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಈ ಆರ್ಡರ್ನೇ ರೀಕಾಲ್ ಮಾಡಿ ಮ್ಯಾಟ್ರೆ ರೀಹಿಯರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ ಅವಾಗ?
ಯಾವ್ದು ಆರ್ಡರ್ ರಿಕಾಲ್ ಮಾಡಿ?
ಇದು ನಮ್ಮ ಆರ್ಡರ್ ಸ್ವಾಮಿ.
ನಿಮ್ಮ ಆರ್ಡರ್ ರಿಕಾಲ್ ಮಾಡ್ತೀರಾ?
ಹೌದು.
ಮಾಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವಾಗ
ನೀವು ಮಾಡಿ. ನೋ ದಟ್ ನೀವು ಮಾಡಿ ಆಮೇಲೆ ನೋಡೋಣ. ಎಸ್. Objections, if any, in the next 2 weeks. List the matter on 8th April ಆಗ್ಬೋದಾ? 8th April.
Section B also is the show cause notice threatening.
What have you prayed?
Invoke.
What have you
for
prayed?
both matters.
As prayed for, I have granted, yes.
The annexure B is notice, Lordship. Let them reply at least.
Serious.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು NSQ
ಅಲ್ಲ ಸ್ವಾಮಿ, ನೀವೇನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು, ಇವ್ರು ಸುಮ್ಮನೆ ಇರ್ಬೇಕಾ?
ಡ್ರಗ್ಸ್ ಗೆ ನಾವು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೋದು.
ವಾಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ದೀರಾ ತಾನೇ?
ಇಲ್ಲ, ಇವಾಗ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೇಕು.
ಹೌದು, ನೋಟಿಸ್ ಯಾಕೆ ಕೊಟ್ಟು, ನೋಟಿಸ್ ಮುಂಚೆ ಯಾಕೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಇದಕ್ಕೆ 14 ಇದ್ರದ್ದು ಸೆಕೆಂಡ್ ರೌಂಡ್ ಆಫ್ ಇದು ನೋಟಿಸ್.
ಸೆಕೆಂಡ್ ರೌಂಡ್, ಫಸ್ಟ್ ರೌಂಡ್ ಇಲ್ಲ. You have given a notice on 6/2/2025. You should have waited for 7 days. Consider it as reply and past orders. Where was tearing hurry? Yes. Next, list on 8th April.
Grateful.
I am for the petition in this case. Lorships.
Water supply, yes.
Kindly see page 39, my lord, annexure B, it's a letter sent through registered post, not even served as an application has to be filed, my lord, at least an application.
Connection.
Connection, new connection,
Madi.
asking for a new
The
connection.
representation, my lord. It may kindly be.
Representation.
acted upon.
Application ನೀರ್ ಬೇಡವಾ?
ನೀರು ಬೇಕು ಸರ್,
ನೀರ್ ಕೊಡೋ ರೀತಿ ಕೊಡ್ಬೇಕೇನಾದ್ರು.
ಅದೇ ತರನೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬಿಟ್ಟು ಡಿಸ್ಪೋಸ್.
ಅಷ್ಟೇ, ನೀರ್ ಕೊಡೋ ರೀತಿ ಕೊಡಿ ಅಂತ.
ಅಲ್ಲ, ನೀರಲ್ಲ ಇದು.
The petitioner is before this court seeking the following prayer. The learned counsel for the respondent submits that no application seeking water connection is made in terms of the statute to the respondent to grant such water connection. It is only a representation made seeking water connection.
Annexure B.
A representation at annexure B.
Through post, my lord.
One minute. Representation at annexure B seeking water connection, which is also sent by way of registered post. The learned counsel for the respondent further submits there is a format seeking water supply connection, and if the petitioner would submit in that format and within reasonable time, the application of the petitioner would be considered and appropriate orders would be passed. In that light, reserving liberty to the petitioner to submit an application in terms of law and with a direction to the respondent to consider the same in accordance with law and pass necessary orders without brooking any delay thereafter. Brooking any delay after the submission of the application, the petition stands disposed. Next.
Other matter.
Both.
Both
Yes.
are same.
Same.
Then unpopular. The other matter, my name is not being shown, my lord.
Registry to print the name of BL Sanjeev. Avradena?
Yes.
25 al first separate order sheet ಮಾಡಿ.
Much
Next.
Much obliged.
26.
It's an interim order.
Yes.
The second round of litigations, my lord, it is
Ah.
at page 113, my lord. This honorable court is directed, my lord, 113, my lord.
Just submit, my lord, if they are ready.
113, my lord.
My lord, may kindly come to page 34, my lord.
Lord, disqualify of the
Right,
tender.
technical bid.
ಈಗ ನಿಮ್ಮ ಡಿಸ್ಕ್ವಾಲಿಫೈ ಮಾಡಿದಾರಾ?
Our
Technical bid has been rejected.
entire all taluk, my lord, another 3 taluk also is disqualified, my lord.
They are
Why?
ready, my lord. I'm
Reason, my lord, it is under violation of the condition number 4 is said notification, my
Who
lord.
are you appearing for?
5 and 6, my lord.
Who is 5 and 6?
Is a bidder, my lord.
Oh, you are also a
I
bidder.
am also bidder.
Government is silent and you have,
Need to
you are
secure
making all the,
instructions.
huh?
Need to secure instructions.
All right.
I have
Learned,
verified the
learned AGA
document.
seeks a week's time to secure instructions and make submissions. List the matter in preliminary hearing on 28th.
tomorrow to continue.
Interim order subsisting will continue to the next date.
To
of
make
hearing.
one more request, my lord. If they can open the financial bid, my lord, if I'm out.
Avat-
My lord, all
Yes.
entire taluk
Next,
is
next,
disqualified, my
next.
lord, not
Good.
only for one taluk.
ಏನ್ dispute ಸರಿ ಹೋಗಿಲ್ವಾ?
No, no,
All
there's.
those memos.
I think your, the writ court is being misused for personal scores. We'll dismiss this. The writ court is being misused for personal scores in the garb of students. This is a dispute between both of you.
Yeah, that is true.
That you resolve wherever you want.
Please. But may I just bring to lots, what is actually transpired, and the reason why not we have approached.
Oh, in the students' interest, I have been passing the orders.
True.
That's all. And that is being misused. If that is misused, then.
No,
you
it
will
is not misused. I may only bring to lordship's notice. It is not misused at all. Lords, I may just narrate one or two events, lords, preceding the filing of the writ petition.
Yes, sir.
Please. But there is a memorandum of agreement at page 104 if lordships.
That I'll be entering into the merit of the.
No, I'm not, I'm only bringing to lordship's notice, now that lordships feel that there has been some, I'm only bringing to lordship's notice what has actually transpired. Or rather, my lord, I'll explain before your lordships what that is. At page 104, my lords, is the memorandum of agreement entered into between the trustees and another association by which, my lord, we were asked to run this institution. But the petitioner was also inducted as a trustee, and the arrangement was about a sum of about 3.4 crores were to be paid to them for the purpose of running this institution.
pursuant to which, my lord, a sum of rupees 3.4 crores was indeed paid. And I was petitioner, one of the petitioners was inducted as a trustee. The memorandum of agreement contemplates that we run the institution. As on today, and this is something, my lord, which I would emphasize and dispute about that, that the person to whom this memorandum of understanding was entrusted is running the institution. The dispute actually arose about the payment of money. They initiated arbitration proceedings and sought for a direction that the money collected by us from the students must be deposited in a bank. And there is an order to that effect.
No, that's a private dispute.
No, I'm only bringing to Lordship's notice why we have come, not for any other purpose. I'm only bringing to Lordship. This is the first order of the civil court. The second order is there was some criminal trespass made. We had filed a complaint before the jurisdictional police. This honorable court passed an order, though stayed the proceedings against them. This honorable court specifically passed an order that please ensure that the educational institution is run without any difficulty. That order, may I request Lordships to kindly see at page 35.
Yes.
It is prelude to, it is as a, at page 35. I put it down.
So its proceedings are stayed.
No, not only stayed, but may I request Lordships to kindly permit me to read the second sentence of that order are hereby stayed subject to the condition that the petitioners and respondent number 2 shall ensure the day-to-day functioning and activities of the school and its students shall continue smoothly till the next date.
How can that order be passed in a criminal petition under 480?
No, I'm only bringing to Lordship's notice. Not that is the kind of an order which came to be passed.
Criminal proceedings stay, crime stay
observation I'm bringing to Lordship's notice. I'm not seeking enforcement of. But what happened thereafter, Lords, was we continue to run the institution. One, Mr. Shiva Prasad, who is a respondent here in Lords, comes to the institution and barges in, and I would now rely upon these photographs. Lords, may kindly see.
I have seen.
I'll just explain. The photographs of David, kindly permit me to read. And look at the nature and the method in which, if these persons are allowed to
register a crime against them.
I'll just take, that also will. No, permit me to read page, show before your Lordships, page 69 of this affidavit, which is now given, page 16. I'm just not Lordship. This is why we have come before your Lordships is because of page 69, 70, 71, 72. He barges into principles in not 72. What should the 72 of that affidavit?
Yes, sir.
He barges into this principal's chamber. 73 is he locks the car. 75 is again he shouts, etc. And pulls out the security guard. But we sent a WhatsApp message to the Commissioner of Police and therefore a complaint. All that we were requesting was provide us protection. But we have not asked for anything else. Now, Lords, the attempt by them is this. Now they are saying, Lord, that we are trying to terminate the certain teachers, etc. Some allegations were made. We have found out. In fact, she has filed an affidavit saying that some of them signatures are forged, etc. But I have instructed them, instead of entering into that controversy, we will give an undertaking, Lord, before your Lordship, that we will not in any other manner terminate any teachers, etc. We will maintain status quo. Our interest is only this. One of them is a trustee, one of them is a principal before your Lordships. The examinations are going on. I have found, once again, re-verified. My friend said no examination. Up to April 4th, practical examination and theory examinations are going on. Now, Lords, as Lordships have rightly observed, there is a civil dispute between the parties. For some reason, they have not sought for injunction against us not to, they admit that we are in running the institution. Their dispute is about money. Obviously, we will also comply with that order. But I must bring to Lordships notice, this petition, Lords, is a fervent appeal when, Lord, we did not get any intervention by the jurisdictional police. But the Lordships are to see the WhatsApp message,
that's
desperation
fine.
which the principal sends her at 11:30 in the night. And Lord, we can't counter this. If that gentleman coming in the designer sunglasses comes and threatens us like this manner, it becomes extremely difficult for only for that limited purpose we are before you, not
now,
for any other.
Police protection, what is objection?
I'll,
Really?
please give me 2 minutes, I will
Yes.
say that. They are not an operator.
Huh?
They are a school operator.
All right.
So they are supposed to operate the school.
All right.
They terminated the agreement.
Agreement, that is a subject matter of.
No, let me explain why it's relevant, Manoj. The trustee who was appointed can only hold position as a trustee till the agreement is in force. Now they terminated the agreement first and said this agreement has come into stopped. Therefore, she was removed as a trustee. So she ceased to be a trustee. But today, Manoj, she says, I'm acting as a trustee and I'm taking over the school and I'm going to run and manage it. Your Lordship sees photographs, Manoj, of a person walking in. You take a photograph and say he was shouting. How do we know if he was shouting or who was shouting at him? No, this is very easy to say.
That's the personal problem between both of you.
Yes.
Whatever it is, if you are in before a civil court or anywhere, the petition is filed only for granting police protection. I have granted and I will continue police protection only in the interest of the students till April 4th.
No, there's no exam. I'll tell you,
No,
Lordship.
that's all right.
Let me point out, Lord. The CBSE has issued an email, which I'll point out to your Lordships, where they said this is not even a center for the examination. Therefore, there are no examinations happening. The fact is, what they did is, and many of the teachers are also before the court, who have confirmed that all of them were asked to resign. Why? Because if I can't run the school, I will not allow the school to run. That's the whole thing.
The fact that
40
No,
teachers.
fact that they
that
call
is-
No, sorry.
teachers.
40 teachers.
Call
That is the
teachers to file
dispute.
these affidavits.
No,
shows
no,
from the
that is the
division which is
Teachers have
dispute
come.
between both of you.
Whatever it is, 40 teachers have
So
been
that is
forced
the
to resign.
dispute between both of you, whether the students are, he says it is there, you say they are not there. The police will give protection in the interest of the students till April 4th if theory or practical exams, whatever is
300
said.
students are there. Even now, not today also they are there for
Well,
practical
but
exam.
I've asked the
No,
teachers.
what's the problem in that?
No, the problem is this, how it is being misused is,
Yes.
in the name a lot of protection of student,
Yes.
you come in and say, now I will not therefore allow anyone else to function. You therefore.
No, I will clarify that.
Let
Clarify
the
that
government
thing and
advocate may be
dispose it.
directed to instruct the police to ensure.
That is what I will direct.
Here, what they do on ground lot is very different.
That's
Not
all.
they call the teachers and say, you resign. Why would not 40 teachers submit an
They have
affidavit?
filed now an affidavit.
That is not
refusing
the
that.
scope of this petition.
Scope.
All
But
right.
Lord, I am
One
only
minute.
pointing out of
The
the
answer,
misuse.
the answer. That's not the scope of this petition. Scope of this petition is with regard to police protection.
Correct.
Police protection I have granted in the interest of the students.
Yes.
In the garb of police protection, misusing the police protection, the police will take care. And if there are no students there, the police, I will observe that if there are no students there, the police will go back without protection.
That's all.
As simple as that.
Very well. Very well, Lord. If that's
So
the case, your Lordship
no,
may
that's all.
clarify it. Because according to us, Lord.
No, I'll clarify.
Yes.
I'll direct the police to, now police protection is given. If students are not there, police protection is not required because it's a private dispute between both of you.
Yes.
If there is any order of injunction, then you seek a separate police
is-
protection
There was specifically an order of injunction
in your favor.
restraining them
In
from
your
taking
favor.
money from
Money,
teachers. One second, sir.
Ah.
Taking money from teachers. What they did is, notwithstanding that, they've collected money.
That's all
and
right.
deposit
So,
in their
one
own
minute, one
accounts.
minute. So it is with regard to money.
Yes.
If
Money is
I
required
give
for
police
running the
protection to money,
No, that's what it is. You get
Then-
police protection and then you do all
no,
these-
no, if I give police protection to implement the order of the court or whatever, it concerns money,
No.
then
No, we will.
I'm not on money.
come to your
I'm
abiding
on
by
the,
the law.
Then
I'm
risk is-
simple
risk
point as
is
how it is
yours.
misused. Your Lordships have now seen. No, please don't give police protection to money, Manoj. That
That's
is
why.
not required. That is not required. But the point, Lord, is nobody can come to this court and ask for an order and then, Lord, go and misuse it and say, I'll ask
I
you to
will
misuse
tell
me."
the police now, I will pass an order.
Yes,
Prabhu sir is also not against that. Yes.
Lord, my learned friend, Lord, will not be against it, but I'm not talking about my learned friend. I'm talking about my learned friend's clients.
That's he is speaking for his client through the advocate on record.
There are two blocks. One is administrative block and one is where the classrooms are. So we will give protection to that building.
One day
Students ಎಲ್ಲಿದ್ದಾರೆ ನೋಡ್ಬಿಟ್ಟು ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡಿ.
campus ಒಂದೇ.
Students,
very
block is different from the.
You identify the students, not the teachers or warring parties here. Yes. Will dispose it, sir.
Yes, please.
The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Prabhuling Navadgi appearing for the petitioner and the learned senior counsel Dhyan Chinnappa representing the respondent and Rahul Karyappa, the learned additional government advocate. Additional advocate, sir. Yes. The petitioners and the respondent, private respondents, have a dispute with regard to the trust which runs the educational institution the Gitanjali Educational Trust. The petitioners are said to be the trustees.
Trustee and principal.
Trustee and principal.
First petitioner is
ನೀವು ಯಾರು?
trustee.
I am for the respondent.
Principal.
No, not for the principal.
ಅವರು
Trustee.
trustee.
We are the
The
trustees.
one ನಿಮಿಷ. Petitioners claim to be the trustees and principal. The respondent also claims to be the trustees and heading the institution. Therefore, the lurking dispute is personal between the petitioners and the respondents. What has driven the petitioners to this court seeking the aforequoted prayer is that the impending examinations in the institution and the dispute, and due to the dispute, the students, the writing of the examinations by the students getting jeopardized. Therefore, this court directed the police to grant such protection so that the students would not be, the career of the students or the examination of the students would not be put to jeopardy. The order, what's the date?
10th March. Lordship said past tense.
The order dated 10/3/2025 reads as follows. After the respondent entered appearance, the issue with regard to collection of fees and resignation of the teachers being forced by the petitioners was projected. In that light, the precipitative action, any precipitative action being taken would be viewed seriously was the opinion of the court. Today, both the learned senior counsel for the petitioner and the learned senior counsel for the respondent would submit that the disputes between the two would be resolved in a competent court if need be, or if the case is pending before the court. If the learned senior counsel for the respondent submits that there are no students at all in the institution and the police protection order is being misused to protect the petitioners and not the students, while it is disputed by the learned senior counsel for the petitioner. Therefore, to resolve the problem, I deem it appropriate to dispose the petition with a direction to the respondent police to grant protection to the students that are in the institution, and if the students are writing the examination, no amount of dispute between the two shall come in the way of the students writing the examination. The learned senior counsel for the petitioner submits that there are classes up to the 4th of April 2025. Therefore, the police protection identifying the place where the students are there shall be granted to those students to enable them to write the examination or continue the classes till the classes would get over. It is made clear that the police, in the event no student is found in the institution as is alleged, police protection shall not be granted to the warring factions unless there is an order of any competent court of law. With the aforesaid observation, the petition stands disposed.
Great, very good. But that.
Affidavit that we filed today.
What affidavit?
Counter affidavit.
Where we have said that we have not held out any such threat.
No, only lordships may take.
Threat ಯಾರಿಗೆ?
No, what he is trying to say is that may be taken on record.
The learned counsel for the petitioner files an affidavit appending certain documents refuting or disputing the allegations made by the respondent. The same is taken on record. Yes.
During with the respondent bank. My lord. Demand notice and reply has been challenged. My lord.
ಎಷ್ಟಿದೆ?
1 crore,
4 lakhs.
1 crore 61,000. My lord.
Again, I have granted an interim order.
No, madam.
Yes, sir.
It's a fresh matter, madam.
ಎಷ್ಟು?
Recently, I paid,
Recently ಇಲ್ವೇ ಇಲ್ಲ. ಎಷ್ಟು?
I'll deposit 20%.
20% of what? 1 crore?
1 crore 61.
4 weeks?
4.
Yes.
20%, failing which
4 weeks.
Because
It
it's
will
only
always
2
be
weeks.
there. 4 weeks, 20% of the amount in due, which according to the learned counsel for the respondent is at 1 crore.
1 crore 61,000, my lord.
In
That's
Berkeley,
what-
madam. The petitioner is before this court calling in question the order under subsection 4 of section 13 of the SurfaceA Act.
Lord, 13(2), my lord, the demand notice.
Subsection 2 of section 13, demand notice, hyphen demand notice. The learned counsel for the respondent submits that the amount in due as on today is at 1 crore.
No, as per the demand notice.
As per the demand notice, yes.
And today it's 84 lakhs, my lord.
No, my lord,
That's on
there is no.
25.
No, no,
2000
Demand notice yavattu,
Go by
sir.
the demand notice,
That
my
is
lord,
on,
on 1 crore.
Demand notice yavattu, sir.
February, my lord.
All right.
Thereafter
As
I
per the
paid.
demand notice is 1 crore,
61,000.
so and so, the 61,000.
But
There shall be an interim order of stay of all further proceedings pursuant to the impugned notice, subject to the condition that the petitioner would pay 20% within the next 4 weeks. List the matter after 4 weeks, condition equity in the event. Yes, next.
59.
Shanti Bhushan, sir, Bani.
Wait, please.
ART, IVF, it is not surrogacy. They are asking surrogacy.
No, no, no. Only, yeah, my lord's unfortunate.
Because father is 59 years,
59
mother
years.
is 46 years.
Only one son they
For
lost.
ART, the upper age limit is not,
My lord, the
it's for
recent
surrogacy.
judgment of the Kerala High Court, my lord, there
Yes,
is a bar.
Calcutta High Court also latest.
Please.
Yes. Really, the judgments kodi.
Please, my lord, I will furnish, my lord. I have the copies. I have the copies. Dear lord.
Kodi.
I don't have the copy of the petition. Can it be
Copy of
taken-
what?
Petition also, my lord. Can it be taken tomorrow, my lord?
It will be taken. No hurry, yes.
Her age, my lords,
What-
her age is not stopping because
Age,
her age
sir,
will advance. my
clock
lords,
can
and
never be stopped.
Yes.
Age will be ticking
the
anyway.
Capacity to.
I don't have the copy also, my lord. There is an
Copy of the petition kodi.
I will.
This is IVF, so just look into it. The learned DSGI, Sri Shanti Bhushan, is directed to accept notice for respondent 1, 2, learned AGA, Jafar, is directed to accept notice for the third respondent.
Fourth is only a private
Fourth
party.
Bekagilla,
Beka.
because Birla Institute where the IVF is sought now.
That's all.
Huh?
Copy.
Petitioner to serve set of papers upon both the learned council, Monday fresh matters,
Please.
Monday fresh, early judgments could.
I will.
Where?
It is in the system, my lord, sir. Download.
System?
Not print out.
Yeah, was it?
Calcutta and Kerala High Court. my lord.
Calcutta High Court there.
Yeah, I have the copies, my lords. In the system, my lords.
Oh,
Assisted. Please, my lords. I have all the decisions, my lords.
you ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಹುಡುಕ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಹುಡುಕ್ತಾ because today there is system, there is some total collapse. We are not able to interact today. There is no data today. Since
ಅದಕ್ಕೆ ನಮ್ಗದಾಗಲ್ಲ ಬಿಡಿ. 2024 SSC online online Calcutta 161.
ಅದಕ್ಕೆ ನಾವು ತಂದಿಲ್ಲ.
That is the latest. That is the latest rendered where it is said that the IVF procedure ಗೆ the upper age limit of the lady will not apply as depicted in statute for surrogacy.
last week, Kerala High Court is also.
Kerala High Court is a little earlier to that. All right, both high courts are there and both you get both the judgments.
Please, man.
Sorry, no, Shanti Bhushan is
I
correct.
will.
Kerala High Court is 2025.
I have that. I will give my lords. But my lords. we
Calcutta
don't
High
have
Court
the-
is 161, 2024 SSC online Calcutta 161. This is 2025 171 Kerala.
Sir, ನಮ್ಗೆ ಅದು ಇದೆ ಅಂತ ಗೊತ್ತಿದೆ. ಪೇಜ್ ನಂಬರ್ ನೆನಪಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ಅದಕ್ಕೆ.
And I put on my lords. I always feel that we should get that.
ಎಲ್ಲಿ ಬರ್ಕೊಂಡ್ರಾ?
Capacity.
What? You remember, is it? Kerala High Court.
There cannot be equal to that memory, my
20
lords. We cannot.
2025 SSC online Kerala 1171. Calcutta 2024 SSC online Calcutta 161.
Now, if anytime now I feel
Get
my lords,
both.
I can completely rely upon this, my lords. So some days like this, my lords, when
ಅದಕ್ಕೆ.
data crashes, my lords.
So total collapse ಅಲ್ಲ ಆಗ್ಬೋದಿಲ್ಲ. Yes.
And in one of the cases, my lord, this coordinate bench my lord, did not consider anything, my lord. Just Krishna Kumar, my lord, granted it, exercising the powers under jurisdiction.
IVF.
That I will produce, my lords, please. Without considering, of course, that was not considered, but
ಅಲ್ಲ, in your
with regard
case,
to the,
it is granted, is it?
please, my lords. On the court,
If I'm granting, I'm granting by way of a
that is one, that is a different
appropriate
footing, my
order.
lords. That's not quoting the provision, but exercising the inherent jurisdiction.
We will
Yeah.
pass a
I
compromise.
will produce that.
Monday ಮಾಡ್ತೀನಿ.
Please.
ಅವೆರಡು ಜಡ್ಮೆಂಟ್ ತಗೊಂಬನ್ನಿ.
Please, my lord. Grateful.
40.
During section.
The retender call, questioning the retender notification.
Single tender.
ಅಲ್ಲ ಸಿಂಗಲ್ ಇಲ್ಲ.
ಮತ್ತೆ?
Multiple ಇದೆ. Kindly see, two.
Why cancellation of tender, madam?
My lords, it was a single bid, my lord.
That's what, single bid.
ಇಲ್ಲ ಇದು. That's why.
Regarding
Kindly
the-
see.
Sir, bidders ಬೇಕಾದಷ್ಟು ಇರ್ಬೋದು, ಕ್ವಾಲಿಫೈಡ್ ಸಿಂಗಲ್ ಆದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಹಂಗಿಲ್ಲ ಕಂಡೀಷನ್ಸ್ ಅಲ್ಲಿ.
Condition ಅದಲ್ಲ, that's the statute. If one single bidder emerges ಅಲ್ಲ, participant ಯಾರು madam?
ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಇಬ್ರು ಇದಾರೆ. That's what I'm trying to tell.
ಎಷ್ಟು?
My lords, I'll secure instructions. There were 3 bidders.
If there are 3 bidders, then that single bid thing will not apply. There's only one bidder, then yes. The one only has to emerge successful, ಇಬ್ಬರು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎಷ್ಟು ಜನ ಕಾಂಪಿಟೇಟರ್ಸ್ ಇದ್ರು ಅದಕ್ಕೆ ಮೇಲೆ ಹೋಗುತ್ತೆ. The learned AGA, HCGP, AGA ಅಲ್ವಾ? Learned HCGP is seeks a week's time to secure instructions and make submissions. ಈಗ ರೀಟೆಂಡರ್ ಮಾಡಿದ್ದೀರಾ?
ರಿಟರ್ನ್ ಕೊಟ್ಟಿದೆ, ಅದು ಸ್ಟೇ ಕೊಟ್ಟಿದೆ. ಸ್ಟೇಟಸ್
Stay ಆಗಿದೆಯಾ?
ಸ್ಟೇಟಸ್
Agar let it come on 4th April in the fresh matters list. The interim order subsisting will continue till the next date of hearing. Yes.
My lord, there is a case related to issuance of passport, my lord. The
Passport.
Also, the petitioner, there's a criminal case pending against the petitioner, my lord.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ? Charge
Charge
sheet,
sheet file ಆಗಿದೆ.
same order, short validity passport.
My lord, may I make one submission? In this case, my lord, the passport had expired in the year 2022. Now, he made an application in the year 2023.
That is pending itself, let him file a fresh application.
Let him file a fresh application, my lord, because that file is closed.
In terms of the judgment, you consider it.
Please,
We'll file a fresh.
in the event he files a fresh application.
That's all right. The petitioner is before this court seeking the following prayer. The words. The learned counsel for the petitioner submits that the passport of the petitioner stood expired in the year 2022 and it is not reissued/renewed on the score of certain criminal proceedings pending against the petitioner. The learned counsel, learned DSGI Shanti Bhushan representing the respondent would submit that the bar under section 62F of the Passports Act would not permit the person against whom charge sheet is filed to get a regular validity passport. However, a regular validity passport. This court in identical circumstances, Santosh has held as follows. The learned DSGI submits that the application of the petitioner was tendered in the year 2022 and reject agidya adu?
File is closed.
And the file is closed as the criminal case was pending, as the criminal.
As he did not give the, he did not give the permission to travel.
You did not give the permission.
No,
to
no,
travel,
my
huh?
lord, he did not furnish the order.
Details of travel.
Details.
The learned DSGI would submit that the application of the petitioner stood closed on account of non-furnishing of the details of travel by the petitioner and would submit that if the petitioner wants a relief, even of short validity passport, has to file a fresh application. The learned counsel for the petitioner, therefore, if he so desires, the petitioner, if he so desires, shall file a fresh application within 2 weeks from the date of receipt of the copy of the order. In the event it is filed, the passport authority shall issue a short validity passport in terms of the judgment rendered by this court quoted supra within 2 weeks thereafter, if not earlier, ordered accordingly. Yes, next.
I have filed NOC Wakalat for R3, my lord.
The registered gift deed by the mother-in-law under the Senior Citizen Act, my lord.
Gift deed yavudu, sir?
The operation portion of the order at Annex A, page 19, my lord.
Execution of gift deed is in the year 9/12/2021 now.
Please, my lord.
Yes, sir.
Lords, I have filed NOC Wakalat for the respond number 3, my lords. Kindly have it on Monday, my lords. My senior wants to appear in this matter.
No problem, sir. List the matter at the request of the council appearing for the respondent. The
Respond number 3, my lord.
respond number 3 lists the matter on Monday in the fresh matters list till such time status quo where the property be maintained.
My name may be shown.
Registry to print the name of
Paike Narayan Sharma.
so and so in place of V Manjunatha
This
Prasad.
matter is also similar.
Next to same, yes. Same 33 no same.
R3, please.
ಅದರಲ್ಲಿ R3 ನೀವು appear ಆಗ್ತೀರಾ?
Please.
Learned counsel so and so undertakes to enter appearance for the third respondent. Registry to print the name of so and so as appearing for the third respondent. Next.
32 copy was not served in the government.
ಯಾವ್ದ್ರಲ್ಲಿ 32 cop? Learned counsel with the petitioner to serve requisite set of papers if not already served upon the state. Next.
What is it?
Oh, notice ಆಗಿಲ್ವಾ? Learned AGA is directed to accept notice for respondents 1 and 2 ಎರಡರಲ್ಲೂ ಅದೇ order. Petitioner to serve set of papers upon the counsel for the state. Next. Learned AGA. Next. 30. Punit. Learned AGA is directed to accept notice for the respondent. First respondent, emergent notice to the second respondent. The gift deed in the case at hand has emerged in the year has emerged on 23/3/2001. After lapse of 23 years of the date of registration of the gift deed, the second respondent approaches the assistant commissioner, and the assistant commissioner entertains the petition and passes the impugned order. The assistant commissioner ought not to have entertained the petition itself in the light of the fact that the gift deed was anterior to the coming into force of the act. Therefore, there shall be an interim order of stay. Interim order of stay as spread for issue rule post for hearing in the usual course. Next.
35.
So petitioner, your lordship. This youth, the Davangere youth.
Davangere.
The respondent had issued notices for vacating the shops.
ಆಯ್ತು ಇವ್ಲಿ ಲೈಸೆನ್ಸ್ ಟರ್ಮ್ ಆಗೋಗಿದ್ಯಾ? ಎಲ್ಲಿವರೆಗಿತ್ತು ನಿಮ್ದು? ಓದ್ಕೊಂಡ್ ಬನ್ನಿ ಕರೆಕ್ಟ್ ಆಗಿ. List the matter on Friday. Yes. Next. Learned AGA is directed to accept notice for the respondent. There shall be an interim order of stay spread for till the next date of hearing. Next.
My possessions back, my lord. I'm a tenant in the premises. I only want my belongings back.
No, but the petitioner is before this court seeking the following prayer. The learned the learned counsel for the petitioner, P.B. Raju, would restrict his claim for taking petitioner is a tenant in the premises owned by the second respondent, which has now become the subject matter of proceedings under the Surrogacy Act 2002. The learned counsel appearing for the petitioner submits that if all the belongings in the premises are returned to the are permitted to be taken from the premises, it would suffice, and he would avail of such remedy as available in law against the borrower. The learned counsel for the respondent bank submits that they have no objection to permit the petitioner tenants to take all their belongings, the immovables, from the house. Yavat? Friday?
Friday.
Therefore, the petitioner shall, the bank shall permit the petitioners to take their belongings on Friday without waiting for a certified copy of this order. With the aforesaid observation, petition stands disposed. Yes, next.
Lordship, our name may be reflected.
ಹಾಕಿಲ್ವಾ?
Vignesh Shetty.
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ heard counsel Sri P.B. Raju sir and Natasha for Vignesh Shetty. Yes.
38.
Possession notice is issued, my lord.
Lokesh?
1.10 lakhs is a total non-due, my lords. 10 lakhs, 1.10 lakhs.
ಅಂದ್ರೆ 1 ಕೋಟಿ 10 ಲಕ್ಷನಾ?
1 ಕೋಟಿ 10 ಲಕ್ಷ. 1 ಕೋಟಿ 10 ಲಕ್ಷ. 1 crore 10 lakhs.
20%.
10%.
10.
Lords, 30%. Lords,
31st ಒಳಗೆ ಏನು
the
ಸಿಗಲ್ಲ
loan term is closed. ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ. Loan term is closed. Let him file affidavit on next date of hearing in regards to the closure of the loan. Term closed ಆಗಿದೆ ಇದು. Let the interim order, no problem. But let him file an affidavit.
Petitioner? ಲೋಕೇಶ್ ಎಲ್ಲಿದ್ದೀರಾ?
My lords, I'm here, my lords.
Jai, 10%, 4 weeks, 4 weeks, list after 4 weeks. The petitioner shall file an affidavit of the timeline in which he would close the loan on the next date.
Yes.
4 weeks ಆದ್ಮೇಲೆ ಒಂದು date ಕೊಡಿ. Yes, next. 16.
My lord, this is petitioner.
39.
My lord,
They're already evicted.
Not yet, my lord.
Don't evict them, we'll hear it.
My lord, I take notice for respond number 5, board, my lord. Slum board.
Some development board.
Yes, my lord.
Yes.
Some development.
Learned counsel, Shankar, what's the name?
Kumar.
Kumar, correct. Learned counsel in Kumar accepts notice for the 5th respondent. Learned AG accepts notice for respondents 1 to 4. If the petitioner shall not be evicted from the subject property, in the event they are not evicted as on today, till the next date of hearing.
6th respondent, my lord, it is a railway department. I will take out.
ಯಾಕೆ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಲ್ವಾ?
Railway.
ರೈಲ್ವೇಸ್ ಯಾಕೆ?
Because, my lord, they are insisting for eviction for the quadruple
Serve
project.
on Shanti Bhushan.
Yes.
Learned DSGI Shanti Bhushan is directed to accept notice for the 6th respondent. Registry to print the name of Shanti Bhushan as appearing for the 6th respondent. Next.
We have the petitioner.
Where is the order of shared residence? Page.
Yes, my lords. Metropolitan Magistrate, isn't it? My lords, Annexure G, my lords, page 91, my lords. That's the first order, my lords, of protection.
You are the wife?
Yes, my lord, I'm the wife.
All right. Where is the order passed by the Assistant Commissioner?
My lords, Annexure A, my lords,
Page
page 20, my lords.
21.
My lords, the order, my lords, is at page 24.
24,
my lords, the operative portion.
Perused case on between suffering multiple ailments, constantly mistreated, exposed to emotional torture. So the husband is shot from the shoulder of the father. All right, but father should also be staying somewhere. Where is he staying?
On the first floor.
Now what is the direction given?
I'm, my lords, to vacate me from the property entirely. I'm on the ground floor
Husband?
with the father and mother on the first floor. They had cut off my electricity supply also, my lords, and I had filed a petition, my lords, for.
That's all right. Now you are on the second floor, first floor.
Non-ground floor or first floor.
ಅಷ್ಟೇ ಅಲ್ವಾ? ಮನೆ ಇರೋದು ಅಷ್ಟೇ.
Yes, two.
Now you are asked to be evicted, is it?
Yes, my lords. By order dated, my lords.
Vacate, daughter-in-law shall vacate the premises.
Yes.
The petitioner is the wife of one Rohit Malik. Dispute between the petitioner and her husband, Galore. Several proceedings are instituted by the husband against the wife or the wife against the husband, as the case would be. In a petition under in criminal miscellaneous 172 of 2022, the concerned court, in a petition filed by the wife invoking section 12 of the Protection of Women from Domestic Violence Act, grants an interim order of shared household with the husband. Since then, it transpires that the husband and the father reside in the first floor.
And the mother.
Husband and her parents, his parents reside in the first floor, and the petitioner wife in the ground floor. The learned counsel for the petitioner also takes this court through an order, takes this court through an act of the husband and her parents to have cut electricity to the house of the, to the place of residence of the petitioner. Not that which comes to be stayed,
No, my lords,
which comes to be set aside with a direction of restoration of electricity. After that, the second attempt is now made by the husband, shooting from the shoulders of the parents, approaching the assistant commissioner, invoking the provisions of the Senior Citizens Act, so and so.
My lords,
The-
ಅದು ಮುಂಚೆನೆ ಆಗಿತ್ತು. Then they cut the electricity.
That's all right, yes, the, we'll strike off that later.
Yes.
So and so. The Assistant Commissioner now has directed eviction of the wife from the premises. Eviction of the wife from the premises. Therefore, there is an order by the concerned court directing shared household under the Domestic Violence Act, and the Assistant Commissioner invoking his jurisdiction under the provisions of the Senior Citizens Act, which is a summary procedure that is to be involved, cannot prima facie, the court is of the prima facie opinion that a summary procedure that is involved under the Senior Citizens Act cannot override the orders passed by the concerned court under the Domestic Violence Act. In that light, there shall be an interim order of stay spread for till the next date of hearing. Emergent notice.
They have also filed, my lords, a writ petition 13189 of 2024 to enforce the order of eviction.
Could, yes. Tag this petition along with writ petition.
13181.
13189
of 2024.
so and so. Emergent notice to the other layer petition. Who appears for that?
My lords, Siddharth Suman, my lord.
Learned Counsel, Siddharth Suman is directed to accept notice for the respondents. Which, what respondents?
My lords, respondents number 2, 3 and 4.
Respondents 2, 3 and 4, AGA for the first respondent.
5 and 6, my lords, I'll file a memo for dispensation. My
They are
children-
5 and 6.
Children, my lords.
Why do you want to bring the children?
They were
File a
all-
memo.
I'll file a
The
memo.
Learned Counsel files a memo seeking deletion of respondents 5 and 6 from the array of respondents. The memo is taken on record. They stand deleted.
Eviction order is also against them. ಅವ್ರ ಜೊತೆಗಿರ್ತೀವಿ ಇವಾಗ.
Don't worry, yes.
Yes, ma'am. Highly obliged.
A very innovative method adopted by the husband. Yes.
41.
Question notice. Standing is 32 lakhs, my lord. Overdue, my lord, ಇರೋದು 4,05,706 million.
32 lakhs.
Total outstanding. total
10%. 2 ವಾರ ಸಾಕಲ್ಲ ನಿಮಗೆ?
4.
4 ವಾರ. Yes.
Please, great.
Emergency same amount. ಗೊತ್ತಾಗ್ತದೆ. Next.
42. I have here for the petitioner, my lords. My lords, we are
Learned
challenging,
Counsel to Gautam Dev Ullad. What's your name?
my lords, we are challenging the.
What's your name? Andre, you challenge. What's your name, madam?
Monisha.
Your name?
Monisha.
Yes. Heard the Learned Counsel, Manisha appearing for the petitioner. The petitioner is before this court calling in question an application filed before the K. RERA seeking to implead the petitioner who had long before resigned as director of the company. Therefore, there shall be an interim order of stay as spread for. Yes.
Great. 43.
For the petitioner, my lord. This petition has been preferred, my lord, challenging the harassment being meted out to him. under
Yeah,
the behalf of-
harassment.
My lord, annexure J, my lord, page number 105 to 110.
ಈಗ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? I will direct them to consider the complaint.
My lord, that is my submission on the ground of 2, formal absence of formal launching of prosecution, and B, if my lords would take page number, annexure H, page number 95, annexure G, the respondent number 5 was a private party, first files a complaint against me, saying that there's a civil case, namge one dispute agide anta. Annexure H, the ACP, CCB, the last 2 paragraphs of annexure H, page 96, if I may be permitted to read. You and the said Channaviraya Harish, who's the petitioner herein, have entered into an MOU as a final settlement dated 27/2 and OS is pending before the Devanhalli court. Under the circumstance, we issue this endorsement stating that you may approach the competent civil court for redressal of your grievance against my client.
ಈಗ you have an interim order in favor?
In the OS, no, my lord.
ಮತ್ತೆ?
Only notice is issued. Then, my lord, after that, there is annexure H1.
I just look into it. Learned AGA is directed to act, heard the Learned Counsel, Srimati Kirtana Nagraj appearing for the petitioner. The Learned AGA is directed to accept notice for the respondent. Respondent number?
1 to 4.
Respondents 1 to 4. Iವರು ಯಾರು?
She is the complainant, my lord. She's a private party. She is the, at her behest.
Dispute. Police are dragged into all this.
My lord, that is my whole claim, that they're acting like recovery agents. He is calling and he is saying,
British citizen, ಗೊತ್ತು.
"She-"
Money transaction between fifth respondent and you.
In fact, my lord, I have issued a notice. I'm
Complainant is a
ready.
British citizen,
Yes,
executes GPA in your favor.
yes,
Then wants to come out of the GPA. By then everything had happened.
yes.
Yes.
And
all
then
right.
MOU is entered into. I have issued a notice. I'm ready.
Why do you
He
want the,
even-
why do you want the police to interfere in your agreement between the two?
My lord, the police have interfered at the behest of R5. His whole claim is Ba police station ige.
ಆ police station ಗೆ?
That is all. My lord, there are call records.
ಏನಿದು ಬಾ ನೋಡ್ಕೊಂತೀನಿ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಾ?
They're saying settle, Madi, settle. And then as of 14th March, my lord, the call is that the R5 is going to come to Bangalore. When she comes, I will file an FIR against you. You watch out. That is why we filed this petition, my lord. Our hands are tied, but
All right, please watch what is happening. Yes. Monday fresh matters.
Please.
Yes. Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
yes, my lord,
ಇದೆಯಾ?
sir. Great.
Yes.
54.
Husband of the petitioner is convict, my lord. He is suffering from
ಅಲ್ಲ, this is a serious matter. See, he's suffering from various ailments which will take him to the abyss. Now, what is the redeeming now to be done? You have to release him now. ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
11 years, my lord.
11 years, 302, but
Can I get instruction tomorrow?
otherwise it should not be a problem to others and
I'm not seeking release, my lord. I'm seeking only direction to the respondent number 2
to
send
publish
a
the report.
Not publish, my lord.
Then?
Send the medical reports to the jail authorities, my lord.
That I will direct tomorrow itself. That's all right. Send the medical report in case of
Because they have given
emergency.
representation to the governor for.
Because so many ailments and HIV, all that, everything is there. Yes. You have the copy?
I have.
List tomorrow in the fresh matters list. Learned HCGP shall secure instructions and make submissions. ನಾಳೆ ಏನಾದ್ರು ಮಾಡುವ. Yes.
Orders 45.
Yes, I appear for petition. Last week the matter had come up, your lordship.
Office objections ಏನು?
Rare ಕೇಳಿಲ್ಲ, this week ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. I have produced the document.
So ಏನಿದೆ? What is the matter? What's the matter?
Petitioner is the daughter of respondent number 3, your lordship.
ಏನ್ compassionate transfer?
ಅದಲ್ಲ, transfer ಅಲ್ಲ ಇದು. Senior Citizens Act ಅಲ್ಲಿ ಬಂದಿದೆ.
Senior citizen.
Last week the matter had come up. Other side did not appear, my lord. Kindly see the photo.
Interim order ಇದೆಯಲ್ಲ? Yes. List the matter on
Status quo is there, your lordship.
ಸಾಕು ಇನ್ನೇನ್ ಬೇಕು? Yes. List the matter on in the second week of April. Interim order subsisting will continue till the next date of hearing. Office objection stands overruled. Next.
After seeing the photographs, my lord was directed the office to post the matter today, your lordship. That is the reason.
Yeah, senior citizen da.
Senior citizens. ನಮ್ಮ
Respondent ಇಲ್ವಲ್ಲ? ಆಯ್ತು, list.
So last time
List the matter on 8th April. Next. In preliminary hearing. Next.
8th April.
8 ಅಲ್ಲ, 8th April.
Yes,
Yes.
obliged.
46.
Rectification of office objections raised on IA ಏನದು?
Filed an IA for clearing, lordship. Only it's a matter of action, lordship. I have
Auction?
Yes, lord. No, that is, yes, lordship. E-auction.
E-auction ನಿಮ್ಗೆಲ್ಲ ಏನ್ ಸಂಬಂಧ? ರೈಲ್ವೇಸ್?
Railways.
Shanti Bhushan sir, one more railways matter I have asked you to take notice and Monday ಏನೋ ಹಾಕಿರ್ಬೇಕು ಯಾವ್ದು?
Please.
Yes. Scrap enterprises. ಏನ್ ಮಾಡ್ಬೇಕೀಗ?
Sure. Made a payment of EMD by paying.
No, we'll post it in preliminary hearing, yes. Rectify ಮಾಡ್ತೀರಾ? Week's time is granted to rectify the office objections so far. List the matter on 4th April in preliminary hearing. Yes, in the event office objections would stand rectified. Next. Another ಕೊಟ್ಬಿಡಿ madam. The eviction. The fourth ಕೊಟ್ಬಿಡಿ. Yes. Yes, next. Non-furnishing wife. Who's R3?
We have the petitioner.
Who's
Like,
third
R3 has
respondent?
already been served. I filed a memo to.
Who's R3?
R3 is the State Bank of India.
India.
State Bank.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
Filed a memo to the effect that the RPID consignment has already been served on R3. A very small issue. I'm seeking release of deposited money
ಇದು
related to
ಬೇಡವಾ?
those matter.
Bank is not a necessary party.
Not particularly, my lords, because the money is held by respondent number 1 and 2.
Held with the district registrar.
Cash branch has highlighted that they cannot make.
Let's the matter on Friday in preliminary hearing.
Lords, if I may.
Office subject, the learned counsel for the petitioner,
Appear for respondent number 1, my lord.
one, Bangalore City Civil Court.
Registrar Civil Court.
Lords, it's a very small issue, if I may just brief.
Vidyulata madam idralla. You are appearing for Vidyulata.
Indeed, my lord.
We had filed an IA for release of an amount of 1 crore in a disposed of matter.
Right.
Trial court and in fact this honorable court has passed multiple orders saying it may be released.
All right.
Cash branch has thereafter raised a technical objection saying that it has to go through the K2 process, which does not empower an international transfer.
The Khazane 2 nalli, now that has to be transferred. Now they are seeking for a transfer. That the registrar has to answer.
My lord,
Difficulty
kindly
to
pass over the
Head
matter.
of the account in the.
Right, pass over, no,
Okay.
pass over.
Grateful.
Yes, next.
But I appear for petitioner, my lords. I have already served the copy of the writ petition on third respondent, my lords, and I have also filed
Pawan
the
Kumar
amended
already.
contract LNM. BBMP was implemented, my lords. I have served the copy on the
Hey.
council.
List the matter in the fresh matters list on Friday. Sure. Learned counsel submits needful has been done. List the matter.
Carry out the amendment in the petition, my lords. I have filed the amended cost title and I have also served the copy.
Carry on, carry on. Learned counsel submits needful would be done in the course of the day. List the matter on Friday in the fresh matters list. Next.
Much obliged.
49.
But I pay for
Office objections ಏನು?
the office objections ಏನು ಅಂತ ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
ಏನು ಗೊತ್ತಿಲ್ವಾ? Comply ಮಾಡಿ.
Next week, my lord, I will complete the office objection.
List the matter, 2 weeks time is granted to comply with the office objections. Interim order subsisting will continue to the next date of hearing. Next.
For the petitioners.
Release of amount ಯಾರು ಹಾಕಿರೋದು?
Pardon?
Release of amount ನೀವು ಹಾಕಿದ್ದೀರಾ?
Release of amount.
Deposit ಇಲ್ಲಿದೆಯಾ?
Our claim is.
Submits the
about
matters cannot be closed by way of settlement as the petitioners are tenants. Claimant deposit. Oh, excess money.
Excess money in the hands of the bank.
Excess ಇದೆಯಲ್ಲ ಈಗ ನಿಮ್ಮ ಹತ್ರ?
ಇದೆ sir. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ respondent number 2, we have believed that she is the only legal heir of the deceased mortgager. But there are another legal heirs who are contesting in DRT and DRAT.
How can we grant this prayer?
I'll give an undertaking.
What undertaking?
Proportionately, I'll return the money if her claim is upheld by DRAT or DRT.
File an affidavit here.
Very well,
File an affidavit before this court. We'll record the undertaking, then direct.
very well.
Tuesday, Wednesday, whenever you want. Friday?
Tomorrow. Day after tomorrow.
Day after tomorrow, all
Day
right.
after tomorrow.
This day after tomorrow. File an affidavit undertaking. Yes,
Very well.
next.
51.
Day after tomorrow, preliminary hearing. What's this, Shanti Bhushan, sir?
He's asking for an Siberian nationals are asking for an extension of visa and to remove the blacklisting.
You blacklisted them, is it?
Yes. Overstaying from 2014.
18,
14.
14 in the overstaying. Why have you kept quiet?
Not they've gone and come back. They've gone and sorry.
There is no representation on behalf of the petitioner. Office objections overruled. List the matter on Friday in the fresh matters list.
Models.
Huh?
2 male models. They claim that there are 2 male models
Male models,
of Parker modeling agency. My lord, they
Vladimir Roxandik, Dmitry, Russian names is that?
no,
Oh, Siberia, correct, yes, yes. Friday, fresh matters, please, next.
One mention, my lordship. Serial number 48. My lordship, I fixed the date on Friday. I'll have it next week because I'm awaiting instructions in that matter.
Next Friday.
Well, it's Monday, my lords.
ಮತ್ತೆ ಇಲ್ಲಿ ಇರ್ಬೇಕು ನೀವು, yes.
Well, it's Monday, my lords.
Yeah, Monday ಆಗಲ್ಲ. We'll take it on Friday, yes, next Friday. ಅದೇನು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಬನ್ನರ್ಘಟ್ಟ ಪಾರ್ಕ್ ಪಕ್ಕ ಇರೋದು.
No, my lords, no. Actually,
ಅದಕ್ಕೆ
we have
I want
already
the-
taken
I
permission,
want
my
the
lords.
PBM.
Even I have taken permission from the BBMP also, my lords.
ಅವ್ರು ಕೊಟ್ಟಿರ್ತಾರೆ.
Tuesday.
ಏರ್ ಕಂಡೀಷನ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಕೊಟ್ಟಿರ್ತಾರೆ ಪರ್ಮಿಷನ್ ಬನ್ನರ್ಘಟ್ಟ ಪಾರ್ಕ್ ಒಳಗೆ
No,
ಕಟ್ಕೊಳ್ಳಿ.
park ಒಳಗೆ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. It is 1 kilometer away from the.
That
property.
we'll see. BBMP ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಏನು don't harp.
My lords, I have also taken permission from the.
I know
park
how
department
permissions
itself.
are granted in the BBMP.
My lords, I have also taken.
Site visit ಮಾಡಿರಲ್ಲ. ಆಫೀಸಲ್ಲಿ ಕುತ್ಕೊಂಡು ಪರ್ಮಿಷನ್ ಗ್ರಾಂಟೆಡ್. ಬನ್ನರ್ಘಟ್ಟ ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ ಒಳಗೆ ಕಟ್ಲಿ ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ.
My lords, I actually have taken permission from the authority itself, from the.
ಅಥಾರಿಟಿ ತಗೊಂಡಿದ್ರು ವಿಲ್ಸ್.
Yes.
Yes.
Only after taking permission from them, I have obtained permission from BBMP.
ಅದು ಹೇಳಿ.
Yes.
BBMP.
No, my lords, on last date of hearing, your lordships had asked me whether I have taken permission from BBMP or not. That's why.
Correct. Let them come.
Plan is given, but
Friday.
we need to.
ಅವತ್ತು ಟೈಮ್ ಕೇಳ್ಬಿಡಿ ಪವನ್.
No, my lords.
Instructions ತಗೊಂಬನ್ನಿ. Yes, next. 50. Non-compliance of office objections.
52, my lord.
Office objections ಏನು?
My lord, I have not, my lord, some more.
ಯಾವ್ದ್ರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
Served, my lord, long back served.
Office objections overruled, less the matter.
My submission is, my lord.
I have filed my objections to IA 1 of 25. It has not been put up.
ಯಾವ್ದು ಆರ್ಡರ್ ಇದೆ ಇಲ್ಲಿ?
My lord. In fact, my lord, the committee is not constituted in accordance with section 25 at all.
It has taken charge anyway.
My lord,
It has
it
taken
is,
charge.
on merits, my lord, I am submitting.
On merits, we will hear you.
No, merits also, my lord.
On merits, we will hear you, sir. Yes. Less the matter on fourth in preliminary hearing. Office objections, learned counsel for the petitioner submits, office objections have been complied with. Yes, next.
Can it be some earlier date?
Fourth is next. In preliminary hearing, yes.
Petitioner in this case, office objection is type copies of annexure G.
ಎಷ್ಟು ವಾರ ಬೇಕು?
G series.
ಒಂದು ವಾರ ಸಾಕಾ?
It's already ready, my lord.
File it then. Learned counsel for the petitioner submits that office objections will be complied in the next 2 days. In the event they stand complied, list the matter on Monday in the fresh matters list. Next.
Hello.
54.
See, petitioner account has been frozen by the respondent number 1, your lord.
Second time,
Number one
R4,
in this
R5 ಯಾರು?
R4 is Chhattisgarh and.
ಛತ್ತೀಸ್ಗಢ.
Police station.
ಲೀನ್ ಎಷ್ಟಿದೆ?
Lien is 4,89,431. Respondent number has been frozen, entire amount of 22 lakhs.
Yes, sir.
I'm for respondent number 1 in this case.
Complainant.
Respondent. R2.
Finance bank,
Yes, my lord.
R2 ನೀವು. We will direct marking of lien on that amount. ಅಷ್ಟೇನ amount ಇರೋದು?
Yes, 4,89,431 is a dispute.
The
amount, your lord.
petitioner is before this court seeking the following prayer. Heard so and so. The learned counsel for the petitioner. Complaints come to be registered against unknown persons on the cyber portal alleging cyber crime. The amount that is alleged to have transacted with the petitioner, even according to the complaint, is 4,89,431. Pursuant to the direction issued by the state of Chhattisgarh, the bank account of the petitioner is frozen complete in its entirety, in which an amount of rupees 22,17,464 is in deposit. In the light of the complaint projecting the disputed amount totaling 4,89,431, the entire account being frozen would, on the face of it, become contrary to law. Therefore, permitting lien to be marked upon the amount 4,89,431 in the savings bank account of the petitioner maintained before the first respondent bank, I direct the first respondent bank to permit the petitioner operation of the account as it was being operated prior to the order of freezing. The defreezing of the amount and marking of the lien shall be done forthwith without broking any delay. Yes, ordered accordingly.
What's it? Serial number 55.
50?
55, sir.
Next matter, huh?
Matter. In that dispute amount is 23,000, your lordship. The respondent number 1, defrozen 11,21,000 in that.
ಯಾರಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದರಲ್ಲಿ?
IDFC First Bank.
Somebody should be present ಅಲ್ಲ?
Notice has been served, your lordship.
ಸರ್ವ್ ಆಗಿದೆಯಾ? ವೆಂಕಟ್ ನಾರಾಯಣ್ ಫಾರ್ R2 ಇದೆಯಲ್ಲ? Get him. Will 2:30 thought. Yes. Right.
Seal number 46, Lord. Sorry, Lordship.
ಯಾವತ್ತು ಹಾಕಿದ್ರು?
Emergency is there, Lordship.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಶಾಂತಿ ಭೂಷಣ್ ಹೇಳಿ I'll take it on Friday. Friday ಹಾಕಿ.
View is not listed today, Lordship, in spite of direction.
Which one?
View yesterday was listed.
No, in that, is there a jurisdictional issue that this court could not have taken the matter? Because it had to go before the division bench.
Subsequently, it was been raised, Lordship. Lordship has disposed that for that reason review is there. Lordship, after deciding review, Lordship can then back the matter to the revision bench. The Lordship decides.
Shall I recall it and post it before the division bench?
Lord, that is
You
much
tell
better.
Prasanna Kumar.
Yes.
I'll post it tomorrow in fresh matters list and close it.
Yes, Lordship. That will be much better.
That's better. You can
Because-
file all the applications
Yes,
there,
Lordship.
only they will
That will be
consider it.
considered there.
You tell Prasanna Kumar will do this. Yes.
Court officer.
Court officer. Madam, WP 14124 of 2023 ಫಿಫ್ತ್ ಮೂವ್ ಮಾಡಿ 18ನೇ ತಾರೀಕಿಗೆ ಇದು ಕೊಟ್ಟಿದ್ರಿ ಡೇಟ್ ಬಂದೇ ಇಲ್ಲ ಕೇಸು ರಿಜಿಸ್ಟ್ರಿಲಿ ರಿಜಿಸ್ಟ್ರಲ್ 18ನೇ ತಾರೀಕು ಹಾಕಿದಿರ 14124 ಆಫ್ 2023
ಚೆಕ್ ಮಾಡಿಸ್ತೀನಿ ಸರ್.
ದಯವಿಟ್ಟು ಅದು 18ನೇ ತಾರೀಕು ಹಾಕಿದ್ರಿ ಫಿಫ್ತ್ ಮೂವ್ ಮಾಡಿದ್ದೆ ಅದು ಸಾರಿ
ಚೆಕ್ ಮಾಡಿಸ್ತೀನಿ.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
Court officer, serial number 100, is it adjourned?
No, sir.
100 is not adjourned, court officer?
No.
Okay, thank you.
Yes,
Notice has
next.
been served, your lordship. Notice has been served. on
Let's
previous-
see, let them come, yes.
Lordship, one more submission in previous serial number.
Huh.
Previous serial number 54. Order has been passed.
You
In
are,
that-
you are the petitioner there?
Yes, your lordship.
Ah,
In
yeah.
that, only state of Chhattisgarh is mentioned in order. Yeah, along with the state of Karnataka and state of
I
Telecast.
know that, I saw that. Andhra and Karnataka is also there. Don't worry about it, yes. Next,
Lordship, date on.
immediately after service of notice, yes, next. Non-compliance of office objections. What's the office objection? MS Devraj. You are MS Devraj?
Petitioner ನಾನು ಸ್ವಾಮಿ.
You are in party in person?
Petitioner ಸ್ವಾಮಿ ನಾಗರಾಜ್.
Party in person ನಾ? Advocate ಇಲ್ವಾ?
ಬರ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ ಪಾಸ್ ಓವರ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ.
ಬಟ್ ತೊಂದ್ರೆ ಇಲ್ಲ, yes. Office objections. ಕೊಡಿ ಇಲ್ಲಿ. Oh, not before this court, earlier bench, yes. List, pass over, yes. Next,
ವಿಕೆಟ್ ಸ್ವಾಮಿ ಬರ್ತಾರೆ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಎರಡು ಕೇಸ್ ನಂದು ಪಿಟಿಷನರ್ ನಾನೇ.
leave it, yes. You can't make a mention like that, yes. Respondent. Vachan.
That's the petitioner has deposited 9 lakh rupees. my lord.
ಎಷ್ಟು ಕಟ್ಬೇಕಾಗಿತ್ತು?
That's
20% ಅಂದ್ರೆ ಎಷ್ಟು? Next ಯಾವಾಗ?
my lord's 4 weeks time. my lord.
No, 4 weeks. I'll give you a week's time.
My lord's,
ಕಟ್ಬೇಕಾಗಿದ್ದು ಯಾವಾಗ ಹೇಳಿ? 4 weeks from 17 to 25.
please. my lords.
8 weeks
I have
ಆಗಿದೆ
the
ಈಗ.
surety, my lords.
Whoever you are. Why are you?
My lords,
Then don't bother, we'll vacate the interim order, dismiss the petition.
no, my lords.
Then-
Actually, I have only stood as surety for only for 40 lakh rupees, my lords.
So what to do, sir?
Annexure B, my lords. Only for an amount of.
Yes,
40 lakhs,
anyway,
my lords.
amount of 40 lakhs ತಾನೆ, 20 lakhs ಕಟ್ಟಿ. Yes. The learned counsel for the respondent submits that the interim order dated 17 to 2025 has not been complied with in its entirety. 3 weeks' time is granted to the petitioner finally to comply with the order dated 17 to 2025, failing which, without hearing the petitioner, the petition would be dismissed. Yes, next. 3 weeks bit on 8th April, yes. Next. Non-compliance of office objection awaiting service. Learned counsel. Yes, madam. D. Narayan Swami is accepts notice for the respondent registered to print the name of so and so is appearing for the respondent.
ಮಾಡಿದ್ದಾರೆ
17 to 25 ಎಷ್ಟು ಕಟ್ಬೇಕಾಗಿತ್ತು?
plus 8,80,000 today they have deposited, my lords.
ಒಂದು ನಿಮಿಷ ಸರ್. 35,15,000 was the due.
Please.
ಅವ್ರು ಕೇಳ್ತಾರೆ. ನಿಮಗೆ
ಕಟ್ಟಿದೆ.
ನೀವು ಯಾವಾಗ ಕಟ್ಟಿದ್ದು?
ನಿನ್ನೆ ಅವರು ಬೇರೆ
Acknowledgement ಎಲ್ಲಿದೆ?
I'll submit to today, tomorrow itself, my lords.
List the matter day after tomorrow in the fresh matters list. ಕಟ್ಬಿಡಿ.
Please, I will deposit, my lords. If that is recorded, my lords, it may be disposed of.
The
We have deposited 8,80,000.
The petitioner is before this court seeking the following prayer. This court on 17 to 2025 had passed the following order. The learned counsel for the petitioner submits that the order has been complied with in its entirety. The learned counsel for the respondent seeks time for verification. He would however submit that if 11 lakhs is paid, the entire amount would be regularized, and later if the EMIs are paid diligently, no problem would arise. The learned counsel for the petitioner undertakes that he would pay 11 lakhs within 4 weeks.
11 lakhs, not, already we have paid 8,80,000.
ಅದು
8,80,000 ಕಟ್ಟಿದ್ದೀವಿ. As per my lords, 11 lakh is saying.
ಒಂದು ನಿಮಿಷ.
Another
11 lakhs is inclusive of 8,80,000?
Yes.
ಸರಿ. 3 lakhs ಕಟ್ಲಿ ಅವ್ರು.
Stay.
Yes. ಆಯ್ತು. The learned counsel for the petition undertakes to pay an amount of rupees 3 lakh ಎಷ್ಟು?
Like 2,75,000. 8,80,000.
2,70,000. 2,70,000 to get the account regularized on or before the 28th of 27th of March 2025. With the aforesaid observation and directing the petitioner to pay another 2,70,000 for regularization of the account as submitted by the counsel for the petitioner, the petition, counsel for the respondent, petition stands disposed. ಅದು ಹೇಳಿದ್ದೀನಲ್ಲ ಆಲ್ರೆಡಿ, ಅದು ಹೇಳಿದ್ದೀನಿ. ಅದು ಅವ್ರು ಕಟ್ಟದೇ ಇದ್ದಾಗ ನೋಡೋಣ. ಎಲ್ಲ ಈಗಲೇ ತಗೊಂಡೋಗ್ಬಿಟ್ರೆ ನೀವು. ಎಸ್ ನೆಕ್ಸ್ಟ್.
The petitioner not paid the amount, my lord.
Not paid.
Not paid, my lord, only. She is a.
Not a single rupee paid.
Not, my lord. 1 week time could put a.
Awesome. The petitioner is before this court seeking the following prayer. This court on 17/2/2025 had passed the following order. Not even a rupee is paid as on today pursuant to the said order dated 17/2/2025. The learned counsel for the respondent bank would also submit that the sale on the said date, sale fixed on the date of sale has not taken place. Therefore, the date of auction has spent itself. In that light, the petition is rendered infructuous and is disposed as having become infructuous, noticing the fact that the petitioner has not paid a rupee even pursuant to the interim order, ordered accordingly. Next.
I would like to.
Would like to pay?
No, they are the leaseholders in respect of 2 premises among 6.
Or let them proceed surfacely.
No, the thing is, on 7th, these 2, I mean, residential premises were sealed by the respondent bank. Not the only the thing I could able to make out the request before this honorable court. I cannot come in the way of the respondent number 1 from recovering the dues from the other private respondents. We are the leaseholders under the landlords. Lord, my request is, if at all in the event of the property put for auction, Lord, so far as the interest of the petitioner could be taken into consideration by the respondent.
The excess bundle ಕೇಳಿ ಆಮೇಲೆ ನೋಡೋಣ.
And the thing is, my lord, reasonable time could be granted because for the past.
Reasonable time for what?
At least now their belongings are, I mean.
Tagoli, belongings, I will fix a date, take everything.
Please.
I'll grant you 4 weeks time to vacate.
Please.
Or, and take. Correct, sir, belongings kodi. Yes. Oh, agare ella position ತಗೊಂಡಾಗಿದೆಯಾ?
7th, they have.
Heard the learned counsel appearing for the petitioner and the respondent. The learned counsel for the petitioner submits that the petitioners are tenants in the premises owned by the second and third respondent, second, third and fourth respondent, who are now in default of payment to the first respondent finance. The first respondent finance has instituted proceedings invoking the provisions of the Surrogacy Act 2002 and have taken possession of the premises. The learned counsel Prakash M.H. appearing for the petitioner submits that all the belongings of these petitioners are inside the house and the house is now locked. Therefore, I deem it appropriate to direct the respondent bank to hand over open the key and open the lock and hand over all the belongings of the petitioners in the premises without broking any further delay. Matten bek nimge?
To consider their request in some.
The learned counsel for the petitioner submits that that in the event the sale would take place and the respondent bank would receive, respondent finance would receive more than what is to be paid by the borrower, their interest could be protected. It is for the petitioner at that relevant point in time to represent to the bank with regard to the aforesaid protection of interest, and the bank shall consider the same in accordance with law and redeem the grievance of the petitioner, if any, would survive on the said date. With the aforesaid observation, the petition stands disposed.
Time for vacating, sir.
ಅಲ್ಲ ಯಾವ ತಗೊಳ್ಳಿ ಎಲ್ಲ ವೆಕೇಟಿಂಗ್ ಆಗೋಯ್ತಲ್ಲ ಇನ್ನೇನು.
Within
ಆಯ್ತು ತಗೊಂತಾರೆ ಬಿಡಿ.
4 weeks. No. ನಿಮ್ಮವ್ರು ಹೇಳ್ತಾರೆ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ.
ನಿಮಗೆ ಯಾವಾಗ್ಲೂ ಹಂಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರೋದು. ಆಯ್ತು ಏನಿದೆ ತಗೊಂತಾರೆ ಬಿಡಿ. ಎಸ್ ವಾಟ್ ಎವರ್ ಬಿಲಾಂಗ್. ಮತ್ತೆ 4 weeks ಏನಕ್ಕೆ ಬೇಕು? ಈಗ ತಗೊಳ್ಳಿ ಯಾವಾಗ ಬೇಕಾದ್ರೆ. The belongings shall be handed over to the petitioners within 1 week from the date of receipt of the copy of the order. Yes.
Petition.
For the respondent number 3 and 2, ma'am.
Post immediately after service of
May-
notice upon the fourth respondent.
May I make one request, my lord?
Yes, sir.
R4 is under the administrative control of R1, my lord.
Who is R4, sir?
Pharmacy Council, my lord.
Pharmacy Council of Karnataka.
Please, my lord. Karnataka Pharmacy Council.
ತಗೊಳ್ಳಿ ನೀವೇ. Learned HCGP is directed to accept notice for the fourth respondent as well. Thus completes the service of notice.
My
List
lord,
them,
a short question is involved, my
list
lord.
them not today, sir. List the matter in preliminary hearing on 4th April. Next.
May I request for 9th, my lord? 9th.
9th April, yes.
Great.
9th is holiday, I guess. Idea?
9th.
9th April, yes. Next.
My lord, 9th April is a little inconvenience, my lord. Maybe on 11th.
Don't worry, madam. Yes, on that day we'll grant. Next. ಇದೇನಾ ಬಂದಿಲ್ಲ ಅಂತ ಇದು?
ಎಲ್ಲೇ ಬಂದಿರಲಿಲ್ಲ ಸರ್.
ಹಾ. ಅದೇ ಬಾಗಲಕೋಟೆಲ್ಲಿ ಇದೆ. ಹಾ. ಅಂದ್ರೆ ತಪ್ಪು ಹೇಳಿದ್ದಾರೆ ಅಂತನಾ? ಹಾ. ಅಲ್ಲ ಅದನ್ನೇ ದೊರೆರಾಜ್ ಹೇಳಿದ್ದನ್ನು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ. 77 ಎಲ್ಲಿದೆ? ಆಯ್ತು ಹೇಳಿ.
The larger multiple review police station can be recommended by the state executive committee. But in any case, the maximum police station already is 4.
All right.
Minimum is 4.
ಆಯ್ತು ಮ್ಯಾಕ್ಸಿಮಮ್ ಮಾಡೋಣ ಬಿಡಿ ಅದನ್ನ. ಆಯ್ತು ಆಯ್ತು. ಆಲ್ ರೈಟ್. ಆಲ್ ರೈಟ್. All right. That does not take away the tenor of the interim order. Amele. Yes. Aitu will replace words minimum with maximum. Dispose madalla sir. New objections haki.
Another submission, my lord. Not only on that account, your lordship may kindly come to page number.
Objection tagoli nodi.
Which is he is appearing for respondent number 4 and 5, who are the contesting party. He is not making a submission for respondent number 1 and 2, who are the election conducting people.
Trained nurses association. Who appears for the association, not served?
Nobody has filed. He is appearing for respondent number 4 and 5.
Right.
With respect to 4 and 5, I may be.
Yak steps ತಗೊಂಡಿಲ್ವಾ ನೀವು?
We have taken all this.
ಯಾವತ್ತು?
Same day we have taken.
Furnishing of PF ಅಂತ ಇದೆ ಇಲ್ಲಿ?
Yes, my lord. Yesterday we have taken, my lord.
Why yesterday you took?
My lord, that day we could not take it because the end of the day.
11-3, all right. The learned counsel for the petitioner submits needful has been done. Counsel A. Krishna undertakes to enter appearance for respondents 4 and 5. Registry to print the name of so and so as appearing for 4 and 5. List the matter on 3rd April. ಯಾವ್ದು? ಥರ್ಡ್ ಬರಲಿ ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಬೇಕಲ್ಲ. ಯು ಗೆಟ್ ದೆಮ್ ರೆಪ್ರೆಸೆಂಟೆಡ್. ನೀವೇ ಬಂದಿದ್ದೀರಾ ಫಸ್ಟ್ ಅಂದ್ರೆ ನಿಮ್ಮನ್ನು ಫಾಲೋ ಮಾಡಕ್ಕೆ ಹೇಳಿ ಜಲ್ದಿ. ಎಸ್, 3rd April. Interim order subsisting will continue till the next date of hearing. Dream Deals International.
Respondent number 4 on 18/2 enters the office, has taken away the computer, etc.
Who is respondent number 4, sir?
Circle Inspector of Police, Madikeri.
He takes away.
Yes, and they have not registered a case. And verbally, I am directed not to open the office from 18/2.
Heard the learned senior counsel Jaykumar S. Patil appearing for the petitioner. The allegation in the case at hand is against the 4th respondent, Inspector of Police, Madikeri Town Police Station. It is the allegation that the 4th respondent barges into the petitioner's office, takes away the computers and directs that the petitioner should not open the office. The learned senior counsel submits that there is no crime registered against the petitioner and the police could not have done such an act. The learned HCGP to secure instructions, and if it is found that the fourth respondent has in fact performed his actions, appropriate orders unleashing the coercive arm of law would be passed against the fourth respondent. List day after tomorrow in the fresh matters.
Please.
Yes, next. 65. Nalega? Nalega. Monday, fresh matters list. Yes. next.
66.
Office objections overruled Monday, fresh matters list. Next.
Tomorrow, Lordship.
Copy.
I give you copy. So the copy, Lordship.
ನೀವ್ ಯಾರಿಗೆ ಅರ್ಜುನ್?
Respondent number 1 copy sound ಮಾಡಾಗಿದೆ.
ಸೇಲ್ ಆಗೋಗಿದ್ಯಾ?
But agriculture land, Lordship ಇದು.
ಅಗ್ರಿಕಲ್ಚರಲ್ ಲ್ಯಾಂಡ್ ಆಗಲ್ಲ ಅಂತೇನಿಲ್ಲ. ಇಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್.
But
saying that it is not an agricultural land?
he is not given the conversion land order copy, Lordship. Is it given the only is agriculture land is.
ಯಾರು ರಾಜೇಂದ್ರ ಅವ್ರದ್ದು ಇದು? ಅವ್ರು ಬರ್ತಾನೆ ಇರ್ತಾರೆ.
Kindly tomorrow, Lordship.
No, tomorrow. Monday, fresh matters list, serve a copy. Next.
I served the copy.
Where?
Just I give it.
ಅವ್ರಿಗೆ ಬ್ಯಾಂಕ್ಗೆ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಹೆಂಗೆ? ನೆಕ್ಸ್ಟ್. Learned counsel Natasha or Vignesh Shetty. Counsel Vignesh Shetty accepts notice for the first respondent petitioner to serve set of papers upon both the counsel, if not already served. Next.
67.
Non-compliance of office objections.
Objection ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕ್ಲಿಲ್ಲ. ಅದನ್ನ ಇದನ್ನ ತಗೊಂಡ್ಬಂದಿದ್ದೀನಿ.
Overruled Monday, fresh matters list.
ಅದರಲ್ಲಿ
ಅರ್ಜೆನ್ಸಿ ಉಂಟಾ?
ಅಲ್ಲ, ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ
ಏನು?
ಇವತ್ತು ಬಂದು ಲಾಕ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮಾಡಾಗಿದ್ಯಾ?
ಹೌದು.
ಯಾರು?
ತಹಶೀಲ್ದಾರ್ ಬಂದು ಇವನ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ನಾಟ್ ಅಪ್ಲೈಡ್, ನಮಗೂ ಬಂದಿಲ್ಲ, ಅವರು ಬಂದಿಲ್ಲ. ಮಧ್ಯಾಹ್ನ 11 ಗಂಟೆಗೆ ಲಾಕ್ ಮಾಡ್ಬಿಟ್ಟು.
Look into it. Tomorrow, fresh matters list. Yes. ನಾಳೆ ಆಗತ್ ಸಾಕಾ? ಇಲ್ಲಿ ನಾಡಿದ್ದಾಕ್ಲಾ? ಬಟ್ ಲಾಕ್ ಎಲ್ಲಿದ್ದಾರೆ ನೀವು?
ಇದು ಈ DC ಕ್ಯಾಂಟೀನ್.
DC ಕ್ಯಾಂಟೀನ್ ನಾಳೆಗೆ ಹಾಕಿ. ಎಸ್. Tomorrow at 2:30 I'll take. Next.
Petitioner, today is action.
Huh?
Action is ಇವತ್ತೇ ಇದೆ.
ಆಕ್ಷನ್ ಇವತ್ತಿದೆಯಾ? ಎಷ್ಟಿದೆ ಡ್ಯೂ?
1 crore 2 lakhs.
ಓ, ಆಕ್ಷನ್ ಆಗ್ಲಿ ಬಿಡಿ. ಯಾರು ಬ್ಯಾಂಕ್ ಯಾವುದು? ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್. ಯಾರು ಮೇಡಮ್? ಮೇಡಮ್ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್. Counsel Srimati Divya Purandar is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. List the matter on Friday in the fresh matters list. Possession ತಗೊಂಡಾಗಿದೆಯಲ್ಲ?
ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ.
ಮತ್ತೆ ಆಕ್ಷನ್ ಆಗೋಗಿದೆಯಲ್ಲ?
ಆಗಿಲ್ಲ, ಇವತ್ತಿದೆ.
ಇವತ್ತಿದೆ, ಆಗೋಗಿರುತ್ತೆ.
20% subject to depositor.
List on Friday in the fresh matters list. The respondent shall not issue the sale certificate if not already issued. Yes, next. Till the next date of hearing.
2 days may I?
Friday.
69.
My lord, I beg to appear for the petitioner.
Yeah, neneda.
Yes, my lord. My lord, I request my lordship to take item number 70.
All right, ade kodi.
That is Niti Trust versus the state of Karnataka.
See, what do you want to do?
My lord, we wanted to conduct a peaceful protest. My lord, the
Protest
permission.
against what?
My lord, protest seeking a special investigation
Into what?
into Saujany's murder.
That matter is still pending, is it?
My lord.
Hello, what has happened to the case now?
My lord, as regards my lord,
Trial is pending?
no, my lord, the trial is not.
Then what has happened?
No, my lord, what had happened was the state arrayed one of the a person as an accused, which my lord, this honorable court acquitted on the ground that the person he was falsely framed. That was the observation of this court.
All right.
After that, my lord, a CBI investigation was also conducted.
What happened to that?
My lord, there they have come up with a conclusion stating that because there was a lack of preservation of evidence, there is no much progress could be made. Now, my lord.
Now what do you want to do?
My lord, that does not stop me from conducting a protest, seeking a special investigation team.
No. Special investigation in what? In a case that is already acquitted.
My lord, where?
In a case that has already been acquitted by a court of law, you want to protest against that?
My lord, my lord,
No,
this
is that the intention of protest?
my lord, my lord,
No, no,
that
no.
being the,
Mr. Velan, you should be clear.
yes,
If
my
you
lord.
are wanting to attack a judgment of this court or whatever competent court of law by
Yes,
way
my lord.
of protest, that cannot be permitted.
My lord, that is not our intention. That is not our
Yes.
intention.
Then what is your intention?
My lord, I take my lordship to the permission grant.
No, no, then what is your intention? Tell me. You leave the permission granted. Why do you want to protest? Tell me.
My lord, just because, my lord, here, it is a matter of
Sir,
record.
1 minute, Velan.
Yes, yes, my lord.
If a matter is pending, if a
Yes, ma'am.
trial is pending, if the
Yes, ma'am.
investigation is shoddy, if
Yes,
the
my lord.
investigation is not correct,
Yes, my lord.
before the conclusion of the trial, you ought to have raised a protest or whatever it is.
Yes, my lord.
Now, it is not what is this empowering team, hope and interaction? Who is this? Who
My
is the
lord,
petitioner?
my lord, if I may answer my lordship's first question.
Ah,
My lord, merely because a shoddy investigation has reached a logical conclusion before this court, that does not
yes.
prevent us to protest, seeking a formation of an SIT or a commission of inquiry.
When to reopen the whole thing, is it?
Yes, yes, my lord.
Okay, yes.
My lord, that does not, the mere conclusion here does not estoppel my right. My lord, now the police, my lord, as regards the scope and ambit.
Where do you want to protest?
My lord, I take.
Where do you want to protest, sir?
My lord, 1 second.
Kadapa. Page number.
Kadapa, my lord.
Where?
Kadapa, Beltangadi Taluk.
ಎಲ್ಲಿದೆ ಅದು?
Beltangadi
Page
Taluk.
number 20.
Dakshin Kannada.
ಬೆಳ್ತಂಗಡಿ ತಾಲೂಕು.
Page 32, your lordship may kindly see. Kadapa is the endorsement issued by the police. And page 28 is the initial permission letter. My lord, then an objection comes to be filed by an advocate representing the whole thing. There is a slanderous campaign against the Dharmasthala and its officers, my lord.
Why Dharmasthala is involved in this?
This is what is happening. That is why this is what is happening. There are serious petitions that were moved. In fact,
Why Dharmasthala is involved in this?
The officials, the Dharmadhikari, they are making allegations against Dharmadhikari and other people.
He was the accused, is it?
He is not the
Then?
My lord, in fact, my lord,
I'm only wanting to know something behind the smoke screen.
No, my lord. My lord, in fact, my lord, the only contention of the respondent is the order of a coordinate bench of this court estoppels us from essentially undertaking any protest. My lord, that is a misreading.
Order of the coordinate bench has become final?
Yes, my lord. My lord, in fact, that is a misreading of the judgment. I take my lordship to page 46 for a moment, my lord. The relevant paragraph is 11. May I, my lord?
Yes, sir.
Having regard to the facts and statements narrated herein above, this court is of a considered opinion that the petitioner herein have a right to seek such directions to the respondent police. The respondent police are required to take action in accordance with law if they find that the 9th respondent or his followers or any person makes any statement in open public or publishes any derogatory statement. I lay an emphasis here, my lord. Any derogatory statement which is an offense in accordance with law. And in that regard, if any material is placed by the petitioner or any person aggrieved of any such action on part of the 9th respondent or his followers, and if such information is placed before the police, it is bounden duty of the respondent police to take action immediately. My lord, I have no quarrel with this direction.
All right.
My lord, it states derogatory statement. My lord, there is the word derogatory does not find any mention in BNS. My lord, I will not deal with a subset of derogatory statement. I would say any statement made. Why only derogatory statement, my lord? If any statement is made, my lord, which is an offense in accordance with law, the police is at liberty to take action. But what the police, by referring to this particular provision, is doing is acting as an arbiter to adjudicate whether the statement is defamatory in nature or not. That the police is not entitled to. And then they make this observation a basis of essentially issuing a gag order, saying the fact that nobody shall protest.
No, gag order we will not permit, but you will be bound by the coordinate bench's direction. If there is any violation, coordinate benches, in terms of the coordinate bench's direction, they will take action.
Yes, my lord. Here, my lord,
I'm really asking, what are you going to achieve by this? If there is any collateral purpose, it's all right, we will not permit you to achieve. But if there if there is any lateral purpose, in genuine purpose in seeking something, then you should come out with that.
Yes, my lord. Here, my lord, I am My lord, I cannot step into the shoes of the potential speakers. I cannot preempt
No, no,
what they are going to.
I'm not, Velan, I'm not asking that.
Yes,
I'm
my
only
lord.
asking, in a case that is completely concluded and everything is over,
Yes, my lord.
are you asking the exhumation of the entire thing now?
My lord, if I answer my lordship in the
No, that
entirety.
you should have challenged the order of, somebody should have challenged the order of acquittal.
My lord, the challenging of an order of an acquittal is qua a particular accused. My lord, that does not answer the shoddy investigation per se. My lord, it is the observation of this court that that particular person was framed. My lord, it does not estoppel me, even if there is a lapse of time, my lord, to seek
it's
an
all right.
investigation
Now,
or an exhumation.
All right, Velan, 1 minute.
One submission.
Yes, Jafar.
Page, order of the coordinate.
Yes, Devdas.
Adರಲ್ಲಿ in page 10 of the judgment, that is 43. Running page 43, in page 10 of the judgment. There, the first paragraph itself, your lordship can read. The justice for Saujanya was found.
Correct.
Adರಲ್ಲಿ, this is where they have made the allegations against the family.
All right. I will straight away follow the order of Justice Devdas, permit them. But if there is any violation as observed by Justice Devdas, you will take action. That is, he will agree that he has no choice about it. Yes, Velan?
Yes, my lord. My lord, the
Learned counsel appeared the other day on YouTube also.
What
that
YouTube?
The YouTuber whom the Lord state the notice issued at Ballari. There are several people who are now, after entire trial has been completed, and there is a judicial order. In fact, they have gone, the 9th respondent, the order of the coordinate bench, Justice Devdas of the order, had even made allegations against the judges of this honorable court. But there was a contempt which came up before the chief. There he apologized. And they gave an undertaking.
You are the advocate, Velan?
No, my lord. I have nothing to do with the respondent number 9.
I don't think he would do all that. Yes.
But anyway, my lord, we will have to follow this.
My lord, here, may I make a submission, my lord? The facts of the case is relevant here, my lord. There was the respondent number 9 suffered an order in the competent civil court which was instituted by the petitioner. He did not follow the said order. A contempt petition happened to be registered before the division bench of this court. It is in that backdrop this particular order was passed. My lord, in fact, my lord, I have checked multiple times all the provisions of BNS. The word derogatory statement does not find place in any of those provisions. My lord, the only provision which remotely deals with such circumstances is section 299 of the BNS. If my statement falls within that ambit, the police is at liberty to take action. They don't need to resort to this judgment. My lord, what they are essentially trying to do is they're trying to be an arbiter.
No. This gag order we will not permit to be sustained. I will pass an order following the order of Justice Devdas and permit the respondents to take action strictly in consonance with.
Permission was accorded.
Then you have withdrawn that permission later.
An objection.
Whatever.
They may be a party
See,
before this court.
what a protest, peaceful protest or whatever, for whatever reason, then you cannot stop them by gag order saying nobody should protest. But their protest should be in consonance and observation of the order of Justice Devdas, saying that if there is any violation, you will take action. That's all. Ashte well, and that's all.
Yes, my lord, only one an additional direction my lordship may consider passing. My lord, what constitutes derogatory statement? That is where all the mischief is sought to be conducted here. There is nothing called as derogatory statement in the BNS.
The order does not stop at derogatory. It says defamatory also.
No, my lord. It doesn't. Please take, my lord. Please take paragraph 47.
It is submitted, 9th respondent cannot claim to have absolute right of speech. Therefore, go before the public. Go on making derogatory remarks against the private individuals. Say, submitted, there is defamatory also I saw somewhere.
Yes.
My lord, that is in the backdrop of a defamation suit preferred by the petitioner. There is no suit preferred against me. Or for that matter, anybody who wants to.
Anyway, I'll tell you.
After the order was passed
in the wake of achieving the object, if you are wanting to achieve collateral things by making statements on persons, that cannot be. You want to achieve your object, you achieve it.
My lord, due process has to be followed. I take my lordship to page 69 for a moment.
Both by you and them, sir.
My lord, page 69 for a moment.
Due process is not only for the state, even for the protesters.
Yes, my lord. Page 69 for a moment, my lord. Page 69 for a moment.
Yes.
My lord, here the division bench of
I
this
thought
court.
the trial is pending still. Yes.
Page 69, my lord. Paragraph 14. My lord, this was in the backdrop of a TI which was granted. Article 19(1)(a) of the Constitution gives freedom of speech and expression to every citizen.
Absolutely no problem with
My lord,
reasonable restrictions.
Paragraph 15 and 16, my lord, for a moment.
Sir.
The learned trial judge, by the impugned order, has restrained the defendants from making defamatory statements against the plaintiff. What is defamatory can be tested and decided only if an act of making a statement or telecasting a program is challenged by the aggrieved person before an appropriate forum. Therefore, in our view, the defendants are not prevented from publishing or telecasting any news.
Which is this, Velan?
My lord, this,
Which order is this?
This is against the division bench judgment.
Division bench judgment.
Division bench decision of this court, my lord, which is the Tejasvi Surya's at page 53, my lord. It starts at page 53. Here, my lord, a TI was granted by the trial court stating that no defamatory statement shall be made. That happened to be challenged. My lord, here this is what honorable division bench of this court held. Therefore, in our review, defendants are not prevented from publicizing or telecasting any news item which is not defamatory in their opinion. That is in our opinion.
See, I will only observe that you can definitely peacefully protest, not violate the law, nor the law as laid down by the coordinate bench or the division bench in any of these cases. Correct?
Yes, my lord. Yes, my lord. My lord, if I may request my lordship, in furtherance of the same, my lord, the police may also not act as an arbiter with regard to a defamatory statement. As regards to any other statement, it is fine, my
Now
lord.
that the observation of the division bench will take make that good.
Yes, my lord.
That will take care of that situation. Paragraph 15.
Yes, my lord.
What the division bench has said, that will only when if it has to be tested. What is it said? Tested and decided only if an act of that statement is done. Yes.
Yes, my lord. So, my lord, the mischief is caused only because they interpret the term derogatory statement as being vesting the power with them to essentially act as an arbiter with regard to any statement made, whether it is defamatory or not. That is where the problem is.
No, mischief is not caused by the state, my lord. What has happened is subsequent to the order of Justice Devdas, my lord. What had happened was the ninth respondent has refrained. In fact, the ninth respondent has also come before this honorable court, where where a petition came to be filed to get an order against all those publications in various newspapers, wherein he pulled down his YouTube channel also. He gave an undertaking for this very own court, my lord.
Ninth respondent, which ninth respondent?
He's the one who had started the Justice for Saujanya movement and theory, where he's targeting one family and the authority, that is the Dharmadhikari of Dharmasthala. Now, what happened after this order of Justice Devdas was passed? Now, what has happened is they are trying to shoot to different forums. Well, they are no way corrected, but whatever it is their right to protest. I will not come in that way.
Yes, my lord.
Are these trust or whatever trying to achieve something that could not be achieved directly?
No, my lord. My lord, we have nothing to do with respondent 9.
You again state what same thing you are saying about this Dharmasthala and other things.
My lord, as regards respondent number 9, my lord, there were specific statements which was made, which were not in accordance with law. That was what the finding of the learned trial court as well as the division bench of this court. I have nothing to do with them. My lord, if my statement is in the teeth of any law, they can take action in accordance with law. I have no quarrel with the same. My lord, if any...
See, 1 minute, Velan. Jafar, we cannot foresee, or you cannot foresee what they will speak.
Yes.
And he is also not saying that something they will speak or not speak.
Even
if spoken, then action you can take in accordance with the judgments laid down.
Not only this matter, now he has filed an application only to protest. He has not even said what is the subject.
That is why he will file a fresh application.
Yes.
You will consider it in accordance with law and not preempt it. But if they make some statements which are contrary to what the coordinate bench or the division bench has held, you should take action. That is all. Yes, Velan, that should suffice, I guess.
Yes, my lord. In fact, my lord, my application is at page 25.
What application have you given there?
My lord, my application is at...
No, annexure. What is annexure A?
My lord, annexure A is the trust deed. Annexure B is the application, my lord. Seeking police permission at page 25. 5.
Yeah, nothing is here.
My lord.
ಸೌಜನ್ಯ ಕೊಲೆ ಪ್ರಕಾರ ನ್ಯಾಯಕ್ಕಾಗಿ ಆಗ್ರಹಿಸಲು ಆರೋಪ ಇದೆ ಹಾ
ಅದರ ಹೇಳ್ತಾರೆ. ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಬೆಳತಂಗಡಿ ಪೊಲೀಸ್ ಠಾಣೆ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 250/12 ಪ್ರಕರಣದ ಕುರಿತು ಕೋರ್ಟ್ ನಿರ್ದೇಶನದಂತೆ ಧರ್ಮಸ್ಥಳ ಗ್ರಾಮದ ಸೌಜನ್ಯ ಅತ್ಯಾಚಾರ ಕೊಲೆ ಪ್ರಕರಣ ಸಂಬಂಧ ಅಕ್ವಿಟಲ್ ರಿವ್ಯೂ ಕಮಿಟಿ ರಚನೆ ಮಾಡಿ ತಟಸ್ಥ ಅಧಿಕಾರಿಗಳ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮ ಹಾಗೂ ಈ ಪ್ರಕರಣವನ್ನು ಎಸ್ಐಟಿ ತನಿಖೆಗೆ ಆಗ್ರಹಿಸಿ ಬೃಹತ್ ಪ್ರತಿಭಟನೆ ಮೆರವಣಿಗೆ ಅನುಮತಿ ಕೋರಿ. Well, that where a matter has been concluded, they are very clearly saying that they want, if that is, they'll have to follow a process of law. Let them go before an appropriate court, get an order of setting up.
So they are not, they are general public, they cannot do that.
Even the relatives or the victim itself, they have not, they have.
No, that doesn't stop, your state should not stop protest even,
Not
if it is peaceful in accordance with law or whatever it is. Now he has given this application, you had granted permission, because there is an objection, you withdrew permission. Now let the permission prevail, and you will take action in accordance with the judgments rendered by the coordinate bench or the division bench. In the event they would breach whatever is observed by the court.
Possession will not be allowed. They
What?
want to have possession and everything.
Allah, that is, you will take action in accordance with law. You permit in accordance with law, but you can't stop them from peaceful protest.
We will not stop them from peaceful.
That's all.
Let them not make derogatory statements.
No,
against
they will, the order of the coordinate bench is there. In accordance with law, whatever action you have to take, please take. In accordance with law, whatever they can do, they are doing. That's all. And
But in fact,
in accordance with law, I will pass some on. Yes.
my lord, in fact, my lord, I have annexed as one of the judgments of a coordinate bench of Annexure F.
Justice
Where-
Hemant Chandan Gaudra.
Yes, my lord. In
All
fact, a defamate, a complaint was preferred through a power of attorney holder. The same was quashed, stating the fact that he
All
is not
right.
an authorized person.
We'll close this. Both matters 69-70 ಎರಡು ಒಂದೇನಾ?
ಅದರಲ್ಲಿ 69 ಅಲ್ಲಿ they want permission in Bangalore. Freedom Park.
ಅಲ್ಲ, wherever Freedom Park. Why?
That is what is happening
No,
now.
where, see, protest, you play designated place if it is permissible in law also. Everything you should consider in accordance with law, that's all. Both these petitions are preferred by different petitioners for the same cause of action, for holding a peaceful protest. For the sake of convenience, the facts obtaining in writ petition 7957 of 2025 is noticed. Heard the learned counsel, you are A. Velan, right?
Yes, my lord.
A. Velan appearing for the petitioner along with Barthkode Israel. So and so in both these cases. The issue in the list lies in a narrow compass at this juncture. The petitioners claim to be petitioner trust. ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಅಂತ ಹೇಳಿಲ್ಲ, ಯಾವತ್ತಾಗಿರೋದು? Petitioner trust registered in the year 2015 is said to now taken up the cause of justice for one Saujanya. In furtherance thereof, for a conduct of a peaceful protest on 11/3/2025, and the demand for an acquittal review committee and to take action against the police officers involved in the investigation and seek reinvestigation, seek permission from the hands of the jurisdictional police to hold such protest. The representation to the jurisdictional police, ಯಾವುದಿದು ಬೆಳ್ತಂಗಡಿ ಕಡಬ ತಾಲೂಕ್ ದಕ್ಷಿಣ ಕನ್ನಡ, reads as follows. Page 25, Annexure B, seal number 70 ಅಲ್ಲಿ madam. So the representation is clear that it is protest against the acquittal or seeking an acquittal review committee for the death of one Saujanya. ಯಾವಾಗ ಆಗಿದ್ದು ಇದು? 2012. Death in 2012. The deputy commissioner, the Tahsildar of Kadaba Taluk grants permission to hold the protest in terms of his in terms of his order dated 14/3/2025. After the grant of permission, it transpires that objection is filed by an advocate, and basing upon the said objection, the permission so granted is withdrawn on the next day by issuance of an endorsement on 15/3/2025. It is this action of withdrawal of the endorsement that has driven the petitioner to this court in the subject petition. The learned counsel A. Whelan submits that the right to protest peacefully or right to protest, as the case would be, cannot be stalled by the state by issuing orders, by issuing gag orders. The gag order in the case at hand is that the state issues an order that nobody should protest on the issue. Therefore, the learned counsel submits such orders cannot be countenanced in law. He would further contend that the permission is withdrawn on twin score: one, objections by the advocate, and the other, the order passed by the coordinate bench in writ petition 19382 of 2023. The learned counsel would seek to distinguish both the cases, distinguish the judgment rendered by the coordinate bench, contending that it would not become applicable to the facts obtaining in the case at hand. He would further contend the protest would be peaceful, and if there is any violation of law, the police are at liberty to take action in accordance with law. The learned counsel for the learned AGA, Muhammad Jafar, would also submit that if the protesters would violate the directions issued by the coordinate bench in 19382 of 2023, they should be reserved liberty to take action in accordance with law. Therefore, the issue is the permitting the petitioners to protest on an issue that they are wanting to project in terms of the representation. The representation is quoted herein above. Permission was granted, it is withdrawn, owing to the fact that owing to the twin fact as observed herein above. Therefore, it becomes necessary to notice the judgment rendered by the coordinate bench in writ petition 19382 of 2023. The coordinate bench has held as follows. Full order applicable. Though the learned counsel for the petitioner would seek to distinguish the said judgment to contend that it is inapplicable to the facts of the case, since both these issues relate to one solitary fact of justice for Saujanya, I deem it appropriate to paraphrase the findings therein to the subject order. As also the judgment rendered by the division bench in WP 15399 of 2019. The division bench in the aforesaid judgment holds as follows. Para 5 to the end. The division bench was considering an identical gag order issued by the state against the protesters. The division bench observes that what is defamatory or what could be defamatory can be found only when the protesters are when the citizen is permitted to protest, as every citizen has freedom of speech and expression as obtaining in Article 19(1)(a) of the Constitution. In that light, following the orders passed by the coordinate bench as also the division bench as quoted supra, I deem it appropriate to permit the petitioners to hold a peaceful protest strictly in consonance with law. And if there is any violation of the observations made in the aforequoted judgment of the coordinate bench, it would be open or it shall be open to the respondent state to take action in accordance with law, which is also observed by the coordinate bench. With the aforesaid observations, the petition stands disposed.
My lord, if I may seek the indulgence of my lordship, if my lordship could make one statement, that the respondent police is specifically estoppel from arbitrating whether the speech is defamatory or not.
ಅದು ಮಾಡಿದಾಗ ಹೇಳಿ. ನೀವು ಹೆಂಗೆ ಸ್ಪೀಚ್ ಮಾಡಿದ್ಮೇಲೆ ಡೆಫಾಮೇಟರಿ ಆಗುತ್ತೆ, ಅವ್ರು ಮಾಡಿದ್ಮೇಲೆ ಹೇಳಿ.
Obliged.
Both disposed. ಎರಡು ಒಂದೇ ಅಲ್ವಾ?
This is a case, my lords, where an inquiry under section 25 is sought to be started against a builder who has,
Urgency, yeah.
that's urgency is that they're calling for inquiry and saying personal presence is
When?
required. 25th is what they've asked for.
Monday, fresh matters?
Jeez.
Yes. Office objection, ಏನು?
So that's office objection is that that's complaining should be made as a party. ನಂಗೆ ಯಾರಂತ ಗೊತ್ತೇ ಇಲ್ಲ.
ಯಾರಂತ ಗೊತ್ತಿಲ್ಲ?
That's the whole thing. That's
Where is the order on 25?
no order. Inna start agide. The order is under 25. I'm sorry, Mills. Emails.
Ravi Joshi yaru?
Correct. Ravi Joshi anta, but we do not know who is he, Mills. If that is the office objection, Mills, I will make him a party. It is not.
But who is Ravi Joshi?
Mills, he says that Mills, there's an the resident welfare activity. Mills, my turn to.
ಮಾಡಿ ಅವ್ರನ್ನ party.
Martin. I'll make
Office
sure Mills,
objections
may
to be
have it on,
complied with, in the next 2 days, list on Monday in the fresh matters list.
Grateful.
72.
Malaships, petition.
Perola,
Yes, Malaships. Extension of Perola.
extension of Perola.
Extension Malaships.
Perola ಯಾರು ಕೊಟ್ರು?
Malaship.
Perola order ಎಲ್ಲಿದೆ? ನಂದೇ ಆರ್ಡರ್. ಸೇಮ್ ಪ್ರಶಾಂತ ಇದು.
Yes, Malaship. ಈ ಮೆಟ್ರಿಕ್ and accident Malaship.
ಅಲ್ಲ ಆಯ್ತಾಯ್ತು, ಒಂದ್ ನಿಮಿಷ ಮಾಡಿ. ಶಮಂತ್. ಎಮರ್ಜೆನ್ಸಿ ಪೆರೋಲ್ 15 ದಿನ ಕೊಟ್ಟಿದ್ದೀವಿ.
Yes, Malaship. Tomorrow is going to be explained Malaship.
Who met with an accident now?
Same person, Malaship, Prashant. He is facing some infections in the head, Your Honor.
Head.
Yes, Malaship. So it's severe infections. He unable to manage infections, Malaship.
Unable to marry?
Manage.
Manage. 15 days. Same conditions, extended 15 days. Emergency ಪೆರೋಲ್ 15 ದಿನದ ಮೇಲೆ ಕೊಡಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್. Yes. ಪೊಲೀಸ್ ಮನೇಲಿ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Yes. 15 days disposed. Madam, same condition. 15 days action.
73.
Lords, I appeal for the petitioner.
Here for direction. What is the direction?
I apologize, I am coming online. Your Lordship had disposed of the matter on 7th December 2023. 8 weeks to dispose of the matter before the maintenance. 11 months he had not conducted any proceedings. Assistant Commissioner Bangalore.
All right.
Subdivision. Lordship had directed 8 weeks. It expired on 6/2/2024.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಹೌದು, ಇದು ಏನು ಕಂಟೆಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅಂಡ್ ಈ ಸಿಟ್ಟಿಂಗ್ ಆನ್ ಸಾಟರ್ಡೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಆಚೆ ವೇಟ್ ಮಾಡ್ತಾರೆ. ಈ ಸೇಸ್ ಸಿಟ್ಟಿಂಗ್ ಕಂಡಕ್ಟ್ ಮಾಡಲ್ಲ ಅಂತ.
Cooperated completely. There is no sitting. I have the order sheet in fact.
Who is it? Assistant Commissioner, is it?
ಹೌದು. ಟೋಟಲ್ ನಾನ್ ಕೋಆಪರೇಷನ್.
I passed the order.
ಏನಿದೆ ಆರ್ಡರ್ ಶೀಟ್? ಯಾರು? Who is the incumbent Assistant Commissioner here?
ಅಲ್ಲ, ಇವ್ರು ಕೂಡ ಮಾಡಿಲ್ಲ. ಇನ್ಕಂಬೆಂಟ್ ಕೂಡ ಮೊನ್ನೆ ಸ್ಯಾಟರ್ಡೆ ಕೂತ್ಕೊಂಡಿದ್ರು. Sitting in the chamber and not conducting the proceedings. Advocates are treated very shabby.
The Assistant Commissioner holding, the person holding the post of Assistant Commissioner Bangalore Subdivision shall be present before the court on Tuesday at 2:30 PM. Yes. Next.
74.
This case appear for the petitioner.
ಬರ್ಕೊಳ್ಳಿ ಒಂದು ನಿಮಿಷ. The learned counsel for the petitioner submits that despite the order of this court to dispose the matter within
6/2/2024, a date reckon ಮಾಡಿದ್ರೆ
within 6/2/2024 has not completed the proceedings till today. We are in the month of March 2025. No application seeking extension is also filed before this court. Therefore, the Assistant Commissioner the act of the Assistant Commissioner fringes on the borders of contempt. The learned counsel for the petitioner's parties submit that proceedings are deliberately not taken up even by the Assistant Commissioner who is presently holding the post. Therefore, the Assistant Commissioner holding the post today as Assistant Commissioner Bangalore Subdivision shall be present before the court to answer the aforesaid allegations on Tuesday at 2:30 PM.
That's one request. One request, my lord, let them bring the file. ತಾವು ನೋಡಿ evidence and conduct.
The Assistant Commissioner shall get the records of the entire proceedings, the proceedings ಅಂತ ಮಾಡಿ.
Please,
Proceedings concerning
the matter in question.
proceedings concerning the matter in question. Yes.
Miscellaneous 13 of 22.
ಆಯ್ತು matter in question.
Please.
Next.
Order sheet ಅಲ್ಲಿ he is writing the entire course of process. He
Huh?
writes it in the hand. whenever the-
ಬರ್ಲಿ.
In this case, I appear for the.
Yes, government. It doesn't know basics of law, I guess. ಸುಮ್ನೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಹೆಂಗ್ ಮಾಡಿರ್ತೀರಾ ಗೊತ್ತು. ಎಲ್ಲಿಂದ ತಂದೆ, ಬ್ಯಾಂಗ್ಳೂರ್ ನಾರ್ತ್ ಅಲ್ವಾ, ತುಂಬಾ ಡಿಮಾಂಡ್. ಅದಕ್ಕೆ ಈ ಕೆಲಸ ಮಾಡಕ್ ಟೈಮ್ ಇಲ್ಲ ಅವ್ರಿಗೆ. Yes.
I appear for the petitioner, my lord. I filed a memo reporting the death of the first petitioner and the remaining petitioners to the legal heirs. And along with that, I have also filed an application seeking direction, my lords. Here, what has happened is on the eastern side of.
ಒಂದೊಂದಾಗಿ ಸರ್. serial number ಏನಿದು? 74. What have you filed, sir?
Memo, my lords.
Death ಯಾರ್ದು?
Reporting the death of first petitioner, who is the mother.
LRC ಯಾರಿಲ್ವಾ?
ಅವರೇ ಇದ್ದಾರೆ, ಮಿಕ್ಕಿದವರೆಲ್ಲ other petitioners or the legal heirs.
All right, fine. Memo accepted. Next.
Next is, my lords, I have filed an IA.
What direction?
My lords, here, towards the eastern side of my property, my lords, there is a Gram Tana. There they are putting up a temple. In the guise of putting the temple, my lords, now they are trying to.
Who is putting?
Government. It's a Muzrai temple in the Gram Tana land. In the guise of construction, my lords, they are trying to encroach upon my land. I only submitted them that let the survey be conducted. And if it is found that the land is even extended in my land, it can be constructed. But they are not doing that, my lords. I have also made a representation to the Tahsildar that the third respondent, second respondent, but they are not considering it.
Yes, government. Government encroaching others' land. Silpa, it is case on the reverse. Government land encroachment is fine. Government encroaching private land. This is the matter on Tuesday in the fresh matters list at the request of the learned HCGP. Yes, next.
75.
There
are two other matters, Lord.
Could it?
This is the expedition because the appeal lies to the state commission as against the order of.
Consumer forum.
District consumer.
ಹೋಗಿ ಅಲ್ಲೇ.
ಇಲ್ಲ, Lord, it's a case of order without jurisdiction. Lord,
Why without jurisdiction?
What has happened is, Lord, the one.
ಇನ್ನೂ ಎರಡು ಕೇಸ್ ಇದೆಯಾ?
ಅಲ್ಲಿ ಇನ್ನೆರಡು ಕೇಸ್ ಇದೆ.
ಕೊಡಿ, ನಂಬರ್ಸ್ ಕೊಡಿ.
Ground of alternative remedy case.
One minute, sir. Why no jurisdiction?
But the reason is this.
ಒಂದು ನಿಮಿಷ.
Alternative ground is on the ground that they have to deposit certain amount before the state commission. Therefore, that is not a case.
No, he says it is without jurisdiction. Let me see. If it is without jurisdiction, I will not send them anywhere. Yes.
Lord, the respondent number 1, Lord, purchased the property from Lord respondent number 2. Lord, I have also purchased the property from respondent number 2. I have obtained plans.
Jurisdiction ಯಾಕಿಲ್ಲ?
ಹೇಳ್ತೀನಿ ಅದಕ್ಕೆ. That's all the issue. Lord, I have developed the layout and Lord formed the layout. The respondent number 1 is neither my consumer, Lord, nor has not taken entered agreement with me. Consumer complaint is filed not against Lord my vendor, it's also Lord as against me. Saying that Lord I am liable to Lord give the money back to him or give him alternative side. Lord, I am not, he is not even my consumer.
You don't have any agreement with?
No, Lord. I don't have any agreement with him. In fact, Lord.
Who has the agreement with him?
Lord, that is respondent number 2.
Who is respondent number 2?
Respondent number 2 is the owner of the property who sold the property to me and also to Lord to the respondent herein. In fact, Lord, what happens is even under the Consumer Protection Act.
He has not gone against a second respondent?
He has filed a complaint against not even that person. Even they are not their parties here, notice awaited to them. Now, Lord, I have developed the layout. Plan sanction is obtained. Even under the Consumer Protection Act, not so kindly see, Lord, where this service is excluded. And Lord, it is not for their own purpose that they have purchased this site.
Number kodi. Yes. Tag this petition along with so and so. List them both on Friday the next.
Friday, Monday.
ಆಯ್ತು Monday end date Monday 31st ರಜಾ ಅಲ್ಲ. 2nd April. Yes.
Please. The interim order.
Numbers ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ. Interim order extended. Yes.
ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ತೀನಿ.
Next date. ಅಲ್ಲ ಇನ್ಯಾವುದೋ ನಂಬರ್ ಕೊಟ್ಟ ಮೇಲೆ ಟ್ಯಾಗ್ ಆಗಿ ಬರುತ್ತೆ.
ಕೊಟ್ಟಿದ್ದೀರಿ ಸರ್.
ಅದಕ್ಕೆ ಕೇಳಿ.
Please.
Next.
76 also.
ಅದು ಸೇಮ್ ಸೇಮ್.
Totally 4 it.
There were 4 writ petitions, only 2 are
ಇನ್ನು
listed.
2 ಬಂದಿದೆ, 2 ಬರಬೇಕು.
ಹೌದು.
All right.
77.
Interim direction ಏನು?
Surfacia matter, my lord.
Surfacia,
Yes, I am tendering check of rupees 2,90,000. But as a part of.
surface C ಗೊತ್ತಿತ್ತು, Surfacia ಯಾವ್ದು? ಹ್ಮ್.
Sorry, my lord.
ಬ್ಯಾಂಕ್ ಡಿಡಿ ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ my lord.
ಯಾಕೆ ಬೇಡವಾ ದುಡ್ಡು ಮನಿ ಬೇಡವಂತ? NPA ಆದ್ಮೇಲೆ ಎಷ್ಟು ದಿನ ಆಗಿದೆ NPA ಆಗಿ? ಮತ್ತೆ ಯು ಕ್ಯಾನ್ ರೆಸ್ಯೂಮ್ ಇಟ್. ಎಸ್, ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಬೋದು. ಆ ಥರ ಎಸ್. ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಅಲ್ಲದೆ ಹೆಂಗ್ ಮಾಡೋಣ, ದಿಸ್ ಕೋರ್ಟ್ ಆನ್ 7/3/2025 had passed the following order. The counsel for the petitioner submits that the demand draft, when sought to be handed over to the respondent bank, they have not accepted it. The learned counsel for the respondent bank submits that the account has become NPA 3 months ago and the bank cannot accept the amount as directed by this court. In that light, I direct the respondent bank to receive the demand draft of
Today 2,90,000, my lord.
ಅವತ್ತು
4 ಲಕ್ಷ.
of both the demand drafts of 4 lakhs and 2,90,000 handed over to the respondent, which shall however remain subject to the result of the petition.
Lord, ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ರೆ ಕೊಡ್ಲಿಕ್ಕೆ ತಯಾರಿದ್ದಾರೆ ಸ್ವಾಮಿ. 2 ವರ್ಷ.
2 ವರ್ಷ?
ತಾವು
2 ವರ್ಷ ಯಾಕೆ?
ಫುಲ್ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂತ.
ಅಲ್ಲಿವರೆಗೂ ಪೇಮೆಂಟೇ ಮಾಡಲ್ಲ ಅಂತ
ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ. ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಷ್ಟೊಳಗಡೆ ಒಂದು ಟೈಮ್ ಲಿಮಿಟ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರೆ ಬಟ್ ನಮ್ಮ ಪೊಸೆಷನ್ ರೆಸ್ಟೋರ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ನಾವು ಬೀದಿಯಲ್ಲಿ
ನೀವು 2 ವರ್ಷ ಟೈಮ್ ತಗೊಂತೀರಿ ಅಂದ್ರೆ 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಪೊಸಿಷನ್ ರೆಸ್ಟೋರ್ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮಾಡ್ಬಿಡ್ತೇವೆ. ಈಗ ಅಪ್ಡೇಟ್ ಆಯ್ತದೆ.
ಅಪ್ಡೇಟ್ ಆಯ್ತದೆ
ಅಲ್ಲ, ಈಗ ಲೋನ್ ಇದಾಯ್ತಲ್ಲ ಸ್ವಾಮಿ, ರೆಗ್ಯುಲರೈಸ್ ಆದಂಗ
ಈ ಅಪ್ಡೇಟ್ ಯಾವಾಗ ಆಯ್ತದೆ?
ಅಲ್ಲ, ಈಗ ಆಯ್ತು ಸ್ವಾಮಿ. ವಿ ಹ್ಯಾವ್ ಕಂಪ್ಲೈಂಟ್ ಮೈ ಲಾರ್ಡ್, ಪೊಸೆಷನ್ ಮೇ ಬಿ ರೆಸ್ಟೋರ್ಡ್.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಪೊಸಿಷನ್ ನೋಡಿ, you have a fair counsel. She says they'll hand over. All right.
ಅದೇ ಎಂಟೈರ್ ಪಿಟಿಷನ್ ಮೈ ಮಿಲಾಡ್ ಬಂದು ತಾವೊಂದು ಟೈಮ್ ಕೊಟ್ಟು ಮಾಡಿದ್ರೆ ಮುಗಿಸ್ಬೋದೇನು?
ಅದು ನೀವು ರೀಸನಬಲ್ ಆಗಿ ಕೇಳಿದ್ರೆ ಕೊಡ್ಬೋದು. 2 ವರ್ಷ ಅಂತಂದ್ರೆ
ತಾವು ಎಷ್ಟಾದ್ರೂ ಕೊಡಿ.
2 ವರ್ಷ ಅಂದ್ರೆ ಹೆಂಗಾಯ್ತದೆ ಹೇಳಿ?
ತಾವು ಒಂದು ನಾನು ಕೇಳಿದೆ, ತಾವು ಒಂದು ಟ್ರೈ ಮಾಡಿ.
ವಿಲ್ post position ಕೊಡಿ. I'll post it on 8th April. ಅವತ್ತು will pass orders.
Please.
List on April the 8th. Next.
Possession ಮಿಲಾಡ್
ಹೇಳಿದ್ನಲ್ಲ ಈಗ.
78. I am withdrawing that early hearing.
Thank you, sir. Early hearing ಅಷ್ಟೇನಾ?
This is covered.
Withdrawing ಅಂದ ತಕ್ಷಣ petition ಅನ್ಕೊಂಡೆ.
Withdrawing early hearing application which is filed.
ಸರಿ.
This first time or 2 days time.
Post the matter after 4 weeks.
ಅಲ್ಲ.
Early hearing application withdraw ಮಾಡಿದ್ಮೇಲೆ ಆಯ್ತಲ್ಲ ಇನ್ನೇನು?
Interim order because the coordinated direct covered.
Covered against you?
Stay. No. This is not stay order. Which one? This is not the other connected matters may be posted.
ಅದೇ ಈ covered against you ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
ಅಲ್ಲ, this is my lord, all matter may be posted. I'll argue the matter. This is my lord all together. I'll distinguish this judgment because here ನಮಗೆ ಅಲ್ಲಿ GPS ಮಾಡ್ಲಿಕ್ಕೆ ರೇಟ್ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತ they have approached the court. Ultimately, my lord, all these notification has not been considered and my writ petition is altogether different. Therefore, list all these matters.
And royalty da?
Not royalty. One state, one GPS.
Other petitions ಇದೆ ಕೊಡಿ ಎಲ್ಲ. Tag this petition along with so and so.
And my lord, in the main one, interim stay, my lord, granted.
ಎಲ್ಲ ಬೇರೆದೆಲ್ಲ interim stay ಇದೆ.
Interim stay ಇದೆ, my lord.
In all cases. Yesterday also I have granted on the ground that there is interim stay in other cases.
And corrected 78 and 70.
78, 79.
Yes, both cases.
Tag this petition along with WP 17133 of 23. In the light of the interim order subsisting in companion petitions, there shall be an interim order of stay as is granted in the companion petitions. Next.
79 also.
Same, yes.
Please.
ಎಲ್ಲ tag ಮಾಡಿ madam. 233 madam. Time ಆಯ್ತು.
80.
Matter arising in provisions of Karnataka Societies Registration.
Motor Sports Club.
Sports Club.
Yes, sir.
A complaint is filed by 6 members of the petitioner club. And
Why early hearings are 2024 matter early hearing ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
there is an urgency in the matter.
ಅರ್ಜೆನ್ಸಿಗೆ ಮೂವ್ ಮಾಡಿದ್ರೆ early hearing ಯಾಕೆ ಹಾಕ್ಬೇಕು?
ಮಾಡಿದ್ವಿ, ಬರ್ಲಿಲ್ಲ, ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಯಾರ ಮುಂದೆ ಹೇಳ್ತಾರೆ?
before the earlier times. 6 members file a complaint with the first respondent district registrar, my lords.
24 LR admit ಆಗದೆ early hearing ಆಗಲ್ಲ. You must know the basic. Admit rule issue ಆದ್ಮೇಲೆ early hearing ಆಪ್ಷನ್ ಬರೋದು. ಎಲ್ಲ ಇನ್ನು preliminary hearing stage ಅಲ್ಲಿ ಇದೆ early hearing ಹಾಕಿದ್ರೆ. ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
6 members file a complaint before the first respondent, my lords. On receipt of notice, the club enters appearance and files a memo objecting to the jurisdiction because the district registrar does not have the jurisdiction at all, territorial jurisdiction.
District
Memo is
minister
filed
passed
on
the order.
The district registrar.
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 Yes, Jafar.
We'll have to seek instructions.
The inquiry is ongoing, my
Learned,
lords.
1 minute. Learned AGA was directed to take notice for the respondents. The AGA to secure instructions and make his submissions, list the matter on 3rd April. Till such time, the inquiry that is being held against the petitioner shall remain stayed. Next, ಇದೇನ್ ಒಂದ್ ನಿಮಿಷ early withdraw ಮಾಡಿದ್.
I withdraw.
The learned counsel for the petitioner seeks leave of this court to withdraw the application seeking early hearing. Hell, I'm seeing all early hearing applications in 2024, 20.
I'll withdraw.
Yes.
There is a connected petition in 9283 of 2023. Again, between the very same parties. But there are some more documents there. My rejoinder is also there. My lord, may kindly.
ಹಾಕಿ rejoinder file ಮಾಡಿ ಆಗ. We'll grant, madam. We'll just take it after 4 weeks. Yes.
I just.
Okay. List the matter on 27th in the fresh matters list. 27th March is before 5th April. Correct. Yes.
Interim order.
Interim order subsisting. I'll tag the petition along with so and so. Interim order subsisting will continue till the next date of hearing.
82. Make resolution.
ಅದು early hearing.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಇಲ್ಲ ಬಟ್ ನಮ್ಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳಿದೀವಿ ಅಷ್ಟೇ.
ಯಾಕೆ ಇಲ್ಲಿ ಮನ್ಮೋಹನ್ early hearing ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
Term ಮುಗಿದು ಹೋಗ್ತಾ ಇದೆ. That not should recollect not this is a matter where it is not so granted in order status. Writ petition order was passed, but without hearing me before the notice is served or not final order was passed to the sound report. I filed a writ petition for seeking for not the recalling of that order so that I can be heard in the matter. But ultimately, my lord said they initially granted order status quo. And Lord, thereafter, Lord said because the order was passed by another bench, Lord said let the matter go before that particular bench. But on the basis of the status quo order that my lords had passed, Lord, now an order is passed, Lord, saying that the Honorable Court granted an order of status quo, because of which, Lord, the archiveship that is given, Lord, to the respondent should be continued on the basis of a legal opinion that is given. There is no reasoning given except the legal opinion. Now, Lord, that writ petition which I had filed.
As on the date I granted status quo, who was performing this archakship?
R4, Nityananda Adiga was performing that writ
was
petition
true,
itself is disposed of today. That writ petition itself is not there.
It is disposed of, Lord, I have filed writ appeal because the judge said that, Lord, although I have not been heard in the matter, the judge said there is no harm caused to me, but I will take Lord this order as well.
Division bench alla.
Writ appeal al haki-
ಇಲ್ಲ, ಇಲ್ಲ,
writ appeal
division
pending ಇದೆ. Now, Lord, my difficulty is, Lord, this term is for 1 year, Lord. That it rotates every 4 years, Lord, I get this term once.
Oh, 4 years once for 1 year, is it?
Now, Lord, my term also is getting over. By virtue of this order, Lord, I have been deprived of that benefit. Even the person, Lord, who authorizes me to execute or perform the puja, Lord, they authorize me to, Lord, perform the puja. That also, Lord, is deprived because, Lord, the government says on the basis of the legal opinion, kindly, Lord, see, Lord, my writ petition, Lord, please see, Lord, the order. Page 69, Lord, my WP is 10447.
It will, Friday is an auspicious day.
Friday in the evening.
List the matter on Friday in the fresh matter.
21st I am not there, my lords, kindly.
22nd.
ಅಲ್ಲ 21st and 22nd I am not here.
All right. ಮಂಗಳವಾರ.
ಮಂಗಳವಾರ ಆಗ್ಬೋದು.
25 in the fresh matters list.
Grateful.
The understanding is the matter would be heard.
Please.
You withdraw this early hearing application. Learned counsel for the petitioner seeks leave of this court. Then I will post it for hearing. ಯಾರಾದ್ರೂ early hearing application preliminary hearing matter ಹಾಕ್ತಾರ? Admit, rule issue ಆದ್ಮೇಲೆ ತಾನೆ. Memo ಮಾಡಿದ್ರೆ we'll take it. Yes, list, learned counsel for the petitioner of arguing, sorry, would seek leave of this court to withdraw the application in IA 3 of 2024 for early hearing. List the matter on 25th in the fresh matters list. IA 3 and IA 1 both.
Please.
ಅದಕ್ಕೆ fresh matter like urgency ಇರೋದೆಲ್ಲ will dispose whatever is possible.
ತಮ್ಮ ಮುಂದೆ it is not difficult. Sometimes not matter does not reach, not everything gets.
What does not reach, sir?
No, here not.
Yes.
Please.
For petition, my lord. At page number 43.
ಇದು ಅರ್ಚಕ.
ಇಲ್ಲ ಅದು ಅರ್ಚಕಲ್ಲ.
ಮತ್ತೆ.
at page number 38. Annexure M.
ಏನಾಗಿದೆ?
The petitioner has requested the government to release 3 crore 50 lakhs.
ಯಾಕೆ?
Towards the development of the petitioner's trust for different development activities. That has been.
ಯಾವ್ದು ಗಾಣಿಗಾರ ಸಮುದಾಯ? All right.
Annexure M. Earlier, the government has, Chief Minister has approved for grant of 3 crore 50 lakh. That has been approved by the Finance Department. Then it has been approved by the Secretary Department of Backward Classes Welfare. 2 crore has been released earlier. We have entered into an agreement for construction with the government Nirmati Kendra. With the government institution only we have entered.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
Now, my lord, 2 lakhs has been released at the first installment.
2 lakhs or 2 crores?
2 crores. 2 crores.
ನೀವು ಒಂದು 0 ಮಿಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
ನಮಗೆ ಕೋಟಿ ಅಷ್ಟು ಅಭ್ಯಾಸ.
ಸರಿ ಆಯ್ತು.
My lord, for the remaining release of 1 crore 50 lakh, we have again requested the honorable Chief
Yes,
Minister.
government.
5 crore.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ನೀವೇ ಎಲ್ಲ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟು 3.5 ಕೋಟಿ ಕೊಡ್ತೀನಿ ಅಂತ ಸ್ವಲ್ಪ ಇಫ್ ಯು ಹೋಲ್ಡ್ ಇಟ್ ಹೆಂಗ್ ಸಾಧ್ಯ? ಯಾವಾಗ ಕೊಡ್ತೀರಾ 1.5 ಕೋಟಿ?
Seek instruction. 2 ಕೋಟಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ಮಂಡೇ.
3.5 ಕೋಟಿ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ ಯಾರು? ನೀವೇ ತಾನೆ? ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ 2 ಕೋಟಿ ಕೊಟ್ಬಿಟ್ಟು ಸಾಕು ನಿಮಗೆ 1.5 ಕೋಟಿ ಏನ್ ಮಾಡಿದ್ರಿ?
1.5 ಕೋಟಿಗೂ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಅಪ್ರೂವಲ್ ಮಾಡ್ಯವ್ರೆ.
ಏನ್ ಮಾಡಿದ್ರಿ ಅದನ್ನ? ಎಲ್ಲಿದೆ?
I will seek instruction.
ಎಲ್ಲಿದೆ? ಅಪ್ರೂವಲ್ ಆದ್ಮೇಲೆ ಇರ್ಲೇಬೇಕಲ್ಲ ದುಡ್ಡು?
We'll verify it.
ಅದು ಅಪ್ರೂವಲ್ ಆಗಿದ್ದು ಯಾರಿಗೆ ಅವ್ರಿಗೆ ಹೋಗ್ಲೇಬೇಕಲ್ಲ ಅದು? List the matter on Wednesday in the fresh matters list. Learned AGA to secure instructions as to why the approval that was granted by the Chief Minister for a grant of 3.5 crores for development work allocated to the backward classes welfare department communities in the budget of 2022-2023 is not made good to the petitioner in its entirety. The allegation is that amount of 2 crores is paid as against 3.5 crores. The learned AGA.
For 1 crore 50 lakh also, again Chief Minister has passed the fresh order.
ಎಲ್ಲಿದೆ ಅದು?
ಅದೇ page number 38.
Which earlier government or the present government?
Present government. ಅದು that has been again approved by the Finance Department. Again it has been approved by the Minister of
ಈಗ
Backward Classes.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
ಅಲ್ಲ, we secure the instruction, I will place it before.
And it has been approved by the
ನಿಮಿಷ.
sessions also.
ನಾನ್ ನಿಮಗೆ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ನೀವು ಅದೇ ಪ್ರಶ್ನೆ ಅಲ್ಲಿ ಕೇಳ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ. ಅದು ಆಯ್ತು.
ಆಮೇಲೆ ಇನ್ನೊಂದು
ಯಾವಾಗ
document.
ಕೊಡ್ತೀರಾ ಅಂತ ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರಿಗೆ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ. ನೀವು ಅವ್ರಿಗೆ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳ್ಬೇಡಿ.
ಇನ್ನೂ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ DC ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ ಇನ್ನು 1.5 ಲಕ್ಷ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಬಡ್ಡಿ ಕೊಡಿ ಅಂತ ನಮ್ಗೆ ಗೌರ್ಮೆಂಟ್ ತಿರ್ಗಾ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಯಾರೆ.
ಅದೆಲ್ಲ ಬರಿ ಮಾಡಬೇಡಿ.
1.5 ಕೋಟಿ, ಸಾರಿ, ನಿಮಗೆ ಕೋಟಿ ಬರಲ್ಲ ಲಕ್ಷ.
ಈಗ ಅದು ಕೊಡ್ಲಿ.
ಆಯ್ತು.
ಕೊಡದೇ ಇದ್ರೆ ಅದೇನೋ ಹೇಳಿದಿರಲ್ಲ ಈಗ DC.
ಹೌದು.
ಅದೇ DC ಕೊಡ್ತಾರೆ ಪಾಕೆಟ್ ಇಂದ. ಎಸ್
Please.
ಎಸ್ Wednesday fresh matters.
Yes, please.
Admission 84.
My lords, the petitioners have borrowed a sum of rupees 1 crore 93 lakhs, my lords, from the respondent number 2, your lords. My lordship, from 2016 to 19, they were regular in repayment, your lordship. In 2019, NPA.
Serial number?
Serial number
84.
Please.
NPA ಗೂ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನ್ ಸಂಬಂಧ
ಇದೆ ಸ್ವಾಮಿ. ಏನಂದ್ರೆ after NPA, the respondent number 2 bank has filed a complaint against the petitioner, your lordship, saying that they have forged 2 documents, one invoice and another receipt. Your lordship, kindly see the document in page number.
Which
45.
bank? Learned AGA is directed to additional SPP na ನೀವೇ ತಗೊಂತೀರಿ?
Serial number. Additional SPP.
Learned additional SPP is directed to accept notice for the first respondent, emergent notice to the second respondent, returnable by the 17th April 2025. There shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Much obliged.
Next.
This
Yes,
matter
Arnav?
is covered by your lordship's judgment, which I had filed in the early hearing application. Insofar as it concerns Mailasandra village, my lords, and thoroughly
Oh,
forest.
that thoroughly forest case.
Please file a objection, my lord, it's ready.
Hakli bidi. Objection hakli. Learned HCGP seeks a week's time to file statement of objections to the petition. Objections, if any, by the next date, 3rd April, preliminary hearing.
Great.
Yes, next.
86.
My lord, I
Total
appeal
need a
for-
week's time.
Same,
ಇಲ್ಲ ಸೇಮ್ ಇಲ್ಲ
ನಿಮ್ದು ಯಾವ
ಫಾರೆಸ್ಟ್
ಫಾರೆಸ್ಟ್?
ಫಾರೆಸ್ಟ್ ಮಾನಿಟರಿಂಗ್ ಕಮಿಟಿನವರು ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಅನ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ದಟ್ ದಿ ಲೇಔಟ್ ವಾಟ್ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಫಾರ್ಮ್ಡ್
ಇದು objections ಹಾಕಿ.
ಗಿವನ್ ಎಫೆಕ್ಟ್ ಟು
2 weeks. List the matter on 17th April. Objections, if any, by then. Yes, next.
Lord, my layout is ready. I have sold.
Layout is ready.
And my lord, it was ready even before the monitoring committee gives me the notice. I have sold 2 sites also even before the notice. Now, my lord, layout plan is approved.
ಹಂಗಂದ್ರೆ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ನಿಮ್ದೇನಾ?
Forest land.
Just because you formed the layout,
No,
hold
it
2
is not
sites.
Forest land, my lord. It is saying that it is within the, my lord, within certain range.
What range?
Now, my lord, within 1 kilometer from the
What range?
forest. Within 1 kilometer from the forest.
Hmm.
Now, my lord, when the conversion order was done, no, my lord, there was no objection. When layout plan was approved, there was no objection. And my lord, the notification states it's only for the commercial activity. But so far as commercial activity is concerned, just abutting the gate of my this thing, Coffee Cafe Day is running. There is no objection for
Cafe
that.
Coffee Day.
Cafe Coffee Day is running. And another hotel is also running. No objection for that.
ಹೋಟೆಲ್ ಹೆಸರೇನು?
My lord, I have produced
ಕಾಫಿ ಡೇ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಇದಕ್ಕೇನು ಹೇಳಿಲ್ಲ?
Hotel Elite.
Elite.
Elite ಆಗಿ ನಡೆಸ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಹಾಗಾದ್ರೆ ಫಾರೆಸ್ಟ್ ಅಲ್ಲ ಬಿಡಿ.
And it is commercial activity
objections.
ban ಆಗಿದೆ notice note ಇದ್ರಲ್ಲಿ.
That's the matter on 17th April. Objections, if any, by the state by then. Next.
May I seek for earlier date, my lord. The reason is
24th April.
I'm sorry.
Yes, 17th. Yes, next.
87.
Yes, Krishna ಅವ್ರ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ?
Interim order ಇದೆ.
Detailed order ಮಾಡ್ರಿ. Objections. 2 weeks time is granted to file statement of objections. The interim order granted on 11/3/2025 stands extended till suspension ಅಲ್ವಾ?
A suspension. I'm only seeking for my lord, no objections so far inquiries
No,
concerned.
that I have already clarified in this. The interim order subsisting would continue till the disposal of the petition.
Hello.
Next.
B group. 88 parting person.
ಶರಣ್ ದೇಸಾಯಿ ಅವರ ಏನ್ ಮಾಡಿಲ್ವಾ?
My lord, despite your order last year, the state has not complied with the order. They are not reconsider my application for
No,
the
they
fresh
said they have
nomination.
complied with the order. Yes, Jafar.
My lord, I filed a memo other day because I obtained some documents in RTI. The applications filed by the other 2 applicants, but they have made application to the PWD principal secretary, my lord, but council does not recognize them as the highest head of the state. Council recognize principal secretary of the state is the head of the state. Chief secretary is the head of the state. So we have to make application to the chief minister or to the chief secretary and then refer to the PWD.
Now you have submitted your application?
Yes, my lord. And
Not considered?
not considered, Mr.
Yaar, who has been nominated now?
My lord, if you see the memo I filed on 10th, there is an application.
Jafar, I disposed this by annexure A, page 17, giving certain directions as to how the nomination should be made to the Council of Architects. Now, the allegation is that the same error is being repeated without considering his application. Not that he should be nominated, but his application should merit consideration. Just check, list this matter on next Friday in the fresh matters list.
My lord, if you see the next.
Council say, the learned AGA to secure instructions and make his submissions will close it on the next date.
Much obliged.
Next Friday, ಬೆಳಗ್ಗೆ.
Yes, my lord.
Two 2:30 ಬಂದ ತಕ್ಷಣ ಹೇಳಿ madam.
Has not filed any objections yet.
ಯಾವ್ದಕ್ಕೆ? You want to file? Interim order ಇದೆಯಾ?
Till further orders.
Learned Counsel H.V. Devraj seeks 2 weeks' time, Devraj? 2 weeks' time to file statement of objections, subjections, if any, in the next 2 weeks. Interim until further orders ಇದೆಯಲ್ಲ, absolute ಇದೆ. Yes. Connected? Number ಕೊಡಿ. Tag this petition along with the writ petition 23?
23869, my lords.
869 of 2024.
Yes.
2024, yes.
Hearing for the petitioner. My lords, petitioner is aggrieved by the action of the respondent in denying interest on the PPF account of the petitioner, my lords, alleging that
Not given interest?
it is alleging that it is an HUF account and from
Oh, you have
2005
invested,
yes, my lords.
invested after the HUF was withdrawn.
Yes, my lords. My account was from the year 1996 for a period of 15 years, my lords.
Correct.
In 2011.
No, 1996 HUF was not yet withdrawn, I guess.
Not yet withdrawn.
Yes, in 1998 they withdraw it, or 2004. I have passed. Where is my judgment?
I
Yes.
placed it on record as annexure J2, my lords. Page number 51. It is
Shankar
covered-
Lal, correct.
Yes, yes, my lords.
I'm told Shankar Lal has been distinguished in 2-3 orders later.
My lords, this is also a case. In fact, my lords, in 2011, I have been after 2011, I have extended the same scheme, my lords, for 3 years. My lords, at page number annexure.
Let's see
B,
who
my
appears for the respondent, madam.
lords,
L. Chandrasekhar.
served. L. Chandrasekhar has.
DSGI for R1 to R3. The registry to print the name of Shanti Bhushan as appearing for respondent 1 to 3. List the matter on Tuesday in the fresh matters list. Copy ಕೇಳಿದ್ರೆ ಅಕಸ್ಮಾತ್ ಕೊಟ್ಟಿರಿ ಅವರಿಗೆ.
Please.
So it expedites the process.
Great.
Yes. Next. Housing board. In representation.
House.
Pradeep Kumar ಇಲ್ಲಿ.
Consider the next.
What is allotment of a house? Yes, we'll close it. So shall I close this or keep it? Pass over. ಆಯ್ತು ಪಾಸ್ ಓವರ್. ಕೇಳ್ಕೊಂಬನ್ನಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ ಅಂತ. ಎಸ್, ಅವ್ರು ಹೇಳಿದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ.
Next.
ನೆಕ್ಸ್ಟ್ ಸೇಮ್. Both the matters counsel. Yes, ask and come. Yes. Non-compliance of office objections. ಏನ್ ಮೇಡಮ್ ಇದು? ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು. CH ಮೆಮೋ ಅಂತಿದೆ. Why AG's office is a party?
That will appear in this matter.
Huh?
We have it next week.
No representation. We have direction. Criminal contempt consent. Why it's here? Anyway, no representation. We have the petitioner. List the matter on Friday, the next in preliminary hearing. Next. Manmohan.
I have filed an early hearing application on matter relates to, but I have an arbitration award against.
We'll post it in 2026. Early hearing application allowed.
But I have an arbitration award in my favor as against not third respondent. Now, my lord, after the award is passed, my lord, there is an insolvency proceedings initiated, and my lord, respondent number 2 takes over that company. Now, my lord, they say no amount is payable to me, despite my lord there being an arbitration award. MSME order, my lord, saying that they have to pay the money to me. Everything, my lord, they say is washed off because the NCLT approved, my lord, the resolution plan. It cannot not wash away, my lord, a decree that is passed by the court, or not an award that is passed.
Resolution plan has been approved, my lords. And if they have a grievance, then appeal is provided under section 31 of the.
I cannot, my lord, challenge the resolution plan. I have nothing to do with it. I have a decree.
We'll answer it. Urgency ಇದೆಯಾ?
But ನನಗೆ ದುಡ್ಡು ಏನೂ ಇಲ್ಲ.
ಏನೂ ಇಲ್ಲ.
GST, my lord, is creating not issues for me.
List the matter on 2nd April in preliminary hearing.
Please.
Yes. Be ready, we'll close it.
Please.
Next.
95 I'm appearing for the petition.
Petrol.
Petrol. ಒಂದು ಸ್ವಲ್ಪ
ಒಂದ್ ಸ್ವಲ್ಪ
ಮೆಡಿಕಲ್ ಎಮರ್ಜೆನ್ಸಿ ಇದೆ ಇದರಲ್ಲಿ ಸ್ವಲ್ಪ
ಮೆಡಿಕಲ್ ಎಮರ್ಜೆನ್ಸಿ ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ಲ
ಎಮರ್ಜೆನ್ಸಿ ಅಲ್ಲ ಸ್ವಾಮಿ ಮೆಡಿಕಲ್ ಇಶ್ಯೂ ಇದೆ ಹಿ ಹ್ಯಾಸ್ ಅಕ್ಯೂಟ್ coronary syndrome ಇದೆ plus
The
interior wall.
petitioner is before this court seeking the following prayer. You are the convict yourself or who is it?
I am the convict, my lordship. I am the convict, my lordship.
ಯಾವ್ದು ಬಾಬಿ ಅಂತಿದೆ
Second, my lordship, that I,
ಏನ್ ಮೂರ್ ಮ್ಯಾಟ್ರ್ ಯಾಕೆ
my lordship, that wrongly got clubbed, my lordship. The other two matters may be listed on some other day, my lordship. I'll produce some documents, my lordship.
ಡೀಲಿಂಗ್ 95.1 and 95.2
They can all be, I've received instructions in all of them.
ಏನ್ ಎಲ್ಲ ಪೆರೋಲ
Ella Petrol.
ಎಲ್ಲ ಪೆರೋಲ
Ella Petrol.
Can all
But
be disposed of.
ಆಲ್ ತ್ರೀ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಇಟ್
my lord,
ಅಪ್ಡೇಟ್ ಆಗಿಲ್ಲ ಮೇಡಮ್ ದಿ ಪೆಟಿಷನರ್ is before this court seeking. You are the convict yourself or what?
all three, I am the convict.
The petitioners in all these cases are convicts themselves who are at the door.
Different, they're all different cases, my lord.
Agar one of this one. The petitioner, first one, the petitioner is before this court seeking quashment of an endorsement dated 6/12/2021 which rejects the claim of the petitioner for grant of parole for a period of 30 days on so-and-so. The heard so-and-so. The petitioner gets embroiled in a crime for offences punishable under section 302 of the IPC and is convicted by the court of session. The petitioner has, as on today, been in prison for 5 years. First time a parole?
10 years, 1 month.
7 years, first time parole.
Yes, my lord.
7 years and 1 month.
Got parole twice.
And has secured parole on 2 occasions. The learned HCGP on verification of the records would submit that the petitioner has not suffered any adverse entry on both the occasions when he was out on parole and has returned to the goal on both the occasions. In that light, occasions, the learned counsel for the petitioner projects who is ill.
He himself, my lordship.
The learned counsel for the petitioner submits that the petitioner himself is ill and would need better treatment outside and has produced certain documents to that effect. In that light, I deem it appropriate to grant the petitioner parole for a period of 30 days to become operational from Friday.
Yes, my lordship.
Yes, Friday agutte.
Other two petitions may be listed on some other.
Badwa.
Okay, my lordship.
Pokso, my lord.
ಎರಡು ಪೋಕ್ಸೋನಾ
The earlier one was, my lord, 302.
ಇದು 3 ಕೊಟ್ಟೆ 302.
Quoted 302. Next is Posco, my lord. Pokso. Pokso. Sorry. Pokso. 3 years, 2 months.
3 years 2 months ಆಗಿದೆಯಾ ಈಗ? ಹಾ. 95.2 ಏನು?
95.2 is also.
95 point.
What's 95.2, sir?
4 years, 3 months, my lord.
Hello, offense.
Offense 326A.
And ಸ್ವಲ್ಪ ದಿನ ಆಗ್ಲಿ, we'll have these two next week. List the matter 95.1, 95.2, list on 3rd April.
Fresh matters.
Fresh matter.
Much.
ಸುಧೀಂದ್ರ ಬರೋಲ್ಲ?
Subject to the matter of rowdy sheeter, lordship. Subject to the matter of rowdy sheeter.
Rowdy sheet.
Lordship, this Dago.
Delete the name. ಏನ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇತ್ತ ನಿಮ್ಮ ಮೇಲೆ?
ಲಾರ್ಡ್ಶಿಪ್ ಅದು ಕೇಸು ಅಕ್ವಿಟಲ್ ಆಗಿತ್ತು.
ಆಗಿದೆಯಾ?
ಆಗಿತ್ತು 28/11/2024 ಅಲ್ಲಿ ಅವರು ಫಾಲ್ಸ್ಲಿ ಕೇಸ್ನ ಫೈಲ್ ಮಾಡ್ತಾರೆ, ಕ್ರೈಮ್ ನಂಬರ್ 77 of 2021.
ಅದಾಯ್ತು, ಈಗ ಅಕ್ವಿಟ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಅಕ್ವಿಟ್ ಆಗಿದೆ. ಒಂದು ಕನ್ವಿಕ್ಷನ್ ಆಗಿರೋದು ಇದೆ, CC 14.
Look into it. We'll close it on Friday the next. List the matter on 28 in the fresh matters list. Yes. ಏನಿದೆ ಲಿಮಿಟೇಷನ್? ಮತ್ತೆ
Two claim petitions have been filed by the claimants before the tribunal mirror. One for the death and one for the injuries.
But they were examined as PW1.
Hmm.
They produced the charge sheet.
Ah.
Kindly come to ink page number 23, my lord.
Ah.
In the charge sheet,
Hmm.
the driver of the car, the claim petitions were filed against the driver, the insured and insurer of car alone. Whereas the charge sheet is filed against the driver of the car.
Hmm.
Second one is BBMP contractor.
Hmm.
Third one is rider of motorcycle.
Hmm.
And fourth one is BBMP officer. Therefore, I filed an application to implead the other three as proposed respondents. My application came to be rejected.
ಬರ್ಲಿ ಬಿಡಿ.
Yes, my lords, I am appearing for the claimants in this case, my lords.
Sari,
That is not
let them come. What's the problem?
The problem is the law does not provide for it, my lords.
ಹೌದಾ? ಕೊಡಿ.
I have already produced one citation.
ಕೊಡಿ. ಅದು citation versus citation ನಿಮ್ದು ಕೊಡಿ.
Can I citation, my lord?
ಏಮಾ?
The full bench decision of Honorable Supreme Court.
Kindly come to the last page, my lords, last paragraph.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಕ್ಲೈಮೆಂಟ್
ಅವ್ರಿಗೋಸ್ಕರ ಹೇಳಿದ್ದಕ್ಕೆ ಏನೇ ಬಿ ಗ್ರೂಪ್ ಹೋಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ
ಈ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಗ್ತೀನಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್.
The last paragraph, my
last
lords.
paragraph, Swami, 22.3. In case of all the joint tortfeasors have been impleaded and evidence is sufficient, it is open to the court tribunal to determine the inter se extent of composite negligence of the drivers. However, determination of the extent of negligence between the joint tortfeasors is only for the purpose of their inter se liability, so that one may recover the sum from the other after making whole of the payment to the plaintiff claimant to the extent it has satisfied the liability of the other. In case both of them have been impleaded and the apportionment extent of their negligence has been determined by the court tribunal, in the main case, one joint tortfeasor can recover the amount from the other in the execution proceedings.
ಆಯ್ತು. ನಿಮ್ದು ಆ ಪ್ಯಾರಾಗ್ರಾಫ್
ಅಲ್ಲ next one ಇರೋದು.
ಆಯ್ತು. It would not be appropriate.
It would not be appropriate for the court tribunal to determine the extent of composite negligence of the drivers of two vehicles in the absence of impleadment of other joint tortfeasors. In such a case, impleadment of joint tortfeasor should be left in case he so desires to sue the other joint tortfeasors in an independent proceedings passing of the decree of the award.
All right.
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅವರೆಲ್ಲ ಇದ್ದಕ್ಕೆ ಈ ಡಿಸಿಷನ್ ಪೂರ್ತಿ ನಂಗೆ ಅಪ್ಲಿಕಬಲ್ ಆಗಲ್ಲ. Therefore, their presence is also required only to the extent of interest.
Yes, madam.
My lords, only one point for my lords' kind consideration. This is a case of composite negligence, my lords. In a case of composite negligence,
Joint
there are joint tortfeasors are there. Whether the claimant has to make all the joint tortfeasors a party to the claim petition, or whether he has got the right of choice to file the case against any one of the joint tortfeasor is the point in question, my lords. Regarding that, this citation is very clearly on the point. Last paragraph, para number 18, and the last points, my lords. May I read, my lords? What emerges from the aforesaid discussion is as follows. Para number 18, my lords. of
I'm
said
there.
judgment.
Yes.
Yes. The first point, in case of composite negligence, plaintiff claimant is entitled to sue both or any one of the joint tortfeasors and to recover the entire compensation as liability of joint tortfeasors is joint and several. The first point is very clear, my lords, that the claimant can file the case against any one of the joint tortfeasors and claim the entire amount. The second point is, in the case of composite negligence, apportionment of compensation between two tortfeasors, that is the plaintiff claimant.
Madam, tell me one thing.
It's not permissible.
In a case of composite negligence,
Yes, my lords.
without impleading the persons who would become liable to pay, in the case the court would order joint and several, can you impose those conditions without hearing them?
Now, for that, the third point is very clear, my lords.
Yeah.
Their rights is also very much reserved, and their rights are
Arey,
also
if somebody's right has to be reserved, he would have the right to contend that, yes, I need not pay.
Yes, my
Joint and several will make him liable for prosecution later.
So what the apex court tells is the claimant has got the right to sue against any one of them, and this joint tortfeasor has to pay the entire amount to the claimant in the judgment. After fulfilling that amount, in the same case, this respondent will get the right to file this application. What
Let's see, little doubtful.
I'll read the third one.
ನಾನು ಡಿಸ್ಪೋಸ್
It's very
ಮಾಡ್ತಾ
clear.
ಒಂದು ನಿಮಿಷ.
It's very clear.
ನಾನು ಸ್ವಲ್ಪ ಓದ್ಕೊಂಡ್ಬರ್ತೀನಿ, ಹೋಮ್ವರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ಬರ್ತೀನಿ. ಎಸ್, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಇನ್ ದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಜಡ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿರಿ ಯಾವ್ದಾರು ಇದ್ರೆ? ಆಯ್ತು, ಕೊಡಿ. ಆಸ್ ಫಾರ್ as prima facie what I feel is, without arraigning somebody as a party, joint and several ಅಂತ ಆರ್ಡರ್ ಕೊಟ್ಟು, then
My lords, para 11 also tells very
no,
clearly.
let's see, madam. Yes. Tuesday, we'll have it on Wednesday. Yes.
Wednesday.
B group ಇಂದ ತೆಗೆದು ಅದು ವಾಪಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆ ಹೋಗ್ಲಿ. Yes, we'll decide it. Yes, next. ಬಂದ ಮೇಡಮ್ 2:30. ಮುಗಿಸಬಿಡೋಣ ಲಿಸ್ಟ್ ಬನ್ನಿ. 2 ನಿಮಿಷ.
Paying for the petitioner in this case.
Ah.
Earlier occasion, this honorable court was pleased to grant interim order. my lord.
20% amount.
We have paid the 20% amount, my lord, and in my
ಮಾಡಿದಾರಾ?
ನಾಟ್ ವಿತ್ ಇನ್ ದ ಡೇಟ್ ಅದ್ರಲ್ಲೂ 12 ಲಕ್ಷ ಮಾತ್ರ ಸೇವಿಂಗ್ಸ್ ಅಕೌಂಟ್ ಹಾಕೊಂತಾರೆ. ಕರ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅಂದ್ರೆ ಬರಲ್ಲ.
ಈಗ ಯಾವಾಗ ಇದೆಯಾ ಅವ್ರ ಅಕೌಂಟ್ಲೇ ಇದೆಯಾ ಈಗ?
Copy of the acknowledgement I have produced.
1
with the
minute
IPA.
sir.
Please.
12 lakhs ಎಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ?
ಸೇವಿಂಗ್ಸ್ ಅಕೌಂಟ್ ಗೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ಅದು ನಿಮಗೆ ಬರ್ಬೇಕಾ ಈಗ?
ಇದು ಲೋನ್ ಅಕೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದಕ್ಕೆ.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಸರ್?
ಮೋರ್ ಓವರ್
Kindly, if you lord.
When are you going to transfer it to the loan account?
Well, it has already been transferred to loan account.
When?
On 4/12/2024, I have transferred 8 lakhs.
Ah.
And on subsequently 12/12/2024, I have transferred 2 lakhs.
Hmm.
And again on 2/1/2025, I have transferred 2 lakhs. my lord. Total 12 lakhs has been transferred. The receipts also been placed along with the
ಏನ್
IE
ಬೇಕು
before this
ನಿಮ್ಗೆ?
court.
20% of the outstanding will
ಎಷ್ಟಿತ್ತು
be about
outstanding?
13 lakhs 90,000.
Total 13 lakh?
90,000, 20%. That has to be paid within 8th December 2024.
ಆಯ್ತು ಈಗ
They have made payments of 12 lakhs to the savings account on subsequent dates after 8th December.
The learned counsel for the respondent submits that 20% as directed on 8/11/2024 is not paid. It where the entire payment of 13,90,200 is not paid in term, which would amount to 20% of the outstanding. The
My lord,
learned
may I make
counsel,
a mention? On the earlier occasion, when I challenged this.
1 minute,
criminal
the learned
misdemeanors-
counsel appearing for the petition respondent will further submit that the entire amount, the amount that is paid, 12,70,000 is paid to the savings bank account and not to the loan account, which is disputed by the petitioners.
Only 12 lakhs.
Disputed by the petitioners. Therefore, the petitioners, if they have held the amount of 12 lakhs in savings bank account as on today and not transferred it to the loan account, the interim order would get automatically vacated, instructions be sought and submissions be made on the next
Lord,
date.
they have
List
issued
on
a fresh-
Friday, in the-
Lord, they have issued a fresh auction notice.
list on Friday, ಯಾವತ್ತಿದೆ ಸೇಲ್?
ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. Despite taking 20% of the amount. they
Then
get a
20% ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಅದಕ್ಕೆ?
My lord, kindly, my lord, may I request-
ಸೇವಿಂಗ್ಸ್ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಯಾಕೆ
Yes,
ಹಾಕಿದ್ರಿ?
check ಕೊಟ್ಟಿದ್ದೀನಿ in the name of the same
ಸೇವಿಂಗ್ಸ್
bank
ಬ್ಯಾಂಕ್
account.
ಅಕೌಂಟ್ ಯಾಕೆ
Yes,
ಹಾಕಿದ್ರಿ?
bank name ಅಲ್ಲಿ I have issued a check as well as the amount. That receipt also I placed before this honorable court.
No problem. Yes, list day after tomorrow. Don't continue with the sale. The sale that is slated to be held tomorrow shall stand deferred.
Grateful.
I'll list this
Sir,
matter on
let the
Monday in the
sale
fresh matter.
that it will not be confirmed.
12 ಲಕ್ಷ ತಗೊಂಡಿದ್ದೀರಾ? Wait.
ಇಲ್ಲ sir. That is on January ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
Let
ಮತ್ತೆ
them place
we will
the-
ask him to deposit. Don't
Let
worry.
let an affidavit be
Sir,
filed, my lord, that they have
ನೀವು
not received
if
the
you
amount.
don't do it in its entirety, sale ಮಾಡೋದವ್ರು. Don't sit in a glass house and throw stones at somebody else. Yes.
As per this honorable court directions, my lord, I have paid.
Wait. Yes. List on Monday in the fresh matters list. Next.
Sir, may I have the interim order, my lord?
ಹೇಳಿದ್ನಲ್ಲ.
Tomorrow is the sale.
Don't sell. Sir. I mean, don't conduct the sale. Yes.
Please, grateful.
Next.
My lords. My lords, there is only one point of law.
One point of law, then you're disappointed. Yes.
My lords.
Respondent in
I beg your
this
pardon.
matter.
Does this point of law regarding the amount that has to be deposited for a stay of the arbitral award that has been settled by my lords in the previous judgment. That judgment was tendered.
Oh, yes, correct. Whether it is the full amount or something else.
Yes, 100% amount that is to be deposited as per the.
Stay ideal, I have granted stay, I guess.
No, my lords, this is.
First time coming?
This had come up on 10th March, my lords. The
Then we'll-
respondent had another writ petition which was not numbered. So my lords had directed the respondents to get it numbered.
Take it on Friday.
Lord, ma'am, morning I have mentioned the matter, the connected matter, which has been directed to be listed on Monday. My only request is both the matters may kindly be have it
All right,
together.
number could give the number.
My lord. I have
Tag
already.
this petition
It's
along
an
with.
FR number, my lord. It's
What
FR
the
number
FR? What is all
669.
this? How can I tag an FR number?
My lord, it's already been complied. What I've been told by the registries, until unless there's a date fixed for the matter, they are not going to even scrutinize the matter.
I the list on Monday.
It's 6653 of 2025.
Along with no numbers, dash. Yes.
My lords, may I
No
request-
compliance.
Much obliged, Lord.
Yes, next.
My lords, may I request it be listed in the fresh matters list? Because.
Fresh matter only, sir. Yes, in the fresh matters list.
Much of-
Grateful, my lord.
Yes, 230 ಮೂಡ್ matters ತೊಗೊಳ್ಳಿ. ಇದೆಯಾ? ಏನ್ ಸೆಟಲ್ಮೆಂಟ್?
Lord, I am for the respondent. The matter has been settled, my lord. Kindly dispose the matter.
See, where is the settlement? What is the matter?
I am for the Union Bank, my lord. The petitioners have already cleared up the debts.
That is okay. Learned counsel appearing, ikade bani, respondent. Learned counsel appearing for the respondent bank submits the petitioners have cleared the loan in its entirety and the bank has discharged its liability. Discharge the liabilities of the petitioner. Documents ಕೊಟ್ಟಿದ್ದೀರಾ ವಾಪಸ್ ಎಲ್ಲ?
ಕೊಟ್ಟಿದ್ದೀವಿ, sir.
All original documents?
Yes, yes, ma'am. Everything has been
And
done.
would
It's just
submit
that
and
the
would-
petitioner advocate is not available. So we are directly.
All right. The learned counsel for the respondent bank further submits that all the original documents that were held by the bank are all returned to the borrower on payment. In that light, the petition does not survive for any further consideration. The petition is disposed as having become infructuous. Yes.
Much.
File ಅಲ್ಲಿ ಅದು settlement lot ಆಯ್ತಾ? Yes.
Raghunath MD.
My lords, I appear for the respondent caveat on this matter.
I appear for the petitioner, my lords.
Lords, this matter is not at all maintainable. It's a writ against Karnataka Golf
Golf
Association.
Association.
What is Gold Association?
Allah, it's Golf Association, my lords.
Golf Association.
Please, my lords.
Cost list ಅಲ್ಲಿ Gold Association. ಏನ್?
The club is also having a lot of gold.
What's your problem?
Please, my lords. My lords, my kindly peruse.
No, these
The
days
petitioner.
everything is gold. That's why. Yes.
My lords, the petitioner is a member of the respondent club.
All right.
Unfortunately, what has happened, my lords, is
Unfortunately.
yes, my
All
lords.
right.
Unfortunately, unfortunately, what has happened, my lords? They have issued a disciplinary notice, which is at Annexure E, at ink page number 64, my lords. To that, I have already
Who has
given
issued?
The respondent, my lords.
All right.
I have already given the reply to the same, my lords,
All
which is at Annexure G.
All right.
And subsequently, at Annexure H, they suspend, my lords.
Oh.
The backstory to this, my lords, is this.
No. You don't go to the past.
Please, my lords.
You tell me the present. How is
The
this
present.
maintainable, sir?
Yes, my lords. The only thing, my lords, is this. The respondent itself is a government itself.
Government?
Yes, my lords.
Golf Association is government.
Yes, my lords. It is under the government land, and my lords had.
On the government land?
Yes, my lords.
So, the government land ಕಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲ government.
Unfortunately, my lords, that is not only one of the contention. In fact, there is a judgment passed by my lords, which clearly showcases, my lord, that the Karnataka Golf Association.
I remember what I have passed. That was
Please, my lord.
atrocities case initiated against the members of the association. Correct, madam?
Please, my lords,
Yes.
a disgruntled.
That is in 2023 I have passed.
482, my
Atrocities
lords,
Act case. Atrocities Act was by another member that was invoking Atrocities Act and complaint registered.
My lords, apart from that, there's one more case also, my lords. I do not have the relevant decision with me.
You don't have the judgment?
My lords, may
Then
kindly post it tomorrow.
Take my judgment, dismissed.
My lords, there is at least.
How is it maintainable?
My lords, this is a government entity, my lords.
Golf Association is a government entity.
Yes, my lords. I shall prove it to my lords.
Seriously?
At least tomorrow, my lords. I have the judgment, my lords. Unfortunately, I don't have it right now with me. At least tomorrow, my lords.
So, ಎಲ್ಲ unfortunate. Proceedings unfortunate. Judgment ಎಲ್ಲ unfortunate.
In fact, that has happened.
Case is also unfortunate.
No, my lords.
No, not
In fact,
maintainable at all.
Illa, it is. If I may be permitted to showcase to my lord, that's it. One final opportunity. If not, then I have no other go but to bow down before this honorable court. Tomorrow, my lords.
Not tomorrow.
My lords, there is an inquiry that is happening on the 22nd.
Then you should have come with all ammunition, sir.
Unfortunately, I didn't know this would be one of the situations. If that was the case, I would have prepared for that aspect also, my lords.
Very unfortunate.
At least tomorrow, my lords.
No, tomorrow you can't.
At least tomorrow at 2:30 or whenever my lords pleases.
Move it tomorrow. Unfortunately, list will be ready now.
I understand, my lord. At least tomorrow, my lords.
Tomorrow. No, tomorrow at 2, you move at 10:30, we'll take it at 2:30.
Please, my lords.
My lords, I have some difficulty tomorrow. I'm not.
Unfortunately, she won't be there.
No, my lords, kindly
But my
see
lords.
my learned friend, all
day after
his
tomorrow, my
chest
lords, because
aside,
it's on the
he's moved a
22nd.
pending matter.
Madam, day after tomorrow in the fresh matters.
No, my lords, I have serious objection, not just on maintainability. He's suspended pending inquiry on 23rd of January.
I'm
That's
not saying
coming
anything,
to,
madam.
My lords, I'm only saying the matter may be had next Friday. My lords, I'm not in station till 26th of March. There's no urgency. He does not want to come for the inquiry. He's moved a pending matter at 10:30. My lords, I'm sorry, that's not
It's
fair.
a pending matter.
Please, my lords, it had already
course
come
not.
up once. He was directed to serve the
Pending matter,
caveat.
No, my lords.
Please, my lords, it's not a fresh matter. I already have a copy.
matter, my lords.
He served it to me on the previous occasion. It's come before this honorable court once.
No, it is office objection compliance.
Please, my lords, it's a pending matter. He cannot
No,
move
no,
it
office
at
objection
10:30.
compliance. All right, 22nd in,
22nd is for the inquiry, my lords. At least
My
21st,
lords, let him
Friday.
appear for
Please,
the
my lords.
inquiry, my lords.
No
He
problem.
cannot
I have not
scuttle.
granted any stay, madam.
No, my lords,
I have
he
not
wants
granted
to.
any stay. Why are you
No, my
worried?
lords,
Yes.
then
List
may I
on
request,
21st.
my lords,
If I
may I
grant an
then,
interim order of stay, then yes, madam, you should get
my
worried.
lords, then may I request one thing, my lords?
Fortunately, I have not granted.
My lords, your lordships may then observe that
Ah.
pendency of this writ will not come in the way of the inquiry
On,
because he,
on 22nd is the inquiry.
my lords, I'm
correct.
not here till 26th, my lords.
No problem.
26th
On
of March.
21st, I will observe that. You can appear from wherever you are.
My lords,
Yes, list on 21st in the fresh matters list.
Please, my lords.
You
much
should
obliged.
first satisfy on maintainability. I'm going to
Definitely, my
dismiss
lords.
it on
With the ammunition.
maintainability.
Please,
Ah.
my lords. Much obliged.
Get some armory from your arsenal.
Surely, my
Yes.
lords. Much obliged.
Next.
very well, I'm grateful, my lords.
No, list total.
Matter, my lord, regarding the tender, he has disqualified on the basis, my lord, he has experience in the food grain transportation.
ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಮೈಕಲ್ಲು ಕೇಳಿಸಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ ಕೇಸ್ ಇಲ್ಲ ಅಂತ ಅರ್ಥ ಮತ್ತೆ
This my lord, a petitioner has applied for the tender, my lord, for the supply of food grains in wholesale transportation. He has rejected, my
what
lord,
is this food grain problem?
in Annexure G is the rejection of the technical
Huh?
proceeding.
Certain condition, my lord, which they say turnover in relation to supply of food grains only, and not turnover, a general turnover. When it comes to transportation of food grains, they say only regarding transportation of food grains only will be taken into consideration and not general transport.
Initially-
That was the condition.
ನೀವು ಇಟ್ಗೆ ಎಲ್ಲ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಫುಡ್ ಗ್ರೈನ್
I
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್
have,
ಮಾಡೋ
I have
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆ
both also, my lord, transportation,
no,
because
no.
here what happened, my lord,
We'll
in
see.
similar
File an
matter, my lord,
objections. Yes.
in similar matter, my lord, the interim matter has granted, my lord,
Oh,
I
no.
have produced it in Annexure D.
ಕೊಡಿ ಯಾವ್ದದು
Annexure D, it is.
ನೋ ಮೇಡಮ್
Annexure D, page number 72,
Nothing,
that
nothing.
is
Tag
approved
this
portion in
petition.
73.
tag this petition
Here
along with
Kumar is financial,
Maybe,
but in
madam.
other petition, my lord, they
One
have
minute.
permitted, they have permitted for, as per the interim matter of
The-
this honorable court, my lord.
madam, what have you experience with carrying food grain still?
Yes, your lordship, I have the experience in both, but in required, because here, my lord, but the tender, they are giving for the 2 years. They are,
ಈಗ ನೀವು
they are prescribing for the 3
technical
years.
technical
Experience.
bid
Technical bit, my lord, in page number 169, page,
Anyway, yes.
Annexure G.
tag this petition along with writ petition 25529 of 2024. The process of tender shall remain subject to the result of the petition.
Financial
List
bid
both-
may be open.
List both the petitions on Wednesday in the fresh matters list.
Financial bid tomorrow, they are going to be.
Let them
started,
open. It will
and
remain-
because, my lord,
it
in
remains
similar
sub-
matter, my lord, 161,
No,
they
madam,
mention the name
yes.
of the repetition number also, my
No
lord.
problem. Yes.
Through
next.
addendum only, they have inserted that word, my lord, food
What
grain.
addendum?
They have initially, I have produced in Annexure B. Initially, Annexure A, they have called for the tender, my lord.
What was the date?
That 23/8/2024.
What was the condition?
Condition was only the transportation itself.
What is the date of the
Thereafter, in
addendum?
addendum, they have issued
Date. Addendum date.
10/9/2024.
What was the last date of receipt?
10/9/2024.
Before
Then
that,
I have applied.
before that ಮಾಡಿದಾರಲ್ಲ ತೊಂದ್ರೆ.
I have approached this honorable court, my lord. I have granted the stay in similar matter, my lord. In Annexure D, I have produced it, my lord.
Why do you do all this? ಒಂದೇ ಸರಿ ಮಾಡಕ್ ಆಗದೇ ಇಲ್ವಾ? State is generating huge litigation in all these frivolous things just because you don't draw a tender properly.
Especially this department.
But food, social welfare ಇದು.
Food and civil supplies.
Food and civil supplies. And they lack basic knowledge in issuing tender notifications. ಎಲ್ಲ ಬೇಕಂತ ಒಂದು ಕ್ಲಾಸ್ ಬಿಡೋದು, ಇಲ್ಲಿ litigation generate ಮಾಡೋದು. ಅಂಡ್ ಯಾರು ಇರ್ತಾರೆ ಟೆಂಡರ್ ನೋಡಿ, ಸಾರಥಿ ಅವ್ರು ನೋಡ್ತಾನೆ ಇದ್ದಾರೆ. LB ಟ್ರೇಡರ್ಸ್, ವೀರಭದ್ರೇಶ್ವರ ಟ್ರೇಡರ್ಸ್, ಇನ್ನೊಂದು ಯಾವ್ದು?
Coming today. Then LB
ಇನ್ನೊಂದು ಯಾವ್ದು
traders-
ಸಾರಥಿ ಅವರೇ? ಇವ್ ಮೂರು, ಇವರೇ ಫುಡ್ ಗ್ರೈನ್ ಸಪ್ಲೈ ಫಾರ್ ದಿ ಲಾಸ್ಟ್ 20 years.
For this purpose only, monopoly only, they have inserted that clause, my lord, because they are giving, my lord, 3 years experience. I have only 2 years is the tender.
We'll
Tender
see.
ಇರೋದೇ 2 years ಸ್ವಾಮಿ, ನನಗೆ ಒಂದ್ಸರಿ ಸಿಗ್ಲಿಲ್ಲ.
ಅದರಲ್ಲೆಲ್ಲ ಸ್ಟೇ ಇದೆಯಾ?
ಅದ್ರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, stay ಇದೆ. Permit them to
in-
proceed with the financial bid ಅಂತ ಇದೆ.
Page 70.
ಪ್ರೊಸೀಡ್, ನಾಟ್ ಟು ಪ್ರೊಸೀಡ್.
ಅಲ್ಲಲ್ಲ, proceed ಮಾಡಿ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. In Annexure D,
ಪ್ರೊಸೀಡ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕು.
without reference to the corrigendum ಅಂತ ಹೇಳಿದ್ದಾರೆ
ಆಲ್
ಸ್ವಾಮಿ.
ರೈಟ್, ಸೇಮ್ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 73 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಇದೆ ಅದೇ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್,
Much obliged.
you should sensitize all your officers. Generating huge litigation here.
copy of the hand delivery, madam, because tomorrow is the
ಹೇಳ್ತಾರೆ
financial.
ಬಿಡಿ ಅವ್ರು. ಶಮಂತ್ will tell.
ಮಾಡ್ತೀವಿ.
Yes, next.
The sale action notice.
KV ಲೋಕೇಶ್. KV8 ಇದೆ. ಯಾವತ್ತಿದೆ
info-
ಸೇಲ್? ಸೇಲ್ ಯಾವತ್ತಿದೆ?
ನಾಳೆಗೆ
ನಾಳೆ ಇರೋದು ಇವತ್ತು ಮೂವ್ ಮಾಡ್ತೀರಾ ಬೇಕಂತ? ಎಸ್.
ಫೈಲ್ ಮಾಡಿದ.
ಎಸ್ KV ಲೋಕೇಶ್.
Informed.
ಎಷ್ಟಿದೆ?
52,80,000.
ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ KV ಲೋಕೇಶ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ರಿ.
We already informed him. Informed on.
Day after tomorrow I'll take. Call him and come, sir. He will appear online. Yes, next.
For 4, censuration.
Sale 14.
Position notice, my lord.
ಎಷ್ಟಿದೆ?
54 lakhs.
10-10-3-3. Yes, next. Next.
So next also.
ಎಷ್ಟಿದೆ?
There is 52 lakhs something
Same,
after.
same order. Next.
6, Karthik V.
Page 22, my lord, is the earlier order of this court.
Hmm.
Where my lords permit me to continue water supply to hospitals.
Sirlamar, GM police ಅಂತಿದೆ?
This is what happens, my lord. After this, they block my vehicle, so I give a complaint to the R3 police officer. He seizes my vehicle, does not register my complaint. From last 3 days, it is standing there.
Vehicle,
Thereafter, I give a complaint to the second sub-inspector.
The
We have not seized his vehicle.
It is
It's not the pleading.
Kindly see the complaint at page.
the petitioner, you are the owner of the vehicle?
Yes, I'm the driver. Complaint is the driver, my lord.
The petitioner is the driver of a vehicle which is said to have been seized by the third respondent station house officer without registering any crime against the petitioner or initiating any proceedings worth the name. The learned counsel submits, takes this court through judgment of a coordinate bench, adralena,
At para 6, my lord, page 22.
in which a direction is issued. A direction issued by the Tahsildar to initiate criminal proceedings against the petitioners were quashed. Despite this, the vehicle is again seized, is the submission/allegation. Therefore, the station house officer, the third respondent, be present before the court at 2:30 PM on Tuesday. Yes, next.
7, history case.
My lord, Tumkur Advocates Association election,
ನಾಳೆ ಎಲೆಕ್ಷನ್ ಇದ್ರೆ ಇವತ್ತು ಹೆಂಗೆ ಮೇಡಮ್?
my lord, tomorrow the process is starting, my lord. Election is scheduled to be conducted on 5/4/2025. Calendar of events, my lord, I have produced at page number 14.
One moment, madam. AGA. 1, 2, 3, 4. ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ ಯಾರು ಮೇಡಮ್? TP ವಿವೇಕಾನಂದ್. Sir, one TP ವಿವೇಕಾನಂದ್.
Please, my lord.
We'll take it tomorrow at 2:30. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ.
Please, my lord. My lord, may I request for a stay of the process, my lord, because
That will only help you to publicize it. ಏನೂ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ನಾಳೆ ಕೊಡೋಣ. List tomorrow at 2:30 PM. ಕಾಪಿ ಈಗಲೇ ಕೊಟ್ಬಿಡಿ, ಎಲ್ರಿಗೂ ಕಾಪಿ ಕೊಡಿ.
please.
ನಾಳೆ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್
ನಾಳೆ start
process is
ಆಗ್ತಾ ಇದೆ.
starting tomorrow, right?
My lord, tomorrow the process is starting, my lord.
Nomination.
Howದು call for nominations, 23/2025.
All right, we'll see.
It's covered by judgment.
I know, madam. Yes, there shall be an interim order of stay spread for till the next date of hearing. Yes,
Grateful, my lord.
but then take it day after tomorrow, fresh matters. Yes, next.
Please, obliged.
Number 8,
In terms of,
number 9, Sandhya Prabhu.
ಇದು ವಿಡ್ರಾ ಅಲ್ಲ? ಯಾವ್ದಾರು ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿವರೆಗೆ ಮೇಡಮ್? Yes.
Petitioner, my lord,
ಎಷ್ಟಿದೆ?
outstanding was 1 crore file, my lord.
ಹಾ.
Later to that, I had challenged the position notice before DRT. my
KV
lord.
ಲೊಕೇಶನ್. ತುಮಕೂರು ಗ್ರೈನ್ ಮರ್ಚೆಂಟ್ಸ್ ಅವರೇ ತಾನೆ?
DRT challenge ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು, ಈಗ ಏನ್?
26 ಲಕ್ಷ ಕಟ್ಲಿಕ್ಕೆ
ನಾಡಿದ್ದು ಹಾಕ್ಬೋದಲ್ಲ?
ಕಟ್ಟಿದೆ.
ನಾಡಿದ್ದು ಹಾಕ್ಬೋದಲ್ಲ?
my lord, regularization ಕೇಳ್ತದೆ plus.
ಅಯ್ಯೋ, ಅದಕ್ಕೆ ಇವು ಇಂಟರ್ ಮಾಡ್ರೆ ಏನ್ ಬಂತು? ನಾಡಿದ್ದು ಹಾಕೋಣ.
Not to dissipate the matter.
List the matter
26
day
ಲಕ್ಷ
after tomorrow.
ಕಟ್ಟಿದ್ದೆ.
KV location serve ಮಾಡಿ.
Please, my lord.
Counsel for the petitioner to serve on KV location represent for the respondents list day after tomorrow in the fresh matters list. The respondents are restrained from precipitating the matter to the next date. Yes.
Great.
10.
10, Abhimanyu Arjun Devaya.
His amount, my lords,
10
about-
crores, huh?
ಇಲ್ಲ ಕಡಿಮೆ 2 crore 75.
Oh, ಸರಿ.
Because the
ನೀವು
agreement to
ಬಂದಿದ್ದೀರಾ
sell-
ಅಂದ್ಮೇಲೆ 10 crores.
agreement to sell orders,
Yes.
but we have almost about
Ah.
about 40% will deposit, my lords, within, I think, ಎಷ್ಟು?
In
4
what
weeks.
time?
4 weeks, my lords, 40% will deposit.
40%, 4 weeks, 6 weeks though. 40%,
Only
6.
one issue is there, I should point out. Annexure D is the most recent auction notice, amendment application is there. What is
All
calendar
right.
is Annexure A?
Date ಹೇಳಿ. There shall be an interim order of stay of the auction notice dated
5/3/25.
5/3/2025, subject to the condition that the petitioners who deposit 40% of the amount within 6 weeks from today. List the matter on 40% of the outstanding amount. Yes. List the matter on 22nd April.
Great one. My lords, auction dated 20th March, because tomorrow is the auction. Notice ಇದೆ, notice stay ಆಯ್ತಲ್ಲ?
ಅಲ್ಲ, notice stay ಆದ್ರೆ ಆಯ್ತಲ್ಲ. Auction notice 5/3.
Correct.
All right. There shall be a stay of the auction notice and all further proceedings taken thereto subject to the conditions. Heard the learned senior counsel Vikram Holigod. Yes, next.
That is for the work of elephant proof barricading.
What?
Elephant proof barricading.
Elephant proof.
Barricading.
ಕೂರ್ಗಲ್ಲ ಎಲ್ಲಿ?
ಇಲ್ಲ, ಇದು ಬನ್ನೇರುಘಟ್ಟ and
ಈಗ ಏನಾಯ್ತು?
ಇದರಲ್ಲಿ ಮೊದಲು 50% ಸಿಮಿಲರ್ ವರ್ಕ್ ಅಂತ ಇತ್ತು. ಎಲಿಜಿಬಿಲಿಟಿ.
ತಂತಿ ಹಾಕಿರೋದು?
ಅಲ್ಲ.
ಎಲ್ಲೆಲ್ಲಿ ಫೆನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
ಯೂಸ್ಡ್ ರೇಲ್ಸ್. ಸ್ವಲ್ಪ ಹೆವಿ ವರ್ಕ್.
ಆಯ್ತು, ಸರಿ.
ಸಿಮಿಲರ್ ವರ್ಕ್ 50%. ಈಗ ಇವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಡೈಲ್ಯೂಟ್ ಮಾಡಿ ಆಲ್ ಸಿಮಿಲರ್ ವರ್ಕ್ ಸಿವಿಲ್ ವರ್ಕ್ ಅಂತ ಮಾಡಿ.
ಆಲ್ ಸಿವಿಲ್ ವರ್ಕ್. ಗಾರೆ ಕೆಲಸಕ್ಕೂ
Only to that extent, only to that extent.
Copy.
ಕಾಪಿ ಕೊಡದೆ. Yes,
Show me the copy.
Deepesh, I have told you in the morning when you move the matter, you should serve a copy on the States Council here. What is this?
Sorry.
Yes.
We've taken up.
First time move ಮಾಡ್ತಿದ್ದೀರಾ. It's not moving it for the first time. Yes.
Lord, page 45, your lordship.
45?
5.
What is the clause?
Clause, all class of civil works as prime contractor for value notional.
Page, sir.
Page number 45.
45. Clause
3.2B.
3.2B.
Satisfactorily completed as prime contractor. All class of work ಅಂತ ಮಾಡಿ.
The learned HCGP is directed to accept notice for the respondents.
Can your lordships have this on Friday? Because
ಯಾವತ್ತು
some
last
urgent-
date?
Last
What
date
happens-
ಆಗೋಗಿದೆ, ಇನ್ನು tender open ಮಾಡಿಲ್ಲ. On 15th.
One minute. ನೀವು apply ಮಾಡಿದ್ದೀರಾ?
Apply ಮಾಡಿ.
No problem. I will not cause any prejudice to anyone. Yes. The learned HCGP is directed to accept notice for the respondents. The tender shall be scrutinized of all the tenderers without reference to subclause B of clause 3.2, which reads as follows, which shall however remain subject to the result of the petition. Yes. List the matter on Friday the next.
There are two annexes. There are two tenders, A and B.
ಒಂದೇ petition ಇದೆ? Clauses ಎರಡಾ?
Clause ಅಲ್ಲ, ಎರಡು ಟೆಂಡರ್ ಬೇರೆ ಬೇರೆ, ಸೇಮ್ ಕ್ಲಾಸ್, ಆಲ್ ಸಿಮಿಲರ್ ವರ್ಕ್ ಅಂತ.
All right, sir. Yes,
Much.
Previous matter, and delivery.
we'll see. Yes.
12. Darshan Gowda P.
B group ಮೂವ್ ಮಾಡಿದ್ದೀರಾ? Why? Covered.
12, serial number 12. Lordship.
Oh, 12, sorry sir. Darshan Gowda Patil. ಎಷ್ಟಿದೆ?
Lordships, as per the possession notice, Lordships, 37 lakhs 50,000, 7,747, Lordship.
37 lakh?
57,000, Lordship.
34 lakhs 89.
ಕಡಿಮೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಬಿಡಿ,
No,
ಪರವಾಗಿಲ್ಲ.
Lordships, after issuance of demand notice, I paid 4 lakhs
ಸರಿ,
99,000.
ಈಗ ಏನೀಗ ಎಷ್ಟು?
Minusing that, Lordships, it will be like 32 lakhs 58,000.
ಆಯ್ತು, 30 ಲಕ್ಷ ಅಂತೂ ಇದೆಯಾ? ಒಂದು 10 ಲಕ್ಷ ತಗೊಳ್ಳಿ. 5 lakhs, 5 lakhs, 4 weeks, 4 weeks. Yes. Next. ಇದು ನೆನ್ನೆದಾ? Disposed. Heard the learned senior counsel vehemently submitted. ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ಅಲ್ಲ, ಆಯ್ತು. Fine, yes, disposed. ನೆನ್ನೆ ಒಂದು ಮಾಡಿದ್ದೀನಿ ಬೆಳಗ್ಗೆ. ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಇತ್ತು ನೆನ್ನೆ, ಸೀರಿಯಲ್ ನಂಬರ್ 1. That is the difference. Yes, yes. Anyway, that I'll do. You're away for a week. Oh, then we'll have it next week. Yes, yes, all right. ಆಯ್ತಾ ಮೇಡಮ್? ಹಾ, ಎಲ್ಲ ಮುಗಿತಲ್ಲ ಎಲ್ಲರದು? ನಾಗೇಶ್ ಸರ್ ಕರ್ಕೊಂಡು ಬರ್ಲಿ ತಗೊಂಬಿಡಿ.
Further hearing?
ವೈ ಸರ್? ವಾಟ್? ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ, ಬಂದ್ಮೇಲೆ ತಗೊಂತೇನೆ. ಬಿಫೋರ್ ಐ ರೈಸ್ ಐಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆ್ಯಂಡ್ ಗೋ. ಡೋಂಟ್ ವರಿ. ಎಸ್ ಎಸ್, ವಿದ್ಯುಲತಾ ಮೇಡಮ್ ನೀವು ಇರಲಿಲ್ಲ.
Matter where that decretal amount has to be.
Decretal
Ah.
amount. Namge, we don't have, now K2 Chalan Mulkane, we have to give it to them. Now they don't have a bank in India. We have no.
Bank, where are you?
Germany.
Entity,
In Germany.
bank account.
We
There was a
don't
deposit
have-
before the
ಇಲ್ಲೊಂದು
flight.
ಎಷ್ಟು, ವಾಟ್ ಇಸ್ ದಿ ಅಮೌಂಟ್?
1 crore
1.47
plus.
lakhs.
ಅಕೌಂಟ್ ಓಪನ್ ಮಾಡಿ ಇಲ್ಲಿ.
Because the difficulty is German entity is not able to open account here. In fact, there was a deposit before the High Court as well. The High Court registrar has written a letter to the
That
bank to
time it
release
was
the amount directly.
2022, it was, the procedure was different. Now
A
it is
letter
K2
can in fact-
Chalan.
my only
Anyway,
submission is
at
a-
4:45 will not resolve this dispute.
Please.
Take it day after tomorrow.
Yes, please.
Day after tomorrow in preliminary hearing.
Great.
Lord, serial number 91 and 92 was not present, not passed over.
ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ ಪ್ರದೀಪ್ ಕುಮಾರ್?
Lord, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, Lord, 9A and C, Lord, have been struck down by this court, Lord. in
ಆಯ್ತು,
PI.
then I'll have it on Wednesday.
Please.
Wednesday.
Serial number 3 passed over.
Preliminary hearing ಎಲ್ಲ ಹಾಕೊಂಡ್ರೆ ಮುಗಿಸ್.
230 list.
230 ಲಿಸ್ಟ್ ಅಲ್ಲ ಯಾವ್ದು ಮೇಡಮ್? ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ, ವೈಟ್ ಸರ್.
ಅಲ್ಲ, ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಅದು ಕೇವೆಟರ್ ಇದಾರೆ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
ಕೆ ವಿ ಲೋಕೇಶ್ ಹೇಳಿದ್ರ?
ಮಾಡಿದ್ವಿ ಸರ್, ಅವರೆಲ್ಲ ಔಟ್ ಸೈಡ್ ಇದೀನಿ ಬರಕ್ಕೆ.
ಅಲ್ಲ, ಔಟ್ ಸೈಡ್ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಅಪಿಯರ್ ಆಗಕ್ಕೆ ಹೇಳಿ.
ಹೇಳಿದೆ.
ಇಲ್ಲ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ, ಅವಾಗ ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ನೀವು ಬರ್ದೇವ್ರೆ ಸ್ಟೇ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ. ಎಸ್, ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ತಗೊಳ್ಳಿ.
91, 92.
It will come on Wednesday. Preliminary hearing.
Lordship, one submission in serial number 61, for the petitioner number 2, we have little inconvenience for finding an alternative accommodation. Lordship may be permitted to, for 3 weeks to find an alternative accommodation. We've informed.
Respondent ಕರ್ಕೊಂಬನ್ನಿ.
We've informed, he said he had a work, so adna.
ನೋಡೋಣ, ನಾಳೆ ಅವ್ರಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂದ್ರೆ ನಾನು have to recall that order.
Please, Your Lordship.
I'll add it anyway.
Please, please, oblige.
Serial number 104 mile.
ವಕ್ಫಾ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಅವರು ಸೂಟ್ ನಲ್ಲಿ ನಾವು we have filed Milord ಅಂತ ಹೇಳಿದ್ರು last time. We have not lost Milord the title.
Election
in the
matter.
original suit.
No, Lord, it's a property matter, not sir.
ಬರಿಯಲ್ ಗ್ರೌಂಡ್.
They are saying that burial ground. And the 1969 itself is a
ಆಯ್ತು,
declaration
we'll see.
suit is dismissed. Last occasion, my Lord, your Lordship directed to produce the all.
Next
trial
week.
court record.
Oh, that might really produce all the records.
Milord, already Milord, the
Wait.
It's
We'll take it on Wednesday. Yes, well, Thursday. Yes.
And all the record, my Lord, they are the piece.
ಇದೇನು ಪೂರ್ತಿ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. Who is work here?
Yes.
You are claiming the property to be work property?
ಹೌದು.
ಎಲ್ಲ ಕೊಡಿ.
We are filing.
ಹೌದು ಅಂದ್ರೆ ಎಲ್ಲ ಕೊಡ್ಬೇಕಿಲ್ಲಿ. ಆಮೇಲೆ ಎಸ್. ನೆಕ್ಸ್ಟ್.
Section 57. Serial number 57.
ಏನಾಯ್ತು?
And ಅದರಲ್ಲಿ 4 ಲಕ್ಷ 50% ಆರ್ಡರ್ ಆಗಿತ್ತು. ಒಂದ್ ತಿಂಗಳಿಂದ
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ, ವೇಟ್. ಎಸ್. ಇನ್ನು ಒಂದು ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ, ತಾಳಿ ಸರ್. 230.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿಲ್ಲ, ಏಜೆಂಟ್ ಹಾಕಿಲ್ಲ.
ಎಸ್ ಚೌಟ ಸರ್. ವೇಟ್. ಬಟ್ ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಬಂದ್ರೆ ಹ್ಯಾಂಡಲ್ ಇಲ್ಲೇ ಮಾಡ್ತೀರಲ್ವಾ? ಸರಿ. ಸ್ಪೀಡ್. ಎಸ್ ಸರ್.
Please. With the last submission I made yesterday.
ವಿತ್ ಒನ್ ಪರ್ಮಿಷನ್, ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಬರ್ಬೇಕು. ಈಗಲೇ ನೀವು ಮಾಡ್ತಾ ಇರಿ, ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಲಿಸ್ಟ್ ಬಂದ್ರೆ ಇಫ್ ಯು ಗಿವ್ ಮಿ 5 minutes I'll finish that and come back to you. ಈಗ ಮಾಡ್ತಾ ಇರಿ.
Absolutely.
ಎಸ್. ಮುಂಚೆನೆ ಹೇಳ್ಬಿಟ್ಟು ಕಟ್, ಮಧ್ಯದಲ್ಲಿ ಕಟ್ ಮಾಡಬಾರ್ದು ಆಮೇಲೆ. ಎಸ್.
The last submission I made yesterday was while inviting my lord's kind attention to the
which came to be filed by the prosecution before the trial court, in which nearly about 153 witnesses are
On different heads,
different
on
aspects
different heads of law, they were to be examined.
including
Eyewitness,
the eyewitnesses,
8 eyewitnesses.
conspiracy, motive, then recovery evidence, and all that. But by no stretch of imagination, it could be said that it is without the evidence of the approver first accused, it may become difficult for the prosecution to bring home the guilt of the rest of the accused who are taking the trial in the case, was the last submission which came to be made by me.
Yes.
But while I also invited my lord's kind attention that unfortunately the learned judge, in the course of his order, despite the fact that he was having the advantage of adverting to the entire records of the case, which contains the statements of eyewitnesses and the entire evidence which the investigator had collected prior to the filing of the supplementary charge sheets and the first charge sheet which came to be filed by the investigator in the case. I submitted to your lordship that unfortunately, my lord, the Larat trial judge would say that the case rests on circumstantial evidence. That is how, my lord, I submitted to your lordship. May I straight away invite your lordship's kind attention to the order, my lord, which your lordship would get, where the Larat judge would say it is only circumstantial evidence. My lord, I shall first take your lordship to the second order which came to be passed. Even in that order also, my lord, he would say it is a case
Which
that
was quashed by me.
which my lord has quashed. May I request your lordship to kindly turn to page 117,
That's the first order.
page 280. I'm sorry. Page 280,
80.
page 0,
Yes, sir.
paragraph 1(3). As could be deciphered from the statement and also from the response which was filed by the CBI. It could be noticed that
It's a clear case of circumstantial evidence for the
prosecution
prosecution.
is entirely based on circumstantial evidence.
Yes.
It is also not in dispute that the case of the prosecution rests upon the statement of various witnesses wherein it is alleged that the accused persons had joined together to hatch a conspiracy for committing the murder of the deceased who gets on the. It is relevant to note at this juncture that the response which is filed by the CBI would indicate various facts which had come into picture in the course of the investigation. For instance, I have called out. Maybe inadvertence or he has not adverted to.
No, if it was inadvertence, it would not have been repeated in the third order.
Now I shall take your lordship.
So that is conscious reasoning. Yes.
Well, if the case rests on the evidence which the investigators collected, including motive, conspiracy, recovery.
My objection still remains, my lord, he is arguing on merits. Merits is not entitled to argue, but that's my submission. This is not procedural, this is merits.
I am not arguing on merits.
Yes, arguing on merits. The learned judge is not right. I'll point out that the learned judge was right when he said circumstantial evidence. But
It's all right, sir. I'll hear you in replies. Yes,
long rope, my lord. Let him argue.
Yes, I'll hear you in replies. Yes.
Very well, my lords.
But
I am making of the court that is important, my lords.
Yes, yes, sir. Yes.
Well, I am making this submission on the legal issue which have raised for my lord's kind consideration. Following my lord, the law laid down by the Supreme Court in Pascal Fernandez, that unless and until it is said that it is difficult for the prosecution to bring home the guilt of the accused who are taking the trial in the case for an offense of murder in the absence of the evidence of the approver. It is for that reason, my lord, I am inviting my lord's kind attention. The evidence with the investigators collected and brought on record in the case. Otherwise, I would not have made this submission at all. Now, my lord, in the present order, may I just request your lordship to kindly turn to page 117. 117.
The impugned order.
Yes, my lord, present order. That is impugned in this.
Yes.
My lord, in the first charge sheet, my lord, the assailants of the deceased
according to the prosecution, my lord, are A1 to A6. And in the second charge sheet, the assailants of the deceased are A7 to
A14.
A14. Now let us see, my lord, what the learned judge would write here. At commencing from page 1.
Even in the response filed by the CBI, ಅಲ್ಲಿಂದ ಓದಿದ್ರೆ ಅದೇ ಅಲ್ವಾ?
ಅದೇ. Further, in the aforesaid judgment, the Honorable High Court has held that the court had not tied the hands of the accused number 1 to file the application seeking pardon, but has found fault with the procedure adopted by this court. Accordingly, on appreciating the application which is filed by the first accused, at present would indicate that he was privy to the incident, wherein he has taken place at the time of hatching the conspiracy, and in his application he has detailed narrated about the acts committed by him, and also contended that he would be a crucial link to establish the conspiracy and sequence of events. My lord has pointed out, even in the response filed by the CBI would state that he had disclosed the whole circumstances played by him along with the accused number 2 to 6, wherein only circumstantial evidence is available against them in the absence of the disclosure of accused number 1. Is allige nilalla. Next to, it is also been contended that the accused number 1 has disclosed both the war acts of accused number 7 to 14, which is a crucial to prove the respect to your role of accused persons, and also he has disclosed the specific role.
Up to the case of prosecution ಅಲ್ಲಿವರೆಗೂ is relevant.
So my respectful submission to your lordship is, in view of the law laid down
Pascal Fernandez.
in Pascal Fernandez, which also came to be followed in Suresh Chandra's case, my lord, unless and until it is contended by the prosecution or endorsed by the prosecution on the application that is filed by the accused who has sought to be pardoned and to be treated as an approver, that but without his evidence in the case, it is either extremely difficult for the prosecution or it is just not possible for the prosecution to make out a case against the other accused who are taking the trial in the case, would be my respectful submission. It is only for that limited purpose, my lord, I drew my lord's kind attention, even yesterday also, by inviting my lord's kind attention to 153 witnesses, including eyewitnesses and all that. And the finding of the trial court is, yes, the case, entire case of the prosecution on both the occasion rests on circumstantial evidence. That is how he would say it. But may I now take your lordship? May I request your lordship to kindly turn to page 99 for a second?
Yes, sir.
Well, before I take your lordship to page 99, it would be useful for me to draw your lordship's kind attention to certain paragraphs in the earlier pages, commencing from page 80. 89. We will go to 88. Then, my lord, I shall take your lordship to 89. My lord, he places reliance for the purpose of granting this application on the statement of the first accused, which came to be recorded under section 164, which came to be set at naught. And your lordship in the earlier order would say, no, you could not have adverted to 164 at all. Still he does it. May I request your lordship to kindly turn to page
89.
First, we will go to 88. Then, my lord, I shall take your lordship to the next paragraphs. Well, kindly skip about 3 or 4 sentences from the top and go to this. In order to maintain this said application, firstly, the accused number 1 is required to point out change in circumstance, as rightly argued. The finding is in my favor, but ultimate result has gone against me. The applicant has to point out the change in circumstance on which the present application is filed, and the same should not be available at the time of making earlier application. Well, it is not the case of omission on the part of the accused in inviting the attention of the court in the application as to what he would be deposing before the court, whether was it within his knowledge or not. In fact, that is the finding. Filed in the same should not be available at the time of making the earlier application. May Lord kindly recall to your lordship's memory, while considering an application for an order of discharge, be it under 227 or under section 239, supposing, my lord, I make an application on certain grounds. That application comes to be rejected. Subsequently, I would make another application. Look here, in the earlier application which I have filed, I had not urged these grounds. Now I am urging these grounds. Consider my application for an order of discharge. As in the case of a bail application. Earlier, my lord, I had not urged this ground. Today I am going to urge this ground. No, the question is not the case of the accused urging a ground that should have come into existence subsequent to his disposal of his application.
According to you,
If
the
it is
ground that was available and not urged earlier cannot be urged or considered to be a changed circumstance later.
That is
That's
how,
all.
That is how the Supreme Court has said there. May I just invite my lord's attention?
Res judicatale.
Alala, this point. He can't be permitted to urge. It can't be a change in circumstance at all. I shall just invite
Yes.
my lord's kind attention. Wait. May I request your lordship to kindly turn to page 11, I believe. Hold on. This is in 2023. Online SC 1399 in the case of Bishamlal Verma versus State of UP. Well, this was an application under section 482. Sorry. Kindly go to paragraph 11. Nandkodla,
I have it here.
please.
Bishamlal Verma.
Yes, madam.
Yes,
Bishamlal Verma.
Hmm.
Kindly go to
Yes,
ink
sir.
page 14,
Hmm.
para 11. Well, this is a petition under 482.
Yes, 482.
Yes, ma'am. We are in complete agreement with those observations of the Madras High Court. Though it is clear that there can be no blanket rule that a second petition under section 482 of CRPC would not lie in any situation, and it would depend upon the facts and circumstances of the individual case. It is not open to a person aggrieved to rise one plea after the other by invoking the jurisdiction of the High Court under section 482 of CRPC. Though all such pleas were very much available, even at
This I myself followed. Not this. Before this, I have held in 2 or 3 cases. In Lata Rajinikanth's case. I've held.
Literally, the question is, I have failed to, there is an omission. No, whether it was available to you or not on the day when you made the first
So
application.
that's what I think Supreme Court in Vinod Kumar and that Anil
Yes, yes, yes. madam.
Khadkiwala.
Was it available to you on the first, when you filed the first application? Was it available to you or not when you filed the second application? But now he can't say, I did not urge that, or the court did not consider that. It was very much available to him. It is not a fresh ground. Therefore, that can't be taken into account or said as a change in circumstance in view of what is-
One clarification.
Please, please. ma'am.
The circumstance then was threat. That was what was projected.
Well,
Circumstance now is threat. What is projected?
a throat threat.
Huh.
That means he can
Till
keep
the
making an
ex-
application till the trial is concluded and judgment is pronounced. May I invite you lordship to attention?
That's itself.
No. What he would plead in the application, right from day one, I have the threat. May I request you lordship to kindly have a look at the application which you filed. My lord gets the application. Kindly go to the present application, third application itself.
That's all right. The concept is threat then, now and forever.
Only one sentence. was
Yes.
left in any.
Yes.
Well, at page 122,
Hmm.
your lordship would get this in paragraph 2.
Hmm.
Page 122,
Yes, sir.
paragraph 2.
Hmm.
The accused number 1 submits that the accused is contesting the litigation for the last several years.
Hmm.
He has lost precious time and money. He is under constant threat to his life. Though he has contested the case till now, due to the change in circumstances, the accused number 1 is ready to disclose the full and true disclosure of the action. What is the change in circumstances?
ಏನು ಹೇಳಿಲ್ಲ.
Threat ಇಲ್ವಲ್ಲ. Well, may I request your lordship? In fact, your lordship would observe.
In the earlier order.
In the earlier order, Kindly go to page 196. for a
No,
second.
I have said change circumstance of threat in real time.
Sir, well, it is just
Qualify.
24 hours. Sir. My lord's order is today.
Day
Is-
after, the
There
2
is
days
next
later
day,
it is.
2 days later the application is filed. He must indicate during this interregnum of 48 hours or 24.
No, 4th December is my order. 6th December is the application.
Yes.
5th December severe threat. ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಅದ್ ಹೇಳಿಲ್ಲ, ಏನ್ ಹೇಳಿಲ್ಲ. ಒಂದು ಇಲ್ಲ. In fact,
ಅದೇ ಥ್ರೆಟ್ ಎಸ್.
but now I would like to request your lordship to kindly turn to Nanda, is it? Another judgment of Supreme Court, this is the latest judgment of Supreme Court, my lord, in 2024. SCC Online SC 2283. It is in the case of K. Ravi. At ink page 16 of my compilation of the judgments. Kindly turn to paragraph 12, my lord, for a second.
Yes.
My lord, Jetsi. I'll take your lordship to para 11 and then I shall take your lordship to paragraph 12, if my lord permits me. It is tried to say that section 216 is an enabling provision which enables the court to alter or add to any charge at any time before judgment is pronounced. And if any alteration or addition to charge is made, the court has to follow the procedure as contained therein. Section 216 does not give any right to the accused to file a fresh application seeking his discharge after the charge is framed by the court. More particularly, when his application seeking discharge under section 227 has already been dismissed. There has been an alteration of charge there, and therefore I want on certain other grounds he can't see it. Unfortunately, such applications are being filed in the trial courts, sometimes in ignorance of law and sometimes deliberately to delay the proceedings. Once such applications, though untenable, are filed, the trial courts have no alternative but to decide them. And then again, such orders would be challenged before the higher courts and the whole criminal trial would get denied. Suffice it to say that such practice is highly deplorable and if followed should be dealt with sternly by the courts. Third application. First application rejected. Second application rejected by virtue of the order passed by this honorable court. Now again the third application, taking leave or advantage of an observation which came to be made, that he can certainly, this honorable court is not prohibiting him from making a further application in the event of there being any change in circumstance. So far as the facts of the present case are concerned, as stated here above, the respondent number 2 had miserably failed to get himself discharged from the case in the first round of litigation when he had filed the application under section 227 CRPC. Still, however, he filed another vexatious application seeking modification of charge under section 216 of the CRPC, probably to get the cause of action. Otherwise, he would not have made the application
There,
at all.
in that case.
In that case. ಅಲ್ಲ ಇದ್ರಲ್ಲೂ discharge application ಹಾಕಿ ಅದು ವಜಾ ಆಯ್ತು.
Why the petitioner there did that was, discharge had been filed, rejected. There was no question of filing another discharge after the charges were framed. The only circumstance is when there is alteration of charge under 216. So he files an application seeking alteration of charge.
He himself would seek for
Himself
alteration
puts
of
it,
charge.
alteration of
Charges
charge.
are altered, that
and
comes up with an application.
Application for
That
discharge.
is him.
So that's abuse of the process, no doubt about it. That was the method deployed by him there.
Not by the accused. Alive.
Because there's no other method to file an application for discharge after the
That's
charges
why I
are
said
framed.
he creates a cause of action for making the application. Otherwise, he would not have made the application
Yes,
seeking
yes,
for
yes.
alteration of charge under 216. The said application also having been dismissed by the Sessions Court, the order was challenged before the High Court by filing a revision application under section 397. The High Court, on an absolutely extraneous consideration and in utter disregard to the settled legal position, allowed the revision application filed by the respondent number 2, though legally untenable, and set aside the charge framed by the Sessions Court against the respondent number 2. The said order being ex facie illegal, untenable, and deharsed material on record, the same deserves to be set aside. Illi change in circumstances really ಏನು ಇಲ್ಲ, ಇಷ್ಟು ಬಿಟ್ರೆ ಬೇರೆ ಇನ್ನೇನು ಇಲ್ಲ ಇದರಲ್ಲಿ. No, my lord, I was just taking your lordship to the certain observations which came to be made by the learned judge in the course of is solved.
Observations about?
I shall show to your lordship. Namparvage.
Oh, Parvag observations order against.
Find, rather I would say, well, findings, ಅನ್ನೋಕ್ಕಿಂತನೂ observations ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ. Now, my lord, may I request your lordship to kindly go to, I was just taking your lordship to page 88. Just a couple of minutes back, I was taking your lordship to page 88. In the middle, the applicant has to point out the change in circumstances on which the present application is filed, and the same should not be available at the time of making earlier application. Was it available to him or not? It was well within his knowledge what he has got to say, be it in the first application, be it in the second application, or be it in the third application. In fact, he even goes to the extent of making an application before the CBI. That application which you would file before the CBI forms part of the record along with the response filed by the CBI. That was available, very much available. The court ought to have adverted to it and then passed appropriate orders. Merely because the court does not refer to it, but the remedy that is available to him is elsewhere. Certainly not in the form of a third application. Admittedly, in the above case, when the application was filed with accused number 1 at the first, nothing was narrated in the application, though despite the fact it was available. It is settled principle of law that when a case committed to the Sessions Court, the provisions of section 307 CRPC would be applicable. The accused who is seeking pardon is required to point out the circumstances on which he is seeking the pardon. However, at that instance, first instance, nothing was narrated and a bald application was filed which came to be rejected by this court. Thereafter, the second application was filed wherein once again, no detailed amendments were made. No one prevented him from making it. He did not choose to do it. However, the accused number 1 has stated that he would disclose the true and material facts if he was provided with an opportunity to get his statement recorded under section 164(5). In fact, this was the endorsement which came to be made on the second application, despite the fact that the CBI itself would place on record his undated application filed before.
That's what I have observed in earlier.
That is how your lordship would also observe. And thereafter, pardon was granted by this court, which was quashed by the High Court by its kind order. With these factual aspects, now the court has to ascertain whether the amendments made in the application, and particularly in para 2 of the application, that the accused was facing constant threat on his life, and though he had contested the case till now, he was ready to disclose the full. That is the only ground on which he would consider this application. But now kindly go to, because your lordship's observation that there is no legal embargo for he making the next application.
No, I have not said so. I have only said on certain circumstance, that's a qualified observation.
Now, my lord, therefore, I request your lordship to kindly turn to page 90. He says, the Honorable High Court has said there is no legal embargo. No, that is not what your lordship has said. Your lordship has said, nothing prevents him from making
That's
yet
what,
another application.
and further, as per the kind orders of the High Court, there is no legal embargo for accused number 1 to file present application
Yes, he
by
has
placing
misread.
fresh or
I
additional
would only
facts.
say, my lord, the line of trial has misread the order which came to be passed
That I have seen.
earlier occasion.
Mark ಮಾಡ್ಕೊಂಡಿದೆ.
By this one.
Yes.
So it is only this, my lord, that enables him to pass the orders allowing the application filed by the accused. Well, now may I request your lordship to kindly turn to page 92. This is also incorrect. The principle of a res judicata will have no application to criminal cases.
ಅದಕ್ಕೆ judgment ಕೊಟ್ಟಿದ್ದೀರ.
The first judgment of this court, my lord, is by Justice Anvay Hanumantappa.
ಅದು ಕೊಟ್ಟಿರ್ಬೇಕು ನೀವು.
ಅಲ್ಲ, ನಾನು ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಲ್ಲ, ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ಕೊಟ್ಟಿದೆ.
Yes.
Supreme Court judgment ಇದೆ ಅದರಲ್ಲಿ.
Chowta sir has given everything, yes. Compilation. He has given everything on constructive,
No, no.
constructive res judicata. It is too instructive to me.
Alala,
Yes.
what I have submitted to Lordship is the finding of the learned judge for the disposal of this application, that the principle of res judicata has no application in criminal cases is,
Will answer.
is incorrect.
Sorry.
Is incorrect. Ashte. Now kindly go to page 94 for a second.
I am there only.
Yes, madam. At the
At the cost, I have
at the
marked that
cost of repetition, it is noticed that at the time of filing of the second
up to
application,
164 CRPs I have already marked.
also no reasons were assigned, but the reasons and the disclosures which he was intending to make was disclosed as statement recorded.
No, there is one interesting, under the the manner in which human mind reacts to a situation when under different circumstances required to be considered. When it's a psychological consideration as well. That's what he's done.
ಅದಕ್ಕೂ approval ಕೊಡೋದಕ್ಕೂ ಸಂಬಂಧ
Alva Nagara Nakre? Ah, yes. Correct. Psychological consideration.
approval ಗೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಬರ್ದಿರೋದು ಅದಕ್ಕೆ.
Let us not say much on that. But now kindly go to page 112 for a second. ಅಲ್ಲ ಇದೊಂದು ಸ್ವಲ್ಪ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಆಗಿದೆ. My lord permits me. Shall take your lordship to page 104 for ಅಲ್ಲ ಚಾರ್ಜ್ ಮೊದಲು ಒಂದು ಸ್ವಲ್ಪ ಹೇಳ್ಬಿಡ್ತೀನಿ ನಾನು ಇಲ್ಲಿ. ಮೊನ್ನೆ ಹೇಳಿದ್ದೀನಿ ನಾನು. First charge was also 302.
Yes.
Second charge is also for 302 read with 120B.
Yes.
But the learned judge writes that. But kindly go to page 99 for a second at the bottom. About 5 or 6 sentences above from the bottom. As per the charge sheet filed by the Dharwad Subdivision Police Station, the allegation leveled was that the accused number 1 and the deceased were friends for about 10 years. And the enmity between them erupted due to their land dispute, which deceased was intending to purchase from CW-31. And on the basis of the said rivalry, the act of murder had taken place. And it is a specific assertion that the accused number 1 had assaulted the deceased with thick club on his head. Adu first charge sheet.
State charge sheet. State charge sheet.
State charge sheet. However, as per the first supplementary charge sheet, that is the CBI, dated 9/9/2016, the very same reason was assigned, and also the Vote Act was similar to that of the earlier charge sheet. Well, I drew my lord's kind attention when I was making my submissions. What needs to be seen for the purpose of consideration of the application was where more than one accused is there, the culpability of the accused has to be seen. It is only for that limited purpose. I drew my lord's attention to the charges that are framed. Even this is the finding which came to be given by the learned judge. Well, now may I request your lordship to kindly turn to page 104. Again, my lord, he refers to. Shall I stop it for a second?
ಇನ್ನೆರಡು ಫೈಲ್ ಬರ್ಬೇಕಾಗ್ತದೆ.
Well, he refers to what is it that the first accused is going to speak if he is giving the pardon. Motive, conspiracy, and then recovery of firearms.
That's what he has said.
First accused. No, that is what the learned judge also says.
Yes.
It is, evidence is there. For motive, my lord, there is a change in motive. Earlier motive is unacceptable for the second investigating agency. The motive as projected by the second investigating
There are
agency.
6 witnesses for that also.
For that also. Although, but he is not a member of a village panchayat even. Kindly note, the evidence brought on record in the case would do demonstrably indicate that this accused is not even a member of village panchayat, forgetting about taluk panchayat or jilla panchayat. He was not the person who had participated in the meeting where there was verbal altercation between the deceased and on the one hand.
So you're speaking of motive.
Motive. He could not have spoken anything. What he speaks is, I got to know about it through the witnesses who are proposed to be examined by the prosecution. What is the motive evidence which you could give? Could not have given. Conspiracy, my lord, about their stay here, there and all that. There are witnesses.
We'll see.
And then Malava's, he speaks to what Malava has said. he speaks to as what the brother of the deceased has said, nothing independent?
So according to you, there is no change circumstance in real time. The application filed now is verbatim similar to the earlier one. The court recording this, recording in its earlier order is the same that is recorded now, all of which would hinge upon circumstantial evidence to be given by the accused number one and nothing else. Circumstantial evidence need not be shown that credence in the light of the fact that there are 158 witnesses, there are 8 eyewitnesses. I think that is the issue. Yes.
Kindly go to page 106 now.
Yes.
At the middle, the Lala trial judge would refer to Pascal Fernandez as well as Dublin Commission Court. However, in the said judgment itself, it has been specifically held that it is not for the special judge to enter into a ring as a vertical director of prosecution, but the court exercises its power not on its own behalf, but on behalf of the prosecuting agency.
Correct.
Yes.
That is. There is nothing said in Pascal Fernandez like that. That's the interpretation of the court.
It's incorrect.
That's what I'm saying.
Say. And must therefore be exercised only when the prosecuting agency joins the case of the person seeking for pardon. Though it can only call for the statement of the agency or the objection on the application that is filed. Then how could, this is not an application which came to be made by the prosecuting agency. It is an application made by the first accused. If that is the finding, my lord, you should not have entertained this application at all. Now, may I request your lordship to kindly go to page 113, 112, and 113. At every stage, my lord, he has faulted. That is what I would like to say. Kindly go to page 1112, paragraph 28. I have also carefully appreciated the submissions made by the Lawrence Senior Counsel. Now, my lord, he says that there are eyewitnesses to the incident. That is our submission, which he did not accept. He says it is circumstantial evidence. Eyewitnesses to the incident as per the case of the CBI, and even otherwise, narration of facts in the application filed by accused number one does not indicate of any circumstances which would require the prosecution to prove their case. Though the said submission seems to be correct, only if the same is appreciated in an isolated manner. In isolation, appreciation in way later. Eyewitnesses are there. Where is the question of appreciating it in an isolation? At the cost of repetition, the alleged incident had taken place on the fateful day, that is on 15/6/2016, in front of Udiajum with the deceased so-and-so, etc. I shall skip all those things. Accused number one, since the deceased had turned out to be his political rival, as per the response filed by the prosecuting agency, it indicates that they are required to prove the allegation of conspiracy and also the motive and intention. Motive, intention, conspiracy evidence is here. Even the
ಇವರಿಂದ ಏನು ಬೇಕಾಗಿಲ್ಲ.
Hello.
ವಾಪಸ್ ಇವ್ರನ್ನ ಅಕ್ಯೂಸ್ಡ್ ರಿಂಗ್ ಹಾಕಿದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ ಅಂತ ಅವ್ರದ್ದು, ನಿಮ್ಮ ಸಬ್ಮಿಷನ್. Draw him back to the ring of the accused.
ತಮ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು.
Draw him back into the ring of the accused. Right.
Just because he files an application seeking pardon.
Good.
Where is Shyam Sundar sir? He's not there.
I'm sorry, madam.
Oh, he's in the air. Yes, yes. Yes.
Kindly turn to page
So
106.
he is in air, but not his arguments. Yes.
In fact, your lordship has permitted him, even when you are in air also, you can just come before the court.
Yes, yes.
Well, 116 again, he would misread the order of this court.
Yes, that I have marked it also.
Now again, my lord, 117,
That also, even the response of the CBI up to prosecution I have marked, sir.
I'm grateful,
Yes.
grateful, my lord. Now kindly go to only one or two paragraphs next, last minute. Then I shall take your lordship to pen drive.
Pen drive?
Yes, yes. In fact, my.
ಅಲ್ಲಿಗೆ ಹೋಗ್ಬಿಡೋಣ.
ಅಲ್ಲ ಒಂದು ಪ್ಯಾರ ಹೇಳ್ಬಿಟ್ಟು my learned friend Mr. Nagendra Naik is very, very anxious to know.
Eager to know about the pen drive.
ಹೌದು. My lord, kindly go to.
Yes.
My lord, imagine the situation, my lord. In fact, your lordship also has observed time and again in this case itself. Because when I drew my lord's kind attention to the judgment of the Supreme Court in Pascal Fernandez, as well as in the subsequent judgment of the Supreme Court in Suresh Chandra's case, what needs to be seen when the application is filed, that his culpability in the case, vis-a-vis the culpability of the other accused who are taking their trial. That is in Ashok Agarwal's case. My lord, imagine the situation, my lord. In fact, your lordship said, if every accused goes on making one application after application, all the 15 accused, all the 17 accused, there are 21 accused in the case. But apart from A1 to A6, and then A7 to A14, who occurred to the prosecution, be it at the first instance or be it at the second instance after the preliminary subsequent charge sheets are filed, they are the actual assailants of the deceased. A1 to A6 in the state charge sheet, A7 to A14
14 in the
in the
CBI charge.
second charge sheets. The culpability is more. Whether the prosecution will become successful in establishing the guilt of the accused or not, we are not at that stage now for the time being. But even according to the prosecution, well, some of these petitioners were not even accused in the first charge sheet. They come into picture, not even in the first subsequent charge sheet which came to be filed by the CBI. He
Yeah,
comes in-
talking of accused number 15.
Yes, but I'm.
Third supplementary charge.
Third supplementary
Yes.
charge sheet I come. Accepting what the prosecution has said. in
ಇದನ್ನ ಕೇಳಿ 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 ಒಬ್ಬೊಬ್ರು ಅಕ್ಯೂಸ್ಡ್ ಏನೇನು ಅಂತ ಗೊತ್ತಿದೆ. ಯಾವಾಗ ಬಂದ್ರು ಇನ್ಸೈಡ್.
But the culpability of the 15th accused who is a petitioner in the case, my lord, according to the prosecution is only, I hatched a conspiracy with my other companion accused. The culpability is certainly less when compared to the culpability of A1 to A6 and A7 to A14. Well, imagine the situation, my lord. Tomorrow morning I make an application seeking for pardon. What should happen to that application? I'm just submitted to your lordship. Therefore, my lord, he has got to analyze the degree. Then, my lord, he should give a call.
Yes, sir.
Well, now, in fact, your lordship wanted me to straight away
Pen drive.
pen drive.
Yes.
But before I take your lordship to the pen drive,
Where is the pen drive?
it is there, my lord, before the court.
ಇಲ್ಲ ಇದೆಯಾ?
Yes, yes, not only before the trial court, but also before your lordship.
ಬಂತ ಮೇಡಮ್ ಫೈಲ್ಸ್?
ಇದು ನಂತರ.
ಅಲ್ಲಕ್ಕೆ ಸರ್ ಪೆನ್ ಡ್ರೈವ್ ಬ್ರೇಕ್ ಕೆ ಬಾದ್ 5 minutes. Yes.
Sometimes we need some humor.
No, there are 4 or 5 matters. I'll take that and get back.
Namagadra, at least we walk in the corridors of the court. But my lord needs some humor at least, because from 10:30 to 5:30, 6 o'clock, you will not.
That is why we'll
Some
be
humor is
trying. That is why keep the court driving away from monotony. That's all. ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್.
30 more. Fresh matters number 1. Nandish.
What? State of Punjab?
Yes, yes, your lordship.
State of Punjab ಮೇಲೆ ಏನ್ ರಿಟ್?
Lordship, I have annexed the proper citation of this honorable court, your lordship. Lordship, present this is case of the defreeze of my account, your lordship.
ಅಷ್ಟೇನಾ?
My lordship.
ಸ್ಟೇಟ್ ಆಫ್ ಪಂಜಾಬ್ ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ
Yes, your lordship. The reason is they are not only state of Punjab, some state of the police officers are not.
ಈಗ ಕಂಪ್ಲೇಂಟ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ ಲೀನ್ ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ?
Your lordship, 50,000 is the disputed amount.
ವಾಟ್ ಇಸ್ ಫ್ರೋಸನ್ ನೌ ಎಂಟೈರ್ ಅಕೌಂಟ್?
Yes, your lordship.
ಎಸ್ ಯುವರ್ ಗವರ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ. ಯು ಆರ್ ನಾಟ್
I didn't made a
ಸ್ಟೇಟ್ ಆಫ್
party for them,
ಕರ್ನಾಟಕ.
your lordship.
ಎಸ್
I didn't made them party.
ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಮಾಡ್ಬೇಕು ತಾನೆ ಪಾರ್ಟಿ.
Your lordship, they are not concerned to our.
They are not
case.
concerned.
Yes, your lordship.
Then we'll dismiss the
No, lordship. The reason is, state of Karnataka
HDFC
is
Bank,
party.
HDFC Bank is everywhere. You can file in state of Punjab. Punjab and Haryana High Court al haki.
My lordship, the reason
Because HDFC operates electronically. Sir, make state of Karnataka a party in everything. Otherwise, I'll dismiss it straight away.
Lordship, for the moment, kindly see the annexure. Annexure D2, page number 37, your lordship.
ಈಗ 50,000 ಇರೋದು.
Yes, your lordship. Lordship, I lost more than 1 crore. I am not having money.
Lost than 1 crore.
I lost more than 1 crore.
Why?
Along with, I am a cyber victim, your lordship.
All right.
Along with my family, I have lost more than 1 crore. Luckily, I got 20 lakhs.
Like from whom?
From the direction of the Honorable learned 45 ACGM. From the cyber victims, cyber accused, I got the amount back. So 20 lakhs directly Punjab police has been freezed without following the section 102 of CR.
102 is not mandatory. Don't worry. Yes.
Lordship, in this, okay. Then they freeze my account, your lordship. My concern is my humble submission to this honorable court.
No, in terms of the latest judgment in Shanto Varghese, 102 is not mandatory. Yes. Supreme Court.
Honorable Apex Court of India is also.
Apex Court of India ne ಒಂದೇ ಇರೋದು.
Yes, your lordship. Lordship, in this case, then I rely on the annexure D2, page number 37.
ಈಗ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
Lordship, defreeze my bank account to lien mark the 50,000. What is the disputed? Let it be lien marked. What is the undisputed and legal money can be total my operation of bank can.
Where
be.
do I get that 50,000?
Lordship, I have annexed.
Complaint ಇದೆಯಾ?
Lordship, annexure B1, page number 21. This is the cyber acknowledgement.
50,000 figure ಎಲ್ಲಿದೆ?
Lordship, page number 24, annexure B3, serial number 21.
Layer 3.
Layer 3, that too they freeze layer 3. Transaction amount is 50,000, disputed amount is 50,000.
Jafar? Complete state of Karnataka.
Much obliged.
Will
I will honor this honorable court direction.
Thank you, sir. Thank you so much. Yes. List the matter day after tomorrow.
Lordship, Lordship, at least defreeze the matter, defreeze the bank.
We will defreeze the matter day after tomorrow.
Lordship, I am not having money to eat the food. I am not having money to buy the medicines.
20 lakhs ಬಂದಿದೆ ಏನ್ ಮಾಡಿದ್ರಿ?
My lordship, they are completely frozen. I am not able to withdraw a single rupee.
Oh, from this account?
Yes, your lordship.
All right. Tomorrow at 2:30. Tomorrow ಆಗಲ್ಲ. It's too late. Let him also, you make him a party first.
Lordship, kindly consider the 25,
You
only for
make,
5 seconds.
make
your
him a
lordship.
party first. Day after
My
tomorrow,
humble
I'll dispose
submission-
the petition.
My humble submission, my lordship. Kindly see the page number 37, your lordship. My humble submission.
ಏನದು?
It's the matter for the 15,000. They freeze the entire account. It was having 5 crores.
Hey, I am not saying I will not allow the petition. I'll allow the petition. You.
ನಮ್ದು ಕನ್ಸರ್ನ್ ಏನಿದೆ ಅಂದ್ರೆ ಈಗ ನಮ್ದು ಅಮೌಂಟ್ we don't have a money to leave. It is a violation of Article 21. Apex Court of India has been stated.
Yo, don't go into larger questions. I'm aware of all that. This lien mark ಮಾಡಿದ್ಯಾ ಯಾವತ್ತು? ಅದು freeze ಮಾಡಿದ್ಯಾ ಯಾವತ್ತು?
Yesterday only I got to know the information from the bank.
Till then you are drawing money, is it?
No, we are not able.
What? How are you living then?
We haven't taken the hand loan. We have taken the hand loan.
So let
We are the senior citizen.
let the hand be till day after tomorrow. Day after tomorrow in the fresh matters list. I'll close it. ಈಗ serve a copy on Jafar.
Much obliged.
KG. Freeze ಆಗಿ 3 ತಿಂಗಳಾಗಿದೆ.
So me.
13/12/2024 is the date on which the disputed amount was seen and frozen.
Kindly see the page
ಆಯ್ತಾ?
number 17.
3 months in the you've been living. How you are living? 2 more days you live. Day after tomorrow
My
we'll give
lordship,
you.
yesterday midnight to 10 a.m. I have downloaded the email because the bank is sent yesterday. Yesterday they communicated me.
No problem. Yes.
Much obliged.
Let's day after tomorrow in the fresh matter. We'll dispose it day after. ನೀವು ಕರ್ನಾಟಕದಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಪಾರ್ಟಿ ಮಾಡಬೇಕು.
My lordship, I have.
State of Punjab I cannot issue directions. If
That's the
state of
reason, my
Karnataka is a 1 minute. State of Karnataka is a party. I would have issued directions to him, communicate, coordinate with state of Punjab and get information. That's all.
My last humble
No,
submission.
no, because you may project yourself to be a cyber victim, but cyber crimes are on the rise. So without getting to know anything, I will not pass any order. Make him a party, give him a copy.
That's the reason I have taken previous occasions of the orders hand summons. I have taken
Yaar
hand
mele,
summons.
sir. State of
State
Punjab.
of Gujarat, against the state of Maharashtra, I served as an advocate.
You
I
want me to
served.
give hand summons?
Yes, my lordship, I will serve. I served it, my lordship. That's the reason
Oh,
I'm
very good,
mentioning
sir.
the
No
annexure.
problem. We'll direct hand summons and
Yes, ma'am.
post the matter after they come appear.
Oh, lordship, we don't have a money. We are suffering.
So that is why, please wait.
Much
Day
obliged.
after tomorrow.
Much
Easy method ಹೇಳಿದ್ರೆ ಕಾಂಪ್ಲಿಕೇಟ್ ಮಾಡ್ತೀರಾ?
obliged.
Yes.
My lords, page number 33, my lords, the deputy commissioner gives a direction. There's an allegation of misappropriation against the priest of Melkote Chilvarayana Swami temple. I am the complainant. DC holds an inquiry. DC finds him to be guilty. That order, my lords, will find at page 33, my lords, point number 1. But
All right.
the sixth respondent does not participate in the proceedings.
All right.
Suspension is revoked. He had been suspended. Suspension is revoked. Division bench of this honorable court, my lords, may kindly see at page 76. Gives a direction in 2021 saying complete the inquiry. And holds that insofar as the suspension is concerned, the suspension can be looked
ಏನ್
into.
ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
My lords, I am challenging now what happened. I'm just coming to background.
ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಬೇಡ ಇವತ್ತಿಂದ.
My lords, what has happened is now assistant commissioner has passed an order on the 17th, on the 13th, saying that exonerating the sixth respondent completely from all allegations.
All right.
This was done without issuing notice to the complainant.
Who are you?
I am the complainant.
All
I was
right.
the original complainant.
All right.
My lords, were to
In
see
a departmental inquiry, you did not participate at all, is it?
there was no departmental inquiry.
Then what is that he has exonerated?
My lord, yes, in this assistant commissioner has passed an inquiry. My lords,
Conducted an inquiry
Conducted
in
inquiry.
which you are not examined. He
Yes.
has exonerated him.
Yes.
You are the complainant.
Yes,
You are aggrieved. 2:30 move
my lords, I'll
ಮಾಡೋದು.
explain. Kindly see. That is what. Kindly see page 76 for a minute.
ಏನಾಗುತ್ತೆ ಈಗ? Exonerate
My
ಆಗಿದ್ರೆ?
lords, 76 al ಹೇಳಿದ್ದಾರೆ. The order of suspension shall be passed. The order in respect of suspension shall be passed on completion of inquiry by the competent authority as provided. The division bench has directed that the moment he is exonerated, if
Suspension should be passed.
no, they can consider and pass orders.
No, sir.
Wait, PC page.
What do you
76.
mean?
My lords,
Yes.
maybe I'm reading is wrong. I'm
Which-
reading it wrong.
which-
I'll read page 76.
Which
my lord.
page?
76 minutes. I'll read it, minutes. In the present case, my lords have page 76.
1 minute, sir.
Yes.
Yes.
In the present case, keeping in view the totality of the circumstances of the case, as a categorical direction has been given by learned single judge to complete the inquiry and pass a final order, this court is of the opinion that the question of revocation of suspension in the peculiar facts and circumstances does not arise. The order in respect of suspension shall be passed on completion of inquiry by the competent authority as provided by the Act of 97, read with rules framed thereunder. My submission is that assistant commissioner is not the competent authority. The competent authority would be the endowment commissioner.
1 minute.
Sorry.
Now, who has exonerated?
The assistant commissioner at.
He is in the nature of an inquiry officer.
Yes, ma'am.
The commissioner is the disciplinary authority.
Yes, ma'am.
The order passed by the assistant commissioner is not be all and end all.
Yes, ma'am.
It will go to the deputy commissioner, commissioner charitable endowments.
My lord,
He will have to accept the report of the assistant commissioner or not. He has the right. And this division bench says after the inquiry is completed, in respect of the suspension, orders will be passed. That doesn't mean he should be placed under
1 minute.
suspension.
That's why.
What is it?
Please see
Reading.
page 70. Please see 79 for a minute. Page 79 for a minute. Just 1 minute. Please see page.
Yes,
79.
sir.
My lord, this is in a pending writ petition. The reason why the inquiry orders were passed in a hurried manner within 1 week is because of page 79. Kindly see.
Again, what is that? What is
My lords, I'm
prejudice?
asking-
What
I'm
is the
asking for-
prejudice cost to you?
My lords, insofar as the temple is concerned, my lord, the person who misappropriated temple jewelry.
All right.
From
He-
2013, he's been under suspension.
All right. Has he come back to the temple now?
My lords, this order, effect of this order.
Effect of this order is not everything, sir.
Minutes.
Commissioner has to pass a separate order.
Minutes, just 1 minute, I follow minutes. Just 1 minute, can you just point one fact after that minutes? I follow what minute? Kindly see page 79 for a minute. This was the order, my lords, which was passed, saying that in the above matter, main allegation made is the brother of the petitioner and so on so is accused of misappropriating and
Sir,
stealing.
allegations may be grave. I am not on that. Now, assistant commissioner has passed an order exonerating. That is not be all and end all. Commissioner charitable endowments is the disciplinary authority. He has the right, he has the power to disagree with the findings of assistant commissioner.
Follow.
Correct?
Yes.
So until that happens, what is your grievance now? Tell me.
My lords, my grievance is that if the endowment commissioner passes an order accepting it without hearing me, of course, because as has been done by this person, kindly see for a minute page 33. There is a finding of guilt by
When
the
that
deputy commissioner.
situation comes about, we will pass some order. Now, Assistant Commissioner's order na stay mado prasanga illa because it's not complete.
No, kindly see,
Now-
because he's passed it across to this honorable court, saying this honorable court may take, kindly see page 31 for a minute. I'll just show
No, sir.
what.
No prejudice is caused to you as on today. If he's entering the temple or the commissioner is endorsing it without hearing you, then come back.
Please, okay.
I'll keep this pending.
My lords, just 1 minute, can I just show page 31? Just one.
30?
Page 31 as compared to page 33. Page 33, 1 minute show between then. Page 33, point number 1. Sorry.
There. Nothing is going to happen, sir.
My lords,
You are
my
the
lords,
complainant, you are not
my lords,
heard, no
my lords,
problem.
over-
That ground can be taken, see, notice will be issued in a departmental inquiry. The complainant stricto sensu has nothing, no role to play. You are an informant. The it is between the department and the delinquent. Now, the inquiry is conducted by the inquiry officer appointed by the disciplinary authority, that is the assistant commissioner.
My lords, that is the thing. My lords, he is not the inquiry officer for the reason that my lords were to see the
Then
act.
why did he hold the inquiry?
My lords, that is the thing. That is what I'm saying, my lords. The
Then
whole
we'll
process,
see, we'll hear
they've
it.
used a court, they've used a court order, my lords, court direction they've used to completely overturn the
We'll
process.
see, we'll see. Learned AGA is directed to accept notice for the respondent
My lords,
1 to 5.
1 to 5 and 12, my lords.
1 to 5
12
and
is the
12.
actual disciplinary
1
inquiry.
minute, 1 to 5 and 12. Others be served by way of hand summons. List the matter on Tuesday in the fresh matters list. ಅಷ್ಟೆಲ್ಲ ಏನಾದ್ರೂ ಮೂವ್ ಮಾಡಿ ಆವಾಗಲೇ ಮಾಡ್ತಾರೆ 10 ನಿಮಿಷ.
Sorry.
Number 3, Varun MR.
Hearing for the petition in this case, my lord. Lord, respond number 3 is the complainant. He was my subcontractor, my lord. There was a contract between him and me to provide service for the third party. And he has raised an invoice, my lord. The invoice at page number 13, my lord. This is the invoice which he has raised. It is at page number 13, annexure B, my lord. As per this invoice, there was some dispute.
Just 1 moment.
Please.
Learned AGA is directed to accept notice for the first respondent. Emergent notice to respondents 2 and 3 returnable by the 17th of April 2024. The petitioners are before this court calling in question a notice issued by the second respondent, National Commission for Scheduled Caste, on the score that the third respondent has complained against these petitioners for non-payment of certain amount. The entertainment of the complaint itself is totally without jurisdiction that is rendered to the second respondent in terms of the statute. Therefore, there shall be an interim order of stay spread for till the next date of hearing. Yes. ಅಷ್ಟೇ ತಾನೇ argument? ಆಯ್ತು, yes.
Petitioner also. Special
Will
lordship.
be traders, yes.
Not seeking the of the notification. Request your lordship kindly.
ಏನ್ ಬೇಕೀಗ?
Now.
ನೀವೇ ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನಾ ಸಪ್ಲೈನೂ ಮಾಡ್ತಾ ಇಲ್ಲ. That is the reason. 25 page. This is the second round of litigation. Lordship has granted interim order. Request your lordship kindly take page 25.
I am there.
Item number 2. The average annual financial turnover of the bidder should be twice the estimated cost of the quantity.
Correct.
Mentioned in the tender document during the preceding 3 financial years. The preceding financial years, if your lordship sees the next class number 3, it should be from 21 to 23, not from 2021. This, your lordship has interfered and granted interim order as per annexure D, page 107.
Copy serve ಮಾಡಿ ಅವರು.
Copy nu serve ಮಾಡಿದೀನಿ. Your lordship,
Yes,
no.
Jafar. ಶಕ್ತಿ ದಾಲ್ ಮಿಲ್ಸ್.
ಅಲ್ಲ ಆ ಪಾಯಿಂಟ್ ಅಲ್ಲ.
ಆ ಪಾಯಿಂಟ್ ಇದೆ ಅದರಲ್ಲಿ.
No, your lordship, preceding 3, no, I am not on the point with regard to the turnover. I request your lordship kindly take annexure D, page 107 for a moment. This is what the order is. 107, annexure D. This is the very same notification now they recalled. It's the interim order.
Interim order ಇತ್ತಾ ಇದರಲ್ಲಿ?
ಹೌದು, ಇದಾದ್ಮೇಲೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ತಿರ್ಗಾ ಇದನ್ನೇ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. That is what I am. Preceding 3 years should be started from
230 ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರು?
The reason is tomorrow is the last date to file my application. Once again, they will reject on the ground that 2021 ಅಲ್ಲಿ COVID ಇರೋದ್ರಿಂದ none of us are able to supply. 39 crores will not become. ಶಕ್ತಿದಾಲಲ್ಲಿ ಟರ್ನ್ ಓವರ್ ಡಿಸೈಡ್ ಮಾಡಿದ್ದಾರೆ. I know the objection should turn over.
ಟರ್ನ್ ಡಿಸೈಡ್ ಮಾಡೋದು ಶಕ್ತಿದಾಲ್.
Twice the turnover has been decided, but the period of turnover should be
I think-
preceding 3 years
I think
commences from
issue-
what, only 21 onward.
ಇಶ್ಯೂ ನಂಬರ್ 6 ಇರ್ಬೇಕು ನೋಡಿ ಇದ್ರಲ್ಲಿ. ಶಕ್ತಿದಾಲ್ ಮಿಲ್ಸ್ ಟರ್ನ್ ಓವರ್.
Turnover ನಾನು ಇದು ಮಾಡ್ತಾ ಇಲ್ಲ. Turnover ಕೊಡ್ಲಿ, because preceding 3 years starts only from 2021 to 24,
You are
not
sim-
2020.
You are simply turning over. Yes.
Let's kindly see annexure D for a moment, page
One
108.
moment. Yes. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ವಾ? ಗೊತ್ತವ್ರಿಗೆ. ಶಕ್ತಿ ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
ಮತ್ತೆ ಗೊತ್ತು, ಅದು ಕವರ್ ಆಗಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
ಆಯ್ತು.
That has been considered by this honorable court in that petition.
We'll
which
take
I-
it day after tomorrow. Look into it. Look into the petition.
Last tomorrow ಇದೆ ನನಗೆ. This honorable court permitted.
You you give your tender. The petitioner shall submit his tender which shall remain subject to the result of the petition.
ಅಲ್ಲ, ಇದು ನಮ್ಗೆ 3 ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋ ಕಾರಣನೇ
Which shall remain subject to the result of the petition. Or if they don't
ಒಂದು ಸಬ್ಮಿಷನ್
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅವಾಗ ನೋಡೋಣ. ಎಸ್,
ಟೆಂಡರ್ಗಳು ಆರ್ಗುನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ.
ಈಗ ನೀವು ಟೆಂಡರ್ ಕೊಡ್ಬೇಕು ಅಂತಿದ್ದೀರಾ ಇಲ್ವಾ?
ಕೊಡ್ಬೇಕು ಅಂತಿದ್ದೀನಿ,
ಕೊಡಿ.
ವಿತೌಟ್ ಇನ್ಸಿಸ್ಟಿಂಗ್ ಆನ್ 2020 ಅಷ್ಟೇ. 21 ಇಂದ 24 ತನಕ 3 ಪ್ರಿಸೀಡಿಂಗ್ ಇಯರ್ಸ್ ಬರುತ್ತೆ, 21 ಇಂದ 24 ತನಕ. That is what.
Let them scrutinize. We will set everything right this time. Yes. ಕೊಡಿ.
ನಾಳೆ ಇದೆ, ನಾನು ತಿರ್ಗಾ ಒಂದ್ ಸೆಕೆಂಡ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಈಗ 6 ಜನದ ಎಲ್ಲರದು ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದೇ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ.
ಈಗ ನೋಡೋಣ ಮಾಡ್ತಾರ ಇಲ್ವಾ ಅಂತ. ಸಾರ್ತಿದ್ ರಿಜೆಕ್ಟ್ ಮಾಡೋದ್ ಕಷ್ಟ. ಕೊಡಿ.
ಇಲ್ಲ, ಅದನ್ನೇ ಹಾಕಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು ಹಾಕಿದ್ದೀನಿ.
The tender scrutiny committee shall scrutinize the applications and not reject the same on the very ground that had met earlier rejections. Yes, next.
ಟರ್ನ್ ಓವರ್ ಡಿಸೈಡ್ ಆಗಿದೆ. ಐ ಆಮ್ ನಾಟ್ ಕಮಿಂಗ್ ಟ್ವೈಸ್ ದಿ ಟರ್ನ್ ಓವರ್.
2020 ಗೆ why have you said ಅಂತ. That is also decided in that. ಕೊಡಿ ಇಲ್ಲಿ. ಶಕ್ತಿ ದಾಲ್ ಕೊಡಿ. ದಾಲ್ ಮೇ ಕಾಲ.
ಇಲ್ಲ ಇಲ್ಲ, because I read out, that is not a point decision. We have challenged twice the turnover ಇರಬಾರ್ದು ಅಂತ, not with regard to the period.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸರ್? 190? ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ. You do one thing. You submit your tender.
Clause number 3
Counsel for the petitioner shall submit his tender which shall be scrutinized in accordance with law, all of which would remain subject to the result of the petition. Yes.
ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಂತ. ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ.
ಅದು subject to the result of the petition.
ಈ ಎರಡನೇ ಮೂರನೇ ಟೆಂಡರ್ ಕರೆದಿರೋದು ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
ಪರವಾಗಿಲ್ಲ ನೋಡೋಣ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
ಥರ್ಡ್ ಟೆಂಡರ್ ಇನ್ ದಿಸ್ ಇಶ್ಯೂ.
ನೀವೇ ಮುಂಚೆ ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ರೆ ಏನ್
ನಾ ಸಪ್ಲೈ
ಅಲ್ಲ ಮಾಡ್ತಿದ್ರೆ ತೊಂದರೆ ಇರ್ತಿರ್ಲಿಲ್ಲ.
ನಾ ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇಲ್ಲ. ಐ ಡೋಂಟ್ ವಾಂಟ್ ದ ಸ್ಟೇ ಆಫ್ ದಟ್. ಐ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್.
That's why I have said yes. ಆಯ್ತು. You ask the government to do that. Madam, ನಾಳೆಯಿಂದ 4 o'clock ಒಳಗೆ ಬಂದ್ರೆ ತಗೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ don't take and don't move the matters.
One sentence may be added so that they should not reject.
Nothing, sir. This 5:45 is enough.
I'm sorry.
From tomorrow, we'll take only memos which come up to 4 o'clock. No FR numbers I will take from tomorrow. Memo of withdrawal estimate. Sorry.
For a petitioner in this case, my lord.
Huh?
Petitioner in this case, my lord. Same case 230 matter 8 and 8.1 ಅದರಲ್ಲಿ ಕೂಡ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. ವಿತ್ ಅಲಾಂಗ್ ವಿತ್ ಲಿಬರ್ಟಿ ಕೂಡ ಆಡ್ ಆಗ್ಬಿಟ್ರೆ ಸಾಕು.
ಆಯ್ತು ಸರ್. ನಾಳೆ. ಎಸ್.
Submission, my lord.
ಮೆಮೋ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord.
List after 2 weeks.
No, my lord. The petitioner father ಇವತ್ತು ಡೆತ್ ಆಗಿದ್ದಾರೆ, my lord. Afternoon, my lord. There is
Petrol.
Yes, my lord.
ಕೊಡಿ. Yes.
Really.
ನಾಳೆ ಆಗಲ್ಲ. Day after tomorrow.
Yeah.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ 2:30. Give it back, madam. ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ 2:30. ನೀವು 7 ಗಂಟೆಗೆ ಮೂವ್ ಮಾಡ್ತೀರಾ ಬಿಟ್ರೆ?
3 o'clock they inform.
ಪರವಾಗಿಲ್ಲ. ಎಸ್. ಪಾಸ್ ಓವರ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಕೇಳಿದ್ರೆ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಎಸ್. ಏನಿದೆ ನಾಳೆ? KV ಲೋಕೇಶ್ ಕರ್ಕೊಂಬನ್ನಿ ಅಂತ ಹೇಳಿಲ್ವ ನಾನು? ಎಸ್, ನೆಕ್ಸ್ಟ್. ವಿಲ್ ಟೇಕ್ ಇಟ್ ಟುಮಾರೋ. ಮೂವ್ ಇಟ್ ಫಾರ್ 2:30 ಟುಮಾರೋ. ಎಷ್ಟಿದೆ ಡ್ಯೂ?
52,80,000.
ನಾಳೆಗೆ 10 ಲಕ್ಷ ಕಟ್ತೀರಾ? ಆಗಲ್ಲ ಅಲ್ಲ. ನಾಳೆ ವಿಲ್ ಟುಮಾರೋ ಟೇಕ್ ಇಟ್ ಎಟ್ 2:30. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Let it come in regular list.
ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಂದ್ರೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
10:30 ಅದು.
ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಂದ್ರೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಮೂವ್ ಇಟ್ ಎಟ್ 10:30 ಟುಮಾರೋ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Request for next week, madam.
Seriously. ಬಿಡಿ ಸರ್ ಸಾಕು ಎಸ್ ನೀವು ಹೊರಡಿ ಮೇಡಮ್. ಅಲ್ಲ ಅವರು ಸರ್ ಮುಗಿಬೇಕಲ್ಲ ಇನ್ನು ಏನು ಡಿಕ್ಟೇಷನ್ ಏನಿಲ್ಲ. ನಾಳೆ ಬೇಡ ನಾಡಿದ್ದಕ್ಕ ಇದನ್ನು ಹಾಕ್ಸಿದ್ದೀರಾ ಹಾಕ್ಸ್ಬಿಡಿ. ಎಸ್ ಸರ್. ಮುಗಿತಲ್ಲ ಮುಗಿಲ್ಲ ಸರ್ ಇಸ್ ಫಿನಿಶ್ಡ್ ಮುಗೀತಾ ಸರ್ ಅಲ್ಲ ನಿಮ್ದು ಮುಗೀತಾ ಓ ಪೆನ್ ಡ್ರೈವ್ ಹೋಗಿಲ್ಲಲ್ಲ ಬ್ರೇಕ್ಗೆ ಬಾದ್ ಎಸ್
This would be. But this would be the last lap of my submission.
Yes, sir.
But three things prima facie I have got to satisfy your lordship. In the event of your lordship being persuaded to accept my submission, to have a look at the conversation. The conversation. Number one.
Where is the transcript of the conversation?
ಅದು ಕೊಟ್ಟಿದ್ದೆ.
Page ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿ ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದೆ ಕಾಪಿ.
ಇಲ್ಲಿದೆ.
But firstly,
but I have serious objection to the pen drive being shown because it is going into the merits. This is all part of he can cross-examine the witness on this point. But this is not the scope of a petition challenging the approvalship. My objection may be noted. I have objection for this.
Yes,
this conduct that he is conducting a mini trial in this court, just in the guise of challenging an approval application.
it is not a mini trial before this court.
Yes, of course, it's a mini trial. Entire evidence, everything is read.
Mr. Raju, please.
Despite the fact that there is no local standing.
Your submission, then I will make my submission.
I am, of course, making a submission that he is addressing the honorable court as if it's the merit of the matter, going into the merits is a contention. You can always challenge an approver by cross-examining him. His right of cross-examination is there.
Raju sir, one moment. What do you want to drive home from this?
Only one point. Only one point.
Yes, what is that point?
The conduct of the first accused is such that he is a blackmailer, a fraud, and he demanded money for the purpose of turning to be an approver in the case, to give evidence against the 15th.
So no credence should be given to the
only for that limited purpose.
That's all right. That we'll see.
Only for that limited purpose.
ಅದಕ್ಕೆ ಇದು ಓದೋದು ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ ಅದು ತೋರಿಸ್ಬೇಕಲ್ಲ ಎಲ್ಲಿ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದಾರೆ ದುಡ್ಡು ಎಷ್ಟು ಡಿಮಾಂಡ್.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ 11 lakhs 11.
ಇಲ್ಲ ಅದಲ್ಲ ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ನನಗೆ.
ಅಲ್ಲ your allegation is that he has demanded. We will ask him about this and leave
matter
it.
of trial.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು Mr. Raju, did you complete your submission?
I'll get back to you, sir.
I am only saying that if you are arguing a matter of an approver and pardon as if it's a mini trial. That's my objection.
Now that the court has permitted me.
No, not to read everything, sir.
Not in depth.
Yes.
Because your lordship posed a question to me for what purpose you are placing reliance on this.
So to demonstrate the conduct of the first accused who.
This material was made available to the court, trial court. It is not for the first time.
ಯಾವ ಪೋರ್ಷನ್ ರಿಲೇ ಆಗ್ತಾರೆ ಅಂತ ಅಷ್ಟು ಮಾತ್ರ ತೋರಿಸ್ಬಿಡ್ಲಿ.
ಅಷ್ಟನ್ನೇ ತೋರಿಸ್ತೀನಿ ಸರ್.
ಯಾವುದು which portion where he demands money ಅಷ್ಟು ತೋರಿಸ್ತೀನಿ.
ಅಷ್ಟನ್ನೇ ತೋರಿಸ್ತೀನಿ, ಬೇರೆ ಏನು ತೋರಿಸೋದಿಲ್ಲ. Three things are necessary here. Number one, that this is a conversation between the first accused and a certain lady. Number one. Number two, this conversation is in or in relation to the case on hand. Number three, that in this conversation, the first accused will put forward a demand for payment of money. if I am able to demonstrate before your lordship from this conversation, or the admission which came to be made by the first accused, I think that would serve my purpose. May I invite your lordship's kind attention?
ಆ ಪೋರ್ಷನ್ ಹೋಗ್ಬಿಡಿ ಸರ್.
ಅಷ್ಟೇ ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ಮುಂಚೆ ಎರಡು ಸೆಂಟೆನ್ಸ್ ಹೇಳ್ತೀನಿ. My lord, my learned friend has filed his affidavit that the first accused, the affidavit of the first accused. In the affidavit so filed by the first accused, he would admit conversation. He does not dispute or deny the conversation. in the
It
affidavit.
disputes the demand for money.
Yeah.
ಅದು accept ಮಾಡ್ಕೊಂಡಿದಾರ as a loan ಅಂತ ಹೇಳ್ದಂಗಿದೆ.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳೋದೇನಂದ್ರೆ it is not,
ಆಯ್ತಾಯ್ತು ನಾಗೇಂದ್ರ ನಾಯ್ಕರ್ wait.
it is not in relation to the case in question. It was in relation to something else, a loan transaction. That is what he would say. I shall now show to your lordship, it was in relation to this case only.
ಅಷ್ಟೇ ಅದೊಂದು
ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
ಕಾನ್ವರ್ಸೇಷನ್ ಕೊಟ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
Conversation. Well, may I request your lordship to kindly turn to my affidavit and the transcript which I have produced along with my affidavit. My lord gets it. Yes, I'm sorry. Kindly go to
Which page?
page 4. Kindly go to page 4 of the transcript. Well, it even makes a reference to my companion accused in the case, to the counsel who is holding brief for the first accused, to the judge.
ಮಾತಾಡಿರ್ತಾರೆ so what?
ಅಷ್ಟೇ, ನಾನು ಇನ್ನೇನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಅಂದ್ರೆ ಡಿಮಾಂಡ್ ಒಂದು ತೋರಿಸ್ಬಿಟ್ರೆ ಸಾಕೋದು ಕಾಣುತ್ತೆ, ಬಾಕಿದೆಲ್ಲ ಬೇಡಲೇ ಬೇಡ
ಅಷ್ಟೇ
ಅಷ್ಟೇ. ಆಲ್ ಮೇ ಐ ರಿಕ್ವೆಸ್ಟ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಟು ಕೈಂಡ್ಲಿ ಸ್ಟ್ರೈಟ್ ಅವೇ ಗೋ ಟು now kindly go to page 5 minute for a second.
Yes.
1, 2, 3, 4. ಬಸವರಾಜ್, ಇಡೀ ಪ್ರಪಂಚವೇ ಒಂದ್ ಸೈಡ್ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಮಗನೇ, ಅಶ್ವಥ್ ಒಬ್ಬ ಫ್ರೀ ಆದ್ರೆ ಸಾಕು ನನಗೆ.
ಅಶ್ವಥ್ ಯಾರು?
A9.
All right.
But even in page 4, but from the bottom, 1, 2, 3, 4, 5, 6, ಬಸವರಾಜ್, ಟೋಕನ್ ಆದ್ಮೇಲೆ 10-15 ದಿನದಲ್ಲಿ ಟ್ರ್ಯಾಕ್ ಆಗಲಿಲ್ಲ ಅಂದ್ರೆ ಟೋಕನ್ ಪ್ಯಾಕ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಟೋಕನ್ ವಾಪಸ್ ₹1 ಎಕ್ಸ್ಟ್ರಾ. My lord gets it? Yes. Now we will go to again page 5 from the bottom, about 5 paragraphs above. ಈಗ ನನಗೇನು ಬೇಡ ಗುರು, ಫೋನ್ ಮಾಡಿದ್ರೆ ಏನ್ ಹೇಳ್ಬೇಕು ಅಷ್ಟು ಮಾತ್ರ ಹೇಳ್ಕೊಡು ಸಾಕು. But you lordship may recall to your lordship's memory that this was a conversation between these two persons, so that a powerful politician is behind this.
There is nothing, no indication about that.
ಇದೆ, ತೋರಿಸ್ತೀನಿ, ಇದೆ.
ಆ ಪೋರ್ಷನ್ ಹೋಗ್ಬಿಡಿ.
ಅವ್ರು ಅಸೆಂಬ್ಲಿಲಿ ಇದ್ದಾರೆ, ಬರೋದು ಲೇಟ್ ಆಗುತ್ತೆ ಅಂತ ಕೂಡ ತೋರಿಸ್ತೀನಿ ನಾನು ಅದನ್ನ.
ಅಸೆಂಬ್ಲಿ?
ಹೌದು, ಸೆಷನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ತೋರಿಸ್ತೀನಿ. ಅದಕ್ಕೆ
all vague things we can't.
ಅದಲ್ಲ.
But this is a transcript produced by the petitioner. It has to
Money,
be proved in the
where
court of
you take me to that portion where money is demanded
Yes.
in connection with this case ಅಷ್ಟೇ, whether it can session, they are in the session or birthday, nothing of that sort.
Yes, yes.
Because those are
before
all
that,
vague
may I
statements
only
which
mention,
would-
where
Sir?
this is not a prosecution documents produced by him. It has to be proved. There has to be 65.
No, true. I only want
Definitely
that sentence with regard to what you're telling, that it.
But
is
that can't
condemned.
be looked at, even if that sentence is, it can't be looked at, my lord. How can it be looked at? Document
That-
produced by him at this stage, unheard of.
We'll consider it, sir. Yes. Whether it should be, ಈಗ ಅದಕ್ಕೆ ಹೋಗ್ಬಿಡಿ ಸರ್ ಅಷ್ಟೇ.
ಅಷ್ಟೇ. Kindly go to page 6. Second para. ಫ್ಯೂಚರ್ಗೆ ಕೇಸ್ ನಡೆಯುತ್ತಲ್ಲ, ಆಗ ನಾನು ಆಚೆ ಇರ್ಬೇಕಷ್ಟೇ.
All right.
Really? ಅಲ್ಲ, this is what my learned friend submitted to your lordship is, this has nothing to do with the case. This is in relation to some other loan transaction.
But where is blackmail money?
ಅದು ನೆಕ್ಸ್ಟ್ ಒಂದೊಂದಾದ್ಮೇಲೆ ಒಂದೊಂದಾದ್ಮೇಲೆ
Yes,
ಬರ್ತಾ ಇದೆ.
yes.
ಇದು ಪೂರ್ತಿ ಓದ್ಬಿಟ್ರೆ ಎಲ್ಲ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ,
Since
ಪೂರ್ತಿ
ಬೇಡ ಅಂತಂದ್ರಲ್ಲ, ಅದಕ್ಕೂ ಇಲ್ಲ, ಓದ್ತಾ ಇಲ್ಲ ನಾನು, ಪೂರ್ತಿ ಓದ್ತಾ ಇಲ್ಲ ನಾನು.
Yes.
Now kindly go to
ಇದಕ್ಕೆ ಪೆನ್ ಡ್ರೈವ್ಗೆ ಬೇರೆ ಬ್ರೀಫಿಂಗ್?
I'm sorry.
ಸರಿ ಸರಿ, ಆಯ್ತು ಆಯ್ತು.
Go to page 7. Fifth paragraph, ಬಸವರಾಜ್. ನನಗೇನು ಇಲ್ಲ, ನಿಮಗೆ ಫೈನಾನ್ಷಿಯಲ್ ಕಂಡೀಷನ್ ನನಗ್ ಗೊತ್ತಿಲ್ಲ. 10 ರೂಪಾಯಿ ಬಂತು ಅಂತಂದ್ರೆ 5 ರೂಪಾಯಿ ನಾನು ಇಟ್ಕೋತೀನಿ, ಇನ್ನೊಂದು 5 ರೂಪಾಯಿ ಬಳಸ್ಕೊಳ್ಳಿ. ಇವತ್ತಿನ ಪರಿಸ್ಥಿತಿಗೆ ಆ ಕಂಡೀಷನ್ 2-3 ದಿನ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ನಾವು ಕೈಂಡ್ಲಿ ಗೋ ಟು ದುಡ್ಡು ಅಡ್ವಾನ್ಸ್ ಕೇಳ್ತಾ ಇರೋದು. ನೆಕ್ಸ್ಟ್ ತೋರಿಸ್ತೀನಿ ನಾನು ಒಂದೊಂದಾಗೆ ಒಂದೊಂದು ಸೆಂಟೆನ್ಸ್.
ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಅಡ್ವಾನ್ಸ್ ಡೈರೆಕ್ಟ್. ಅದರ್ವೈಸ್ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಡ್ರಾ ಇನ್ಫರೆನ್ಸ್ ಫ್ರಮ್ ಕಲೆಕ್ಷನ್ ಆಫ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್, ಇಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ ಹೇಳ್ತೀನಿ, ಇಲ್ಲಿ ನಾನು ಇದು ಮಾಡ್ತೀನಿ ಅದಕ್ಕೆ ನನಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕು
ಅಷ್ಟ್. ಅದೊಂದು ಸೆಂಟೆನ್ಸ್
ತೋರಿಸ್ತೀನಿ. ಇವ್ರು ಹೇಳಿದ್ದು ಮೈ ಲಾಯರ್ ಇನ್ಫಾರ್ಮೇಶನ್ ನಾಗೇಂದ್ರ ನಾಯ್ಕ್ ಸೆಡ್ ದಿಸ್ ಹ್ಯಾಸ್ ನಥಿಂಗ್ ಟು ವಿತ್ ಪ್ರೆಸೆಂಟ್ ಕೇಸ್ ಅಂತ.
ಅಲ್ಲ,
A9 ಇದೆ, ಜಡ್ಜ್ ಇದೆ, ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಫಸ್ಟ್ ಅಕ್ಯೂಸ್ ಇಸ್ ಆಲ್ಸೋ ಹಿಯರ್. ಆ ಲಾಯರ್ಗೆ ಏನೋ ಗೊತ್ತಿಲ್ಲ ಅಂತಾನೆ ಇದೆ. ನಾನು ಹೇಳೋನು ಎವಿಡೆನ್ಸ್ ಕೊಡೋನು ಕೋರ್ಟಲ್ಲಿ, ಅದ್ರ ಕಷ್ಟ ಸುಖ ನನಗ್ ಗೊತ್ತು. ತೋರಿಸ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಗೆ. ಕೈಂಡ್ಲಿ
ಕೊಡೋನು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ, ಅದನ್ನ ಬ್ಲಾಕ್ ಮೇಲ್ ಒಂದು ಮನಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, ನಾನು ಎವಿಡೆನ್ಸ್ ಕೊಡೋನು ನಂಗೆ ಕಷ್ಟ ಸುಖ ಗೊತ್ತು ಇದೆ ಅಂತ ನಾನು ಸರಿ ಓದಿದ್ ನನಗೆ ಕಾಣಿಸ್ತು.
ಇದು ಪರವಾಗಿಲ್ಲ, ನಮ್ ಕಷ್ಟ ಸುಖದ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಎಸ್.
ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 11. One, two, three, four, five, 6 from the top. ಅದೇ ಯಾವ ತರಹ ಏನು ಎತ್ತ ಅಂತ ಮಾತಾಡ್ಬಿಟ್ಟು ಫಸ್ಟ್ ನಾನು ಏನು ಅಂತ ಕೇಳ್ತೀನಿ. ಏನ್ ಮ್ಯಾಟ್ರ್ ಬನ್ನಿ ಮಾತಾಡಿ ಸರ್. ಓಕೆ, ಎಲ್ರೂ ಸೇರಿ ಮೂವ್ ಆಗೋ ಹಾಗಿದ್ರೆ ಮತ್ತೆ ಮಾತಾಡಿ. ಚೀಪ್ ಆಗೋದಕ್ಕೆ ಆಗಲ್ಲ. ಮೂವ್ ಆಗೋ ಹಾಗಿದ್ರೆ ನೀವು ಅವರು ಡೈರೆಕ್ಟ್ ಆಗಿ ಮಾತಾಡೋದಿದ್ರೆ, ಡೈರೆಕ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡೋದಿದ್ರೆ ಕೂತ್ಕೊಂಡು ಮಾತಾಡ್ತಾರೆ. ಹುಡುಗರು ಎಲ್ಲ ಮಾತಾಡ್ಕೊಂಡು ಟೈಮ್ ಇಲ್ಲ. ಓಕೆ, ದೆನ್ ಮೆಲೋಡ್ ಬಸವರಾಜ್. ಇಲ್ಲ ಅಂದ್ರೆ ಪಟ ಅಂತ 2-3 ದಿನದಲ್ಲಿ ಮುಗಿಬೇಕು. ಜೊತೆಗೆ ಇಂಪಾರ್ಟೆಂಟ್ ಆದ ಅವರು 100% ಸಬ್ಜೆಕ್ಟ್ ಅನ್ನ ಪ್ಯಾಕ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಬಾ.
ಒನ್ ಮೊಮೆಂಟ್ ಸರ್. ಈಸಿ ಅಡ್ರೆಸ್ಸಿಂಗ್ ಆರ್ ಟಾಕಿಂಗ್ ಟು ಸಮ್ವನ್ ಹೂ ಆರ್ ಅಗೇನ್ಸ್ಟ್ ಯು?
Not someone against me.
So whatever conversation is there,
he becomes an authorized representative of this man. That is what he says. He is the authorized representative.
now who is this Aishwarya Gowda? It is his accomplice?
Yes. Yes.
ಅವರೇ ಅಫಿಡವಿಟ್ ತಂದು ಹಾಕಿದ್ದಾರೆ.
Affidavit is by you.
No, I know her also.
You know her.
Undoubtedly. I am not here to make a false statement or incorrect or inaccurate statement. They have gone to Delhi. ಅದೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ ನಮ್ಗೆ, as my lord has said.
ಅಲ್ಲ, ಆಯ್ತು. If she is the person who is also known to you,
yes,
and they have some conversation, the conversation does not relate to demanding money from you.
No, my lord.
Then the conversation relates to money transaction of something else somewhere spoken.
No, it looks that I have not made myself clear to your lordship.
No. What I know what is there, but these transactions wherever ದುಡ್ಡು ಬರುತ್ತೆ, evidence ಕೊಟ್ರೆ, all that is not there. And if it is there, this is a matter of trial.
A politician who is inimically disposed towards me and who is after my blood and who wants to ruin my political career.
Where is that reference?
Well, that is what I have said. That is what I have said. And this would indicate, well, kindly permit me to take your lordship some 2 or 3 next step. Well, kindly go to page 10, bottom, page 10, bottom. ಇದು ಲೋನ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇದು ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ಈಗ ಟೋಟಲ್ ಏನ್ ಅಡ್ವಾನ್ಸ್ ಎಷ್ಟು
ಆಯ್ತು.
ಪೇಜ್ 11 at the top. ರಿಲೀಫ್ ಏನಿದೆ ಆ ಡಿಸ್ಕಷನ್.
ಯಾವ ರಿಲೀಫ್?
ಅಪ್ರೂವರ್ ಆಗೋದು.
How do you draw such
But
inference?
a cumulative reading of,
That is why I said, if you want this court to read it cumulatively on collection of sentences, what is of the transcript, it becomes a matter of trial.
No, it is-
One sentence saying that, yes, he has demanded money and he has, for the purpose of blackmail or giving evidence against, that one sentence I am asking. It should not be like sentence should be searched like a needle in a haystack, straight away.
well, now kindly go to page 11. From the bottom about 7 or 8, Basavarajan. Okay. ಅದಕ್ಕೆ ಮುಂಚೆ ಪಟ ಪಟ ಅಂತ 2-3 ದಿನದಲ್ಲಿ ಮುಗಿಬೇಕು. ಜೊತೆಗೆ ಇಂಪಾರ್ಟೆಂಟ್ ಆದವರು 100% ಸಬ್ಜೆಕ್ಟ್ ಅನ್ನು ಪ್ಯಾಕ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಬಾ. He is communicating to her. You go and tell them. ಪ್ಯಾಕ್ ಮಾಡಿಸ್ಬಿಡ್ತೀನಿ ಅವನ್ನ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
Go and tell them ಅಂದ್ರೆ ಯಾರು?
Politician. ನನಗೆ ಅಲ್ಲಿಂದ ಬ್ಯಾಕಪ್ ಆಗಬೇಕು. ಬ್ಯಾಕಪ್ ಆಗಬೇಕು ಅಂದ್ರೆ ಸಪೋರ್ಟ್, ಹಿ ವಾಂಟ್ ಸಪೋರ್ಟ್.
ಬ್ಯಾಕಪ್.
ಬ್ಯಾಕಪ್ ಜೇದು ಅಷ್ಟೇ, ಅಂದ್ರೆ ಜಡ್ಜ್ದು ಕೋಡ್ ವರ್ಡ್.
ಅಂದ್ರೆ ಜವಾನನು ಆಗ್ಬೋದು,
ಜಡ್ಜ್ ಅಂತಾನೆ ಒಂದ್ ನಿಮಿಷ ತಾಳ್ಮೆ ಅಂತೀರಿ ಸರ್. ಏನ್ ನೀವ್ ಹೇಳಿ ಹಾಗಾದ್ರೆ ಜೇದು ಅಂದ್ರೆ ಏನು, ನೀವೇ ಹೇಳ್ಬಿಡಿ ನೋಡಿ. ಏನು
ನಮಗೂ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ನೀವೇ ಮಾತಾಡಿರೋದು, ನಾನಲ್ಲ. ನಾನಲ್ಲ ಮಾತಾಡೋದು, ಅವರು.
ಹೆಂಗ್ ಓದ್ಕೊಂತಾರ ಅವರು?
ಅಲ್ಲ ಜೇದು ನೀವೇ ಹೇಳ್ಬಿಡಿ ಸಾಹೇಬ್ರಿಗಳು, ಏನು ಅಂತ ಹೇಳ್ಬಿಡಿ. ನೀವ್ ಏನ್ ಹೇಳಿದ್ರಿ ಜೇದು ಅಂದ್ರೆ ವಾಟ್ ಡಸ್ ಇಟ್ ಮೀನ್ ಹೇಳಿ ನೋಡೋಣ. ತೋರಿಸಿ ನೆಕ್ಸ್ಟ್ ಜಡ್ಜು ಅಂತ ನೀವೇ ಹೇಳಿ. ಅಲ್ಲ ನಾನು ಒಪ್ಕೋತೀನಿ ಹಾಗಾದ್ರೆ. ಯು ಆರ್ ದಿ ಆಥರ್, ಯು ಆರ್ ದಿ ಪರ್ಸನ್ ಹೂ ಸೆಡ್ ಅಬೌಟ್ ಜೇದು. ನೆಕ್ಸ್ಟ್ ಬಸವರಾಜ್, ಐಶ್ವರ್ಯಗೌಡ. ಓಕೆ ಬಸವರಾಜ್.
ಅವನು
ಜೇದು
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ, ನಾನು ಕುಡ್ದಿದ್ದೇನೆ ನೀನು ಕುಡ್ದಿಲ್ಲ, ಕುಡ್ಕೊಂಡು ಇಬ್ರು ಒಂದು ಗಂಡಸು ಒಂದು ಹೆಂಗಸು ಮಾತಾಡ್ತಾರೆ, ಅದಕ್ಕೆ ವಿ ಕೆನಾಟ್ ಆಡ್ ಅಬ್ಜೆಕ್ಟಿವ್ಸ್. ಜೆ ಅಂದ ತಕ್ಷಣ ಜಡ್ಜ್ ಅಂತ ಹೆಂಗ್ ಹೇಳೋದು?
ಇದು ಕುಡಿದ್ಬಿಟ್ಟಿದ್ರೆ ರಾತ್ ಗೈ ಬಾತ್ ಗೈ.
ಆದ್ರೆ ಹೇಳ್ತಾರೆ 4 ಪೆಗ್ ಹೋಗಿದೆ ಒಳಗಡೆ, ಇನ್ನು 4 ಲಕ್ಷಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ವಲ್ಲ ಅಂತ ಮಾತಾಡ್ತಾರೆ.
ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 11 ನಲ್ಲಿ ನಾನು ಏನು ಅಂದುಕೊಂಡಿದ್ದೇನೋ ಅಷ್ಟು ಜನ ಒಳಗೆ ಹೋಗೋ ಹಾಗಿಲ್ಲ, ಉಳಿದವರಿಗೆ ಏನಿದೆ ಅಷ್ಟೇ. ಈ ಬೈಫರ್ಕೇಟ್ಸ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ A9 that they should not be made to suffer, and whatever he is saying for the rest of the accused. Then ನಾಳೆ ಒಳಗೆ ನೀವು ಮಾತನಾಡ್ಕೊಳ್ಳಿ, ನಾನು ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೀನಿ. ಸರಿ ಮಾತಾಡ್ಕೊಂಡು ಬಂದು ಹೇಳ್ತೀನಿ ಮುಂದಿನದೇ ಏನು ಅಂತ. ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 12.
Oh, is this lady planted to him?
I'm sorry, madam.
Is this lady planted?
No, ಅವರು ಆತ್ಮೀಯ ಸ್ನೇಹಿತರು, ನಮಗೆ ಗೊತ್ತದ. That is not their case.
ಪೂರ್ತಿ ಹೇಳಂಗಿಲ್ಲ ಅದು.
ಅಲ್ಲ, it is not their case. Nagendra Naik repeatedly is saying that this conversation is.
No, this conversation according to him is in a complete inebriated state.
No. His submission before your lordship is, it has absolutely no relevance as far as this case is concerned. It has all the relevance in relation to loan transaction that took place anta. So loan transaction,
not this application.
ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳಿ ಸರ್, ಕೂತ್ಕೊಳ್ಳಿ ದಯಮಾಡಿ.
Yes.
ದಯಮಾಡಿ ಕೂತ್ಕೊಳ್ಳಿ. Now kindly go to paragraph, page 12. From the top, skip
transcript ಮಾಡಿರೋದು ಯಾರು?
I'm sorry, madam.
ನೀವಾ? Yes.
Translation correct ಆಗಿದೆ.
ಅದು ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಕೇಸಲ್ಲಿ ಅವ್ರಿಗೆ ನೋಡ್ಕೊಂತ.
ಇತ್ತೀಚೆಗೆ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, ಈ ಫಿಲ್ಮ್ ರೈಟರ್ಸ್ ಇರ್ತಾರಲ್ಲ, ಡೈಲಾಗ್ ರೈಟರ್ಸು, ಅವ್ರಿಗೆ ನಾವು ಪೆನ್ ಡ್ರೈವ್ ಅಥವಾ CD ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಕನ್ವರ್ಸೇಷನ್ ನಮ್ಗೆ
ಸ್ಕ್ರೀನ್ ಪ್ಲೇ ರೆಡಿ ಮಾಡ್ತಾರೆ,
ಮಾಡ್ಕೊಡ್ತಾರೆ.
ಇದು ಅವರೇ ಮಾಡಿದ್ದು.
ಒಂದು ನೀವ್ ಯಾವ್ದು ಯಾರ ಮಾಡ್ಸಿದ್ರಿ? ಅಲ್ಲ, ಇದು ಇವ್ರು ಅವ್ರೇ ಹಾಕಿದ್ದಾರೆ. ಸೇಮ್ ಥಿಂಗ್ ಮಿಲಾಡ್.
ಹೌದು, ಸ್ಕ್ರೀನ್ ಪ್ಲೇ ವರ್ಸಸ್ ಸ್ಕ್ರೀನ್ ಪ್ಲೇ
ಅಷ್ಟೇ. ಅಲ್ಲಲ್ಲ, ಇದನ್ನೇ ಅವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ, ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಬೇರೆಯವ್ರ ಹತ್ರ ಮಾಡಿಸಿದ್ದಾರೆ. ಸೇಮ್ ಥಿಂಗ್. ಕೆಲವು ಪೇಜ್ಗಳು ಬಿಟ್ಬಿಟ್ಟು ಮಾಡಿಸ್ತಾರೆ ಅಷ್ಟೇ.
ಆಯ್ತು, ಈಗ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ಕಳ್ಸೋಣ
ಅಷ್ಟೇ. ಈಗ ನೋಡೋಣ, ಈಗ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 12 ಫಾರ್ ಎ ಸೆಕೆಂಡ್. ಈಗ ಅವರು ಬಂದು ಸರಿ ಬೇಡ ಅಂದ್ರೆ ಡಿಸ್ಕಷನ್ ಏನೂ ಬೇಡ. ಯಾರು ದಟ್ ಪಾಲಿಟಿಷಿಯನ್, I don't want to name him, my lord. Let us keep him safe.
Oh, that's all right. Is there nothing here? Let us not get into all that, all those things. Yes.
ಬೇಡ ಅಂದ್ರೆ ನಿಮ್ಮ ಸಪೋರ್ಟ್ ಇರ್ಲಿ, ಅವರಿಗೆ ಒಳ್ಳೆಯವರಿದ್ದಾರೆ, ಮಿಕ್ಕಿದ್ದು ಏನಾದರೂ ಅವಶ್ಯಕತೆ ಬಂದರೆ ರಾಜಕೀಯವಾಗಿ ನಿಮ್ಮ ಸಪೋರ್ಟ್ ಇರಲಿ. ರಾಜಕೀಯವಾಗಿ ಆಯ್ತು, ಮುಂದೆ ಕೇಸಿನ ವಿಷಯದಲ್ಲೂ ಸಹ ಸಪೋರ್ಟ್ ಇರಲಿ. ನಾಳೆ ಅವರಿಗೆ ಸೆಷನ್ ಇದೆಯಲ್ಲ, ಮುಗಿಯೋದ್ರಲ್ಲಿ ಸಂಜೆ ಆಗತ್ತೆ. ಆಗಲಿ, ಒಟ್ಟು ಒಂದು ಚೂರು ಡಿಸ್ಕಷನ್ ಆಗಲಿ, ನಾನು ಆಮೇಲೆ ಮಾತಾಡ್ತೀನಿ. Because your lordship said where is that politician comes into picture. Now kindly go to the next page, page 13, my lord. ಆದರೂ ಕೇಸ್ನಲ್ಲಿ ಏನಾದರೂ ಮಾಡಿ ಎಲ್ಲರೂ ಆಚೆ ಬಂದ್ಬಿಡೋದು ಒಳ್ಳೇದು. ಸುಮ್ಮನೆ ಇದೆಲ್ಲ ಯಾಕೆ ಟೆನ್ಷನ್ನು ಫ್ಯಾಮಿಲಿಗಳು ಇದ್ದಂಗೆ ಅಂತಂದರೆ, ಅಪ್ಪಿತಪ್ಪಿ ಕೇಸಿಂದ ನೀವು ಒಳಗಡೆ ಹೋಯ್ತು ಅಂತಂದರೆ ಇನ್ನು ವಾಪಸ್ ಬಂದು ಎಲೆಕ್ಷನ್ಗೆ ರೆಡಿ ಆಗೋದು ಕನಸಿನ ಮಾತಾಗುತ್ತೆ. ದಿಸ್ ಲೇಡಿ ಟೆಲ್ಸ್ ಹಿಮ್, ಸಪೋಸಿಂಗ್ ಯು ಆರ್ ಕನ್ವಿಕ್ಟೆಡ್.
Exactly the point. Lady tells him.
Lady tells
Yes.
him. Supposing you are convicted and suffer some imprisonment or gets into prison, then for your future career for politics and contesting the election may become a little bit difficult.
Accused number 1 contest ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಹೌದು, aspirant.
ಬಸವರಾಜ್ ಮುಟ್ಟಿಗೆ.
ಹೌದು, JDS. Now he is the president of Jai Karnataka Association.
ಜೈ ಕರ್ನಾಟಕ.
ಎಲ್ಲೆಲ್ಲ ಹೋಗೋದು ಬೇಡ.
ಅಲ್ಲ, ಏನ್ ನಗ್ತಾ ಇದೆ ಹೇಳಿ, ಅದೇನು ಹೇಳಿ.
ಜೈ ಕರ್ನಾಟಕ ಅಸೋಸಿಯೇಷನ್.
ಹೇಳಿ ನೋಡೋಣ, ಅದೇನು ಹೇಳಿ.
ಜೈ ಕರ್ನಾಟಕ ಪೊಲಿಟಿಕಲ್ ಪಾರ್ಟಿ ಅಲ್ಲ.
ಅಲ್ಲ, ನಾವು ಅದರಲ್ಲಿ ಸ್ಮಾಲ್ ಅಸೋಸಿಯೇಷನ್ ಇಂದಾನೆ ಬರೋದು ಎಲ್ರೂ.
ಅಲ್ಲ,
ಮಿಡ್ ನೈಟ್ ಆಪರೇಷನ್ ನೀವು ಎಲೆಕ್ಷನ್ ಹೋಗಿ ನಿಂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಿಮ್ಗೆ ಓಟ್ ಹಾಕ್ಬಿಡ್ತಾರೆ. ನೀವು ನೋಡ್ಬಿಟ್ಟು ಯಾರು ಓಟ್ ಹಾಕೋದಿಲ್ಲ.
ಜೈ ಕರ್ನಾಟಕ.
You should make your presence felt by getting yourself associated with some useful organization or not. ಅಲ್ವೇ, ಅದರಿಂದಾನೆ ಮುಂದೆ ಬರೋದು.
That is this association.
ಹೌದು. Now my lord, kindly see the next sentence. ಅಲ್ಲ ಮರ್ತು ಬಿಡೋದು ಅದನ್ನ. ಇದರಲ್ಲಿ ದೊಡ್ಡ ಮಟ್ಟದಲ್ಲಿ ಆಗುತ್ತೆ, ಸಣ್ಣ ಮಟ್ಟದಲ್ಲಿ ಆಗಲ್ಲ. I don't know anything about all these things, but the fact remains that this is the conversation that you may find it difficult if you are convicted and held guilty of the offense in this case, and if you step into the central prison, well, it may become difficult for you to contest the election, is the conversation. I don't know whether he is a political leader or is he going to contest or not, is he attached to some organization or not, or in a political party or not. I am not concerned at this point of time. Well, the conversation would indicate to us that she would say that election ಗೆ ಮುಂದೆ ರೆಡಿ ಆಗೋದಕ್ಕೆ ಕಷ್ಟ ಆಗತ್ತೆ ನಿನಗೆ ಅಂತ. Then my lord, what is his response? ಅಲ್ಲ ಮರ್ತು ಬಿಡೋದು ಅದನ್ನ. ಇಲ್ಲಿ ದೊಡ್ಡ ಮಟ್ಟದಲ್ಲಿ ಆಗುತ್ತೆ, ಸಣ್ಣ ಮಟ್ಟದಲ್ಲಿ ಆಗೋಲ್ಲ. ದೊಡ್ಡ ಮಟ್ಟದಲ್ಲಿ ಆದಾಗ ಅವ್ರ ಮನೆಯಲ್ಲಿ ಅವರ ಮಿಸಸ್ ಹೇಳಿ ನಿಲ್ಲಿಸ್ತಾರೆ, ಅಧಿಕಾರ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ನಮ್ಮ ಪರಿಸ್ಥಿತಿಗಳು ಎಷ್ಟು ಸಲ ಕೇಳಿ ಆ ಮನುಷ್ಯನಿಗೆ ಜಗಳ ಮಾಡಿದ್ದೀವಿ, ಕೂಗಾಡಿದ್ದೀವಿ, ಪ್ರೀತಿಯಿಂದ ಹೇಳಿದ್ದೀವಿ, ಒಡೆದು ಹೇಳೋದನ್ನ ಬಿಟ್ಟು ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಮಾಡಿದ್ದೀವಿ. Now we will come to the payment of money. ಆಮೇಲೆ ನಿನಗೊಂದು ಕ್ಲಾರಿಟಿ, ಕ್ಲಿಯರ್ ಪಿಕ್ಚರ್ ತಲೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡ್ಬಿಡು. ಅಧಿಕಾರ ಅನ್ನೋದು ಬಹಳ ಹೊಲಸ್ದು. ಅಧಿಕಾರಕ್ಕಿರೋ ಬೆಲೆ ನಮಗಿಲ್ಲ. ಇದೇ ಅಧಿಕಾರ ನನ್ನ ಕಡೆಯಲ್ಲಿ ಜನ ನನ್ನ ಕಡೆಗೆ ತಿರುಗಿಸ್ತಾರೆ. ದಿಸ್ ವಾಟ್ ಹಿ ಸೇಸ್. ಮಾಡ್ಲಪ್ಪ, ಅವನು ಏನೂ ಮಾಡಲ್ಲ. ಇಲ್ಲಿ ನಮ್ಮ ಸಿಚುಯೇಷನ್ ಹೆಂಗೈತೆ ಅಂದರೆ, ಈಗ ನನ್ನ 0 ಆದಮೇಲೆ ನಾನು ಏನೂ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ದಿಸ್ ವಾಟ್ ಹಿ ಸೇಸ್ ಅಲ್ವಾ. ಈಗ ಸ್ವಲ್ಪ ಮಾಡಿದ್ದನ್ನ ದೊಡ್ಡದಾಗಿ ಮಾಡಿದ್ದಾನೆ ಅಂತ ಹುಡುಗರನ್ನ ನಿಂದಿಸ್ಬೇಕಲ್ಲಿ, ಹೋಗ್ಬಿಡು ಇಷ್ಟೇ. ಆದರೆ ತಗೊಂಡು ಏನಾದರೂ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ಈ ಪರಿಸ್ಥಿತಿಗಳಿಗೆ. ಈಗ ಮೇನ್ ಸಬ್ಜೆಕ್ಟ್ಗೆ ಏನಾದರೂ ಸಿಕ್ಕುತ್ತೆ ಅಂದರೆ ಅದನ್ನು ಇಟ್ಕೊಂಡು ಬಿಡು, ಬಿಡಬೇಡ, ಟೈಟ್ ಮಾಡಿ ನೋಡು. ಹಾ ಬಿಟ್ಟಿಲ್ಲ, ನಾನು ಮಾತಲ್ಲೇ ಇದ್ದೀನಿ. ನಾವು ಹಿ ಸೇಸ್. ಯಾಕಂದರೆ ಈಗಂತೂ ತುಂಬ ಹತ್ಕೊಂಡು ಉರಿತಾ ಇದೆ ಇಬ್ಬರ ಮಧ್ಯದಲ್ಲಿ. ದಟ್ ಇಸ್
ಯಾರಿಬ್ಬರ ಮಧ್ಯದಲ್ಲಿ?
Politician and 15th accused. Now that they are both of them are at loggerheads, this is the right time for us to strike ಅಂತ. ಹೌದು, ಎಲ್ಲಿ ಹೊಡಿಬೇಕು ಅಲ್ಲಿ ಬಿಟ್ಟು ಹೊಡಿತಾರೆ ಅವರು. ಯಾರು? ದಟ್ ಮ್ಯಾನ್ ಹೂ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಸ್. ಕೇಸ್ ತುಂಬಾ ಟಫ್ ಆಗಿದೆಯಲ್ಲ, ಇವನು ಹೇಳೋದು.
ನಾನು ಕೇಳ್ತಾನೆ ಇದ್ದೀನಲ್ಲ, ತುಂಬಾ ಟಫ್ ಆಗಿದೆ.
ಸುಸ್ತಾಗ್ಬಿಡ್ತೇನೆ.
ತುಂಬಾನೇ ಟಫ್ ಆಗಿದೆ.
ಕೇಸ್ ತುಂಬಾ ಟಫ್ ಆಗಿದೆಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮೇಲೆ ಈಗ ನಮಗೆ ಬೇಕಾಗಿರೋದು ಅಮೌಂಟ್ ವ್ಯವಸ್ಥೆಗಳು. ದಿಸ್ ಇಸ್ ವಾಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವಾಂಟೆಡ್ ಫ್ರಮ್ ಮೀ. ಪೇಜ್ 16. ಈಗ ನಮಗೆ ಬೇಕಾಗಿರೋದು ಅಮೌಂಟ್ ವ್ಯವಸ್ಥೆಗಳು. ಆದರೆ ಏನಾದರೂ ಮಾಡಬಹುದು, ಇಲ್ಲ ಅಂದ್ರೆ ಏನೂ ಮಾಡೋದಕ್ಕೆ ಆಗೋಲ್ಲ. ಭಗವಂತನ ಮೇಲೆ ಸುಮ್ಮನೆ ಬಿಟ್ಬಿಡೋದು.
ಕರೆಕ್ಟ್. ಅಲ್ಟಿಮೇಟ್ಲಿ ಫೈನಲಿ ವಿಸ್ಡಮ್ ಡಾನ್.
ಅಷ್ಟೇ.
ಲೀವ್ ಇಟ್ ಟು ಗಾಡ್.
ಇದು ಯಾವಾಗ ಅಂತಂದ್ರೆ ದುಡ್ಡು ಕೊಡದೇ ಇದ್ರೆ ಭಗವಂತನ ಮೇಲೆ ಬಿಟ್ಬಿಡೋದು.
ಅದು
ದುಡ್ಡು
correct.
ಕೊಟ್ಬಿಟ್ರೆ ಈಗ ಸ್ಟೆಪ್ ಇನ್ ಟು ದಿ ವಿಟ್ನೆಸ್ ಬಾಕ್ಸ್ ಅಂಡ್ ಡಿಪೋಸ್
ಅದೇ ಕರೆಕ್ಟ್, ಅದು ಮಾಡ್ಬೋದು
ಅಲ್ವೇ?
ಈಗ ಸದ್ಯಕ್ಕೆ.
ಇದೊಂದೇ ಸತ್ಯ ಹೇಳಿರೋದು ಅವ್ರು. ನೆಕ್ಸ್ಟ್ ತೊಂದರೆ ಆಗತ್ತೆ. ಯಾರು ಹೇಳ್ತಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕೇಸ್ ಬಗ್ಗೆ ಲಾಯರ್ಗಿಂತ ನನಗೆ ಜಾಸ್ತಿ ಗೊತ್ತು.
ಇರ್ಬೋದು.
ಅದಲ್ಲ, ಮೈ ಲಾಯರ್ ಫ್ರೆಂಡ್ ಹ್ಯಾಸ್ ಬೀನ್ not that he came into picture for the first time
No,
by
that
making the
can't,
application. Right from day one he is there for
you
him.
can't deny that old patient is better than a new doctor.
ಇರ್ಬೋದು. ಹೌದು, ದಟ್ ಇಸ್ ಎ ಪ್ರೊವರ್ಬಿಯಲ್ ಸೇಮ್ ಅಲ್ಲ. ಹಳೆ ಹೊಸ ವೈದ್ಯನಿಗಿಂತ ಹಳೆ ರೋಗಿ ಉತ್ತಮ ಅಂತ. ಇವನ್ ಲಾಯರ್ಗಿಂತ ಅವನಿಗೆ ಚೆನ್ನಾಗಿ ಗೊತ್ತಂತ ಪಾಪ. ನೆಕ್ಸ್ಟ್ ಮಿಲಟ್, ಈಗ ನಿನ್ನ ಮೇಲಿನ ಪೂರ್ತಿ ಡಿಮಾಂಡ್ ಇರೋದು ಸತ್ಯವಾಗಲು ಡಿಮಾಂಡ್ ಇರೋದು. ಕೇಸಿಂದು ನಿನಗೆ ಅರ್ಥ ಆಗೋದಿಲ್ಲ. ಸೇಮ್ ಸಿಚುಯೇಷನ್ ಈಗ ಅದು ಅನುಭವಿಸೋರಿಗೆ ಗೊತ್ತು. ಹೂ ಗೆಟ್ ಪಿಂಚ್ ಮಿಲಟ್, ಹಿ ನೋಸ್ ದಿ ಪೇನ್ ಆಫ್ ದಟ್ ಪಿಂಚ್. ಯಾರಿಗೂ ಗೊತ್ತಾಗಲ್ಲ.
Only if it is on the wrong nerve. Yes.
ಅದು ಹೊರಗಡೆ ಸುಮ್ಮನೆ ನಕ್ಕೊಂಡಿರ್ತೀವಿ ನಾವು, ಒಳಗಡೆ ಅದನ್ನು ಅನುಭವಿಸೋನಿಗೆ ಗೊತ್ತು. ಮಗನೇ, ನನ್ನ ಫಸ್ಟ್ ಪ್ರಯಾರಿಟಿ ಎಲ್ಲರೂ ಪಾರಾಗಿ ಹೋಗ್ಲಿ. It reminds me, please do not mistake me, my lord, if I were to say this in good humor, I am saying it. One lawyer, senior lawyer was arguing one matter, a criminal appeal before this court, before a learned single judge. Well, I would always use for every word, my lord, my lord, my lord, my lord, for every word, or 2 or 3 words when they go together. Then the learned judge would ask him, what is the case you just come out? Then the learned counsel who was representing the senior counsel went on saying, my lord, the case of the prosecution, my lord, is, my lord, that the accused bet my lord with chappal. ಎಷ್ಟು ಆಭಾಸ ಈಗ ತಾವು my lord God, when I said ಮಗನೇ ಮಗನೇ, ನನ್ನ ಫಸ್ಟ್ ಪ್ರಯಾರಿಟಿ ಎಲ್ಲರೂ ಪಾರಾಗಿ ಹೋಗ್ಲಿ. ಸುಮ್ಮನೆ ಯಾಕೆ ಅಂದ್ರೆ ನಾನು ಯಾಕೆ ಇದನ್ನು ಓದ್ತಾ ಇದ್ದೀನಿ?
ಟಾಕಿಂಗ್ ಟು ದಿ ಲೇಡಿ ಅಲ್ವಾ?
ಅಷ್ಟೇ, ಸರಿ, ಪ್ರೀತಿಯಿಂದ ಕರೆಯೋದು ಕನ್ವರ್ಸೇಷನ್.
ಈಸ್ ಟಾಕಿಂಗ್ ಟು ದ ಲೇಡಿ ಸೇಯಿಂಗ್, ಮಗನೇ, ಈ ಕಾಂಟ್ ಟೆಲ್ ಹಿಮ್ ಈಸ್ ನಾಟ್ ನಾರ್ಮಲ್ ಎಟ್ ಆಲ್, ಈಸ್ ಡ್ರಂಕ್.
ಇರ್ಲಿ, ಬಟ್ ಬಾಕಿದೆಲ್ಲ ಕರೆಕ್ಟ್.
ಟೆಂಡರ್ ಪ್ರಾಬ್ಲಮ್
ಅಲ್ಲ, ದುಡ್ಡು ಬೇಕು, ಅಡ್ವಾನ್ಸ್ ಬೇಕು, ಕೇಸಲ್ಲಿ ನಾನು ಈಚೆ ಇರಬೇಕು, ಕುಡ್ದವ್ನಿಗೆ ಅದೆಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ, ಇದು ಮಾತ್ರ ಗೊತ್ತಾಗುತ್ತೆ.
ಕುಡ್ದಾಗ್ಲೇ ಅವೆಲ್ಲ ಗೊತ್ತಾಗೋದು. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು
ದುಡ್ಡು ಬೇಕು ಅಂತ ಅನ್ನೋದು.
ಇದು ಬೆಳಗ್ಗೆ ಎದ್ದು ಇದೇ ಕಾನ್ವರ್ಸೇಷನ್ ಮಾಡಿದ್ರಾ?
ಹೌದು.
ಇಲ್ಲ, ಇದು ಯಾವಾಗಿಂದ ಇದು
ಹೇಳ್ತೀನಿ ನಾನು, ಇನ್ನು ತೋರಿಸ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಎರಡೇ ನಿಮಿಷ. ಮಲ್ಟಿಪಲ್ ಕನ್ವರ್ಸೇಷನ್
ಅಲ್ಲ, ಮತ್ತೆ ಪಿಕ್ಚರ್ ಅಭಿ ಬಾಕಿ ಹೈ ಅನ್ಬೇಡಿ, ಮುಗಿಸ್ಬಿಡಿ,
ತೋರಿಸ್ಬೋಣ ಅದನ್ನ.
ಎಸ್.
What if the transcript is not correct, my lord? These are all matters of trial. What if the transcript is not correct?
He'll 2 more lines, he will finish it.
Yes.
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 Now kindly go to page 18, my lord. This is what he says. ನಾಳೆ ತಿನ್ನೋ ಒಂದೊಂದು ತುತ್ತು ಅನ್ನಕ್ಕೂ ಡಿಪೆಂಡ್ ಆಗ್ಬೇಕಾಗತ್ತೆ ಅಷ್ಟೇ. 1-2 ದಿನ ಇದ್ದು ಬನ್ನಿ, ಫ್ಯಾಮಿಲಿಯವ್ರ ಜೊತೆನೂ ಮಂಡೇ ತನಕ ಇದ್ದು ಟ್ಯೂಸ್ಡೇ ಬರೋದು ಅಥವಾ ಮಂಡೇ ಈವ್ನಿಂಗ್ ಬರುವುದು ಹಂಗೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಇವಾಗ ಹಿಂಗೆ ಹೋಗಿ ಅಲ್ಲೆಲ್ಲ ಜೊತೆ ಮಾತಾಡ್ಕೊಂಡು ಬಂದರೆ ಪಾಪ ಅವ್ರಿಗೂ ಬೇಜಾರಾಗತ್ತೆ. ಈಗ ಒಂದು ಫೈನಲ್ ಡಿಸಿಷನ್ ತಗೊಂಡ್ರೆ, ಅಶ್ವಥ್ ಏನು ಫೈನಲ್ ಡಿಸಿಷನ್ ತಗೊಂಡಿದ್ದಾನೆ, ದಟ್ ಇಸ್ A9. ಇಲ್ಲ ನೋಡು, ಅಚ್ಚ ನನ್ನ ಹತ್ತಿರ ಈಗ ಮಾತಾಡಿದರೆ ಮನೆಯಲ್ಲಿ ಫುಲ್ ಟೆನ್ಷನ್ ಆಗಿಬಿಡ್ತಾಳೆ, ಅಲ್ಲಿ ಮಾತನಾಡೋದಕ್ಕಾಗಲ್ಲ, ಈಗ ಮಾತಾಡಬೇಕು. ಯಾರು ನಿನ್ನ ಹತ್ರ ಮಾತನಾಡಬೇಕು? ಅಶ್ವತ್ಥನ ಹತ್ರ ಮಾತನಾಡಬೇಕು. ನಾನು ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಕ್ಕೆ ಕೇಸ್ ಇಲ್ಲಿಯವರೆಗೂ ಬಂದಿದ್ದು ಅಲ್ಲ, ಅವನು ಮೇಂಟೈನ್ ಮಾಡಿದಂತೆ ಕೇಸ್ ಇಲ್ಲಿ ಅಂದ್ರೆ ಮೊದಲೇನೆ ಇವನೇನಾದ್ರೂ
ಎಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್
ಅಪ್ರೂವರ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಗೊತ್ತಾಯ್ತೆ.
No, we're getting too much into the conversation where there is nothing explicit saying that he has demanded money for the purpose of the case.
ಡಿಮಾಂಡ್ ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲ,
ಅಡ್ವಾನ್ಸ್ ಕೊಡಿದ್ರೆ ಇದೆ ನೆಕ್ಸ್ಟ್.
That should be explicit, that should be direct. If it is inferential, then it is
ಮೇಬಿ
inferential.
ಇದು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಓದಿ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು
yes.
ಸಾಕಷ್ಟೇ. Having read the mind of the court, my lord, I should not
That's what I
stress
feel.
too much on
That's
this.
what I feel.
Yes. ನಾನು ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಕ್ಕೆ ಇಲ್ಲಿವರೆಗೂ ಬಂದಿದ್ದು. ಇಲ್ಲ ಅಂದಿದ್ರೆ ಯಾವತ್ತೋ ಸಮಸ್ಯೆ ಆಗೋಗ್ಬಿಡ್ತಾ ಇತ್ತು. ದೇವರ ಮೇಲೆ ಭರವಸೆ ಏನು ಅಂದ್ರೆ ಇಲ್ಲಿವರೆಗೂ ಬಂದಿದೆ ಅಂದ್ರೆ ಇದುವರೆಗೂ ಸಹ ಸಮಸ್ಯೆ ಆಗಿಲ್ಲ. ಮೊದಲೇ ಇವನೇನಾದ್ರು ಆಗ್ಬಿಟ್ಟಿದ್ದೆ ಸಮಸ್ಯೆ ಶುರು ಆಗ್ಬಿಡ್ತಾ ಇತ್ತು ಅವತ್ತೇ ಅಂತ. As my lord has said, it may be an inference. Next, but ಆದ್ರೂ ಜಡ್ಜು ಜೆ ಹೇಳಿಲ್ಲ ಯಾರು ಜೆ ಅಂತ.
ಈಗ ಜಡ್ಜ್ ಅಂತಾನೆ ಹೇಳಿದಾರಲ್ಲ.
ಈಗ ಜಡ್ಜ್ ಅಂತಾನೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾಯಕ್ ಜಡ್ಜ್ ಅಂತಾನೆ ಹೇಳ್ಬಿಟ್ಟು
ಜಡ್ಜ್ ಅಂತ ತಗೊಳ್ಳೋಣ ಜೆ.
ಆಯ್ತಾಯ್ತು ಕೂತ್ಕೊಂಡು. ಜೆ ಅಂದ್ರೆ ಬೇರೆ ಏನೇನೋ ಇದೆ. ಎಸ್.
ಬಟ್ ಜಡ್ಜ್ ಆದ್ರೂ ಜಡ್ಜ್ ಇನ್ನೊಂದು 3 ತಿಂಗಳಿಗೆ ಎಲ್ಲ ಕೇಸನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಕೇಸು ಹಂಗೆ ಹಿಂಗೆ ಅಂತಂದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡೋದು ರೀತಿ ಯಾವ ತರ ಇರುತ್ತೋ ಏನೋ ಹಂಗಾಗೋಗುತ್ತೆ. ಅದೇ ನಿನ್ನ ಮೇಲೆ ಡಿಪೆಂಡ್ ಅಂದನಲ್ಲ, ನನಗೆ ಫೈನಾನ್ಷಿಯಲ್ ಕಂಡೀಷನ್ ಕ್ಲಿಯರ್ ಆಗ್ಬಿಡ್ಬೇಕು, ನನಗೆ ಏನು ಡಿಸಿಷನ್ ನಂತರ ತಗೋಬೋದಲ್ಲ. ಈಗ ನೀನು 30ನೇ ತಾರೀಕಿನ ಒಳಗಡೆ ನನಗೆ 5 ಕೊಡ್ತೀನಿ ಅಂತ ಪಕ್ಕಾ ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ರೆ ನಾನು ಪಕ್ಕಾ ಡಿಸಿಷನ್ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ.
ಪಕ್ಕಾ ಪ್ರಾಮಿಸ್.
ಪಕ್ಕಾ ಪ್ರಾಮಿಸ್ ಆಗ್ಬೇಕು ಇವನಿಗೆ ದುಡ್ಡಿಗೆ.
5 ಏನು
5 ರೂಪಾಯಿಗೆ ಇವನಕ್ಕೆ $5 ಅವನಿಗೆ ಕುಡಿಯೋಕೆ ಬಾಟ್ಲು ಕೂಡ ಬರೋದಿಲ್ಲ, ಕಳಬಟ್ಟಿ ಸರಾಯಿ ಕೂಡ ಬರೋದಿಲ್ಲ ಅವನಿಗೆ. ಅಟ್ಲೀಸ್ಟ್ $500 ಆದ್ರೆ ಒಳ್ಳೆ ಬರುತ್ತೆ ಅಂದ್ರೆ ಜಸ್ಟ್ ಸೇಯಿಂಗ್. ಬಟ್ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಾದ್ರೂ ಇದನ್ನ ರೆಫರ್ ಮಾಡಬಹುದಾಗಿತ್ತು. ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಡ್ ನಾಟ್ ರೆಫರ್ ಟು ಇಟ್ ಅಟ್ ಆಲ್,
ವಿಲ್ ಕನ್ಸಿಡರ್
ಡಿಸ್ಪೈಟ್ ದಿ ಫ್ಯಾಕ್ಟ್ ಇಟ್ ಹಸ್ ಕಮ್.
ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಲ್ಯಾಂಡ್ ಆದ್ರ ಇನ್ನೂ ಇಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಆಗಿದೆ, ಮತ್ತೆ ಮಾಡಂಗಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಓನ್ಲಿ ರಿಪ್ಲೈ tomorrow.
One submission. Therefore, my learned friend cannot contend that this conversation, whether it is acceptable or not acceptable, whether an inference could be drawn or not, irrespective, that his contention was, this was not vis-a-vis this case is concerned. That is number one. There was no demand for payment of any amount. Is only incorrect submission would be very respectful.
ಅಲ್ಲ ನಾ ಪೆನ್ ಡ್ರೈವ್ ಮೇಲೆ ನಾನು ರಿಪ್ಲೈನೇ
ನೀವು ಸುಮ್ಮನೆ ಇರಕ್ಕಾಗ್ಲಿಲ್ಲ. ಈಗಲ್ಲ ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೇಳಿದ್ ನಾನು
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲೂ ಹಾಕಿಲ್ಲ,
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಏನು ಹಾಕಿಲ್ಲ,
ಇಲ್ಲೂ ಹಾಕಿಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಅವ್ರು ಬಿಟ್ರು ಅದನ್ನ, ನಾನು ಸುಮ್ಮನೆ ಬಿಟ್ಬಿಟ್ಟೆ. ಈಗ ಇಲ್ಲಿ
ಯಾರು ಬಿಟ್ಟು
ಇಶ್ಯೂ ಮಾಡಿದ್ರಿಂದ
ಬಿಡೋ ಹಾಕಿದ್ರೆ ನಾವ್ಯಾಕೆ ವಿತ್ ಮೆಮೋ ವಿ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಇಟ್.
ಹೇಳಿ
ಹೇಳ್ಬಿಡಿ.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಜಡ್ಜ್ ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂದ ತಕ್ಷಣ ಅದನ್ನ ನಾವು ಬಿಟ್ಟು
that is an incorrect statement. My lord,
ಈಗ
how could the judge say that there is nothing in even without production? The judge would say he might have played somewhere. I don't know where he has played it.
ನಾಳೆ ನಾನು ರಿಪ್ಲೈ ಮಾಡುವಾಗ ಹೇಳ್ತೀನಿ.
ಮತ್ತೆ don't make
ನಾಳೆ
inaccurate
ನಾಳೆ
statement.
ಮಾಡ್ತೀನಿ.
How could the judge say that there is nothing
take more than
without him playing it and seeing it?
that's a
I
submission.
have right to reply.
that's a submission. ಈಗಲೇ
15 ನಿಮಿಷ
ಈಗಲೇ ಮಾಡ್ತೀರಾ ನಾಳೆ?
ಇಲ್ಲ ನಾಳೆ ಮಾಡು. I will just comprehend whatever they have said. ಒಂದೇ ಸರಿ
ಕಾಂಪ್ರಹೆಂಡ್ ಬೇರೆ
ಹೌದು, ಇಲ್ಲ ಯಾಕೆಂದ್ರೆ ಏನೇನೋ ಸಬ್ಮಿಷನ್ಗಳಾಗಿದೆ. I will have to meet it.
Yes, tomorrow.
In that case, my arguments may be kept on 24th, my lord, first session.
Yes, sir, definitely.
24th first, because
Yes.
24th is
That
Monday.
is your reply to senior counsel C.V. Nagesh.
And yes, because that will be my
Because
reply.
others you have already replied.
Yes, I'll reply, my lord.
Yes, sir.
I'll try to be brief, not as lengthy as my Nagesh, but I'll try to be brief.
Yes, sir. You were brief the other day also. That's all right. Yes.
I'll be to the point, and 25th is Tuesday, heavy board in the Supreme Court. So I'll
No,
request in the first.
24th will finish it, sir, with your
First
reply.
session, first
Yes,
session,
there
my
is-
lord, because-
There is no reply to his reply then. Yes,
Grateful.
already. Yes. ನಾಳೆ
ನಾಳೆ
ಮತ್ತೆ ನೀವು ಎಲ್ಲ ಓದ್ಕೊಂಡು ಕೂತ್ಕೋಬೇಡಿ.
ನಾ ಏನು ಓದಲ್ಲ.
ಹಾ.
ನಾನೇನು ಓದಲ್ಲ. ಐ ವಿಲ್ ಮೇಕ್
ನೀವ್ ಯಾಕೆ ಓದ್ತೀರಾ? ನಿಮ್ ಅಗೇನ್ಸ್ಟ್ ನೀವ್ ಯಾಕೆ ಓದ್ತೀರಾ?
ಇಲ್ಲ, ನನ್ನ ಅಗೇನೆಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಸರಿ,
ಅದು ತೋರಿಸ್ಬೇಕಂತ ತೋರಿಸ್ತೀನಿ. ಯಾಕಂದ್ರೆ ನಾನು ಏನು ಕನೆಕ್ಟಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ ಅಂದ್ರೆ ಜಸ್ಟ್ ಟು ಎಕ್ಸ್ಪ್ಲೈನ್ ಇಟ್ ಈಸ್ ನಾಟ್ ರಿಲೇಟಿಂಗ್ ಟು ದಿಸ್. ದೇರ್ ಆರ್ ಅದರ್ ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಷ್ಟೇ.
Between you and her.
Yes.
Since when do you know her?
I know her last 2 years.
Oh.
ಅಂದ್ರೆ ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಈ ಕೇಸ್ ವಿಚಾರ, ಜಡ್ಜ್ ವಿಚಾರ, ಲಾಯರ್ ವಿಚಾರ.
ಮಾತಾಡಿದ್ರೆ ಗೊತ್ತಿದೆ ಅಂದ್ರೆ ಎಲ್ಲಾನು ಮಾತಾಡಿದ್. ನಾನು ಹೋಗಿದ್ದೀನಿ, ಅವರು ಹೋಗಿರೋದು, ಅವರು ಇದ್ರೆ
ಅಂದಲ್ಲ ಇರೋದು. ಪ್ರಶ್ನೆ ಇರೋದು ನಿಮ್ಮದು.
ನಂದು
ಇದ್ರೆ ಕೊಡಿ.
ನಂದ?
ಅಲ್ಲ, ನಾನೇ
ಅದಕ್ಕೆ ಸರಿ
ನಂದು ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಕೊಡಿ. ಡೆವಲಪ್ an argument, point out. ತಪ್ಪಿಲ್ಲ ಅದರಲ್ಲಿ. If it is going to inure to your benefit, do it, produce it.
ನಿಮ್ದೇನ್
Boldly accept it.
ಒಟ್ನಲ್ಲಿ ನಮ್ಮನ್ನ ಮಾತ್ರ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮಧ್ಯದಲ್ಲಿ ಈ ಕಾನ್ವರ್ಸೇಷನ್.
ಇಲ್ಲ ನಿಮ್ಮನ್ ಬಿಟ್ಟಿಲ್ಲ. ನೀವು ತಲೆ ಮೇಲೆ ಕೈ ಇಟ್ಕೊಂಡು ಕೂತ್ ಬಿಟ್ಟಿದ್ದೀರಿ. ಇವ್ನಿಗೆ ಯಾಕಪ್ಪ ನಾನ್ ರೆಕಮೆಂಡ್ ಮಾಡಕ್ ಹೋದೆ ಅಪ್ರೂವರ್ ಆಗ್ಲಿ ಅಂತ ಅನ್ಬಿಟ್ಟು ತಲೆ ಮೇಲೆ ಕೈ ಇಟ್ಕೊಂಡು ಕೂತಿದ್ರಿ ಈಗ ನೀವು. ಆಯ್ತಾ? ನಾ ಇಂಥವ್ನಿಗೆ ಮಾಡಬಾರ್ದಾಗಿತ್ತು ಅಂತ.
Even if the conversation is admitted by the other side, whether it is tampered or not, everything will have to be established in a court of trial.
That will, I'll answer all that.
Yes.
It is for him to say that it has been tampered. He doesn't say it is tampered.
He has not yet made his submission.
ಅಲ್ಲ, ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ. ಅಫಿಡವಿಟ್ ಇದೆಯಲ್ಲ.
ಮಾಡಿ ನಾಗೇಂದ್ರ ನಾಯಕ್ ನಾಳೆ ಮುಗಿಸ್ಲಿ.
ಮಾಡ್ಲಿ. ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಟ್ಯಾಂಪರ್ಡ್ ಅಂತ.
ನಾಳೆ 4:15 ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
Grateful minutes.
Well, your lordship did not give much importance to these things.
Which things, sir?
ಈ recorded versions ಅದಕ್ಕೆಲ್ಲ
ಇಲ್ಲ, I will answer legally. This
I know where I stand.
The submission is only, your submission is only with regard to his conduct.
ಅಷ್ಟು ಬಿಟ್ರೆ ಬೇರೆ ಇನ್ನೇನಿಲ್ಲ. Much importance need not be given to this.
That will, yes. But I'll answer the contentions, all the contentions.
Grateful to your lordship.
Yes, sir.
Immensely grateful. My lords are sitting beyond court. Grateful.
Tomorrow also we'll finish it.